The respondent alleged that the marriage of the respondent and the petitioner was solemnized on CMR Convention or Sarjapuram Main Road. And according to prevailing Hindu rites and customs, in the presence of family members, date of marriage, that is since 1992, the respondent has been subject to physical and mental abuse, being helplessness, unhappiness, and anger on the account of the petitioner and being unable to bear the trauma and damage, the respondent fearing for her life, being destitute without any financial support and freedom. The respondent also alleged different domestic violence acts. Thus, the respondent filed petition on Section 12 of the Protection of Women from Domestic Violence Act. The master without jurisdiction and without following procedure ruled by order dated 19/3/2000, passed by the Metropolitan Master Traffic Court. Pradeep R. Advocate, Senior Advocate, Dushyant Dave.
Lord, may I? Is the court in session?
No, sir.
Is court in session? I can't see the.
No, sir. The court has not yet begun.
Okay.
You're not permitted. Sir, you're not permitted.
ఇందుక కపిల్ సిబ్బాలు డాక్టర్ సీనియర్ అడ్వకేట్ దుష్యంత్ దవే అందరూ కానొస్తారు.
Can you mute yourself? You can be heard, sir. Lord, may I have your Lordship's liberty to mention?
What?
Can your Lordships hear me?
Yes, sir. 1 minute.
Lord, item 82.
That's at 2:30, sir.
Yes, Lord, but I was mentioning to Lord, inform your Lordships that.
No, the other side is there?
Yes, Lord, we have informed.
Yes.
Lord, we have challenged both your Lordship's substantive judgment insofar as my client has been condemned, Devaraj, and also your Lordship's order of 5th of November. The division bench has issued notice and kept the appeals, although no stay.
Is there an interim order of stay?
No, there is no interim order.
Yes, sir.
But both appeals have been fixed for hearing in January.
No problem, sir.
I'm in your Lordship's hands, my Lord.
Yes, sir. 2:30 we'll consider it. Well, the other side, because a lot of advocates are waiting.
Very well.
2:30 we will take it, sir.
Very well, Lord.
I have some submissions to make.
No, at 2:30 we'll take it. Not now at all.
My lord, it was filed.
Why are you quoting the name? I will not take that memo. Yes. Rush matter iದ್ರೆ Monday ಕೊಡಿ ಅಲ್ಲ.
Lordship 2:30.
Why? By 2:30.
Tomorrow, Lordship.
If all of you are saying at once, not a single memo I will take. If you have cooperation amongst yourself, please be there. Yes. Settlement ಬರ್ಕೊಡಿ ಯಾವತ್ ಬೇಕು. ಬರೆದು ಕೊಡಿ ಯಾವತ್ ಬೇಕು ಅಂತ ಅವತ್ತು ಬರುತ್ತೆ. Yes, what is it? When? 20th, Monday, give it. Yes.
There's no stay.
Pending matter? After vacation. Yes, next. ತೊಂದರೆ ಇಲ್ಲ ಕೊಡಿ. Yes. Memo ಕೊಡೋದು ಕೊಡಿ. Pending matters I won't take. Yes. Give it. Monday, yes. Now tell me. You decide who has to tell first.
Asked us to complain to the Commissioner of Police for protection.
Hmm.
Still they are hiring tools and he's not even able to stay in his own house. He's belonging to the SC community.
Tomorrow, give it tomorrow.
Restaurant about 5th of March.
Monday ಆಗ್ಬೋದಾ? Monday, we'll fix it for Monday, give it. Madam, 4-5 ಸರಿ ಮೂವ್ ಮಾಡ್ತಿದ್ದಾರೆ ಅವರು. Why is not coming? ಆಮೇಲೆ 1 ನಿಮಿಷ. Monday. Why warrant issue ಆಗೋರ್ಗೆ ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ ಕೊಡಿ. Yes. Monday, please.
Before it is coming, before court, they have filed charge sheet.
Now what have you challenged? Monday ಕೊಡಿ. ಎಲ್ಲ fresh matters which can wait till Monday, please give. No, please don't shout. Wait. Monday ಆಗುವಂತದೆಲ್ಲ ಕೊಡಿ. ಯಾಕೆ wait ಮಾಡಿ?
2:30.
Filed a complaint after being served with a legal notice for.
That ground don't tell in my court at all. Anything else? Fresh or pending? Give it.
Lordship.
One matter for 2:30.
Monday, sir. Why, sir?
ಸ್ಟಾರ್ಟ್ ವಿಡಿಯೋ ಅಂದ್ರೆ ಆಗ್ತಾ ಇಲ್ಲ.
Wait. Who is on VC, please? Yes. $2:30 ತಗೊಳ್ಳಿ. Yes. Monday. ಬರ್ದ್ಕೊಡಿ. When do you want it? Give it. Tomorrow 2:30 settlement ಹಾಕಿ. Yes, Raghu. Wait. Yes. ಏನ್ ಬೇಕು? ಮಂಡೇ ಆಗ್ಬೋದಾ? 12:12. ಓ ಸರಿ, 12:12 ತಗೊಳ್ಳಿ. ಮುಹೂರ್ತ ಚೆನ್ನಾಗಿದ್ಯಾ? ಆಯ್ತು ತಗೊಳ್ಳಿ. ಎಸ್. 12:12 ಹಾಕಿ ಅದು. ಸೆಟಲ್ಮೆಂಟ್ ರೈಟ್ ಅಂಡ್ ಗಿವ್. ಸ್ಪೆಷಲ್ ಕೋರ್ಟ್. ಓಯ್ ಸ್ಪೆಷಲ್ ಕೋರ್ಟ್ ಮ್ಯಾಟರ್ ಅಂದ್ರೆ ಥರ್ಸ್ಡೇ ಸರ್. ಆಯ್ತು ಕೊಡಿ. 2:30 ತಗೊಳ್ಳಿ. ಮಂಡೇ ಸರ್. ಮಂಡೇ ಆಗ್ಬೋದಾ? ಏನ್ ಮಾಡೋದು ಸರ್? ಅದಕ್ಕೆ ಈಗಲೇ ತಗೋ ಕೊಡಿ. 2:30 ತಗೊಳ್ಳಿ. ಒಂದ್ ಸಾಕು. ನೀವು ಡೋಂಟ್ ಗಿವ್ ಕಲೆಕ್ಷನ್ ಆಫ್ ಮೆಮೋಸ್. ಏನಾಗಲ್ಲ ಅದ್ರಲ್ಲಿ ಏನಾಗಲ್ಲ ಬಿಡಿ. You withdraw the petition and for challenge the charge sheet. ಕೊಡಿ ಅದು 2:30 ಹಾಕ್ಸಿ ಮೇಡಮ್. ವಿಡ್ರಾಲ್ ಮಂಡೇ. ಪೆಂಡಿಂಗ್ ಫ್ರೆಶ್ ಮಂಡೇ. ವೈ ಸರ್ ಮಂಡೇ ಸೆಟಲ್ಮೆಂಟ್ ಪ್ಲೀಸ್ ಗಿವ್ ಸರ್. ಕೊಡಿ ಸರ್. ವೈ ಟುಮಾರೋ? ಅದಕ್ಕೆ ಅದು ಓಕೆ ಕೊಡಿ. ಇವೆಲ್ಲ ಹೇಳ್ಬೇಡಿ ಸುಮ್ನೆ. ಎಸ್ ಅದು ನಾಳೆಗೆ ಹಾಕಿ ಮೇಡಮ್. ಮಂಡೇ 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 ಎಸ್.
Petitioner 1 and 2, my lord, the 1 and 3 are there, ladies, my lord, allegation of kidnap of.
ಇರೋದು ಒಂದೇ ಒಂದು ಮಂಡೇ on 16th. We'll see how many matters will be posted. ಕೊಡಿ.
Allegation of kidnap of minor child, my lord, by the mother, complaint is husband, my lord.
ಏನ್ JNWC ಇದೆಯಾ? 2:30 ತಗೊಳ್ಳಿ. ಎಸ್
Lordship.
Cities Act, my lord, there's a prior.
2:30
Lordship.
2:30 ಅಂದ್ರೆ tomorrow ಅಂತಿರಲ್ಲ. 2:30 ಕೊಡಿ.
2:30
You
Lordship.
want to get it for 2:30? Get it. Yes, give it. ಏನು ಫೈಲೇ ಮಾಡಿಲ್ಲ, ಸುಮ್ನೆ ಮೂವ್ ಮಾಡ್ತಾರೆ. Then ಆಯ್ತು. ಅರೆ you get it at 2:30. Give it. You
2:30.
prepare and come.
Lordship.
At 2:30 come. Yes.
2:30.
2:30 ತಗೊಳ್ಳಿ.
My lord. Cities Act, read with Atrocities Act, my lord, the co-accused have been discharged.
Co-accused have been discharged. Monday. Yes.
2:30 Lordships.
Wait, sir. I can't come back like this. Wait. Yes.
Tomorrow Lordship, the date has been fixed by the trial court to frame a charge sheet charge against me.
2:30.
My lord, this is a part heard matter.
Ah.
My lord, the urgency is this. The petitioners, my lord, are producers of renewable energy. They've gotten into a power purchase agreement with the BESCOM. Earlier, the price fixed.
GM part ಅಡ.
Please, my lord.
ಅದು 2:30 ರಿಲೀಸ್ ಮಾಡ್ಬಿಡ್ತೀನಿ, ನಾಳೆ ಅಲ್ಲಿ ಮೂವ್ ಮಾಡಿ.
My lord, tomorrow, my lord. Tomorrow.
Tomorrow, okay, give it. Yes.
Please, my lord.
Madam, ನಾಳೆ ಹಾಕಿ, release it. Yes.
And for petition number 2 is aged about 80 years.
No problem. Monday, give it. Monday. Stay ಆಗಿದ್ಯಾ?
They don't stay agida Swami. Petition number 2 is pending.
ಕೊಡಿ. Yes.
I'm for the petitioner, my lordship. High Court have a stay order, but they are.
High Court has what?
Stay order, my lordship. Again.
This is what court? Give it.
They again
Yes.
filed the charge sheet.
Give it. Yes.
Proceedings under 138, application is rejected. I go for an appeal before the sessions court. It is dismissed as not maintainable. 12th matter.
Monday, sir.
12th matter is there before the trial. court.
Monday. Yes.
12th ಗೆ matter is.
ಏನಾಗಲ್ಲ, ಮಂಡೇ ಕೊಡಿ. ಅದ್ಯಾವ್ದು ನೋ ಅಬ್ಜೆಕ್ಷನ್ ಟು ಅಲೋ ದ ಪೆಟಿಷನ್ ತಗೊಳ್ಳಿ, ನಾಳೆಗೆ ಹಾಕಿ ಅದು. Yes.
Enact matter, my lords, the petitioner is a erstwhile director. After his resignation from the
Monday.
company, they have issued,
ಮಂಡೇ ಸರ್.
please,
My lord, ನವೆಂಬರ್ ನಲ್ಲಿ
three matters.
ಮಂಡೇ ಕೊಡಿ.
My lord, ನವೆಂಬರ್ ಫಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ FIR ಮೇಲೆ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರು. My lord, ಇವಾಗ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕ್ಮೇಲೆ ನೀವೇ ಸಬ್ಮಿಷನ್ ಮಾಡಿ ಮೂವ್ ಮಾಡಿ.
2:30 ತಗೊಳ್ಳಿ ಅದು.
ಮೈ ಲಾರ್ಡ್, ಇದರಲ್ಲಿ ಒಂದ್ ಸ್ವಲ್ಪ ನಾನು ತಾಯಿನ ವಿಟ್ನೆಸ್ ಮಾಡ್ಬೇಕು. ನಾನು 311 ಅಪ್ಲಿಕೇಶನ್ ಫೈಲ್ ಮಾಡಿದ್ದೀನಿ.
ಮಂಡೇ. Monday, sir. Even if you have given 10 memos, it's not botheration to the court. Give it, sir. Yes. ಸುಮ್ನೆ ಇವೆಲ್ಲ ಹೇಳ್ಬೇಡಿ.
Your lordship,
Yes.
may I submit, lordship?
Wait.
Request at 2:30.
All complaints are false only. Give it. Yes. Monday. Yes, Monday. All Monday.
My lord,
Fresh matter, my lords, are given memo
Matter is
twice,
before
my
the
lord.
trial court.
ಕೊಡಿ, sir.
Matter is
fresh
before the
matter.
trial court on 12th. At 2:30.
Try to understand. Give it. Yes.
My lord, at least
Fresh
tomorrow.
matter, my lords, are given memo.
Because
twice.
12th
It has
is-
not been listed, my lord. Practice act.
I am telling you, if all of you at once speak, I am not going to take a single memo. I am hearing him. You don't understand?
My lord, it's on 12th before the.
I'll
trial.
give it for Friday. Yes.
Friday.
Please, what's your problem?
Record falls down from the roof, my lords. The
Ah.
complaint is lodged under section 92 of Practice Act, my lords.
All right. What's the problem?
I have given. the
What?
memo
Because
twice.
you're a factory and the director of the factory is accused, you want urgency here? We'll post it after vacation. Give it.
Twice, has been-
Even if you're given 20 times, not a problem. Give it. There are many advocates who have given 20 times and memo has not come. What can I do?
Your lordship, may I submit, your lordship? Last time, this,
Monday kodi, sir.
your
Then
lordship,
vacating stay na?
vacating stay, last time the office had not put up the thing because 3 months back it was filed, my
Sorry.
lordship. Kindly put it
Yeah.
on 13th, my lordship, because it was not heard.
There are only 8 working
And,
days. I have no time to hear matters and vacate this
Your
day.
lordship,
Immediately after vacation, you take it.
your lordship, for your kind consideration, the last time the office had not put up the file
All right.
So your
Pending
lordship,
matters, I will not.
it is not fish matters.
Pending matter, I will not.
It is
take,
vacating
sir.
stay, my lordship. R2,
Give
it
it,
is a
sir.
420 and covered by your lordship.
ತೊಂದ್ರೆ ಇಲ್ಲ, sir.
Lordship
ಕೊಡಿ, sir.
judgment. Kindly put it on 13th, my lordship.
No, no, not a date of your choice. Give it.
Oh, whichever next Wednesday also.
Quick, we'll see. Give
Next
it.
Wednesday, my lordship.
No, give it, sir.
Next Wednesday, my
Give
lordship.
it.
My lord,
My-
owner of
My lord, I am for the petitioner, my lord, this is.
Monday.
482.
Yes, everything is 482. Yes.
I'm not tomorrow.
No, no. Yes.
my lord, owner of
Much
Monday ಎಷ್ಟಾಗತ್ತೆ ಅಷ್ಟು. Monday, no admission cases, even date given ಆದ್ರೆ don't post, madam. Give it.
ಅಲ್ಲ ಇದು 4ನೇ ಮೆಮೊ ಸ್ವಾಮಿ ಮೆಮೊನೇ ಬಂದಿಲ್ಲ ಅಂತ ಅವ್ರ ಕೆಳಗಡೆ ಹೋದ್ರೆ ಮತ್ತೆ ಇಟ್ ಇಸ್ ವೆರಿ
ಮತ್ತೆ ನೀವು ಇದೇ ಹೇಳಿದ್ರೆ ಸರಿ ಹೋಗಲ್ಲ. ಕೊಡಿ ಇಲ್ಲ ಅದು.
my lord, owner of.
ಯಾವ್ದು ಮೆಮೊ ನೋಡಿ ಮೇಡಮ್.
My lord, owner
Fresh
of
matter ಗೆ ನಾಳೆಗೆ ಹಾಕಿ ಅದು.
matter. My lord, owner of
Take
the,
that memo.
owner of the property, upon him, the trespass case they have bought, my lord, he's a developer.
Monday, sir, give it. Yes. Give all the memos. Give the memo.
Appearing for the
Settlement
petition-
memos ಯಾವ್ದಿದೆ ಕೊಡಿ.
My lord,
No problem, give it, sir. Sort out the problem with her. Give it, yes.
my lord.
Use Monday, sir. No, nothing. ನಿಮಗೆ ಪೊಲೀಸ್ ಇಂದ ಹರಾಸ್ಮೆಂಟ್ ಅಲ್ಲದೆ ಇದು ಈ ಹರಾಸ್ಮೆಂಟ್ ತಗೋಬೇಕಾ ನಾವು? Give it. Yes. There should be some limit for mentioning. Give it, yes. No problem, sir. What can be done? Leave it, sir. Leave it. Give it, yes.
My lord.
No date. Yes, give it. ತಗೊಂಡಾಯ್ತು ಬಿಡಿ ಮೆಮೊ. Yes. Thursday, yes.
My lord.
Monday, give it, sir. Monday, give it, yes. Monday.
My lord.
If all of you want it on Monday, give it, or else I will post it after vacation. Choice is yours. Please give it. Please give it. Parvaila, kodi. Give it. What is Monday? 16th, huh?
Lordship, there
framing
is
of-
the urgency
Give all the memos.
Blood.
Yeah, ಏನಕ್ಕಿದೆ ಡೇಟ್? ಪರವಾಗಿಲ್ಲ. Monday, yes. No problem. Give it, yes. Nothing is going to happen. Give it, yes.
Lordship,
So what? Give it, yes.
my lord,
Lordship, humble request, may the matter.
ಏನ್ ನಾಳೆ ಜಡ್ಜ್ಮೆಂಟ್ ಮಾಡ್ತಾರಾ? If your petition is here, right? Then leave it, yes.
Your lordship,
Give it. If you want it on Monday, give it. Otherwise, we will post it after vacation. That's all. ಕೊಡಿ.
your lordship, humble request.
ಅಷ್ಟೇ, ಆಪ್ಷನ್ಸ್ ಎರಡೇ. Give it. ಅದು ಬರುತ್ತೆ, ಎಲ್ಲ ಒಂದಿನ ಪೋಸ್ಟ್ ಮಾಡಿಸ್ತಾರೆ.
Lordship, humble request, may the matter be listed on 12th, day after tomorrow, your lordship. In this case, they have filed FIR for recovery of money, your
So
lordship.
what? And Monday ಅವ್ರಿಗೆ ಏನಾಗ್ಬಿಡುತ್ತೆ?
Your lordship, the petitioners are whistleblowers. They.
No problem, give it, madam.
my lord, the matter was
the-
posted
And
for
all.
hearing
If you want it on Monday, please give it, otherwise no other date. Yes.
HBC guard.
Please give all,
On 16th, hearing before charges ಇದೆ. Offense under section.
ಪರವಾಗಿಲ್ಲ, ಮಂಡೇನೆ 16th ಕೊಡಿ, ತೊಂದ್ರೆ ಇಲ್ಲ.
My lord,
ಇಲ್ಲಿವರೆಗೂ ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ?
my lord, destruction of,
ಇಲ್ಲಿವರೆಗೂ ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ?
my lord, earlier, ನಾನು NOC ಹಾಕೊಂಡು ಬಂದಿದ್ದೀನಿ.
ಅದಕ್ಕೆ ಅರ್ಜೆನ್ಸಿ ಹುಟ್ಟಲ್ಲ, ನೀವು NOC ಹಾಕಿದ ತಕ್ಷಣ ಕೊಡಿ.
Fresh matter, my lord, it
ಕೊಡಿ
filed-
ಸರ್. Yes.
My lord,
Give all the memos. Maybe whoever it is, give all the memos. Give all the memos, sir.
Lots.
Adjournment.
No.
Wait. Yes. Give. Being spoken to her. Yes. Two 30. Yes.
That's one matter for 230, my lords.
Monday ಕೊಡಿ sir.
That's one matter for 230, my lords. The
Why?
urgency is this.
Please
my
give
lord.
it, sir. ಯಾವುದು ಕೊಡಿ. ಈಗ ಮಂಡ್ಯಾಗ ಬೇಡವಾ? ಆಫ್ಟರ್ ವೆಕೇಶನ್ ತಗೊಳ್ಳ? ಪರವಾಗಿಲ್ಲ ಕೊಡಿ. ಈಗ ಮೆಮೊ ಕೊಡ್ತೀರಾ ಇಲ್ವಾ? ಕೊಡಿ, ಮೆಮೊ ಕೊಡಿ.
Lords, the urgency.
ಮಂಡೇ ನಿಮ್ಮ ಮುಂಚೆ ಕೊಟ್ಟಿರೋ 560 ಮೆಮೊ ಇದೆ. ಮಿಸ್ಟರ್ ಮಂಡೇ ನಿಮ್ ಮುಂಚೆ ಕೊಟ್ಟರು 560 ಮೆಮೋ ಇದೆ, ಅದಾದ್ಮೇಲೆ ಬರುತ್ತೆ. ಎಸ್, ತೊಂದರೆ ಇಲ್ಲ, ನಿಮ್ದು ಅದ್ರಲ್ಲಿದ್ರೆ ಅದು ಬರುತ್ತೆ. ನೋ ಪ್ರಾಬ್ಲಮ್ಸ್, ಎಲ್ರದ್ದು ಪ್ರಾಬ್ಲಮ್ ಇದ್ದೇ ಇದೆ. ವೈ ಯುವರ್ ಪ್ರಾಬ್ಲಮ್ ಇಸ್ ಸ್ಪೆಸಿಫಿಕ್ ಇಸ್ ಇಟ್? ಎಲ್ಲ ಅಡ್ವೊಕೇಟ್ಸ್ ಪ್ರಾಬ್ಲಮ್. ಎಸ್, ಏನು ಮಾಡಕ್ಕಾಗಲ್ಲ. ಎಸ್, ಡೋಂಟ್ ನೋ ಸರ್, ಡೋಂಟ್ ನೋ ಸರ್. 500 ಮೆಮೋ ಇದೆ ಅಂತ ಹೇಳಿದ್ನಲ್ಲ, ನಾನು 1000 ಮ್ಯಾಟರ್ಸ್ ತಗೊಳಕ್ ಆಗಲ್ಲ. ಎಸ್,
the urgency is this.
ಗಿವ್ ಇಟ್ ಸರ್. ಗೊತ್ತಿಲ್ಲ, ಕೊಡಿ, ನಾವು ಕೊಡಿ. ಎಸ್,
The urgency is this, my lords. First FIR is registered against me. I obtain an anticipatory bail. As a thwarted attempt, now second FIR is registered.
230, take it. Yes,
230.
Monday ಹೇಳಿದಾರೆ madam.
The reason that police notice has been issued, my lord, it is.
ಅದೇನ್ ಪರವಾಗಿಲ್ಲ. ಏನ್ ಪೊಲೀಸ್ ನೋಟಿಸ್ ಇಶ್ಯೂ ಯಾವತ್ ಬರಕ್ಕೆ?
I'll brief it.
ಯಾವತ್ ಬರಕ್ಕೆ ಹೇಳಿದಾರೆ?
Actually, it was yesterday, my lord.
ಹಾ, give it at 2:30. Yes,
That's date is not given.
Monday.
Your Lordship, petitioner had filed petition under section 19, obtained a residential order in countenance to the respondent husband has filed FIR under section 506, seeking a threat.
506, Monday.
Date is
Monday.
ಕೊಡಲ್ವಾ ಮೆಮೋ? No urgency, give it. 18 years. So?
He has to apply for passport due to his.
ಆಯ್ತು, ಕೊಡಿ. Tomorrow, take that tomorrow, madam. Passport ನಾಳೆ ತಗೊಳ್ಳಿ. Monday ಕೊಡಿ.
I'm a student, my lord, I want to travel abroad for my.
ಆಯ್ತು, ನಾಳೆ ತಗೊಳ್ಳಿ. ಬಹಳ ಸಂತೋಷ. ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಮಾಡ್ಲಿ ಬಿಡಿ, ಕೊಡಿ. 7A ಅಲ್ಲಿ ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆಗೋವರೆಗೂ ಕಾಯ್ತಾ ಇದ್ದೀರಾ? Don't take that 7A memo. Yes.
One matter, my lord,
After vacation.
one matter, I mentioned it yesterday. I think there was some mistake in the
ಬಂದಿಲ್ವಾ
memo,
ಅದು?
ಬಂದಿರ್ಲಿಲ್ಲ ಅದಕ್ಕೆ.
ಅವ್ರದೇ ಬಂದಿಲ್ವಾ?
Number wrong.
ಆಯ್ತು, ತಗೊಳ್ಳಿ. Yes.
Same matter, my lord, same by the first informant, same matter.
Which
We say
matter?
in the same.
ಅವ್ರದೇನಾ?
Where the government is same.
ಹಾ, ತಗೊಳ್ಳಿ.
Please.
ಎರಡು 2:30 ತಗೊಳ್ಳಿ.
Please.
ಏನು?
19 ಅಥವಾ 20 ಡೇಟ್ ಕೊಡಿ ನನಗೆ.
ರಜೆಗ್ ಮುಂತೆ ಆಗಲ್ಲ, ಆಮೇಲೆ ರಜೆ ಆದ ನಂತರ.
19 ಕೊಡಿ ಸರ್.
19ಕ್ಕೆ ಬೇಕಾ? ಆಯ್ತು, 19ಕ್ಕೆ ಕೊಡಿ ಮೇಡಮ್. ಡೇಟ್ 19.
But submission date is not given.
ಡೇಟ್ won't be given sir. ನೀವು ಪಾರ್ಟಿ ಇನ್ ಪರ್ಸನ್.
Monday at least.
ಅವ್ರು ಡೇಟ್ ಕೇಳಿದ್ರೆ ನೀವು ಪ್ಯಾರಿಟಿ ಕೇಳ್ತಾ ಇದ್ದೀರಲ್ಲ.
ಮೇಡಮ್,
So many memos more, my lord.
What can be done, sir? Move less memos. I will take all the matters.
Best matters.
If you move 1000 memos, you know how many memos are pending? 7,500. Where should I go?
We're going to settle matters.
7,500 memos you have moved for the last 29 days. And I have posted 5,300 cases. Beyond this, what can be posted? What can be posted, sir? I'm also a human being. 5,500 ಕೇಸ್ ಪೋಸ್ಟ್ ಮಾಡಿ ಲಾಸ್ಟ್ 29 ದಿವಸದಲ್ಲಿ. 7,500 ಮೆಮೋಲಿ. ಇನ್ ಎಷ್ಟು ಪೋಸ್ಟ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ? ಇನ್ ಎಷ್ಟು ಮ್ಯಾಟರ್ ತಗೋಬೇಕು?
Matter going.
ಮತ್ತೆ ಅದನ್ನೇ ಹೇಳ್ತಾ
Matter
ಇದ್ದೀನಿ.
going to settle matter.
Whatever it is, sir, you cannot milk the cow until it bleeds. Stop it. Yes.
One fresh matters. Number one.
I will modify it and then ಏನು ಇದು ಹೇಳಿದ್ರಲ್ಲ?
Yes, I really am not, my submission to your lordship is, now the order not by your lordships has been communicated not to the CBI. Not in letter and spirit, not we are complying with the order. Today, not in the afternoon, not we are also not meet all the officers, not are meeting, not in compliance with the order of your lordships. Not the apex court, not in the Tirupati Laddus matter, may I just may not pass on there.
Yes. And then a file ಇಲ್ಲಿ ಮೇಡಮ್.
Really, not though.
ಹೌದಾ?
Not paragraph number 9 may not may kindly be seen.
Yesterday file was there. Yesterday file was there.
But paragraph number 9. Third page. However, in order to assuage the feelings of the crores of people by devotees, we find that the investigation should be conducted by an independent SIT consisting of representatives of CBI, representatives of state, and a representative of food safety, so on and so. We further find that it will be appropriate the investigation is carried out under the supervision of Director of CBI. Not now.
Director of CBI.
Director of CBI ಇದರ ಅವಶ್ಯಕತೆ ಇರ್ಲಿಕ್ಕಿಲ್ಲ ಯಾಕೆಂತಂದ್ರೆ now
ಅಲ್ಲ
the
ಇದ್ರಲ್ಲಿ
issue
ಬೇಕಾಗಿ
involved, it was a very larger not aspect of feeling of not crores of people. Now not since it is a case of either 302 or 306 which is still not known. Not in under the CBI manual and the Delhi Special Police Establishment Act, it is a SP not who heads not the state and the he will be the head of the not branch. Therefore, But in my humble submission, though the apex court may not would direct the director of CBI to monitor, but law is not laid down that SIT must be not headed by either IG or by director.
But it is a model constitution when it is an amalgam of two different wings. That's the only thing.
Then not.
One supervision of the director CBI is fine. That is too big.
But even otherwise,
position for
not
this
wherever, may not the Honorable High Court would direct not CBI to be a part of the investigation team. Not the head office will not.
True. Now we will not
supervise.
take the CBI officer whom we have set out. Since the apex court says that higher ranked officer should head the SIT, we will direct heading of the SIT by an IG. And continue, will alter the team by continuing the lady who's in the team because the accused is a lady. And it's the death of a lady. So one lady will be there.
Please.
The last time Madidal, Nisha James, and we will do that. Then we will continue the CBI officer and appoint an IG to that.
Can I request for a password? I'll seek instructions. 2:30 anyway. We have other matters. Please.
Instruction IG ಇರ್ಬೇಕು ಅಂತಿಲ್ಲಿದೆ ಅದಕ್ಕೆ IG ಮಾಡಿ. IG rank ಯಾರು ಇಲ್ವಲ್ಲ CBI ಇಲ್ಲಿ.
ಇಲ್ಲ ಕರ್ನಾಟಕದಲ್ಲಿ ಯಾರು
ಮತ್ತೆ we can't draw someone from there and create further problems.
I'll. By afternoon, not.
ಆಯ್ತು 2:30.
Please.
Being spoken, number 2.
ಏನೇನು being spoken?
For the petitioner in this matter, there are 4 inconsistencies, my lord. In the oral order, the para that is extracted is irrelevant. In serial number,
This is not yours.
not at all. And para
This is not yours.
is said being spoken.
That's in the second list. ಯಾರು ಬರಲಿ ಅವರು. This is 33(5) POCSO. ಆಮೇಲೆ ಒಂದೇ ರಂಜ ಕಳಿಸ್ಕೊಟ್ಟಿದ್ದಾರೆ. Yes, next. Akram Pasha.
ಇದರಲ್ಲಿ CC ನಂಬರ್ ಹಾಕಿದ್ದು ನಾವು ಜಾಯಿಂಟ್ ಮೆಮೊ ಹಾಕುವಾಗ ಅದು ಕಮಿಟ್ ಆಗಿದೆ. when I filed in petition.
ಆಯ್ತು ನಂಬರ್ ಕೊಡಿ.
SC ನಂಬರ್ 6 ಆಫ್ ಅದು ನಾನು ಮೆಮೊನಲ್ಲಿ ಹಾಕಿದೆ.
ಸೆಟಲ್ಮೆಂಟ್ ಅದು.
SC ನಂಬರ್ 6 ಆಫ್ 24 6th additional judge ಅಷ್ಟೇ ಸರ್. ಅದೇ ಆಡ್ ಆಗ್ಬೇಕು.
ಆಯ್ತು.
ಯಾಕಂದ್ರೆ ಅವರು
ಈಗ ಆಯ್ತು ಆಡಿಟ್ ಮಾಡಿ.
ಕ್ಲೋಸ್ ಮಾಡುವಾಗ ಅವರು SC ನಂಬರ್ ಇಲ್ಲ ಅಂತ ತಗೋತಾ ಇಲ್ಲ.
ಆಯ್ತು ಮಧ್ಯಾಹ್ನಕ್ಕೆ do that and upload it. Next.
Fresh matters, number 4.
My lords, the senior engaged is just on his legs before another court in the very next court hall, my lords. His item is going on at the moment.
Start.
Item may be
You
passed over.
You ask the senior to come, you start. Yes.
My lord, a dispute which is purely in civil in nature.
This is highly incorrect. I told you no adjournment would be granted.
It's item number 2 in court hall 17, my lords.
Fine.
My lord, sir.
We have every intention of attending if a short passover may be given, just
No,
couple
Passover,
of matters. my
Passover
lord.
will not see the light of the day.
Just couple of matters, my lord. It might be just stood over for 1 or 2 matters. He'll be here in the next few minutes, my lords, please.
Passover.
My lord, sir.
Please, my lords.
You are
Please.
kindly.
Oblige, my lord.
When the moment he comes, I'll
The
take
moment he comes, it may be taken up, my lords.
The problem with
Much
this, my
obliged.
lord.
No problem idea.
I have 2 other matters in other courts. If there is called
ಎಲ್ಲರೂ ಮುಗಿಸ್ಕೊಂಡು ಬನ್ನಿ
that's
after
for-
vacation.
Your lordship,
Then
kindly see.
we may
I have
just
only one sentence to submit.
appreciate.
I have only one sentence to submit before the Sonal Court with kind permission, my lords. Your lordship had delineated, my lords, my submissions at the time of granting an interim order.
Interim order is the final order, according to me, unless you convince me otherwise.
That's all my submission.
That's just
ಆಯ್ತು
a minute.
Please,
ನೀವು ಇಲ್ದೇ ಪರವಾಗಿಲ್ಲ ಅವರಿದ್ರೆ ಸಾಕು.
please. Most grateful. Please.
Five.
Lordships, I prepare for the responding. This is the unishare matter. Your
Yes, unishare matter. Stay
My
there.
lord. Illa Kottya Swami,
No, my
the petition is not being handed over despite multiple follow-ups.
My
Copy
lords,
ಕೊಟ್ಟಿಲ್ವಾ?
in this another
ಕೊಟ್ಟಿಲ್ಲ.
connected matter is there 5597 of 2020. None of these complaints, my lord, there is no allegation whatsoever in the
1
complaint
minute.
against the
The
petitioners, my lord.
1 minute, sir. Which is that unishare? Why are you on VC, Ayappa?
Your lordship, some
Venkatesh.
multiple road blockades because the demise of the former CM.
All right, yes. The petitioners, the respondents have filed vacating ಹಾಕಿಲ್ಲಲ್ಲ?
ಇಲ್ಲ ಹಾಕಿಲ್ಲ. I am in 5.1 your lordships.
Learned counsel KG Ayappa appearing for the respondent submits that the issue in the list stands completely covered by the judgment rendered by this court in Unishare, which is that number
Criminal petition number 6658 of 2024.
disposed on
Disposed on 21st/10/2024.
24. The learned counsel for the petitioner would submit that the said order would not cover the issue as the facts are entirely different. The matter would require consideration. List the matter after vacations.
Yes. And connected with the 5597 of 24, my lord.
Tag the petition along with 5597.
Your lordship, the petitioners may be directed to serve a copy.
Petitioner shall serve requisite set of papers upon the counsels representing the complainants in all these cases. Yes.
Yes, ma'am. Much
Grateful.
Settlement.
It has not materialized. There is only so far as areas are concerned, my lords, there is a.
List the matter after vacation. Yes.
Great.
There is a stay, my lordships.
No, what to do? Yes. Next after vacation. Areas ಕೊಟ್ಟಿದ್ದಾರೆ ಪೂರ್ತಿ?
ಇಲ್ಲ.
ಎಷ್ಟಿದೆ?
45,000 is.
ಯಾಕೆ ಅದು ಕೊಡೋಕೆ ಪ್ರಾಬ್ಲಮ್? I'll vacate the interim order.
ಅಲ್ಲಲ್ಲ 8,26,000 ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ. ನಾನು I've been requesting my learned friend to share her memo of calculations. That has not been done. 2 ವಾರದಿಂದ ನಾನು ಕೇಳ್ತಾ ಇದ್ದೀನಿ.
My lordships.
Memo of calculation ಕೊಡಕ್ಕೆ ನಿಮ್ಗೆ?
ಕೊಡ್ತೀನಿ.
ಕೊಡಿ. Yes, after vacation. ನೀವು ಜಗಳ ಆಡ್ತಾ ಇರಿ, vacation ಹೋಗುತ್ತಂಗೆ. Yes. List immediately after vacation. Next, interim order subsisting will continue to the next date of hearing.
7. It's a matter which had come up earlier, my lords. Lack of territorial jurisdiction. 2 accused, my lords. The present petitioner is accused number 2. A1, A2 are at Sikkim, my lords. A1 was into real estate development.
Correct, sir.
My lords, from Hyderabad, a partnership firm sends online 5 crores to the company.
1 minute. I asked you for investigation papers.
In fact, the present informant has committed fraud on the court below. I will point that out, my lords. He files an application. The frozen amount he takes into his personal account. Now he becomes an accused in Hyderabad where the complaint has been given by the partnership firm. He only claims to be a consultant in Bangalore.
ಎಲ್ಲಿದೆ?
Please, ma'am.
ಕೊಡಿ. List tomorrow in the fresh matters list. Yes.
Tomorrow, ma'am.
Tomorrow. I'll just see the investigation.
And one aspect, my lords, may notice is how he has committed fraud. He's taken this money into his personal
Crime is
account.
registered against him.
Yes, my lords, in Hyderabad.
All right.
And no part of the cause of action here. Entire thing between Hyderabad and Sikkim.
All right. Tomorrow.
8.
456. And yes, JK. Accused 456, 498A.
Please.
Yes, next.
Married system.
9.
Yes.
9.
Stay ಮಾಡಿದ್ದೀನಿ sir.
Please.
Accused 456 ಅಲ್ವಾ?
Tomorrow is the date for.
Accused 456 ಅಲ್ವಾ?
ಹೌದು. ಹೌದು.
ಮತ್ತೆ ಇನ್ನೇನು?
Tomorrow ಇದೆ hand delivery.
ಏನ್ ಬೇಡ.
ನಾಳೆ ಡೇಟ್ ಇದೆ.
ಅಪ್ಲೋಡ್ ಆಗುತ್ತೆ. ಡೇಟ್ ಅಂಡ್ ಕನ್ವಿಕ್ಷನ್ ಗ. ಮತ್ತೆ?
NBW.
Yes. Next.
9.
307 sir.
I am in custody last 13 years.
13 years, why?
13 years. After 7 years, one case has registered against me. I was in jail. Some 4-5 persons entered and attacked to assault me.
In the jail?
Illa, or outside.
Outside.
I have suspected that petitioner is involved in that, except that there is no allegation against the petitioner. That case is pending since 2016.
Where is?
That is the complaint is in
Yes,
page
sir.
number 20.
Yes, Harish.
Only with intention to not to get parole.
Petitioner
The
is
petition was,
A1, my
the
lord.
case was registered against the.
He is in jail. And from the jail, my lord, he has made the.
Operated this?
Yes, my lord.
To substantiate, there is absolutely, there is no material.
2016 ಇಂದ ಏನ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ ನೀವು?
I was in jail.
ಈಗ ಆಚೆ ಇದ್ದೀರಾ?
ಇಲ್ಲ, ಒಳಗೆ ಇದ್ದೀನಿ ಈಗಲೂ.
He is in jail.
Because of this.
Yes, sir. What is the material?
Charge sheet is filed, my lord.
That's all right. If he is in jail, how will he operate this 307?
Or phone, my lord.
Over phone. Attempt to murder over phone.
No phone call list is not registered, seized, nothing is there.
Page number 34 and 35, my
List
lord.
tomorrow. Read and come.
Please,
Yes.
please.
After tomorrow.
ಯಾಕೆ?
Tomorrow may
Day
be
after tomorrow.
doubtful, ರಜಾ ಇರ್ಬೋದೇನೋ.
ಯಾಕೆ? ಓ ಗೊತ್ತಾಯ್ತು.
That is the reason.
ಆಯ್ತು, ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ.
10.
KP,
They
my
asked you
lord.
the last case.
Yes, my lord. Permission is obtained, my lord.
By words permitted or a detailed order?
Detailed order, my lord.
ಕೊಡಿ.
Report not secured, my lord, but it is there in the page number 26 and 27, my lord.
ಸರ್, ಇದು ನಿಮ್ಮ ನಿವೇದನೆ. I'm asking the order.
I'll secure, my lord.
Last time I directed you. This court on 2/12/2024 had passed the following order. Even today, there is no information sought about the order being granted by the court granting permission to register a case under 78(3), a non-cognizable offense. In that light, interim order continues, list the matter after vacation.
11.
Lord, I seek a short accommodation in this matter.
List after vacation, interim order subsisting will continue to the next date of hearing. Next.
12.
In this case,
Respondent,
I take to file wakalat for.
learned
respondent.
counsel so and so undertakes to enter appearance for the respondent. There is no representation behalf of the petitioner. List after vacation. Next.
13.
List the matter after.
13.2.
List the matter after vacation. Interim order subsisting will continue to the next date of hearing.
13.2, R2 is the wrong number.
R2 ಯಾರಿಗೆ ನೀವು ಅಪೇರ್ ಆಗ್ತಿದ್ದೀರಾ?
13.1 ನಲ್ಲಿ R2 ಪಾರ್ಟ್ ಬಂದಿದೆ.
13.1 ನಲ್ಲಿ R2 ಜಯರಾಜ್.
ಪ್ಲೀಸ್.
ಹಾ.
ನೆಕ್ಸ್ಟ್ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ 13.2 ನಲ್ಲಿ R2 is a wrong party ಆಯ್ತು.
Wrong party.
ಹೌದು.
Wrong party.
Hasib Khan is the complainant.
Station is different.
Party is different.
Whatever, yes. Next.
One more matter is
Tag the petition along with.
10908.
List them all after vacation. Next. Interim order subsisting will continue till the next date of hearing.
Lord, in 14, Lord, I undertake to file wakalat for R2, Lord. Sri Prasad.
Learned counsel so and so undertakes to enter appearance for the second respondent.
Copies may be handed.
To submit.
Petitioner to serve set of papers upon the aforesaid counsel.
There
Yes,
is-
my lord, I will serve. On 5/12/2024, I filed memo and synopsis in the counter. Kindly, I will take support of that. document.
Register to
It
put
is
up.
there, my lord. It is there in the file.
ಏನಾಗ್ಬೇಕು
If
ಈಗ?
I am permitted, I will, interim order is not granted in this. It's a case and counter case. Both the parties resisted. My lord, I may be permitted to point out the.
ಕೌಂಟರ್
out of
ಕೇಸ್
my-
ಚಾಲೆಂಜ್ ಮಾಡಿದಾರಾ?
ಇಲ್ಲ
ಇಲ್ಲ, ನನ್ಗೆ ಇವಾಗ ಗೊತ್ತಾಗಿದ್ದು. ನಾನು I have to file the,
ಹಾಕ್ಬಿಡಿ, ಎರಡು ಮುಗಿಸ್ಬೇಡ.
please,
323, 324.
please. file
ಎರಡು
the-
we will close, file it.
Please.
Civil dispute ಇದೆ.
ಪರವಾಗಿಲ್ಲ, ಅದಕ್ಕೆ ಈ ಡಿಸ್ಪ್ಯೂಟ್ ಯಾಕೆ? ಎರಡು ಕ್ಲೋಸ್ ಮಾಡೋಣ, ಸಿವಿಲ್ ಡಿಸ್ಪ್ಯೂಟ್ ನಡೆಸ್ಕೊಳ್ಳಿ.
Interim order ಕೊಟ್ಟಿಲ್ಲ, ಚಾರ್ಜ್ ಪೋಸ್ಟ್ ಆಗಿದೆ.
ನೀವು ಚಾರ್ಜ್ ಪೋಸ್ಟ್ ಆಗಿದೆಯಾ?
ಎರಡು ಚಾರ್ಜ್ ಪೋಸ್ಟ್ ಆಗಿ.
When do you file the petition?
In this week.
ಮಾಡ್ಲಿ, yes.
ಅಲ್ಲ, ಈಗ ಈ
ಇನ್ನ ಅದ್ long date
ಪೋಸ್ಟ್
ಇದೆ.
ಆಗೋದಕ್ಕೆಲ್ಲ
Next date ಯಾವತ್ತು ಸರ್?
ಇನ್ನ
ಪೋಸ್ಟ್ ಆಗೋದು ಕಷ್ಟ ಇದೆ. ಅದಕ್ಕೆ ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಬಂದು
Date ಕೊಡ್ತೀನಿ ಸರ್. List the matter on 17th in the fresh
Please.
matters list.
please.
By then you file, otherwise I will grant stay in this.
I'll do it.
ಪ್ಲೀಸ್.
ಅವರು ಬಂದ್ರೆ ಎರಡು ಕ್ಲೋಸ್ ಮಾಡೋಣ. ನಿಮ್ದ್ರಲ್ಲಿ ತುಂಬಾ ಒಳ್ಳೆ ಕೇಸ್ ಇದೆಯಾ ನೀವು ಹಾಕಿರೋ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ?
16.
Yes.
Appear for the petitioner, my lord. This is a matter under section 138.
Have
my
you
lord,
served?
your
I
lordship.
directed you to serve on the council.
Page 40,
I directed you to serve on the council.
what, my lord?
ಅವ್ರಿಗೆ ಹೇಳಿ ಸರ್, ನಿಮಗ್ ಗೊತ್ತಾಗಲ್ಲ ಬಿಡಿ.
Council, I did not notice that one.
This is the order, sir, last time.
Sorry, my lord.
Serve on the council who represents the complainant there.
It may called on Monday, my lord.
It will be called on Monday. You serve it, yes.
I'm sorry, my lord.
Maintainability, second petition and
Second, first petition, that is challenging the charge sheet.
ಹಾ.
ಅದು earlier they challenged the FIR.
ಅದು ಯಾವುದು?
Second one.
ಅದು
ಅದು
disposed.
Disposed of.
The 16.1 FIR.
ಹೌದು, 16.1 FIR.
ಇದರಲ್ಲಿ what is challenged is a crime that is registered during the subsistence of the petition. Charge sheet is filed that is challenged in the companion petition. Therefore, the subject petition becomes is rendered infructuous. Yes. ಇದು ಹೇಳಿ.
The case and counter case, your lordships. Relatives ನೊಳಗೆ ಗಲಾಟೆ ಆಗಿದೆ.
ಅದೇ ತರ ಅವ್ರದ್ದು ಕರ್ಕೊಂಬಂದ್ಬಿಡಿ.
ನಮ್ದು ಕಂಪ್ಲೇಂಟ್ ಫಸ್ಟ್ ಹಾಕಿದ್ದೇವೆ.
ಸರಿ.
ನಾವು ಇನ್ಸಿಡೆಂಟ್ ಇಸ್ 240 ಹೇಳಿದ್ದೇವೆ. ಅವ್ರದ್ದು 1 ಗಂಟೆಗೆ 1:15 ಹೇಳ್ತಾರೆ. ನಮ್ದು ಕಂಪ್ಲೇಂಟ್ ರಿಜಿಸ್ಟರ್ ಆದ್ರು.
One of it should be true.
Both are injured, both are injured.
Both are injured, right? Then get the complainant.
Notice may be issued.
One additional HCGP, two emergent notice, returnable by 18th. Yes. Serve ಮಾಡ್ಬಿಡಿ somehow. We'll
Please.
close it, yes.
Please.
17.
Split charge sheet, Split.
Not split to charge.
ಹಾಗಾದ್ರೆ ಏನ್ ಕೇಸ್ ಇಲ್ಲ. 399, 402 will not
No,
interfere.
except the voluntary statement of the petitioner. Absolutely, there is nothing on record
Absolutely no case.
to show that indeed this petitioner was involved in the alleged commission of offense, my lord. Except the voluntary statement. And the issue in this case is covered by the ruling of this court, my lord.
Ooh.
Yes, your lordship only render the judgment, reported judgment, Paritosh judgment, wherein this court has held that.
That is NDPS.
Not NDPS, my lord.
Yes, sir.
Yes.
NDPS. Paritosh.
Para 17, yes.
That is NDPS. Idu.
Yes, NDPS.
Is the
yes.
dacoities.
So 399 and 400.
Preparation for commission of dacoities.
No, except the voluntary statement of the petitioner.
Yes, sir.
Yes, my lord. Preparation. For
No case at all.
committing.
No incriminating
he is
materials.
Parvala.
collected by
Preparation
the-
voluntary
no-
statement.
No
ಬೇಕು.
incriminating
He is a A4.
materials collected by the
All are
prosecution.
involved.
One HCGP, notice ಆಗಿದೆಯಾ? One HCGP, two, ಎರಡು ನೀವೇ ಅಲ್ವಾ?
Yes,
HCGP accepts notice for the respondents. Yes,
stay
next.
may be granted.
No,
Date may be fixed, yes, late.
no, after vacation. Yes, just after vacation.
18.
Earlier order.
I has not been served on me, my lord, to file my objections.
But the entire set was.
He is out of civil prison.
He's out
He is
of
here,
civil
is it?
prison.
ಹಾ.
It was directed to. be kept-
ಮೇಂಟೆನೆನ್ಸ್ ಯಾವಾಗ ಕೊಡ್ತಾರೆ ಅದ್ ಮತ್ತೆ ವಾಪಸ್ ಕಳಿಸ್ಬೇಕಾ?
ಅಲ್ಲ, some 10 lakhs has already been deposited. An observation was made that the arrears would come up to 5 lakhs. Yet we have made 10 lakhs of deposit. The only thing in dispute is the medical bills, which has not been ascertained by either of the courts.
ಆಯ್ತು, we'll hear it after vacation. Copy ಕೊಡಿ ಅವ್ರಿಗೆ.
But-
Counsel for the petitioner to serve complete set of papers upon the counsel for the respondent. List after vacation. Interim protection subsisting shall continue to the next date of hearing.
19.
Post immediate AVIO.
20.
It was posted for the consideration of the interim order today. My lords, 2,000 rupees check, discounting. My lords, there was rains in Bangalore on 24/9/2010, my lords.
ನಿಮ್ಮ ಮೇಲೆ ಬರೀ 2000 rupees.
2,000 rupees and without even taking cognizance, my lords. My lords saw the cognizance
I
order.
know.
Page 36 ಅಲ್ಲಿ 2,000 rupees discounting, not
ಇಲ್ಲ 2000 ಒಂದೊಂದರಲ್ಲೇ ಮಾಡ್ಕೊಂಡು.
ಇಲ್ಲ my lords, ನನ್ ಮೇಲೆ ಏನಿರುವುದು BBMP identifies, my lords, 1,241
Beneficiaries were identified.
by BBMP.
Yes.
The checks are given to them. One check for discounting, they come to my Sangha, give the check and take 2,000 rupees. Accused 8 to 15 are accused for that, for discounting. And my lords, please notice page 36, how on this additional charge sheet.
Heard the learned senior counsel Sandesh Chowta appearing for the petitioner. The fulcrum of the complaint against accused number 13 or others is that the BBMP identifies how many thousand?
1,241 beneficiaries.
1,241 beneficiaries to become to get the benefit of rupees 2,000 from the hands of the state. The petitioner, which Sangha is this?
My lords, the petitioners.
Petitioner is Gandhinagar Sauharda Cooperative Bank.
Cooperative society, my lords, Sauharda Cooperative Society.
Cooperative Society. Before whom?
He is the director, my lord.
Before whom certain checks are discounted. Against the petitioner accused number 3, what is alleged is discounting of check of rupees 2,000. Therefore, the allegation revolves around rupees 2,000 against the petitioner. Finding no ingredient of the offense under section 420 or 468 as the case would be, as discounting is done as a normal procedure in any banking or a non-banking financial institution. Therefore, there shall be an interim order of stay of further proceedings. Quay this petitioner till the next date of hearing.
Obliged.
ಎರಡು ಅದೇನಾ?
21 also same.
Same.
20 and 20.
Offense, my lord, 468, 471, 420 is not there.
420, 468, 470, 408. 420 ilva?
420 also is there, my lords. 420.
Yes, sir.
There is 420 do the cheating.
Yes. 420 ಇಲ್ದೆ 468 ಬರೋದೇ ಇಲ್ಲ. Effect
My-
ಇರ್ಬೇಕಲ್ಲ.
all
ಒಂದು
that
cause
was-
ಒಂದು effect.
My lords,
Effect ಇರ್ಬೇಕು ಒಟ್ಟಿಗೆ.
all that was against the revenue inspector, my lords. He identifies discounting is done here, my lords. Same 20 and 21.
Same. Which accused is that?
16, A16.
ಒಂದು 13, ಒಂದು 16 is. Yes.
Oblige.
22.
My lord, offenses of wrongful confinement.
No, sir,
kidnapping,
364A. I saw the entire papers.
My lords, it is a complaint by my husband against me. He is
For
an
what purpose?
alcoholic, my lords. I've got him admitted in a rehabilitation center. My lords,
No, this is the complaint where you were, the allegation is that you were taken into the rehabilitation center?
my lords, please, my lords.
Ah.
He himself, he goes to the rehabilitation.
ಇಲ್ಲ, ಈಗ one surprising thing is, CGP,
Please, my lord.
who will goes into the rehabilitation center? Which rehabilitation center will drag someone into, ಅದೊಂದು stay ಮಾಡದ್ನಲ್ಲ ಇಲ್ಲಿ?
ಅಲ್ಲ, ಒಂದು ಅದು as against the rehabilitation center.
Who is
Matter
this
was
then?
stayed, my lords.
Who is this?
Now it is the wife, my lords. It is the wife.
Which is that petition?
Petitioner number 3 is the husband, is the landowner, my lords.
Which is the petition, that petition?
My lords, criminal petition number 1156 of 24, my lords.
Tag this petition along with so and so of 2024, 1115 ಬರ್ಕೊಡಿ ಅದು. List them both on 17th. There shall be an interim order of stay of further proceedings in the case at hand as well. Next.
Grateful.
ಅದು records ಇರ್ಲಿ.
My lord, in this matter, my lord, the second wife, first wife will file a habeas corpus petition and file.
First wife is complaining about second wife snatching away the husband.
Yes, my lord.
It is between wives.
Wives.
ಯಾಕೆ ನಿಮಗೆ ಯಾಕೆ ಬಿಡಿ? ಅವ್ರು ಮಾಡ್ಕೊ. They will solve the issue.
My lords, in fact, he has cheated me, my lords, before obtaining a divorce. He gets married to me at a
That's
later
correct.
point
ಅಲ್ಲ,
in time.
now 2 wives are in squabble for 1 husband. Why police wants to interfere? ಅವ್ರು ಜಗಳ
My
ಮಾಡಿ-
lord, the second wife, without knowing to the first wife, he will go and take the this person Atiya Kanam to the rehabilitation center. my
ಯಾಕೆ?
lord.
Why?
Because she wants the husband to herself, keep herself.
My lords, he is not.
One wants the husband to themselves. Why police want both of them? ಬಿಡಿ.
It's like
Yes.
abduct.
ಏನು ಅಬ್ಡಕ್ಷನ್ ಇಲ್ಲ, ಏನಿಲ್ಲ ಇದರಲ್ಲಿ. 2 wives are
Even
fighting
the
for the husband,
rehabilitation
habeas
center-
corpus ಹಾಕಾಯ್ತು, ಈಗ ಅಬ್ಡಕ್ಷನ್ ಹಾಕಿದ್ದಾರೆ.
Rehabilitation center also.
So which
they have not
rehabilitation center will
inquired.
track them and go? That is the allegation against that rehabilitation center.
That-
ಇವ್ರು ದಾರಿಲಿ
that is-
ನಡ್ಕೊಂಡು ಹೋಗ್ತಾ ಇದ್ರು, ಗಾಡಿಲಿ ಕರ್ಕೊಂಡು ಹೋಗ್ಬಿಟ್ರೆ.
That is what happens, my lord. Rehabilitation center, they will not
Sir, one
inquire
ನಿಮಿಷ.
about the
I'll tell you what.
background of the.
ಬ್ಯಾಕ್ಗ್ರೌಂಡ್ ಅಲ್ಲ, ರಿಹ್ಯಾಬಿಲಿಟೇಷನ್ ಸೆಂಟರ್ the allegation of the second wife or the first wife against the second wife is that rehabilitation center admit ಮಾಡಿದ್ದಾರೆ. Rehabilitation center ಮೇಲೆ ನಡ್ಕೊಂಡು ಹೋಗ್ಬೇಕಾದ್ರೆ dragged into the van and took them into the rehabilitation. Why will they do that?
ಹೌದು.
Why will any rehabilitation center drag someone and take them into the rehabilitation center?
If I can
And their
submit, my lords,
application
he has only
application
signed
is
it.
filed. It is ಅದಕ್ಕೆ pure out of proportion blown dispute between 2 wives fighting for a husband. ಅಷ್ಟೇ. Yes. ಯಾವತ್ತು 17th?
70. Grateful.
23.
AVIO
24.
See, madam.
ಹೇಳಿ. PCPNDT ಯಾರ ಮೇಲೆ?
Send the copy to the AGP.
PCPNDT.
Yes, my lord.
ಕನೆಕ್ಟೆಡ್ ಪೆಟಿಷನ್ ಸ್ಟೇ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ತಾರೆ.
Yes,
ಯಾವ್ದದು?
5467, my lord.
Tag this petition along with 5467 of 2024.
This, my lord, cognizance has taken by the magistrate. That he has challenged, my lord. The cognizance has rightly taken by the magistrate.
Only cognizance ಮಾತ್ರನಾ?
Yes, my lord.
Where? Page.
Page number 45 and 50. my lord.
What's wrong with this?
My lord, under section 30 of the PC and the PND Act, the appropriate authority has to take decision whether the reason to believe that the offence has been committed, my lord.
Oh, who has taken the
There is
decision?
no order passed by the appropriate authority, my lord. Involve the decision of the Honorable Supreme Court of India.
Oh.
The seizure measure is vitiated, my lord.
Yes. We'll see, we'll hear it.
I have
Just
given
immediately after vacation. Yes, please. Next.
My lord, I press for the
Put it,
interim
put it.
matter.
Yes.
I
Next.
press for the interim connected.
No, no grants. Yes, next.
25.
Complaint is of assault.
Sir, assault, but
Where is the wound certificate? Elide?
wound certificate ಇಲ್ಲ.
Papers.
Certificate ಇಲ್ಲ, but
Yes, Harish.
even my complaint is pending before the
Paper, sir.
first.
Which is your complaint?
Annexure C, your lordship. Annexure C, page number 19, sir.
ಅದು NCR ಕೊಟ್ಟಿದ್ದಾರಾ?
ಹೌದ್ರಿ. ಇದರಲ್ಲಿ ನಂದು ಕಂಪ್ಲೇಂಟ್ ಇದೆ ಸರ್. ಇದರಲ್ಲಿ I have also filed complaint before the first respondent against the.
On the same incident? On the same incident?
Same incident, sir. Same time, same incident.
Yes, how did you render NCR in one and accept the complaint in one?
Report is there.
Good
ಅವ್ರ ಕಂಪ್ಲೇಂಟ್ ರಿಲೀಸ್ ಮಾಡಿದ್ರೆ ನಮ್ಮ ಕಂಪ್ಲೇಂಟ್ ಹಾಗೆ ಇಟ್ಬಿಟ್ಟಿದೆ ಅಂತ.
Yes, sir.
ಸೇಮ್ ಟೈಮ್ ಸೇಮ್ ಇನ್ಸಿಡೆಂಟ್ಸ್. ಇವನ್ ಇಂಜುರಿನೂ ಏನೂ ಇಲ್ಲ ಸರ್, ಏನೋ ಒಂದು ರಿಕವರಿನೂ ಏನೂ ಇಲ್ಲ ಸರ್. ರಿಕವರಿ ಒಂದು ಸಿಮೆಂಟ್ ಚಿಕ್ಕದ ಕಲ್ಲಿದೆ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ.
Wait. Injury ಇದೆ.
This petitioner, my lord, assaulted in the pot, my
ಅಲ್ಲ,
lord.
they have registered complaint. Why you rendered an NCR on that?
Beginning, maybe they,
Beginning ಏನು? ಎಲ್ಲ beginning same day.
ಸೇಮ್ ಡೇ ಸೇಮ್
Wait. Same offense, same incident, same day.
Yes.
Why you registered an NCR in his complaint and an FIR in this?
I'll take instruction.
The learned HCGP to secure instructions as to how two complaints springing from the same incident on the same day is rendered different treatment. One by rendering a non-cognizable report and the other resulting in the impugned FIR. List the matter on 16th in the fresh matters list. Instructions be sought by then, failing which this court would be constrained to grant an interim order of stay in favor of the petitioner in the subject petition. Next.
26.
Matter that came up last week. The check bouncing matter, my lords. Application under 391 filed before the appellate court was dismissed with cost of 2,000 rupees for the reason, my lords, in the lower court when the
So
trial was.
I said I'll pass some order. What
Yes,
is
my
it?
lord, that day my lords was supposed to.
Documents produced, madam.
Yes, my lord.
Let him produce documents, that's all.
Yes, my lords.
Otherwise, I'll allow this.
How one aspect, my lords may notice, my lords, the whole amount of this 1 crore, the check amount, was by virtue of a settlement that the parties arrived at. He gives the check, my lords, it bounces.
Sir, I am not on the merit of the matter. He files an application under section 391 before the appellate court, that is rejected.
Prior to that, he filed it under
That's all right, that before the trial court.
91.
All right.
And that attained finality.
So what?
That was not challenged.
So
my
what?
lords.
That is,
Same thing.
that is before the trial court, this is before the appellate court.
How, my lords, if my lords should just for a minute notice the interim or the order that is passed, my lords,
Yes,
what has
sir.
been considered under 391, just that order if it is.
Last time, Tara, he has agreed that he will produce those documents and documents. If you still insist, I will
My
allow the
lords, could I
application.
make a request for the disposal of the appeal within a time-bound manner?
Which
1
yav-
month, my lords,
yav
because
varshada appeal?
4 years I waited for this, my lords.
That is before the trial court.
Yes, my lord. 4 years.
Appeal is of the year 2024.
Yes,
We
my
can't
lords.
burden the court like.
My lords, court finds this application has been filed only to protract.
No problems. These documents will be produced and conclusion of the trial will be there.
Only an argument, my lords.
Not
It's
4
an-
weeks. Court will regulate its procedure as expeditiously as possible.
My lords, one aspect can I point out in this, my lords? Whole issue arises where he enters in an agreement
That is
with,
on the merit of the matter.
He
I am
protracts for
on section 391.
my lords, he protracts for 4 years.
Sir, 391 and 311. It is 311 before the appellate court. 391 is 311 before the appellate court, except that cross-examination is not. It is for the purpose of production of
My lords,
documents.
if it's only, all right, my lords may permit production, my lords, but please put a time frame to finish the appeal. Because I have waited for 4 years on an admitted aspect, my lords. Even my notice goes unreplied. Court holds all this on his conduct.
What can be done?
Well, it's 1 crore amount for
What can be
4
done?
years on the
Sir.
admitted.
138 proceedings are pending since 2012 in many cases, still going on. And 4 years and forever. Everybody have lost 4 years, 5 years. That is the way it is functioning. What to do?
Well, it's 391 ಅಲ್ಲಿ powers exercise ಮಾಡುವಾಗ it should be an exception, not a rule. my
Exactly.
lords. That is what the
exception I
court
will
has
say,
held.
definitely.
And looking at the conduct, they said this is done
311,
only to
391 are
protract.
both 311 and 391 are same towards the ends of to meet the ends of justice or to discovery of truth. That's all. Appellate court ಮಾಡಬಾರದು ಅಂತ ಹೇಳಿದೆ.
Power ಇದೆ, my lords. They say that power is exercised exceptionally because you are allowing additional evidence to come in.
Permissible, sir.
What this additional,
Permissible.
my lords, what this additional evidence is, it should be relevant. So a person files 91, suffers an order. After that, he does not lead an evidence at all. Suffers an order of conviction, comes to the appellate court, files 16.
That is not a bar.
My lords,
More so because he has suffered conviction.
it's not a bar, my lords. I'm not on the aspect that it is bar, but while we're excising 391, my lords, court will see, is it for the purpose of protracting the
No,
proceedings?
sometimes you will come this side.
My lords, kindly, at least, because 4.5 years, if I'm not able to get back an admitted amount, which he has given on a compromise, recorded by the court.
Scores and scores of cases where it is pending. 4 years. Appeal is of the year 2024.
Appeal alla, main, my lords may even see the
Main is
main
all right,
matter
sir. Appeal is
on
of
a
the-
compromise.
Now we are on appeal. On a compromise?
Yes, my lords,
Where-
I'll just explain, my lords.
One minute,
My lords, please, my lords, I will, please.
Where is the compromise?
Compromise. My lords may kindly notice the B report that was.
Where is the compromise?
Here's my file.
You are the accused.
My
who is
lords,
who is
he was an accused.
running away compromise?
Yes, my lords.
My lord, what has happened is that they filed a PCR, my lord, registered a complaint in Jayanagar police station. After that, my lord, they demands the check. The check has been given outside the police station is what they say.
Compromise.
I'm sorry, my
No,
lords.
There is no
1 minute.
compromise.
Compromise before a court of law?
No, my lord. There is no compromise before the court of law, my lord.
Yes, Sandesh, sir.
My lords, sorry, my
Compromise
lords.
before a court of law?
My lords, please
Or
no.
compromise before a court of law or in a police station?
My lords, police station recognized in a 482. What happened is
Now,
this.
where is that? Which is,
My lords, what?
which is that?
My lords, I'm my lords, I think my filed just a short password. I'll just point it out, my lords. I'll just point it out. My lords, I had filed a complaint where he had cheated me for 5 crores. He comes for a settlement,
Password.
pays 1 crore, recorded in the B
No.
report.
Password, it may not see the
I
light
will-
of the day, but your risk.
My lords, could it be tomorrow then, my lords?
Fresh matter.
Could it be tomorrow?
ಇದೇ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಬರ
Please, my lord.
tomorrow.
Interim order, my lord.
Nalega. I'm
Interim
sorry,
order
my lords.
subsist-
I'll just point it
interim order
out.
subsisting
On a
will continue.
compromise, all this has happened.
See, compromise recorded by this court in 482 becomes binding.
Recognized by this court in 482. I'll point that out.
That's
That
enough.
I'll point it out.
Then I will dismiss it straight away.
Absolutely.
Yes.
Absolutely. Obliged.
Next,
27,
For the petitioner, my lord.
AVIO. Yes, next.
28,
Interim
Interim
order.
orders.
ಆಯ್ತು. After vacation, interim order. ಅಷ್ಟೇ ಅದು.
Interim order.
Interim protection is granted.
Yes, ma'am.
AVIO. Yes. Next. After vacation, interim order extended. Yes, next.
29,
That's offense of 306.
306.
Objections.
4 ಕುರಿ. ಅದಕ್ಕೆ suicide ಅಂತ ಹೇಳಿರೋದು.
ಅಲ್ಲ.
ಅದೇ ಅಲ್ವಾ ಇದು?
Please,
ಹಾ.
Seek instructions, my lord. I'll seek
that's
instructions.
one submission.
After
Page
vacation.
number
and all.
23 is the charge sheet. Absolutely no ingredients of 306.
That's why-
No mens rea forthcoming.
Detailed interim order, I guess. Yes.
No mens rea forthcoming, no.
Not accommodation.
We'll post it on 18th. ಏನಿಲ್ಲ ಇದ್ರಲ್ಲಿ. Take my 4 judgments, everything is over.
Lord, after vacation.
No, sir.
ಇಲ್ಲ.
Section filing.
ಮಾಡಿ. ಇದೆಲ್ಲ ಮುಗಿಸ್ಬೋಣ. Yes. List the matter on 18th in the fresh matters list. At the request of
Not
the council.
18th minutes, 19th, please.
19th and the fresh matters list at the request of the council appearing for the petitioner. Respondent, complainant. Interim order subsisting shall continue till the next date of hearing. Objections, if any, by then.
Please.
30,
5,50,000 was paid to the worker.
5 lakh ಆಗಿದೆಯಾ?
ಪೇ ಮಾಡಿದ್ದಾರೆ ಅವರು ಒಂದು ಮುಚ್ಚಳಿಕೆ ಪತ್ರ ಬರ್ಕೊಡ್ತಾರೆ.
Council for the petitioner places on record 5,50,000 compensation being paid to the family of the deceased, though compensation would not amount to obviating the offense, but for grant of an interim order, it would suffice. There shall be an interim order of stay.
Interim order already.
Yeah, an interim order subsisting will continue to the next date of hearing, lest after vacation. Yes, next.
Notice not ordered.
Emergent note 1, HCGP 2, emergent notice. Next.
But in 31, my lord, I represent, my lord, the council. I represent, my lord, the petitioner's council.
Sir, you're not audible, sir.
I am sorry, my lord. My lord, I had to compulsorily travel. I'll make my best effort to, my lord, be audible.
Yes,
Kindly,
sir.
my lord, have page number
ಅದು
30.
ಏನಾಗುತ್ತೆ
my lord.
audible ಇಲ್ಲ ಅಂದ್ರೆ interim order ಕೊಡೋದು ಕಷ್ಟ ಆಗ್ಬಿಡುತ್ತೆ.
May I come tomorrow, my lord? Personally, my lord, so kindly have this matter tomorrow on the same stage.
No problem. Where are you?
My lord, I am in Belgaum.
Ah.
If your lordship could kindly see, my lord, page number 30.
Yesterday's matter alva?
Yes, ma'am.
Howದು. My lord, this is seemingly, my lord, sheer abuse
Yesterday
of
I said
police.
I'll grant a stay. He said one more matter should come. Only then you can grant stay.
No, my lord, there were 4 petitioners, one, my lord, there were 3 petitioners in one petition.
Then tomorrow we'll take up.
No, my lords, may kindly proceed to my lord. I'll not take more than, my lord, 30 seconds
It's all
on
right.
this.
Let's tomorrow in the fresh matter.
The matter before the trial court is tomorrow, my lord.
Tomorrow, all right. Yes.
Yes, my lords, kindly, my lord, have page number 30, my lord. In the first paragraph of page number 30, column number 17, what they would say is, I am a company, I carry, my lord,
Lords, we'll have.
a framing of charges, my lord, we have been issued notices.
Chetan.
ಅಲ್ಲ ಬೇಲ್ ಬೇರೆ ತಗೋಬೇಕು. We'll have to.
ತಗೊಳ್ಳಿ.
Bail ತಗೊಂಡಿದೀವಿ ಇಬ್ಬರಿಗೆ. One person, my lord, is not able to move around. But the court, my lord, will not be concessional. Court is going on, my lord, insisting for his presence. He has hurt his leg. Lord, this is one case, Lord, sheer abuse of police
List the
powers.
matter on Friday in the fresh matters list. Till such time, the concerned court shall defer its proceedings. Yes.
So grateful. Both the matters, sir.
Kudi, both the matters.
Both the matter. I am so grateful.
32.
Petitioner, accused number 1, please.
The petitioner is before this court calling in question so and so. The registration of the crime happens on the reference being made by the learned magistrate in a proceeding invoking section 200 of the CRPC. A perusal at the complaint would not indicate its compliance with the rigor of the judgment of the apex court in the case of Babu Venkatesh versus State of Karnataka, 2022 SEC Online SC page 200. Therefore, there shall be an interim order of stay on HCGP 2 emergent notice. Next.
33.
Avinash, husband illa. Husband illa.
My lords, I would, my lords, draw the attention of this honorable court to Annexure G, which I have lodged the complaint before masjid.
So what?
The contention, my lords, of my grievance all put forth in this complaint, my lords.
So what?
My lords, police without preliminary inquiry have registered this.
No problem. I'm staying everybody else except the husband.
My lords, may I permit it to make one submission, my lords?
Yes, sir.
My lords, they have, my lords, Annexure E, my lords. The prosecution have appended this document with a charge sheet to show that to meet the desire of the husband, the father of the respondent number 2 sold this site. My lords, may I draw my lord's attention to page number 60, which says this entire consideration is 10,000.
Sir. ಯಾವ 10,000? 10 lakhs.
ಇಲ್ಲ ಸ್ವಾಮಿ,
ಒಂದು zero ಬಿಟ್ಬಿಟ್ಟು ಓದ್ಬೇಡಿ.
ಅಲ್ಲಲ್ಲ, rupees 10,000 only paid by the purchaser to the vendor.
Come to pay, 1 minute, Avinash. Come to page 34. 1, 2 and 6, all of them indulged ಅಂತ ಇದೆ. But 1 is definitely their husband.
My lords,
ಕೊಲೆ ಮಾಡಿ, ಬೇರೆ ಮದುವೆ ಮಾಡಿ, ತಲಾಕ್.
even though, my lords, there is no prima facie, my lords, the complaint, my lords.
Husband, I will not give. If
My
you
lords.
insist for the husband, you may lose others as well.
My
What
lord,
do you want?
for my satisfaction, my lords, may I make one more such
Yes.
submission, my lord? My lords, this complaint, my lords, she said, my lords, the complaint is lodged in the hospital. There is no endorsement of the doctor. There is no medical report appended in the charge sheet, my lords. The prosecution has cited only the documents which, my lords, the father of
Okay,
respondent
let-
to.
Let the complainant come, we'll consider husbands later, or
Please.
everybody's later?
My lords.
Everybody later consider Marna? Yes. Payal Sharma or Kailas Ben, other. Husband matra illa. Very.
Date may be.
After vacation? Vacation munche.
Great.
Yes.
34.
Kindly pass. 34 kindly pass.
ಯಾವ್ದಿದು?
These are asking for additional report notes.
Huh?
Kindly pass on this.
ಇದು ನಾನೇ ಬರ್ದಿದ್ದೀನಿ man. One documents ತಾನೆ?
Yes, ಹೌದು.
173 ನಾನೇ at least I am bound by what I have written.
Satyanarayana Chalke is
Huh?
that's the same.
ಕಾಪಿನ ಬಂದಿದೆಯಲ್ಲ? ನಾನು ಮಾಡಿದ್ದೀನಿ, ಅವತ್ತೇ ಮಾಡಿದ್ದೀನಿ.
I've not seen.
I remember. Yes.
One password.
We'll take it tomorrow. ಅಷ್ಟೊತ್ತಿಗೆ ಕಾಪಿ ಬರುತ್ತೆ. I passed an order myself. Relying on RSPI. Next.
35.
Petitions.
ಇದು ಏನೆಲ್ಲ?
But I filed that particular as my lords directed. What are the provisions that requires to be urged here, and what are the grounds of challenge? But the first ground is that, my lord, it's a seed samples or biopesticides. So
Yes.
biopesticides should have have two submissions in this connection. One, section 2024, my lord,
Insecticides Act.
Insecticides Act. They allows that it has to be tested by his laboratory, which we have done. We have submitted the report to
He
him.
has a second chance of
Yes,
getting
sir.
it tested by a central laboratory.
Yes,
That's
sir.
Hyderabad, I guess.
Yes, ma'am.
Yes.
So we
Is
have.
that done?
No, there, my lord, there are the two issues. One, either he can get it done.
Or you should get it done?
Yes. So he has the sample.
Who has the
He
sample?
has the sample.
No, sample is disputed by you.
No, sample.
Once it is disputed by you, it is your duty to send it to Hyderabad, I guess. That's the provision.
Please, 24/3 is what?
Yes, that is what.
May see 24.
There is, where is, I have myself.
Please,
held
that
it,
judgment
that
also I have produced.
Hasmat Pasha ಅವರು appear ಆಗಿದ್ದು ಧಾರವಾಡದಲ್ಲಿ.
Please, my lord.
Where is that?
There are two judgments.
Kodi.
In my compilation yesterday.
2022, myself passed this
Yes,
order.
I've seen that. 13, my lord.
I've seen
Page
the
13 of
judgment.
my compilation file yesterday.
Compilation element.
Adರಲ್ಲಿ, what
Ninde
happened in
kodi.
those judgments, my lord, there was no notification.
What notification?
There was no notification notifying state laboratory. In the absence of state laboratory, it was.
No, not only
That's,
that.
again, that is also a disputed thing, my lord. The reason is that the central government has issued a notification that biopesticide should be tested at Hyderabad. The provision also may kindly be seen in the notification.
Where is the notification, sir?
It is along with
Statement
the
of objection.
Objections.
their objections and along with
yes.
my petition also.
Page?
6, ma'am.
What date of the notification? 19.
23/2019.
To analyze samples of biopesticides for chemical substances. ಇದು ಎಲ್ಲಿದು?
Lord,
This
this is
Raichur, my lord.
Raichur, but please see the provisions, my lord. In the powers conferred by the section 19 of the
Specified in
Insecticide
column
Act.
2 to analyze samples of biopesticides of chemical substances. 3 as insecticide analysis. Yes.
Please see the provisions, my lord. Section 19, it only speaks about the qualifications of the insecticide analyst. But section 16 speaks about establishment of a laboratory by the central insecticide laboratory. The notification which I have produced along with my petition may kindly be seen for a moment.
Page?
In 178, that the first case, my lord, it's page number 53. Please see, my lord. The proviso to section 16 of the Insecticide Act, read with rule 5 of the insecticide rules, the central government may hereby direct the following functions of the central insecticide.
Carried out the National Institute, Hyderabad, namely so and so.
Please, madam. So section 16 may kindly be seen for a moment. I've called out in my compilation, both section 16.
Okay, 16, yes.
Please. The central government may by notification in the official gazette establish a central insecticide laboratory under the control of the director to be appointed by the central government to carry out the functions entrusted to it
Under the, by this
Under
act,
this act.
all right.
and provided central government so directs by notification the official gazette, the functions of the Central Insect Laboratory shall to such an extent as may be specified in notification be carried out at any such institution as may be specified therein. So here in this notification, it's only the laboratory at Hyderabad to carry out such things. And Rule 5 also may kindly be seen for a moment. Functions of the, it speaks about the functions of the laboratory.
Rule 5.
Rule 5. My lord.
4B. Rule 5 ಎಲ್ಲ. Functions of the laboratory.
Please, madam. So the functions of the laboratory shall be as follows: to analyze such samples of insecticides sent to it under the act by any officer or authority authorized by the central or state government, and submission of certificates of analysis to the concerned authority. Now, my lord, please see the provisions mentioned in the notification produced by the respondents. That is section 19. It starts from section 19.
Insecticide analysis.
Analyst. So what is the functions of the role of the insecticide analyst? It defines, and that also corresponding along with Rule 23, which speaks about duties of the insecticides analyst. Nowhere it says it should carry out the functions of the central insecticide laboratory as specified under section 16 of the act.
Where is Rule 23? Yeah?
23. Sir.
Duties of insecticide
analyst. What he needs to do it is only specifies that. So these two provisions are incorporated in the notification produced by the respondent, based on which they say that they are empowered to undertake the analysis.
Hyderabad Kalsakenan.
There are two issues, my lord. We have no issues sending it to Hyderabad. Two issues. One, he doesn't claim that he claims that it's a biopest. It's not even insecticide according to him.
Biopest is defined?
It is not defined.
Then?
Even in that particular seizure report, they mention specifically it as a biopesticide.
According to
who is to test biopesticide?
No, what we have tested in we have tested the product for insecticides, and insecticides have been found in the
no, biopesticide says laced with chemicals is what the allegation. And how that needs to be
selling the product as a bioproduct, whereas this product in fact contains.
Where is the schedule? Schedule to section 3. Insecticide means any substance specified in the schedule.
Yes.
Where is the schedule?
Schedule, my lord, is that schedule.
Adರಲ್ಲಿ biopesticide ಇದೆಯಾ?
ಇಲ್ಲ, ಇದರಲ್ಲಿ ಇಲ್ಲ. He cannot even have a pesticides in his
biopesticide doesn't cover here. He has to carry out it only in Hyderabad.
Pesticides Act ಅಂತೇನಿಲ್ವಲ್ಲ, insecticide ಮಾತ್ರ ಇರೋದು.
ಅಷ್ಟೇ ಸರ್, insecticide act ಅಂತ ಮಾತ್ರ ಇರೋದು. So that is to be carried out specifically over there. That is one ground. Second ground is that, as my lords pointed out, 24(3), in all the cases there was a request sent by the.
You also requested for.
I requested. There is that particular letter is also available. Annexure K.
That's enough. Request is enough.
That is also there. So they do not carry out. And in my compilation, what page 6 may kindly be seen. Now that all the products have also expired, lost its shelf life.
Now you can't send it for testing also.
You can't send it. Your lordship may see section 24(3), my lord, for a moment.
24(3).
24(3).
Yes, sir. Any document purporting to a report of the insect analyst shall evidence facts shall be conclusive unless the person from whom sample was taken was within 28 days or so report writing.
In writing, insecticide inspector or the court. Before which.
Or the court before which any proceeding in respect of the sample intends to adduce evidence in contravention of the report.
Yes, he has the.
Well, there is one provision which permits you to challenge it for a second testing.
Please, my lord. Second analysis is 24(3). After test analysis has been carried out under sub-rule 2, the insecticide analyst forthwith supply
within 28 days.
The issue is this section 4(3) says he can challenge it, he can adduce this evidence, because what happens when we draw sample, we also give him a sample. He has a sample with him. So he can.
Where is your application?
Lord, Annexure K.
To send it to.
Reanalysis, please. My lord,
page.
Lord's taking up,
Whichever petition. This
One,
is,
two,
I'm having
it's a-
17894.
17894, they have conducted it as per my request, but the report, what has come is totally different.
Totally different.
Different.
In the
Because
sense
they
it is
allege
in your
there are-
favor?
No, no, one particular chemical ಇದೆ ಅಂತ ಹೇಳ್ತಾರೆ. But again, that was conducted in Banshankari here. Then later on my request, it was sent to Central Insect Laboratory, Faridabad. But again, there, my lord, should have been sent to Hyderabad. My lord, may kindly take up the second petition, my lord.
Faridabad ಯಾಕೆ ಕಳಿಸಿದ್ರು?
CAL, that's the request, Central Insect Laboratory on my request. In all other cases, they don't follow it. Only in that case, they followed it.
So in this case, they have followed.
They followed it. But second case may kindly be seen, no, where my request
We'll
is
take
there.
it as this case, it is followed. In all other cases, you have requested.
I made a request, they have not followed it up, my lord. In the second petition, my lords may kindly take up the letter at page 66.
So this case, nothing is there, Angara?
My lord, again, as I submitted, my lord, it should have gone to Hyderabad, not to the Banshankari here in Bangalore.
No, second sampling.
Second sampling, they have sent you to Faridabad. The first text itself is the moment.
First is Banshankari.
Banshankari.
What, that's also central laboratory.
They say so.
Amade?
Banshankari alla.
You can't choose your laboratory.
No, my lord.
Under the act, sir.
Under their notification, it says, under the act, it should have gone to Hyderabad.
It is for the second sampling.
No, even first sample
First
also.
sampling.
Biopest, the moment,
Biopest.
wherever they do the analysis, it should have happened in the Hyderabad. After I give a request, then it should have been sent to other place.
Yes. Now you took me to this page 53 in this. That says, this is for the second testing or the first testing itself?
Lord, it's in first petition.
It is, no, first petition alle. First testing itself goes to Hyderabad.
Illa.
Come to page 53, sir.
The notification, my lord, which I will.
Yes, sir.
Please. First test, I'm sorry. First test itself, that should have been carried out at.
That is exactly what I'm asking. In terms of this notification, it is specific to biopesticides.
Very well.
Biopesticides at the outset should be sent to Hyderabad.
Yes.
Is this notification correct?
Yes, my lord.
It was not sent to Hyderabad.
Any of the cases, it has not
been sent. It is sent to laboratories here.
Here.
Like how insecticides are sent.
How
This is biopesticide specific notification.
Notification to that.
Open and shut.
No, this.
Yes. Central government, page 53 ನೋಡಿದ್ರಲ್ಲ?
Yes, ma'am.
In exercise of powers conferred under 16 so and so, hereby directs the following functions of Central Insecticide Laboratory in respect of biopesticides shall be carried out by National Institute of Plant Health Management, Hyderabad. That's why it's open and shut. If you have sent it elsewhere, the case goes elsewhere.
Allah, that is if they're testing the biopest.
Biopesticide.
No, we are not testing-
Allegation is biopesticide.
No, allegations is insecticides.
No.
Yes, my lord.
That laced with chemicals is what
No,
the
no,
question.
allegation is insecticide. That is where, my lord, the petitioner is misleading. They claim is that it's a biopest. It is not a biopest. What is found in insecticide?
Where is the report now?
Reports, my lord, is
Where is the test report?
is attached the test report, my lord. It's,
My lord, kindly, the first petition itself, please come to page 27, their complaint itself.
27.
Please,
Yes,
ma'am.
sir.
Mail in the second line, ಕನ್ನಡದಲ್ಲಿ ಇದೆ.
Yes.
ಜೈವಿಕ ಪೀಡನಾಶಕದ ದಾಸ್ತಾನು ಪೈಕಿ ಮಾದರಿಯನ್ನು ತೆಗೆಯಲು
ಯಾವ್ದು ಹೈಬ್ರಿಡ್ ಕನ್ನಡ ಹೇಳ್ತಾ ಇದ್ದೀರಾ?
ಸ್ವಾಮಿ?
ಹೇಳಿ ಬಯೋಪೆಸ್ಟಿಸೈಡ್ ಅಂತ ಎಲ್ಲಿದೆ?
ಜೈವಿಕ ಪೀಡನಾಶಕ is not biopesticide.
ಏನದು?
ಜೈವಿಕ ಪೀಡನಾಶಕ.
ಜೈವಿಕ.
ಪೀಡನಾಶಕ.
ಜೈವಿಕ is bio. Yes.
That is a complaint. The complaint itself is biopesticide.
Lalla, they say, my lord, their product, which is a pest, they say it's a biopest. It is not an insecticide.
Her complaint is
Allah, correct.
biopest.
That is what we have. That is why we went and inspected, because we have a complaint saying that the product which is selling has insecticides. So we tested that.
So it is biopesticide.
So it is not biopest. What has been found, your lordship may see the laboratory report.
Laboratory report ಎಲ್ಲಿದೆ?
At page number 39, my lord, if your lordship has 17894.
Yes.
Page number 39, my lord. Now, your lordship may come to page 40.
Plant protector.
Yes, ma'am.
ಎಲ್ಲಿದೆ ಇದ್ರಲ್ಲಿ ಬಯೋಪೆಸ್ಟಿಸೈಡ್
Next page, Melo. Is the pesticides found in the product and the prescribed and what is found.
It contains pesticides, not
Correct.
insecticides. Two are different.
That pesticides, my lord, is a schedule.
Yeah, pesticides alle ide illi.
Correct.
What it contains is what is found in this analyst result.
Correct, my lord.
It contains thiamoxythom and amacetin benzoate. That is what is said.
May I kindly turn to Annex G, next page, very next page, my lord. ಅದರಲ್ಲಿ show cause
Nowhere it is insecticide, it is biopesticide. ಅದು ನಿಮಗೆ ಗೊತ್ತಿಲ್ಲ, ಗವರ್ಮೆಂಟ್ ಸಪರೇಟ್ ನೋಟಿಫಿಕೇಶನ್ ಮಾಡಿದಾರೆ ಬಯೋಪೆಸ್ಟಿಸೈಡ್ಗೆ ಅಂತ, ಅದಕ್ಕೆ ಇದರಲ್ಲೇ ಮಾಡ್ತಾ ಇದ್ದೀರಾ. ಇನ್ಮೇಲೆ ತಿದ್ದು ಕೊಡ್ಬೇಕು.
ಅಲ್ಲ, your lordship may
kindly see the show cause notice that is.
ಶೋ ಕಾಸ್ ನೋಟಿಸ್ ಅಲ್ಲಿ ಏನಿದೆ?
ಸೆಕೆಂಡ್ ಲೈನ್ ನೋಡಿ. ಮೇಲಿನ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ದಿನಾಂಕ ನಿಮ್ಮ ಮಾರಾಟ ಮಳಿಗೆಯಿಂದ 250
ಜೈವಿಕ ಪೀಡನಾಶಕ ಮಾದರಿಯನ್ನು
ತೆಗೆದು ವಿಶ್ಲೇಷಣೆಗೆ.
ಎನಿಥಿಂಗ್ ಎಲ್ಸ್ ಸರ್?
your lordship may see that.
ಜೈವಿಕ is bios. ಪೀಡನಾಶಕ is pesticides. ಕೀಟನಾಶಕ is insecticide. Lot of difference. Your case is it is ಜೈವಿಕ ಪೀಡನಾಶಕ. Clear biopesticide.
When that, your lordship may see the report.
No,
What is it?
ಕೀಟನಾಶಕ and ಪೀಡನಾಶಕ is totally different.
ಅಲ್ಲ, your lordship may see page 14 ಅಲ್ಲಿ, what is
Yes, sir.
required quantity and what is found in the quantity.
Whatever quantity may be,
No,
it is who has to test it ಅಂತ ಅಷ್ಟೇ. That's mandatory. Shall. Government of India says under section 16 of the Act that it shall be Hyderabad, so and so institute itself of plant medicine. Insecticide ಎಲ್ಲಿ ಬೇಕಾದ್ರೆ ಮಾಡಿದೆ. Biopesticide ಗೆ for the first time it is constituted. ಅದಕ್ಕೆ ಹೇಳಿದ್ದು open and shut ಅಂತ.
ಇದರಲ್ಲಿ he is not challenge one of the
ground of challenge is that itself.
The legal ground, sir.
35.7. He is
No
not
challenge to a legal ground is of no avail, sir. We can always
35.7
certiorari proceeding. ಅಲ್ಲ ಇದು 482, sorry. WP na criminal petition. WP, yes.
35.7 ಅಲ್ಲಿ he is not even asking for a revaluation, retest.
Retest ಆಗದೇ ಇಲ್ಲ ಈಗ. It's all expired.
ಅವರೇ ಕೇಳಿದ್ದಾರೆ.
It's all expired.
ಅವ್ರು ಕೇಳಲೇ ಇಲ್ಲ ಅದನ್ನ.
ಅದಕ್ಕೆ we should set the law straight now. Let them not commit this mistake repeated.
Lordship may have to lay down something.
That is what biopesticide for the first time it is coming here. Biopesticide ಅಂತ ಗೊತ್ತೇ ಇಲ್ಲ ನಿಮ್ಗೆ. Insecticide, biopesticide ಎಲ್ಲ ಒಂದೇ. It's separately constituted.
She may have to lay down something.
That will do, yes. ನೀವು ಹೇಳಿಲ್ಲ. Yes.
Yeah, that is the first time, my lord. Even I, after finding it out, I brought it.
What was there? ಎಲ್ಲೆಲ್ಲೋ ಹೋಗ್ತಾ ಇದ್ದೀರಾ, traveling elsewhere.
That is the only ground.
You should have come here straight. The petitioners in all these cases, ಎಲ್ಲ same proprietor ಬೇರೆನಾ?
Same proprietor, ಒಬ್ರೆ.
In all these cases, the petitioner in all these cases is common. It is the proprietor of Karnataka traders. The allegation against this petitioner in all these cases is also common. It is for violation of the Insecticides Act insofar as it relates to biopesticides. Therefore, these petitions have now become a conglomeration and are disposed by this common order. Heard so and so. For the sake of brevity and convenience, facts obtaining in writ petition 17894 of 2024 would be narrated. The respondent state, i.e. the insecticide inspector and the assistant agriculture director, visits the premises, i.e. the Karnataka traders, owned by the proprietor, of which the petitioner is the proprietor, on what date is that?
3 dates, my lord. 24/2020.
On? What are the dates, sir? Yeah, synopsis is also sketchy.
15/7/2020. My lord,
On
which is,
15/7/2021 and 3 dates ಎಲ್ಲಿದೆ ಇಲ್ಲಿ?
in my compilation where I provided.
Which compilation, sir?
The lots were looking at where I have judgments and.
1 minute, Vasudev. Conducted an inspection of the petitioner's premises on 20th July 2019, 27th April 2020, 28th April 2020, and 34/2020, and collected samples of various bioproducts as is found in the petition. 3 samples were drawn of the bioproducts from the sealed containers from the premises of the petitioner, and 1 sample each was sent to the laboratory at the University of Agriculture Sciences, Raichur, for its analysis and report. The test report of the laboratory confirmed presence of traces of chemicals in the sample. The petitioner in all these cases requests sending of those samples to the Central Insecticide Laboratory for re-examination within 28 days from the receipt of the report from the respondent. The respondent did not send the samples is the allegation of the petitioner in all these petitions except one, that in 17, except one that is in the subject petition. I am narrating the facts that only. So and so. Therefore, the petitioner is before this court. A complaint is preferred. Show cause notice is issued to the petitioner as to why proceedings should not be initiated for finding certain chemicals in the biopesticides that was seized from the ಬಟನ್ ಒತ್ತಿದ್ದೀರಾ? ಆಮೇಲೆ ತಂಗ್ ತೊಂದರೆ ಆಗುತ್ತೆ. Don't forget that in every case. Yes, madam.
Madam.
ನಿಮ್ಗೆ ಹೇಳ್ತಾ ಇರೋದು. Don't forget that in every case. Yesterday hand delivery ಎಲ್ಲ ಪ್ರಾಬ್ಲಮ್ ಆಗಿದೆ because you have not pressed the button. Is that difficult? Yes. ಏನ್ ಹೇಳಿದೆ? That was seized? What? The samples that were seized were laced with certain chemicals is the allegation against the. So, illa madam, show cause notice ಹೇಳಿದ್ನಲ್ಲ. A show cause notice was issued to the petitioner as to why proceedings should not be initiated under the Insecticides Act for its violation and finding of chemicals laced on the said samples that were taken for its testing. The show cause notice results in initiation of proceedings against the petitioner and the concerned court taking cognizance of the offence and registering CC 4701 of 2023. The CC would vary from case to case in all these cases. The petitioner is at the doors of this court after a receipt of summons from the hands of the concerned court in the aforesaid CCs, calling in question the very registration of the crime and the taking of cognizance by the concerned court. The learned counsel appearing for the petitioner would contend that the show cause notice addressed the problem to be one of biopesticides, but the biopesticides were not tested in a particular laboratory as is directed in terms of a notification of the Government of India dated 12th March 2023. The learned counsel would submit that the proceedings are taken up under the Insecticides Act for a biopesticide sample, and the proceedings are continued as if it is an insecticide. Even otherwise, he would submit that the samples were not sent to the central laboratory at Hyderabad for a second testing as obtaining under subsection 3 of section 24 of the Insecticides Act, which has taken away the statutory right of the petitioner to get the sample tested on the second time. The sample today has lost its efficacy as they have all become expired products, and therefore the sample cannot be sent even on a direction by this court today. The learned additional SPP would vehemently refute the submission of the petitioner, contending that subsection 3 of section 24 has twin obligations. On receipt of the sample on the first testing, and if the sample goes against the goes against the accused, it is his right as well to send the sample to the central testing laboratory at Hyderabad, or the right of the prosecution. The petitioner has not exercised his right of sending the sample to the central laboratory at Hyderabad, and therefore the ground on which the petition is projected is erroneous. He would further contend that the samples did contain the samples that were drawn biopesticides, which they did contain lacing of chemicals, which is punishable under the Act. He would therefore submit that the matter is it's a matter of evidence, and for the petitioner to come out clean in a full-blown trial, and seeks dismissal of the petition. You found some answer, huh?
Lordship, it's your notification one.
ಯಾವುದು?
Our notification.
ನಿಮ್ notification.
Yes.
ಆಮೇಲೆ
Says analysis.
under
samples
what
of
power
biopesticides-
did you issue this notification?
Analysis of biopesticides and chemicals.
Under what power did you issue this notification?
Sections
19.
Under
19.
under 19. Under section 19.
Yes.
There is already under section 16. Section 19 is of no avail for you. Well,
Only
answer.
for analysis.
It is regarding analysis and analysis. Biopesticide specific notification is by the central government and its occupied field. Where will issue a contra notification to that?
The second evaluation which required to be sent to central notification.
The first itself is erroneous in this case. It's your case that it is biopesticide.
Correct.
If it's your case, it is biopesticide. The only laboratory is here under the notification, not for second testing.
Like even our notification issued on section 16 talks about the bio.
Section 16, 19.
Section 19.
19.
Speaks about the.
Maybe it may speak about anything, but it cannot speak contrary to what central government has spoken. You can't override what is there. Though this is not it is definitely an act, notification under the Act. So it can't be repugnant at all.
That's correct.
Will not go into repugnancy, but it cannot be contrary to what central government says. It's occupied by a notification issued by the central government. It's a theory of occupied field. Can't. Yes.
And these insecticides which were found are part of the schedule.
Sorry?
Are part of the schedule. The insecticides which were found are part of the schedule.
Chemicals that were found. Chemicals that were found in the biopesticide are part of the schedule. So definitely, whatever it is. But biopesticide and ನೀವೇ ಹೇಳ್ತೀರಾ. ಅದಕ್ಕೆ ಯೂಸ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ವರ್ಡ್ಸ್ ಕರೆಕ್ಟ್ ಆಗಿ ಮಾಡ್ಬೇಕು. ಕೀಟನಾಶಕನೋ ಜೀವನಾಶಕ. Yes. So the afore narrated facts are not in dispute. I have given my so and so the afore narrated fact. The issue that falls for consideration is the consideration is whether the testing, the place of testing of the biopesticide that was found in place of testing of the sample that was drawn as biopesticide from the premises of the petitioner. Therefore, certain statutory provisions are late will pass out. That order will be there. Because it's going to take some time. All allowed cost. ಈಗ ಸ್ಯಾಂಪಲ್ ಕಳ್ಸಕ್ಕೂ ಆಗಲ್ಲ. All expired. Javai.
Petitioner in this case, my lord.
Attachment order.
Yes, ma'am. I served the copy to the other side, my lord, through council also filed acknowledgement also, my lord. In this case, that 138 proceedings was initiated. That recovery proceedings was also initiated.
ಒಂದು ಚಾನ್ಸ್ ಕೊಡೋಣ, ನಾಳೆ ಫ್ರೈಡೆ ತಗೊಂತೀನಿ. ಅರ್ಜೆನ್ಸಿ ಅಲ್ಲಿ.
Proceedings 17th ಇದೆ, please.
List 7th ಇದೆಯಾ?
17th.
ಫ್ರೈಡೆ
Please.
List on Friday in the fresh matters list. Let him come. Serve ಮಾಡಿದಿರಲ್ಲ?
Serve ಮಾಡಿ acknowledgement ಆಗಿದೆ.
Yes, next.
37.
All these 4 matters, I filed a NOC
ಎಷ್ಟು ಮೊಬೈಲ್? ಮೊಬೈಲ್ ಥೆಫ್ಟ್ ತಾನೇ ಇದು?
No, no, no.
ಮತ್ತೆ?
This
ಇಲ್ವಾ?
is of, please, 37.1234. Four matters.
ಮೊಬೈಲ್ಗಳನ್ನು ಕಿತ್ತುಕೊಂಡು ಹೋದ 3 ಅಪರಿಚಿತರ ವಿರುದ್ಧ ದೂರು.
My lord, this is a case wherein as an option.
SPP appears, my lord.
Appearing for second respondent. Serial number
ನಿಮ್
30.
ಮೊಬೈಲ್ ಕಿತ್ಕೊಂಡು ಹೋಗಿದ್ದು?
Lord, this is a offshot of the earlier case.
What earlier case?
First case, what happens is this is first case, this the serial number 37. This is a case which has been registered subsequent to the first case. The first case initially it is registered by
Yeah.
Kodagehalli police
ಫಸ್ಟ್
station.
ಕೇಸ್ ಯಾವುದು?
That is not before your honor.
Then ಅದೆಲ್ಲ ಯಾಕೆ?
That is the reason. No.
How do
The
I know
facts
it is
what
first
your
case?
honor has expressed is of that case. And that was the reason I said.
Oh.
Where initially FIR was registered by Kodagehalli police. In Kodagehalli police, it is the case of the respondent number 2 that some unknown person has snatched away his phones. And he also gives a further statement where he implicates this petitioner, saying that the phone was snatched at the instance of this petitioner for the reason that there was some conversation which apparently discloses the conversation between the first informant as well as this petitioner, where there is some business transaction and this petitioner has acknowledged that he owes money to him. That is what he makes the allegation in that case. And as a matter of course, what he does is that he files as many as 7 complaints. As many as 7 complaints are filed. Out of that 7 complaints, 1 complaint the police have registered, and that is the first case, ma'am. And in this case, what is his case is that the second respondent, he alleges that this petitioner apparently has shown some property and also stated that this property belongs to some other person. And he also alleges that in that pretext, some money has been transferred to one Alpha Enterprises. And he says that I am managing all those accounts. This petitioner is managing all those accounts is his allegation. My case is that between the petitioner as well as the first informant, there is a long-standing relationship and we both have indulged into real estate business. And it is not the case that in that pretext this money has been obtained.
Yes, sir.
Today I filed my objections, my lord. Senior also met with an accident, my lord. He is now bedded.
406, 420.
I'm not, frankly speaking, today, in fact, even I am not completely prepared, my lord.
ಮತ್ತೆ ಈಗ ಎಲ್ಲ ಗಾಳಿ ಇಲ್ಲ ಮತ್ತೆ ಇದು?
No, my lord, because today morning I have filed my NOC and I have submissions.
7.3. Respondent number 3 is passed away on 27/12/2019.
Complainant.
I have a separate submission with respect to other 3 cases because these are not arising out of the
ಆಯ್ತು
same
ಈಗ
crime number.
Learned counsel ಹೆಸರು ಬರ್ಕೊಡಿ ಎಲ್ಲ. Learned counsel so and so enters appearance for the second respondent in 37. Devi Prasad Shetty is there already.
Yeah.
I appear for Devi Prasad Shetty.
ನೀವು
I appear for Devi Prasad Shetty.
you are for Devi Prasad Shetty, all right. 37.1.
I appear for that.
Learned counsel so and so undertakes to
My lord,
enter.
in fact, I have a submission 37. Allala, ನಾನು I am withdrawing it.
ಬೇಡವಾ?
I'm withdrawing it. That is my submission.
Withdrawing, all right.
That is the reason.
Counsel for the petitioner submits, seeks leave of this court to withdraw the petition. The submission is placed on record, petition is disposed as withdrawn. I think
Please.
ಅವ್ರು ತೋರಿಸ್ಬೇಡ ಒಂದು ನಿಮಿಷ. Learned counsel ವಕಾಲತ್ ಹಾಕಿದ್ದೀರಾ?
37.2 ಅಲ್ಲಿ ಹಾಕಿದ್ದೀನಿ.
ಅದಕ್ಕೆ 37.2 have a submission. What has happened is this, sir.
Withdraw ಯಾವುದು sir?
37.1 I am withdrawing it.
Withdrawn.
The reason is that it is a double petition.
ಆಯ್ತು ಈಗ 37.2 learned counsel so and so undertakes to
I have filed ವಕಾಲತ್.
submits that he has entered appearance for the second respondent, registry to print the name of so and so as appearing for the second respondent.
I have a
ಆಯ್ತು 37.3
Complainant.
learned ಬರ್ಕೊಡಿ. Learned counsel so and so submits that she has entered appearance for the complainant, second respondent, complainant in the case at hand, registry to print the name of so and so as appearing for the complainant. Yes.
May I make one submission in 37.2, my lord?
ಇವತ್ತೇನ್ ರೆಡಿ ಆಗಿ
ಏನಿಲ್ಲ. In fact, there is a petition according to me because yesterday I have read through the file. What my submission would be is, this is a case where it requires a trial. All that, please. I am not withdrawing with respect to serial number 37 and 37.4. I would still 37.
ಈಗ 37.2 ವಿಡ್ರಾ ಮಾಡ್ತೀರಾ?
37.2, but all that the request would be is this, my lord. This is a charge sheet of 2020. 1 year disposal ಕೇಳಿದ್ರೆ I am ready to face the trial.
All right, that will do.
Please, that is my submission.
The 37.2 ಅಲ್ಲಿ ಬರ್ಕೊಳ್ಳಿ. The learned, one withdraw ಆಯ್ತು 37.12. The learned counsel, petitioner is before this court so and so. Counsel for the heard so and so. Learned counsel Arun appearing for the petitioner would though project submissions on merits, would restrict his prayer for an expeditious disposal of the proceeding before the concerned court. In the light of the said prayer, I deem it appropriate, said prayer and it being innocuous, I deem it appropriate to direct the concerned court to dispose the petition with an outer limit of 1 year, if not early. With the aforesaid observation, petition stands disposed. ಅವ್ರದ್ದು ಫಸ್ಟ್ ವಕಾಲ ತೋರಿಸ್ಬಿಡಿ, ಆಮೇಲೆ ಹರ್ಡ್ ಸೊ ಅಂಡ್ ಸೊ ಅಂತ ಹಾಕಿ ಈ ಆರ್ಡರ್ ಮಾಡಿ.
So 37 and 37.3 may be
What
taken up
remains is now 37 and 37.3.
next week.
ಆಯ್ತು, ಎರಡು ನಾಗೇಂದ್ರ ನಾಯಕ್.
Kindly have it after vacation. I have filed NOC in all matters.
List the matter on 17th in the fresh matters.
Please, ma'am.
Yes.
17th after vacation. Okay.
Otherwise, I'll state, let it come after vacation. Enter order ಕೊಡ್ಲಾ? ಕೊಡ್ಲಾ?
17th.
ಹಾ, 17. ನೀವೇನ್ ಇಲ್ವಲ್ಲ ಅವರು.
They are all from same office.
Complainant different.
ಅಲ್ಲ, like,
Okay,
Petitioner same, complainant.
It's all right, yes, yes. 17th fresh matter.
37.3, there is an
What
interim
remains
order.
is 37 and 37.3.
37.3, there is an interim order. So
Interim order in any of these cases shall continue to the next date.
Interim order is not,
it is there, sir.
One ಇದ್ರೆ continue
37.3 it
ಆಗುತ್ತೆ.
is there.
interim order is not.
ಇದ್ರೆ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ, ಇಲ್ಲದೆ ಇದ್ರೆ ಇಲ್ಲದೆ ಇರೋದು ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ. Yes.
38.
It's 98 of KP Act, my lords. The government servant could not give the account satisfactory
Interim order ಇದೆಯಲ್ಲ,
disposal, my lords.
Why?
Covered by, my lords, two judgment.
ಯಾವ್ದು ಕೊಡಿ?
Lords, one is Asu Surendranath Tiwari, my lords, and the other one is
ಅದೇ de-exoneration.
also, my lords, and also there is no permission as recorded by the magistrate itself, my lords, page number
Permission
Page
ಇಲ್ವಾ?
number 20.
20.
Page number 20, magistrate has recorded
ಇದು
that
ಗೊತ್ತು
there is no
ಸರ್.
permission obtained.
No permission obtained. Then
Permission.
over, it cuts at the root of the matter. The petitioner is before this court seeking the following prayer, heard so and so. The learned counsel appearing for the petitioner takes this court through the crime so registered and the order of the learned magistrate while taking cognizance of the offense for offense punishable under section 98 of the Karnataka Police Act. It is an admitted position that section 98 of the Karnataka Police Act is a non-cognizable offense. And for a non-cognizable offense, the NOD of the learned magistrate prior to registration of the crime is imperative. In the light of where is that order?
Oh, my
Page
lords, page
number-
number 20, my lords.
Page number 20, my lord.
1 minute.
19 and 20.
19, last paragraph it starts, my lords, hence without.
The learned magistrate, while taking cognizance of the offense, observes as follows. Page 19 and 20. ಎಲ್ಲಿದೆ no permission ಅಂತ?
My lords, in 20, the court records the finding,
20.
my lords. IO has stated specifically. In
Without
the
court
initial itself,
permission.
without court permission, IO has no power to register an FIR or arrest the accused. Moreover, the IO was not complied with the guidelines of so and so. Hence, my lords, in the
Lords,
last,
The learned counsel would submit on the aforesaid order. The learned counsel, on the strength of the aforesaid order, would submit that there is no permission taken at the hands of the magistrate prior to registration of the crime as obtaining under subsection 2 of section 155 of the CRPC. The learned HCGP on verification of the records would also submit that would also admit the position that no permission was taken prior to registration of the crime. The learned counsel for the petitioner has projected yet another circumstance to be in his favor. The circumstance is
page number
that the
67.
petitioner getting exonerated of the offense under exonerated in a departmental inquiry instituted on the same cause of action. The exoneration has become final by the order of the disciplinary authority closing the proceedings against accepting the exoneration and closing the proceedings against the petitioner on the departmental side. The issue in the list, insofar as it concerns exoneration of a departmental inquiry, in the departmental inquiry, stands answered by the apex court in the case of Ashu Surendranath Tiwari, 2020, 9 SCC, page 636. ಅದರಲ್ಲಿ paragraphs ಕೇಳಿದ್ರೆ ಹೇಳ್ತಾರೆ. In the light of the aforesaid twin circumstance which runs in favor of the petitioner, the inescapable conclusion would be obliteration of the crime for the aforesaid reasons. So on. Washed.
The amount has to be released, my lord, because yes,
ನಾನು ಇಲ್ಲಿ ಬರೆಯಲ್ಲ, ಅದನ್ನ ಕೋರ್ಟಲ್ಲಿ ಮಾಡ್ಬೇಕು.
because liberty may be.
The consequential
not necessary
action
now.
of release of the amount may be sought by the petitioner. ಮತ್ತೆ ಯಾಕೆ court yes? All consequential benefits that would flow from the order shall inure to the petitioner. Yes.
Please.
ಸಾಕಷ್ಟು.
Oblige.
Yes, next.
39.
Complainant before this court, my lord.
Why, sir? What do you want?
They are not called for any production of the document
yes,
and
sir.
my father's statement has not. been recorded.
498 ಏನು ಮಾಡೇ ಇಲ್ಲ.
I placed all the documents along with the petition, my lord.
We'll get the IO, Jagdish.
IO records now they have submitted.
Two dates, date ಅಲ್ಲೂ ಅದನ್ನೇ ಹೇಳ್ತಾರೆ. 25th.
ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದಾರಾ?
ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದ್ದಾರೆ.
ಏನ್ ನೋಡ್ಕೊಂಡು
ಕಾಲ್ ಫರೇ ಮಾಡಿಲ್ಲ.
ಇವ್ರ ಸ್ಟೇಟ್ಮೆಂಟ್ ತಗೊಳ್ದೆ ಚಾರ್ಜ್ ಶೀಟ್ ಹೆಂಗ್ ಹಾಕಿದ್ರಿ?
In fact, mother has
Further
not.
investigation. Huh? List tomorrow in the fresh matters list. I will direct further investigation now. Yes.
Great.
40.
Breach of agreement.
It's breach of agreement. 6.25% partner says that his share of profit is not yet given.
Heard the learned senior counsel appearing for the petitioner. The learned senior counsel taking this court, so the documents appended to the petition would demonstrate that a partnership dispute between the two or a breach of an agreement is dressed with a color of crime. The learned senior counsel submits that the amount of 6.25% in the partnership is not received by him and therefore the criminal law is set in motion by the respondent. Such actions, if permitted, would run foul of the judgment of the apex court in the case of. Yes, sir. Vijay Kumar Ghai
I
versus
mentioned two
so-and-so,
judgments. my lord.
2022 7 SCC page 124
Yes.
and the judgment of the apex court in the case of Lalit Chaturvedi versus so-and-so, 2024 SCC online SC page 171. Therefore, there shall be an interim order of stay.
Please.
Yes, sir. Mention ಮಾಡಿದ್ದೀರಾ?
I mentioned it.
ಎರಡೂನು?
Lords, no, I have mentioned Medmem LLC because that was with
Then
reference to the
1998.
2018.
Yes. 2018, sorry.
Yes, and then 2021, my lords, this is by this honorable court, your lordship said.
Oh, my goodness. ಅಷ್ಟೇ, stay ಆದ್ರೆ ಆಯ್ತು ಬಿಡ್ತಾರೆ.
41.
ಗಾಂಜಾ.
Yes,
Ah,
as per the Mahazar, it is very
Yes.
clear, my lord. Only
yes, madam. Stem ಎಲ್ಲ ಸೇರಿಸಿ ತಗೊಂಡಿದ್ದೀರಾ ಏನು?
there is no flowering top or fruiting top.
ಫ್ಲವರ್ ಆಗಿರ್ಲಿಲ್ವಾ ಇನ್ನು?
Your lordship, as per Mahajar, it is along with the seeds, along with the leaf and.
Leaves and root.
ಏನ್ ಕವರ್ಡ್ ಇದು?
Lord, as per the definition of 2(3)B, only the fruiting top and flowering top of the ganja.
Karnail Singh has been distinguished in
That
the
is,
latest judgment.
cannabis
Karnil
like-
Singh is section 42 is concerned, Lord. The coordinate bench has held that, Lord. In order to come under the definition
That
of.
is Justice Anand Bharat Reddy in
Yes,
2006.
Cannabis.
ಅದು ಗಾಂಜಾ ಸೊಪ್ಪು.
ಹೌದು.
ಆ ಕೇಸ್ ತಾನೇ ಅದು.
Definition
There
itself
was-
is very clear. 2(3)B of the definition of the NDPS Act. It is clear that the ganja, that is flowering top or fruiting top of the cannabis plant,
Stem roots, other parts, ಅದೆಲ್ಲ ಸೇರಿಸ್ಬೇಕು.
excluding the seeds, leaves when it is accompanied by the tops, by whatever may be named it is
different now.
designate.
That's not. ಇದು ಕ್ಯಾನಬಿಸ್ ತಾನೇ ಇದು?
ಅಲ್ಲ, present it is ganja.
Cannot take a shelter under ganja. These plants needs any part.
ಅಲ್ಲ, ಕೆನಾಟ್ ಟೇಕ್ ಶೆಲ್ಟರ್ ಅಂಡರ್ ಗಾಂಜಾ ಅಲ್ಲ, ಕೆನಾಟ್ ಕಂಟೆಂಟ್ ಅಂತ ಹೇಳಿ.
Yes.
Lord, they specifically mentioned it as a ganja. In order to come under the definition of ganja, it requires a flowering top or fruiting top. And it is not the mixture of
Karnail-
all things.
Karnail Singh, there is some change.
Colonel Singh, it is so far as section 42 is concerned. 42's Lord, on the information which was received, and on the such information, same shall be forwarded to the higher officer. Lord, the second point I am considering here, saying that, Lord, the definition of ganja, it not attracts, Lord, to invoke. If it is a mixture of flowering top, seeds and leaves, everything, then it's a matter of the investigation under FSL. If it is mixed with the plant and seeds and leaves, everything, then the prosecution can continue for investigation. Here it is a specific case in the Mahazar itself, it is a leaves and root.
ಪಾಂಡ ನಾರು ಹಸಿರು ಎಲೆಗಳು. ಪಾಂಡ ನಾರು ಹಸಿರು
Let's see.
ಎಲೆಗಳು.
We'll dictate tomorrow. Please, look into the,
ಗಾಂಜಾ ಅಂತ ಬರಿಬಾರ್ದಾಗಿತ್ತು ಅಷ್ಟೇ. Otherwise, you have to see section 2. 4, Canadian planted basic right.
I'll give it to. Surendra could put it. Surendra could it. Yes, ನಾಳೆ.
That's in this case, appear for petitioners, my lords. This is 498A3(4) of Double Prohibition Act. Your lordships in the last occasion.
Pass a detailed order.
Yes, my, insofar as petitioners.
ಅದೇ ನೀವೆಲ್ಲಿ ಸರ್? 42 ನಿಮ್ದಲ್ಲ. ನಾನು ಇದೇನು 35(3) ನೋಟಿಸ್ ಇದು 498 ಎಲ್ಲಿ ಬರ್ತದೆ? Yes, I asked the IO. Yes, sir. You are released?
Please, I am.
ಯಾರು ಜಗದೀಶ್ ಅಪಿಯರ್ ಆಗಿದ್ದಾವ?
Please.
ಅದೇ
Illegal arrest.
nothing is appended to the FIR. So, sorry, 35(3) notice. He's been released, but how do you correct this errors? ಅಲ್ಲ ಅದರಲ್ಲೇ ಹೇಳಿದ ಆಲ್ರೆಡಿ ಡಿಪಾರ್ಟ್ಮೆಂಟಲ್ ಇನ್ಕ್ವೈರಿ should be initiated against those persons. Against this man, I will direct initiation. Ignorance of law is no excuse.
One opportunity.
ರಿಲೀಸ್ ಆಗಿದಾರಲ್ಲ,
Please,
ಬೇರೆ ಪ್ರಾಬ್ಲಮ್ ಇದೆಯಾ? ಕ್ಲೋಸ್ ಮಾಡೋಣ.
please.
He is also there, yes. The petitioner is before this court calling.
There are instances where now police officer ಹೇಳಿದ್ರು ಅರ್ಥ ಆಗಲ್ಲ. Only thing
ಏನ್
is
ಮಾಡೋದು?
only last
Oh.
opportunity.
ಅದು ಏನಾಗತ್ತೆ, it is police officer sitting in police station has to do too many works. Unfortunately, the writer sometimes writes. So all this bound.
ಅನ್ಫಾರ್ಚುನೇಟ್ಲಿ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಯಾರು ಬರೆಯಲ್ಲ, ರೈಟರ್ಸೇ ಬರೆಯೋದೆಲ್ಲ.
ಅಲ್ಲೇ ಆಗಿರೋದು.
ಅದಕ್ಕೆ ಎಲ್ಲ ಸೈಕ್ಲೋಸ್ಟೈಲ್ ಚಾರ್ಜ್ ಶೀಟ್ಸ್ ಕಾಲಮ್ 17 ಎಲ್ಲ ಸೈಕ್ಲೋಸ್ಟೈಲ್. 498 ಅಂತ ಒಂದು ಫಾರ್ಮ್ಯಾಟ್ ಟೆಂಪ್ಲೇಟ್ ಇಟ್ಕೊಂಡ್ಬಿಟ್ಟಿದ್ದಾರೆ ಅನ್ಸುತ್ತೆ, ಎಲ್ಲ ಅದೇ ಟೆಂಪ್ಲೇಟ್. ಅಕ್ಯೂಸ್ ಚೇಂಜ್ ಮಾಡೋದು ಅದೇ ಆಫೆನ್ಸ್.
ಚೇಂಜ್ ಮಾಡಿದ್ರೆ ಸರ್
ಹೊಡೆದು ಬಡದು ದೈಹಿಕ ಹಿಂಸೆ ಕೊಟ್ಟಿದ್ದಾರೆ,
ಅವರೇ ಇರ್ತಾರೆ.
ಅಷ್ಟು ಬಿಟ್ಟು ನೇರಲ್ಲ.
Correct it.
Anyway, we'll close this.
And impugn order of remand should also go.
Everything.
Please.
Because it stems from.
Please.
The petitioner is before this court calling in question the order dated 3/12/2024. Any order?
The order
passed by the concerned court, a remand other.
Please.
Remand.
Concerned court remanding the petitioner to police custody or granting police custody of the petitioner on him being taken, on being arrested by the respondent, by the investigating officer. This court on so and so had on 5/12/2024 had passed the following order. It is an admitted fact in the case at hand that the notice so issued under section 35(3) of the BNSS 2023, which is 41A of the earlier regime, the CRPC, did not append to it the FIR or the complaint as was necessary, as is held by this court. Intermodal WP 515125 of 24 anta ide, as held by this court on so and so. That being an admitted illegality resulted in an interim order being granted for release of the petitioner from police custody. The learned additional SPP submits that he has been released from the police custody. This court in WP so and so is held as follows. Adu quote madi from reasons in the court madi. It transpires that despite the order passed by this court, circular issue madidira? No circular is issued as on today. The non-issuance of circular has resulted in the investigating officers repeating the same illegality that was found fault with in the aforesaid petition. Therefore, the state shall place on record the circular so issued in terms of the said order by the next date of hearing. List the matter on 18th, failing which it would fringe on the borders of contempt, as this court had already directed issuance of a circular of the kind.
19th.
19th in the fresh matters list. this court had already issued a direction to issue a circular.
One clarification with respect to FIRs. Now all FIRs are online.
So
Yes,
what? Crime
quoting
number
them.
ಹಾಕದ್ ಬೇಡವಾ? Append ಮಾಡಿ ಅದನ್ನ. ಇವ್ರು ನೀವು ಕರೆದ ತಕ್ಷಣ ಇವರು ಇದಕ್ಕೆ ಹೋಗಿ and no FIR opens up in your website.
ಇಲ್ಲ ನಾವು
It is not at all user friendly. That is why I wrote that, you know, how I wrote that order to bring about a robust system of access of FIR. I myself accessed, no FIR gets opened. That's the reason I gave that direction.
No, I think it depends. Of course, my lord.
No, I don't know. See, ಯಾವುದೋ ಒಂದು petition ತಗೊಂಡು I accessed the FIR, no, did not open at all.
I think it depends on the
So
browser.
I wrote that order, you should develop a robust system where it is easily accessible. But that doesn't obviate your duty to append the FIR in this.
In there are some cases, my lord, may not be.
Exception, I have said exception also in that. ಈಗ NIA, sorry, UAPA offenses,
And even sexual offenses.
PMLA, POCSO, ಅದರಲ್ಲೆಲ್ಲ ಬೇಕಾಗಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ದೀನಿ. Exception ಅಂತಾನು ಹೇಳಿದ್ದೀನಿ. You read the order.
Yes.
Circular issue ಮಾಡಿಸಿ. Exceptions you carve out, no problem. But don't give ambiguity to that also.
People are beg to assist on behalf of the petition.
43.
36 lakhs.
No, my lords, may I just produce my lords full photographs?
Photograph 36 ಲಕ್ಷಕ್ಕೆ ಏನು?
Alala. The contention of the state, my lords, this respondent state was, my lords, that I am not the wife of the second respondent. My lords, my marriage with the second respondent has taken place in the year 2020 in a private ceremony that took place in a church. Now, my lords, the entire complaint, my lords, itself looks imaginary. Now, my lords, he would say that I am a maid. And my lords, he stayed with the maid for 7 years, along with the children of the maid. And my lords, one fine day, my lords, the locker was broke open and 36 lakhs was taken away. And my lords, it does not stop here. Why I am making, my lords, this submission that looks imaginary is, his allegation in the complaint is, no sooner he realized at 12 o'clock in the night it was broken.
Paper broke.
He says that he called me. And my lords, I would reply to him that, no, yes, I have taken it away. If you continue to call me, I'm going to switch off my phone. And then thereafter, my lords, he would say that thereafter I communicated to him that I'll return back the 36 lakhs. Hence, there is a delay of 4 days.
Whom are you married to?
Lords, I am married to the Chandrasekhar, my lords, who is the second respondent before your lordships. I, in fact, produced my Aadhaar card.
Single ಅಂತಿದೆ ಅಲ್ಲಿ? Marriage certificate ಯಾರೋ ಬೇರೆ ಇದೆ ಅಲ್ಲಿ?
ಬೇರೆಯವರು ಅದಕ್ಕೆ ಹೇಳ್ತಾರೆ. That's
No,
why
that is
I
my
said-
first marriage.
That's why I said I also.
My lords, my
produced
first marriage was
certificate.
resolved.
Oh.
Children, my lords, my children and myself, my lords, stay with the second respondent after my marriage with the second respondent. May I just produce these photographs, my lord? I'll just persuade your
Maze
lordships.
of facts, sir.
In fact,
my lords,
Investigation ಬೇಕೇ ಬೇಕೇ.
I'll just persuade your lordships to kindly look at the photographs, my lords, for a moment.
ಏನಿದು?
Lords, these are family photographs, my lords, that were taken. If my lords, these photographs, my
Give
lords,
it to
in my
the-
most respectful submission.
Give it to the investigating officer.
No, my lords, in my most respectful submission, if my lords, if I was, my lords, not the wife of the second respondent, there would have certainly not been photographs of this nature, my lord.
ಏನ್ ನೇಚರ್ ಏನಿಲ್ಲ ಇಲ್ಲಿ.
Let's have a look at this
ಪಾರ್ಕ್
photograph.
ಅಲ್ಲಿ
my
ಇಬ್ರು
lords.
ಒಟ್ಟಿಗೆ
These are
ನಿಂತಿದ್ದಾರೆ.
no,
ಮಕ್ಕಳ
my
ಜೊತೆ
lords, these are
ನಿಂತಿದ್ದೀರಾ?
family photographs.
Of this nature ಅಂದ್ರೆ?
No, my lords, photographs, my lords, family photographs which were given to the authorities. Now, my lords, can I persuade your lordships to have a look at my Aadhaar card, my lords? The name of the second respondent is being reflected.
No, post this case, the
My lords, if at
document
all, my lords, this complaint was, my lords, I am proceeding under the assumption that there was an allegation of, my lords, theft.
You got into the house as a maid, is it?
Is his allegation. And 7 years, my lords, his allegation is, I stayed with the maid.
ಅಲ್ಲ ಮೇಡ್ ಜೊತೆ ಸಂಸಾರ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
ಇಬ್ರು ಜೊತೆಲಿ ಇದ್ದಾರೆ.
ಹಾ?
ಇಬ್ರು ಜೊತೆಲಿ ಇದ್ದಾರೆ ಮನೆಯಲ್ಲಿ.
ಆಲ್ ರೈಟ್.
ಅವರು ದುಡ್ಡಿರೋದನ್ನ ಎತ್ಕೊಂಡು ಹೋಗಿದ್ದಾರೆ.
ಇವ್ರು ಎತ್ಕೊಂಡು ಹೋಗಿದ್ದಾರೆ?
Your brother is an MOB. Father was an MOB. Father, of course, no more. Brother has multiple cases of same theft. And your lordship, subsequently she is staying with that person. Their rent agreements have been produced subsequent to this case being filed.
My lords, all the,
new ploy, new age crimes, new things.
My lords, may I make the submission, my lord?
Yes, sir.
The factum of whether my brother is, my lords, involved in several other cases, I am involved in several other cases, my lord, does not take away my marriage with the second respondent. The true facts, my lords, were that my private ceremony of my marriage with the second respondent, when I informed the second respondent that I am going to inform.
When did you get in as a maid?
My lords, I was always his wife.
Always a maid?
No, my lords, his allegation, my lords, is he's demoted me to the status of a maid.
ಯಾವ್ದು? Yes, sir. Maid in Manhattan ತರ ಏನ್ ನಿಮ್ problem?
My lords, I am proceeding under the assumption an incident of theft took place.
Bad.
My lords, he could not have filed such an imaginary complaint where he says that soon after the theft, I called the petitioner and petitioner said, no, if you continue to call me, I'll switch off the phone. And then thereafter, I would voluntarily say,
ಇದೇನು ಮಾರ್ತಳ್ಳಿನಾ? ಅದೇ ಮೇಡ್ ಇನ್ ಮ್ಯಾನ್ಹ್ಯಾಟನ್, ಮೇಡ್ ಇನ್
ಅಲ್ಲ, ಇದು
ಮಾರ್ತಳ್ಳಿ.
ಹೊಸ ಮನೆ, ಗಂಡನ ಹೆಸರಲ್ಲಿ ಹೊಸ ಮನೆ, ಗಂಡನ ಜೊತೆನಲ್ಲಿ ಬಾಡಿಗೆ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ ಈಗ. That also the rent
ಈಗ
agreement.
after the
ಹೌದು, after
incident.
the incident.
no. My lords, I do not continue to stay with the second respondent as of now.
Why, sir?
My lords, he has thrown me away, my lords.
You are married and
No, I
two
was,
children.
my lords, the true facts are, my lords, which form, my lords, the backdrop of this complaint where I was married to him. My children, my lords, from the first marriage also were staying, my lords, with the second respondent, subsequent to, my lords, my marriage with the second respondent. When I informed the second respondent that I'm now going to tell everybody that we
about
both,
what?
my lords, about the factum of the marriage.
ಅಲ್ಲಿವರೆಗೂ you kept it as secret, is it?
The family members of the second respondent were not known, my lords, about the
For
marriage.
7 years.
After 7 years. No, my lords, I am proceeding under the.
ಕಹಾನಿ ಮೇ ಟ್ವಿಸ್ಟ್ ಯಾವಾಗ ಬಂತು ಮತ್ತೆ?
ಅಲ್ಲ, ನಾವು ಯಾವಾಗ ಹೇಳ್ತೀವಿ ಅವ್ರ ಮದುವೆ
36 lakhs ಹೋದಾಗ.
No, my lords. When I informed him that I'm going to inform his family members about our marriage, that is when, my lords, he would file a false complaint like this. My lords, I'm assuming for a moment, my lords, an incident of theft
You
took
tell
place.
me, in these facts,
Please.
are they not totally disputed? Trial ಬೇಡವಾ? Investigation ಬೇಡವಾ? 482 quash ಮಾಡಕ್ಕಾಗತ್ತಾ? It is such a maze that it would amaze this court to interfere.
May I make the submission? My lords,
Ajay should know. Idರಲ್ಲಿ seriously disputed questions of fact.
in all fairness,
ಯಾರು, who's maid, who is wife, whose children? Made in ಮಾರ್ತಳ್ಳಿ ಅಂತ ಹೊಸ ತೆಗಿಬೇಕು.
my lords, I'll fairly concede, my lords, there are certain disputed facts. But, my lords, I'm trying to develop an argument only to persuade your lordships to consider my prayer in this petition. My
For
lords.
conduct of investigation?
No, my lords, only for just, bear with me for just one. Only, my lords, trying to, my lords, develop an argument insofar as this petition, my lords. My lords, assuming, my lords, there was a theft in the house, he could not have filed a false complaint to the extent of demoting me to a maid. And 36 lakhs, my lords, in cash. And where he says, my lords, that ನಾನು phone ಮಾಡಿದೆ.
ಆಯ್ತು, 7 ವರ್ಷ ಯಾಕೆ? Why did you keep it a secret?
I never kept it a
No,
secret.
if you have married her,
Please.
you should have told it to your family members.
No, he did not inform it to his family members. In fact, kindly, my lords, may I
ಆಯ್ತು,
proceed your lordships to have a
why
look
did
at
he not inform? Why did he not inform that he has married and 7 years has been staying with you?
My lords, I, in fact,
that is the needless suspect.
no, my lords, I in fact questioned him about the same aspect. And when I informed him that I'm going to tell his family members, my lords, this complaint would surface against
When
him.
did you question him?
My lords,
Last day of the 7th year?
No, my lords, in the month of August, when I informed
1 month before the 7th year.
Please.
Yes, sir.
But demoting is very serious issue.
No, my lords, I'm trying to develop an argument, my lords. That 36 lakhs, my lords, in cash, and where, my lords, he makes, my lords, my most respectful submission is, it does not even, my lords, appeal to the law of prudence where he says, I called her, she said, if you continue to call me, I'll switch off my
Right now
phone.
it may be imprudent, but investigation will give out prudence.
I'm at your lordships.
Yes. The final report ಬಂದಾಗ you can avail of the remedy. Learned counsel appear with the petition after arguing the matter at length, seeks leave of this court to draw the petition and avail of such remedy as is available in law at the appropriate stage before the appropriate forum. Yes.
I'm so very grateful.
Disposed.
Court surety ಕೊಡಕ್ ಬಂದಾಗ they got 3 different sureties. All
This I'm not aware of, my lords. My only instructions
So
are.
investigation ಆದ್ಮೇಲೆ you will become aware of so many things.
No, my lords. My lords, I in fact, my lords, questioned, my lords, the petitioner as to what are the documents that were available to, my lords, show that they were married. My lords, I was able to lay my hands on these photographs. And they were my lords, and also in the private ceremony of the church, my lords, I am informed that, my lords, the register is maintained. However, my lords, given we could not.
There's a marriage certificate itself.
Is there marriage certificate? Is it?
Marriage certificate.
Not with this somebody else.
No, my lords, I fairly consider that marriage certificate is, my lords, he would even say that I was divorcee, my first marriage had failed, and my children, my lords, were staying with him. My lords, he could have at least, my lord, my most.
So the more you submit, it's getting complicated. So the investigation agli.
My lords, he could have at least told, my lords, my lords, if at all, my lords, that there is an offense, he could have at least given me the status of a wife and told, my lords, the wife has stolen the amount.
7 years, why did you keep quiet, sir? Status ಕೇಳಲಿಲ್ವಾ? Yes.
I'm so very grateful.
Yes. Next.
Orders?
Non-compliance. NM. counsel submission is madam. A week's time, 2 weeks' time is granted to comply with the office objections. Next,
45.
raised by objections.
The respondent number two in this.
Office objections. Statement of objections ಯಾರು ಫೈಲ್ ಮಾಡಿರೋದು?
Respondent.
ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿಲ್ವಾ?
ಇಲ್ಲ.
ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ಹಾಕಿದ್ದೀರಾ?
Yes, my lord.
ಮತ್ತೆ ಕಾಪಿ ಸರ್ವ್ ಮಾಡ್ಬೇಕಲ್ಲ?
We have served it, my lord.
That's the objection.
I even have the acknowledgement, it's served to the advocate.
Three not six,
304B.
304B.
And 498A.
And who's the petitioner?
Also husband and in-laws.
Husband stay ಆಗಿದೆಯಾ?
Yes, my lord.
I have granted. Husband ಗೆ?
Yes, my lord. Stay is granted.
My
lord.
order.
We had,
Justice Ashwa Shetty.
Not
sorry, my lord, sorry. I apologize.
husband ಗೆ ಅದು 304B ಅಲ್ಲಿ.
Yes, my lord. Stay has been granted. I have filed vacating stay as well. Along with written statements, had put even the photographs and all the details as well, my lord.
Husband will continue, sir. In-laws I will,
Means your loss. Kindly come to page number 100.
nothing, whatever it is. If husband
death
cannot be responsible, 304B, who can?
One
Yes.
submission, one more submission. Earlier occasion, it was loss or order the state to get the FSL report now, pertaining to the handwriting of the victim.
Death note wish ಇವಾಗ.
ಹೌದು.
Forget the death note, don't worry. Death has happened?
Please.
Don't,
But
yes.
My lord, I had provided certain details, including the hall ticket and passport copy, where a signature was different from the death note. I had made a submission to your lordship.
That is all a matter of trial, sir.
Yes, ma'am.
Like next date, my lords.
Husband cannot escape 304B at all.
Let
Because
the
already
FSL
3
report
days
comes.
they had taken, so.
Let the FSL report comes.
No,
to
sir.
100.
Early, where are the records?
I'll secure my lord.
My lord, in humble submission, there has been several cases where even this honorable court has said just because an FSL is not filed does not mean
It's all
there can be a
right.
stay.
304, but in-laws, see, the ground on which interim order is granted is the deceased was staying separately.
No, no.
Interim order, ground on which interim order is granted. So what do you have against the mother-in-law and father-in-law? If you have no acts, if you have other acts to grind, don't grind it here. If there is nothing against them, tell them. Husband, we will not permit it. Husband, 100% definitely trial him.
Even
Lord,
the
in
304B
take with
husband,
her
I am not
husband.
going to say.
Even the
Another
deceased
one
was
more
not
submission,
staying-
my lord. She was
was
5
staying
weeks
in the PG.
pregnant.
Even the deceased, she was not staying with the husband.
No
She was
problem,
staying in the PG.
It was only on weekdays when she was working in IBM, my lord.
No problems.
Let the report comes.
No, sir.
Every weekend she would visit back home, and even the suicide happened in the home. That day, even the husband was at the home. So while taking stay, they had told that the petition number 2 and 3, the in-laws were staying in Mysore. In fact, they stay in Bangalore. It is only the petition number 1 who is the husband would stay in Mysore and come back on weekends.
Where did the wife stay?
Wife would stay in the PG on weekdays, my lord, because she,
Where? Which place?
it was no, it
Bangalore or
was,
Mysore?
Mysore.
no, Bangalore. She stayed in PG. It was the PG name was PG Halli in Whitefield.
What is that? FSL report.
FSL. So matrimonial home was in Naksandra. Since she was working in IBM Whitefield, so she stayed in PG, but with a condition that she has to get back to the matrimonial home on weekends. And she was in fact 5 weeks pregnant, my lord. That was even brought to the notice of her respondent number 2 and even the petitioners. So without even caring, this step has been taken. And even the death note which they are specifying, so the words which are used in the death note is clearly proving that she has been harassed and she was made to take that extreme step.
She herself has written, no one is responsible for us.
So that is a standard.
You need not labor on that much.
Yes.
ಎಲ್ಲಿದೆ ಒಪಿನಿಯನ್ ಇದರಲ್ಲಿ? Logical reasoning. The similarities in writing. Anyway, FSL nodi, we can't quash it. It's a matter of evidence. Anything, sir?
The next date, Manoj.
Next week, no. Sir. Now,
In-laws may be
not in a
protected.
304 base.
Maybe in-laws may be protected, Manoj.
The daughter-in-law has died committing suicide.
Cause of depression,
Was
Manoj.
pregnant as well.
Who has led her to depression?
All the evidence has been given
First,
and
let's
even
say-
in charge sheet, it's accepted, my
Who
lord.
else
So
can
page
do it
number
other than
100,
the
that
husband?
note,
The petition numbers 2 and 3,
written that
the in-laws have.
Yes, sir.
she herself has written, my lords,
No
one
problem.
mistake in my life is my lords, I have not been born.
Huh?
That's the death note. She herself has written.
Repeatedly, she was scolded for being
Is there a
fat,
jacket?
body shamed,
Allah,
harassment.
these photographs indicate something else.
Yes, my lord, so that's the reason I had.
The way suicide is shown, photographs, that itself is doubtful.
The window was at around 10.5, 12 feet.
In-laws may be protected at this stage.
In-laws melo idea?
Yes, my lord, because they had also, even in the charge sheet, it has been proved that they were repeatedly asking for dowry and repeatedly shaming her, that she has not bought enough money. If she would have got it from some other place, they would have got 4 lakhs. And in the charge sheet also, it is clearly mentioned that they had asked for dowry. That is the reason the father spent so much of money to get this marriage done by taking hand loans and other things.
Oh, evidence in the charge sheet to show, my lord, dowry.
Let's see. Yes. Heard reserved.
You know, interim order.
That will continue. Heard so and so, judgment reserved. In the light of the matter being reserved for its pronouncement, till the pronouncement, the interim order would continue. Yes.
Much obliged, my lord.
46.
My lords,
Clearly.
I-
Harish, clearly.
Please.
my lords,
But you should have you seen those photographs? You have not invoked appropriate provision.
I've even explained in the written statement also about the photographs, my lord.
Suicide itself is doubtful. Yes,
For petitioner, my lord.
Much obliged.
yes, sir.
And the 324, 323.
Post immediately after service of notice. of-
my
My
lords,
lord,
I undertake to file.
Ah, yes.
Wakalat
Learned counsel
Charge
so and so undertakes to enter appearance for respondent number 2 complainant registry to print the name of so and so as appearing for the respondent. Yes.
my lord, date may,
After vacation.
my
Yes,
lord,
next.
my lord, urgency is there, my lord.
Yeah, no,
The
urgency.
Session court is going to frame the charges, my lord. Because,
Yeah, special court,
without
what
int-
offense?
Uh,
my lord,
uh,
atrocities act, my lord.
lords.
324, 323, 506.
I pray
atrocity.
time, my lords. I'll file necessary objections to the
intention,
main
my lord.
petition, my lords.
List on 19th in the fresh matters list. Yes. Objections, if any, by then. By then you file it, madam?
Yes.
Next.
47.
My lords, I appear for respondent number 1 in this
Lord, I
matter.
served the copy on the respondent for the IAM.
I seek
Where
for
are
short
you? Sushil
accommodation, my
Shankar?
lords.
Who is on record?
Nitin
Nitin Ramesh.
He is on record, my lord.
Registry to delete the name of Sushil Shankar as appearing for the petitioner. Early hearing.
Yes, my lord. My lord, difficulty is this, my lord.
Ah.
The petitioner is an insolvency procedure along with chartered accountant, my lord.
Ah.
His membership to the ICAI, my lord, has been expired, my lord. To renew it, this 138 proceedings is
List the
impediment.
matter on Monday in the fresh matters list.
Obliged.
My lord, I may be permitted to file my objections, my lord. I
No
appear for
problem. That day
respondent.
that day we will grant. Yes. Interim order idea? Illala.
Yes, Swami.
Interim order is there, my lord.
Then problem.
But they are not renewing. They are saying this 138 proceedings being.
I
a
list
criminal-
on Tuesday in the fresh
Fresh
matters.
matters.
Yes,
Obliged.
next.
Interim order may be extended.
That will continue. Next.
58.
CST matter, civil suit is pending since 2020, my lords.
Office objections ಬಂದಿದೆ sir.
ಅದು ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿದ್ದೀವಿ ಪಾರ್ಟಿ ಸೆಕೆಂಡ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ನ ಆಡ್ ಮಾಡಿಲ್ಲ ನಾವು ಡನ್
Complainant ಮಾಡಿದ್ದೀರಾ ಈಗ?
ಮಾಡಿ
List on Monday in the fresh matters list.
List.
Office objections, learned counsel submits, office objections have been complied with. Yes, next.
49. One memo.
In terms of the memo.
50.
Rectification of office objections.
That may not arise, my lords. The party in person is already appearing. This matter was heard at length by my lords.
ಯಾವ್ದಿದು?
ಶೇರ್ ಕಲ್ಕಟ್ಟಾದಲ್ಲಿ ಕೇಸ್ ಹಾಕಿ
ಅವರು ಬೆಳಗ್ಗೆ ಬಂದಿದ್ರಲ್ಲ. He is 19th ಬೇಕು ಅಂದ್ರು ಅವರು.
ಓ
ಬೆಳಗ್ಗೆ ಬಂದಿದ್ರು.
ಆಯ್ತು ಆಯ್ತು
Yes.
ಬರ್ತೀನಿ 19th.
Oh, that case there. Yes,
Yes,
now I
madam.
got it. Yes. list the matter on 19 at the request of the respondent in person, heard senior counsel, they hold on ಮಾಡಿ ಆಮೇಲೆ. Yes.
Interim order has to be extended, ma'am.
That will be
Yes.
interim order extended. Yes.
P1.
No petitioner.
Awaiting service.
Please.
Post immediately after service of notice upon the respondent. Interim order there.
Interim order.
Continue till the next date. Fair.
One second.
Second list down, madam.
List
Madam.
num- List number 2, being spoken to still number 1.
Appear for the petition. My lord, there are 4 errors in this order.
ಯಾವ್ದಿದು?
My lord, this is a matter on 188, 269 and Disaster Management Act.
Huh.
All were covered.
Yes.
The covered judgments were also part of the compilation and I
Why that's not quoted here?
not at all, my lord. First, my lord, under the oral order, the preamble itself is incorrect.
Oh, ಇದು ಬೇರೆ, they
The-
have quoted something else.
Yes, and in para 2, the
We'll correct it. Yes. ಕೊಡಿ judgments ಕೊಡಿ.
compilation is already part of the
So ಅದೇ
petition.
ಪ್ರಾಬ್ಲಮ್ ಆಗಿರುತ್ತೆ, ಯಾವ್ದು ಕೊಡಿ.
These are all part of the petition itself, my lord.
Let me see, we'll correct it. ಕಾವ್ಯ,
So, my lord,
ಇದು ಯಾರು ಮಾಡೋದು ನಿಮಿಷ. NG ಯಾರು?
these. My lord, as regards councils who had argued, actually Jagdish sir who had opposed that day.
ಅವ್ರ ಹೆಸರೇ ಹಾಕ್ಬೇಕಾ?
No, no,
Ah,
I'm just
all right.
stating because other names are mentioned.
Yes.
Grateful, man.
ನಾನು ಹೇಳ್ತೀನಿ ಕಾವ್ಯ, ಏನ್ ಮಾಡ್ಬೇಕು, ಬರ್ಕೊಡ್ತೀನಿ ಕರೆಕ್ಟ್. Yes, next.
Fresh matter still number 2.
You'll notice are
ಡಿಸ್ಚಾರ್ಜ್ ಆರ್ಡ್ರಾ?
discharge.
ಏನ್ ತುಂಬಾ ಡಿಸ್ಚಾರ್ಜ್ ಆರ್ಡರ್ಗಳು ಡಿಸ್ಚಾರ್ಜ್ ಆಗ್ತಾ ಇದೆ, ಮಾಡ್ತಾ ಇದ್ದೀರಾ? I'm for the first time seeing discharge orders being passed. ಇಲ್ಲಿವರೆಗೂ ನೋಡೇ ಇರಲಿಲ್ಲ. ಎನಿವೆ, ಎಮರ್ಜೆಂಟ್ ನೋಟಿಸ್ ಆಗಿದೆಯಾ?
It's ಆದಂಗಿದೆ ಮೇಡಮ್, I don't know.
ಅಮರ್ ಕೊರಿಯಾ is here.
ಇನ್ನೊಂದಿದೆ.
First one ಅಲ್ಲಿ ಎಮರ್ಜೆಂಟ್ ನೋಟಿಸ್ ಟು ದಿ ರೆಸ್ಪಾಂಡೆಂಟ್ ಅಂತ ಮಾಡಿ.
Please.
Yes. Next,
Number 3,
list after vacation. Vacating stay. Who appears for the respondent? ಕೊಡಿ.
Lordship are directed to settle the matter, my lords.
For raw materials.
Please,
Yes. ನೋಡೋಣ ಬರ್ಲಿ.
please.
ಪಾಸ್ ಓವರ್ ಮೇಡಮ್.
Lords, kindly have it day after tomorrow.
Day after tomorrow, all right.
Much obliged.
4,
Where are you? You will file wakalat in the other case also?
We have filed on the 5th, my lords.
Which one, Amar? This
Both matters.
registry to print the name of Amar Korea as appearing for the either list number 2, seal number 2. Learned counsel, ಇದು ஒரு copy ಕೊಟ್ಬಿಡಿ. Counsel Amar Korea undertakes to already filed.
We have filed
Submits
on the
that is
5th.
already entered appearance for this respondent. Registry to print the name of so and so as appearing for the respondent.
Please,
After vacation?
please.
Yes. Discharge order.
This is almost more than a year and a half.
ಏನ್ ಸ್ಟೇ ಏನಿಲ್ಲ after vacation. ಯಾವ್ದಿದು?
This is DCHL is one of the accused, which is Deccan Chronicle Holdings Limited. There's a bank fraud
All right, yes.
as against these
After.
petitioners.
Yes. Suyog, ಆಯ್ತಲ್ಲ. Pass over, Suyog. Serial number 4, Rajesh.
4.
Rajesh Rao.
Please.
Huh.
And for petitioner.
Yes, sir.
My lord.
ಯಾಕೆ ಏನಾಯ್ತು?
ಇಲ್ಲ ಸ್ವಲ್ಪ ಕಾನೂನು.
All right.
Hip joint pain.
ನಿಂತ್ಕೊಳಕ್ಕಾಗತ್ತಾ?
ಇಲ್ಲ ಅದು.
ಕೂತ್ಕೊಳ್ಳಿ.
Please, ಇಲ್ಲ.
Sit and submit, no problem.
ಇಲ್ಲ ಪರವಾಗಿಲ್ಲ.
Yes.
Manage.
ಇದೆ, ಅದೇನಾಯ್ತು?
My lord.
Two 2013,
Please, my
16.
My lord.
Charge frame ಆಗಿಲ್ವಾ?
No, my lords. The other accused, my lord, they are absconding, my lord. That is the reason the proceedings is getting delayed. I am on bail, my lord. Petitioner is accused number 2.
Other accused ಯಾರು?
They are the employees. The main allegation is against accused number 1, my lord. He is the partner and he is the investor in the company.
Who are you, his wife?
ಇಲ್ಲ, no, not the wife.
She is one of the
Accused.
employees. there.
Employee ಅಷ್ಟೇ. ನನಗೂ
Employees.
ಇದ್ರಲ್ಲಿ ಯಾವುದೇ
The heard the learned counsel appearing for the petitioner. The petitioner is an employee owned by accused number 1. The accused number 1 is said to be absconding and the trial is, the proceedings are languishing before the concerned courts for the last 11 years. A perusal at the complaint so made by the second respondent would point at all allegations against accused number 1 and none against the present petitioner accused number 2. Therefore, there shall be an interim order of stay of further proceedings qua the accused number 2, the present petitioner before the concerned court till the next date of hearing.
Much obliged.
Yes, next.
5.
Kindly pass over.
Okay.
Appear for the respondent.
Oh, vacating stay.
No, my lords, leak.
Vacating.
It's
Oh,
already
vacating
vacated.
stay.
It's already
date,
vacated at the last
No, your
meeting.
lordship vacated
Oh,
the stay order on the
vacated
last
subject to
issue.
condition
My lords,
put forward. ಏನ್ ಆಗ್ಲಿಲ್ಲ. Has he come forward?
No, not so far, no communication at all.
Yes.
The problem is that, my lords, now police are behind the petitioner.
ಅಂದ್ರೆ ನೀವು ಹೈಡಿಂಗ್ ಅಲ್ಲಿ ಇದ್ದೀರಾ?
We are in Gwalior, my lords.
Gwalior.
They are not cooperating with the police.
Please, my lord.
People have gone. They have.
Yes, sir.
please.
You have not put your first foot forward.
No, both the feet, my lord, tied. because-
Tied,
Both the feet are tied because they sent 4 policemen from here by flight to arrest them. Because my lord vacated it.
Survey notice.
No, my lord, 4 policemen to arrest 4 policemen.
ಮಾಡಿದ್ರಾ?
Luckily, my lord, because Sunday they were out. Sunday morning, 11 o'clock, they were
ಆಯ್ತು, ಈಗ ಅರೆಸ್ಟ್ ಮಾಡಿದಾರಾ?
ಮಾಡಿಲ್ಲ.
to our luck and to their bad luck could not be arrested, my lord. We were not there.
4 policemen ಮತ್ತೆ
4 policemen. We have all the photos. They went to the apartment where they were
ಅಲ್ಲ,
sitting.
4 policemen, what did they do? Had thali and came back?
No, they are
Then?
having still the tali there, continuing,
ಮತ್ತೆ
my lord.
ಸುಮ್ನೆ-
Your lordship, no. They have sent the 4 policemen by flight to arrest us. We have the photographs. We will file affidavit. This is not proper. When the matter is
How do you know they came by flight?
the policemen themselves told. Their local advocates went and asked. They came by. The policemen said.
So you met the policemen?
Our advocates met them because we wanted to know which case they come to arrest. Which case we wanted to know, my lords. Then we come to this case. Because my lords, for this short period, my lords were pleased to, my lords, vacate it on the ground that there should be a proposal. Now, this is not the way, my lords.
Proposal ಅಲ್ಲ.
Please, man, there should be.
Proposal ಆಗಿ ಮದುವೆ ಆಗಿದೆ.
ಆಗಿ ಮಗುನು ಆಗಿದೆ.
ಮತ್ತೆ ಈಗ
My lord,
proposal.
For settlement, my lords, they cannot.
Yes.
Please, my lord, they cannot do this, my lords. And for this matter, my lords, sending the police, my lord, they would have called us. Sending the police, my lords.
ಎಷ್ಟು ಸರಿ ಕರೆದ್ರು ನೀವು ಬರದೇ ಹೋದ್ರೆ ಪೊಲೀಸ್
That's not correct, my lords. I have a small
They have
child,
not
my lord.
cooperated
There
with the
are several
investigation, sir.
proceedings initiated between the parties. They are, my lords. And as far as the allegations made here in concern, your lordship are pleased to direct.
No, police notice is repeatedly issued to you.
Please, my lords.
You don't cooperate with the
Your lordship
investigation.
kindly see, when the police notice were issued, my lords, we had replied to them. At that time when it was issued, my lords, we had replied to them, my lords.
And then there was an interim order by this honorable court. After the interim order was vacated, my lords.
Local uniform person, the local police officer.
ಹೋಗಿದ್ದಾರೆ ಅಂತ ಅದಕ್ಕೆ ಗೊತ್ತಾಯ್ತು ನಮ್ಗೆ ಇವರು ಅಂತ ಪೊಲೀಸ್ ಅಂತ.
ಯೂನಿಫಾರ್ಮ್ ಇಲ್ದೇ ಇರೋದು. Only one.
Lady.
ಎಂದು?
1 and 2. 4 ಯಾರು?
ಏನು? ಅದು ಯಾರು 4 ಪೊಲೀಸ್ ಮೆನ್ ಹೋಗಿದ್ದಾರೆ. ಅದು ಲೋಕಲ್ ಎಷ್ಟು ಇದು ನಮ್ಗೆ ಅವ್ರು ಹೇಳ್ಬೇಕು ಈಗ. ಹೋಗಿದ್ದಂತ ಹೌದು ಅಂತ ಆಯ್ತು ಈಗ ಸರ್. ಮೈ ಲಾರ್ಡ್ಸ್ ಮೆಕ್ಯಾನಿಸಮ್ ಹೋಗಿದ್ದಂತ ಹೌದು ಅಂತ ಆಯ್ತು. ಆಫ್ಟರ್ ಮೈ ಲಾರ್ಡ್ಸ್ vacated.
ತೊಂದ್ರೆ ಇಲ್ಲ.
After my lords vacated the interim order, they should have asked us to come by issue a notice. Now, my lords, your lords may kindly see how the police machine is working. For this matter, my lords, for this matter, between husband and wife, a complaint is filed by the husband, 4 policemen can fly immediately. That's at the instance of the
petition. Let the proceedings go on.
Now, my lords, now your lords may kindly see.
ಅಷ್ಟೇ ಎಲ್ಲ 4 policemen.
My lords,
all policemen will be there.
The spirit of my lord's order was, my lord, to facilitate the
Settlement.
compromise. They cannot use a criminal case to threaten like this and terrorize my lords to going there.
ಇದು Rolex watch.
They say, why, again, the wife, my lord, Rolex has his wife. That is the case, my lords. And thereafterwards, they cannot do this.
Oh, you are the wife.
Wife and wife's father is an accused, 75 years.
Rolex watch ತಗೊಂಡು ಏನ್ ಮಾಡ್ತಾರೆ?
The last may kindly see, the allegation by the wife is, wife has left the house last year. Last September, October, she has left. They filed a habeas corpus petition, which was dismissed. Then wife has filed 498 there. After 5 months, they say, wife has gone along with the Rolex watch and other ornaments.
Oh, for the first time, I'm coming across a complaint between husband and wife, other than a torture, Rolex watch. She has carried away Rolex watch.
That is the complaint, my lords.
My lord, ancestral jewelry.
By the wife against, by the husband.
Ancestral jewelry has been taken away. She sent a message to the husband, you settle with me and I'll return the jewelry to you. I have
This
placed it
cannot be
on
used
the-
to threaten, to settle. Your lords may kindly see.
All right.
Yes, it's a message.
ಯಾವಾಗ when do you come?
Your lords may kindly see, your lords may kindly, as far as this situation is concerned, it's impossible because they will, my lords, sending the police to arrest.
I will direct them not to arrest you. Come.
Now, we were compelled to, my lords, move for anticipatory bail because of this, my lords.
ಈಗ
Of course,
bail ಕೊಟ್ಟಿದ್ದಾರಾ?
interim is granted yesterday, my lords.
I'm sorry, I'm sorry,
Your
I'm
lords,
sorry, it's not
because- and
granted.
for that also they're opposing. Your lords may kindly.
I'm sorry, it's refused.
Do you come, sir?
No, with a great respect to my lords, now, this is the situation I wish to bring to the kind notice of the honorable court. They have misused the process, my lords. After the short period, your lordship vacated only for between 2nd to 6th.
Correct. ಅಷ್ಟು ಸಾಕು. 24 hours ಸಾಕು.
And that is not a license for them to take the
Oh,
police. That is not at all a license, my lord. The husband cannot use like this.
That is
Husband
because,
cannot use, my lords.
that is because you have been dodging the.
No, your lords may kindly see this contention, my lords. We have spoken, I have instructions, my lord,
Now
that
come,
Rolex
you-
watch is there, etc. It's not correct. Factually, it is.
ಏನಿದೆ?
The allegation is wife has taken the Rolex watch.
ಅದು ಗೊತ್ತಿಲ್ಲ.
It's factually not
Let
correct.
husband and wife sit and decide.
No, my lords. Your lords may also.
You are coming forward or not?
May I beg to, as far as this aspect is concerned, my life, the demanding that Rolex watch you want, there is
ಇದು ಗೊತ್ತಿಲ್ಲ ಏನ್ ಡಿಮಾಂಡ್ ಅಂತ ಫಸ್ಟ್ put your foot forward
all
for
those-
settlement.
Your lordship permits me, my lords. They have given a list of demands before the Honorable Supreme Court last week, my lords. The Honorable Supreme-
Before the Supreme Court.
Before the Supreme Court, my lords. Those, it went to the mediation, did not happen. The Honorable Supreme Court directed transfer of the case.
I will post it later. All right. Let the investigation go on.
Now, my lord, in a case of this nature, my lords, is it a case for investigation? One aspect, lord may
It is
kindly
a case
consider,
for
my lords.
investigation.
When case of this,
Supreme
this
Court
sort
ಏನ-
of allegation,
Supreme Court ಏನಾಗಿದೆ? ಸ್ಟೇ ಕೊಟ್ಟಿದ್ದಾರಾ?
matter has been transferred. All, it was stay, there was a stay, my lords. Initially, there was a stay, then the matters are transferred.
Yes, yes.
These
sir.
are the,
Let's
let them,
not
my lord,
just-
they have given in writing.
Let's not
No, my lord,
precious
one
time on
sentence.
Rolex.
They
watch.
have,
Yes.
they have given in writing to Supreme Court certain demands.
Yes.
If there is any other demand, they can,
If
my
you
lord.
want to comply with the order that I have said on
No, your lordship-
12/20/24, no problem. List next week.
Your lords may kindly see, my lords, as far as the proposals are concerned, we are open. My lords, the instructing council is there. They will also, they will discuss, my lords. We open, I beg to submit. But they cannot use, my lord, both my lords, threaten with the police at this time, my lords, may the respect to submission.
You put your foot forward.
My lords,
for
husband filing
settlement.
this sort of cases, my lords may kindly see.
Anyway,
Uh,
anticipatory bail you've taken.
That's true, my lords, but terrorizing in this manner, my lords.
No,
They did, no, I beg to submit how the complaint is doing, taking the police at this moment, my lords.
Yes.
Therefore, your lords may kindly, my lords, as far as I beg to even now say, as far as the compromise talks, my lords, they will continue with the compromise talks.
Continue.
Councils will speak, my lords, between them, both the councils will speak is my respectful submission,
Do
my
it.
lords. If it happens, my lord, we are happy.
Yes,
If it
Arun
ends,
sir.
My lord,
Reach the settlement.
instructing
last
council
one
will
month we've
speak,
been
my lords.
requesting, my
They
lord, we
can't
have
demand
sent-
that they should come from there to speak. They should not say that, my lord. They will speak.
Lord, for the last 1 month, we have
You-
sent umpteen emails.
Speak
Whichever
again.
No
council
response.
on instructions, our ಮೇಲೆ ತಗೊಳ್ಳೋದು ಬೇಡ.
ಹೌದು.
On instructions, let them sit with the council and do it.
Yes, online.
All right.
And your lords may kindly continue the interim order. Let them not use it.
Whatever order is there, that will continue.
That order, my lords, your lordship's order, my lords.
2024 will continue, that's all.
Pardon me, my lords.
Order dated 2/12/2024 will continue.
That your lordship said there. Now I am coming for that. Your lordship will go down and say, my lords.
I'll
the
take it
previous-
on 17th, you demonstrate bona fides, then I will restore the interim order.
Very well.
Let that be now coercive steps, my lords, now that.
Arrest ಎಲ್ಲ ಮಾಡಕ್ ಹೋಗ್ಬೇಡಿ, settlement ಮಾತಾಡ್ಕೊಳ್ಳಿ. Yes.
Trust me.
If there's
Good night.
anything, move the.
Allow the no coercive steps, my lords.
If-
Because now,
If
because
there is
they
anything,
are
move the
capable, he's
matter.
very capable. Yes, can take the policeman for this case. They are very capable. Therefore, your lordship's protection is required till 17th, your lordship.
You,
There was a protection till then, last day.
steady bail, why are you worried? Yes.
Please. I'm worried because police had actually gone there. My lords, that anything can happen. He's very influential.
Yes,
Therefore,
next,
your
next.
lordship may kindly continue the previous interim order. Well, still you 17th only.
17th, I will restore it with whole hog if you enter, if you just start the talks of settlement. Don't engage criminal courts with these trivial husband and wife problems.
He has filed
Yes.
a criminal case.
Whatever, next.
Please, great.
But appear for petition. But 417, my lord, 376 and like 506, 504.
Common merits ಅಂತ ಹೇಳಿದೆ ಇದೆ ಅಲ್ಲ.
House. ಮದುವೆ ಆಗಿದ್ದಾರೆ, ಜೊತೆನಲ್ಲಿ ಇದ್ದಾರೆ, ಮ್ಯಾರೇಜ್ ರಿಜಿಸ್ಟರ್ ಆಗಿದೆ. Last occasion, my lord, complaint is appeared before court through his counsel, she has said no objection to past.
We close it. The petitioner is before this court calling in question, petitioner is before this court calling in question proceedings in special case 945 of 2024 registered for offense punishable under so and so. The second respondent is the complainant. It is the case of the heard so and so Madi. It is the case of the complainant that the two, i.e. the petitioner and the complainant, were friends and had relationship which was physical as well. After physical as well on the pretext of marriage, the promise of marriage having been breached by the petitioner leads the complainant to the jurisdictional police to register a crime for offenses punishable as afore quoted. The police, after investigation, file a charge sheet. The filing of the charge sheet has driven the petitioner to this court in the subject petition. The learned counsel appearing for the petitioner submits that a consensual relationship between the two for 2.5 years is now sought to be projected to become a crime, that too for offense punishable under section 376 of the IPC. He would seek to place reliance upon several judgments of the apex court on the issue to buttress his submission that the court should quash the proceedings against the petitioner. The learned counsel appearing with second respondent complainant submits that the complainant is not willing to pursue the matter. Yakadu? Pursue the matter as she is already married to someone else and is having a.
This petitioner.
And since the petitioner is already married to someone else and has a child child born from the wedlock, the counsel for the respondent would leave the decision to the court. The learned HCGP, on the other hand, would refute the submission to contend that the petitioner should come out clean in a full-blown trial, as the offense is the one alleged under the Atrocities Act or the offense of rape, as the case would be against the petitioner. She would seek dismissal of the petition. The afore narrated facts are not in dispute. Since the relationship, not in dispute, the relationship between the petitioner and the second respondent complainant springs in the year 2022, and the relationship blossoms into, the friendship blossoms into relationship, and relationship was physical as well. It is the case of the complainant that the relationship was physical on the promise of marriage. The petitioner breaches the promise of marriage and gets in marriage with someone else. And therefore, the crime comes to be registered. Since the entire issue is now triggered from the registration of the crime, I deem it appropriate to notice the complaint dated 21/3/2024. It reads as follows, page 15 and 16. Sorry, page 15 to 17. The subject of the complaint itself is that the petitioner petitioner and the respondent were in love and on the promise of marriage has indulged in physical relationship with the complainant. The dates on which it has happened are narrated in the complaint from 2022 to 2024. The police, after investigation, file a charge sheet. The charge sheet is verbatim similar to what is alleged in the complaint, although succinctly narrated. It reads as follows, page 27, 28. The issue now would be whether the petitioner should be permitted to be tried on such acts which are consensual and on the promise of marriage or its breach. The issue need not detain this court for long or delve deep into the matter. The apex court in plethora of judgments has considered the interplay between consensual sex and the offense of rape, all of which bear consideration at the hands of this court in criminal petition 9120 of 2024 disposed on so and so. Adanna quote ಮಾಡಬಿಡಿ. In the light of the issue standing answered by the apex court, all of which bear consideration at the hands of this court in the aforesaid judgment, I deem it appropriate to obliterate the crime against the petitioner, failing which it would run foul of the aforequoted judgment and result in miscarriage of justice and would become an abuse of the process of the law and result in miscarriage of justice. For the aforesaid reasons, allowed quashed.
Seven.
I am for the petitioner, my lord. Allah is assisting in this case, my lord.
Huh?
We will call day after tomorrow, my lord. And the last case,
Respond.
Recording stack ಇದೆಯಾ? ಏನಿದೆ?
No, my lordship. It was
Offense under section
directed to
420
file a
and
report, complete investigation
Your
report.
records.
Last case, and your lordship wanted to know the investigation
Under
to what it has.
ಕೊಡಿ ಮೇಡಮ್. Multi-leap
day after
benches,
tomorrow.
yes. Day after tomorrow.
Yeah. Much.
Eight.
My lordships on Monday or Tuesday, my lordships.
No, sir. Day after tomorrow.
Your
Next.
lordship,
306, my lords.
your lordship
After-
had asked me to secure records, your lordship.
Yes.
Short accommodation. Records.
6 ತಿಂಗಳಾದ್ಮೇಲೆ ಕಂಪ್ಲೇಂಟ್ ಕೊಡ್ತಾರೆ, ನ್ಯಾಚುರಲ್ ಡೆತ್ ಪೊಲೀಸ್ ಇನ್ಸ್ಪೆಕ್ಟ್ ಮಾಡ್ತಾರೆ. The second respondent files the suit before the concerned civil court seeking injunction not to give the pensionary benefits to the first petitioner because of the death of the husband. My lord, he files a suit on
The petitioner is before this court. Petitioners are before this court calling in accused 1 to 3, calling in question. In charge sheet ಆಗಿಲ್ವಲ್ಲ?
ಏನು ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ, ಜಸ್ಟ್ FIR ಮಾಡಿ ಇಂಜೆಕ್ಷನ್ ತಗೊಂಡಿದ್ದಾರೆ. ನಾನು ಹಾಕಿದ್ದೀನಿ, ಒಂದು ಮೊಬೈಲ್ ಸೀಸ್
List on
ಮಾಡಿ.
Friday.
ಫ್ರೈಡೆ ಬೇಡ ಸ್ವಾಮಿ, ಮಂಡೇ.
List on Monday in the fresh matters list. In the event, the state would not.
ಫ್ರೈಡೇನೇ ಇರ್ಲಿ ಸ್ವಾಮಿ, ಮಂಡೇ ಜಾಸ್ತಿ.
List on Tuesday in the fresh matters list. In the event, the state would not secure the investigation papers, this court would be constrained to grant an interim order. Yes, next.
9.
Appear for the respondent.
Appearing for petitioner Swami, kindly pass over. Senior ಬಂದು arguments ಮಾಡ್ತಾರೆ.
My lord.
AVIO. Yes, after vacation. Next. Urgency ಇದೆಯಾ?
Single submission, ma'am.
ಹೇಳಿ.
They had filed an application under section 91 in the previous.
91 application da?
311, my lord. 91 file ಮಾಡ್ತಾರೆ, ರಿಜೆಕ್ಟ್ ಆಗುತ್ತೆ, ಫೈನಲೈಸ್ ಆಗುತ್ತೆ, ಅದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡೋದಿಲ್ಲ. When the matter was posted for the arguments on accused side, they came up with 311.
Pass over. Yes. Next.
10.
That 138. Check amount of rupees 15 lakhs.
15 lakhs.
At page 33.
Now, why is it not a legally enforceable debt?
Well, at page 33, please. Legal notice, please, my lord, wherein the complainant first issues the legal notice. It is dated 24/1/2022. Para 1, may I read, please, my lord?
Page?
Page 33 of the petition.
33 check ಇದೆ.
My lord, I'm sorry, legal notice, my lord, dated 24/1/2022.
33. Yeah, page number tallyನೇ ಆಗಲ್ಲ ಯಾವಾಗ್ಲೂ ಅಷ್ಟೇ. Yes. ಹೇಳಿ.
First para. My client instructs me to say that you are known to my client from past several years and both are well acquainted each other and you have approached my client in the month of July 2020. Jonas, my client approached in the month of July 2020 and requested her to pay a sum of rupees 15 lakhs for the business necessities. And subsequently, in the next page, please, my lord, subsequently on 5/8/2020, and a sum of rupees 15 lakhs was being paid to the petitioner hearing. That is the case of the complainant, please, my lord, in the first notice.
All right.
Now kindly come to second notice, please, my lord.
Page.
Page 36. They would say that petitioner herein had approached the complainant and sought for
Hand loan.
hand loan. Andre, idrali para 2 ತಾವು ನೋಡ್ಬೋದು ಸ್ವಾಮಿ.
ಹಾ.
My client represent means to state that in the month
check
of June 2018.
Check ಯಾವ್ದು, for what purpose did you give
For
the
the
check?
very, blood, what has happened? Earlier point of time, there were transactions between the petitioner and the complainant. She had paid the entire loan amount of rupees 6 lakhs. I have produced the copy of the bank statement, please, my lord, at page number 45, which is being paid to her, the complainant and her daughter. Page 45.
File your
Date-
objections.
I file objection. That is earlier transaction.
Huh?
I will file objection.
Counsel for the respondent takes time to file statement of objections. List immediately after vacations. In interim order subsisting will continue to the next date of hearing. Next.
Please.
Seven.
Petitioner will. Jammu Bandari's case, check amount 20% was there.
ಬೇಡವಾ?
May
My
request
one
kindly
to,
see the orders.
interim order which was.
One, 9/7 is the orders passed. 60 days time was given. Thereafter, extension was given by another 30 days on 10/9. Even then, they did not pay.
2 crores?
Check amount is 2.94 crores. ಇದಾಗಿರೋದು 3.29 crores.
And 10
Conviction ಆಗಿರೋದು.
10
ಯಾವಾಗ ಡೆಪಾಸಿಟ್ ಮಾಡ್ತೀರಾ?
Let's, my submission is this, the trial court, if the first appellate court will be directed to dispose of the matter within 30 days,
No.
I'm ready. Yakandre, my instructions are as such with this matter and a couple of other matters.
Instructions are not acceptable.
Alla, they're report, trying to settle the matter ante.
List after vacation. Yes.
Conviction order is of June 2024.
Yes.
6 months.
Interim order ಇಲ್ಲ ಇದ್ರೆ.
ಇಲ್ಲ.
After vacation. ಒಂದೂವರೆ ಮಾಡೋಣ.
Should matter may be taken up any day in next week.
List immediately after vacation at the request of the counsel for the petitioner. Next. ಇದ್ರಲ್ಲಿ ಯಾವುದು interim order ಇಲ್ಲ. Mandate ಕೊಡ್ತಾರೆ. ಪ್ರಸನ್ನ ಕುಮಾರ್.
5.
He was here. Yes. Notice ಆಗಿಲ್ವಾ?
ಆಗಿದೆ.
ಲಾಸ್ಟ್ ಅಕೇಶನ್ ಮಾಡಿ ರಿಕ್ವೆಸ್ಟ್ ಇದರಲ್ಲಿ PRE SCA NE ಅಂತ ಬಂದಿದೆ, ಹಂಗಾಗಿ ಕಂಪ್ಯೂಟರ್ ಅದು ಕ್ಯಾಪ್ಚರ್. SCA NNE ಅಂತ ಬಂದಿದೆ. Therefore,
Registry to appropriately print the name of Prasanna Kumar. Yes.
Friday.
File the
file.
List problem. List on Friday. Yes. Next.
14.
Passed over by 1 week. Yes, next. ಅದು ಡೇಟ್ ಬೇಕಾ? 1 week, yes. Tuesday. List on Tuesday in the fresh matters list. Yes, next. Yes, Ravi Shankar.
Split up charge sheet, your lordship's covered by judgment. Say 45 years thereafter,
Oh, that one. Yes.
even the judgments.
ಕೊಡಿ.
Manjunath's case.
45 ವರ್ಷ. 1988 crime. Allowed cost. Yes. Enter ಮಾಡ್ರಿ ಇತ್ತಲ್ಲ? Anyway, yes, next.
16.
Madam, petitioner filed a atrocity case against the petitioner. Respondent filed, respondent number 2. These also belongs to be a same community.
In the meantime, yes, next.
Please take out.
States.
States.
ಬೇಡ್ವಾ?
7.
Yes.
Next.
Petitioners, madam.
Plus complaint, my lords.
Lord, charge sheet is filed and CC is registered.
ಚಾಲೆಂಜ್ ಮಾಡ್ತೀರಾ?
Lords, there is a counter plus complaint, my lords.
ಸ್ಟೇ ಮಾಡಿದ್ದೀನಿ.
Insofar as petition number 5 is concerned.
ಅದೇ ಲೇಡಿ ಅಂತ.
Please, my
ಹ್ಮ್
lords.
ಸಾಕು.
Charge sheet ಆಗಿದೆ.
ಚಾರ್ಜ್ ಶೀಟ್ ಚಾಲೆಂಜ್ ಮಾಡಿ ಎಲ್ಲರಿಗೂ ಕೊಡ್ಬೋದು ನಾವಾಗ. ಬಿಕಾಸ್ ಸಮರಿ ನೋಡಿ. ಎಸ್.
Please, my lords.
ವಿಲ್ ವಿಡ್ರಾ ದಿಸ್?
My lords, kindly.
5 ಸ್ಟೇ ಇದೆ. ಬೇಡ. ನೀವು ಚಾರ್ಜ್ ಶೀಟ್ ಚಾಲೆಂಜ್ ಮಾಡಿ ಆಮೇಲೆ ಐ ವಿಲ್ ಪರ್ಮಿಟ್ ಟು ವಿಡ್ರಾ ದಿಸ್.
Please,
ಎಸ್.
Before that itself, my lord, before granting stay, CC was registered.
ಪರವಾಗಿಲ್ಲ. ಸೊ ವಾಟ್? ಎಲ್ಲ ಗೊತ್ತಿರ್ಬೇಕು ಅಂತಿಲ್ಲ ಕೌನ್ಸಿಲ್ಸ್.
ಇಲ್ಲ ನಂಗೆ ನಿನ್ನೆ ಇನ್ಫಾರ್ಮೇಶನ್ ಗೊತ್ತಿಲ್ಲ.
ನಿಮಗೆ ನೆನ್ನೆ ಬಂದಿದೆ.
ಹೌದು.
ಎಸ್. ಅದು ಚಾಲೆಂಜ್ ಮಾಡಿ ಮೂವ್ ಮಾಡಿ.
Please, my lords.
ಎಸ್.
Grateful, my lords.
ಪ್ಲೀಸ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್. ನೆಕ್ಸ್ಟ್.
18.
ಅಲ್ಲ ಇದು ಲಿಸ್ಟ್ ಆನ್ 18th ಅಂತ. ಲಿಸ್ಟ್ ಆನ್ 18.
But it's freeze the bank accounts of the petitioner.
Yes, government.
They were stated in the last date of hearing, my lords, all the,
Oh, this matter. No, sir.
all the complainants' bank accounts has been freezed.
List immediately after vacation. Yes.
So I may be permitted to, if they are agreeable, my lords, my client is inclined to create a charge on one of the properties.
It's fine. Move it. We'll close it later if they are, if you are doing it. ಎಲ್ಲಾದ್ರೂ ಲೀನ್ ಮಾರ್ಕ್ ಮಾಡಿ ಚಾರ್ಜ್ ಕ್ರಿಯೇಟ್ ಮಾಡಿ ಅಷ್ಟೇ. Yes.
But the other complainants, they have not even made them an accused or they have not,
Then let it come immediately after vacation. Yes, next.
in the meanwhile, I may be permitted to move the matter if they are,
If they do it, you move the matter.
okay,
Yes.
great.
19.
Pastor, your lordship, senior is in VC.
Attica Gold matter, madam.
Attica Gold.
ಗೊತ್ತಾಯ್ತು.
Attica Gold.
Pastor, your
Now,
lordship.
the petitioner.
I
As by
request
trust,
Pastor, your lordship.
the various notices
time
have been issued
also-
now by following strict rules contemplated. Now, it doesn't challenge that under 482. It challenges under 226 and get a stay.
ಓ ಸ್ಟೇ ಆಗಿದೆಯಾ?
Yes.
ಹೌದು.
ಇಲ್ಲಿ ಪ್ಯಾಟ್ರಿ ಪೆಂಡಿಂಗ್ ಇತ್ತಲ್ಲ.
ಇಲ್ಲ. Pastor, your lordship.
Passover.
ಅದ್ರಲ್ಲಿ ಒಂದು ನೋಟಿಸ್ ಕ್ವಾಶ್
ಸ್ಟೇ
ಆಗಿದೆ.
ಆಗಿದೆಯಲ್ಲ ಬಿಡಿ.
ಒಂದು ನೋಟಿಸ್ ಕ್ವಾಶ್ ಆಗಿದೆ ಅದರಲ್ಲಿ.
ವಾಶು ಆಗೋಯ್ತಾ?
Yeah.
Yes. ಯಾ? ನೋ ಯಾ? Yes. List after vacation. ಅಲ್ಲಿ ಸ್ಟೇ ಆಗಿದೆಯಲ್ಲ ಏನ್ ಮಾಡ್ತಾರೆ?
ಅಲ್ಲ, ಬೇರೆ ಕೇಸ್.
ಇದ್ರಲ್ಲಿ ಸ್ಟೇ ಆಗಿದೆ.
ಬೇರೆ
ಬೇರೆ ನೋಟಿಸ್ ಶ್ರವಣ ಬೆಳಗೊಳ.
But after vacation. Next.
Parted, lordship is heard.
ಇದಾ?
Further hearing.
ಲಿಸ್ಟ್ ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಇಲ್ವಲ್ಲ?
ಥರ್ಸ್ಡೇ ಮೇ.
ಆಯ್ತು ಲಿಸ್ಟ್
Further
ಆನ್
hearing.
ನೆಕ್ಸ್ಟ್ 19.
19.1, Lord. 19.1, Lord, has become infructuous. On the other day, Lord.
ಪರವಾಗಿಲ್ಲ. ಲಿಸ್ಟ್ ಸೀರಿಯಲ್ ನಂಬರ್ 19, ಲಿಸ್ಟ್ ಆನ್ 19th. Yes.
ಮಚ್ ಒಬ್ಲೇಜ್ಡ್.
Next.
20.
Round of litigation ಇಲ್ಲ. ಒಂದೊಂದಿದೆ, discharge ಒಂದಿದೆ. Discharge ಆದ್ಮೇಲೆ ಎರಡಾಗಿದೆ, ಮೂರಾಗಿದೆ. This is not.
ಏನಿದು?
My lords, this is a matter pertaining to wire tapping, my lords.
Wire tapping.
My lords, probably covered by my lord's decision in Mannan's case.
Clear order.
Can I
ಹಾ,
just,
ಹೇಳಿ.
if I'm able to? My lords, the petitioner, he was a law student, my lords, at the time of incident. Allegation against him is he mediated between A1, who was the then vice chairman of the Bar Council, with a law college. Allegation is that of my lord's PC Act.
Started his practice.
My lords, he was a mediator. So my lords, his conversation gets tapped. And my lords, he files a 482 before this honorable court.
How did it get tapped without permission?
That's the point, my lord. So he filed a 482 before this honorable court.
Page.
And the first order passed by this honorable court is at page 291, where my lords, they withdraw it with liberty in the event the trial court would rely on it.
It's
My lords would get it.
my order.
No, my lords, just before my lord's order, there's one more order at page 291.
There is Justice
coordinate
Vishwesh
page.
Shetty ಅವರ order.
ಹೌದು, 291 ಅಲ್ಲಿ. Kindly notice this order, my lords. They would say that in the event, the trial court relies on
No,
the.
because it was without approval from the review
Yes,
committee.
my lords, at that point of time. Then comes my lord's order.
Withdraw
at
ಮಾಡಿದ್ರು.
Page 294. My lords also felt in view of what liberty that has been given earlier. Now, my lords, when PW 28 is being examined, page 26. He's a deputy superintendent of police, CBI. At page 28, when the CD was sought to be marked, my lords, objections that were raised on the admissibility of the CD. Now, what the court to do is, instead of answering it whether it is an admissible document or not in view of the Telegraphy Act, court would merely postpone it to say we will consider it during the final hearing, which in my respectful submission is not permissible if it is on admissibility. My lords would notice at page 28 is where the
So
marking
it
took
is, then I've written all this in Mandan's case.
out. That's
Hmm.
what, that's the reason. we're here.
Wiretapping is illegal without permission.
That was the stage, not prior to charge. Charge agi, evidence agi,
ಹೌದಾದ್ರೂ
now they are
ಅಷ್ಟೇ.
requesting.
Sir, if
not-
you have built your case on wiretapping and wiretapping is illegal.
No, that is not
without-
only one part of the evidence,
No,
not
one
the
part
whole.
If the entire thing has sprung only from wiretapping, everything will fall lock, stock, barrel. Because that is the foundation. You have built a superstructure on a faulty foundation. Foundation
But
goes.
this, not in that case,
Structure
not,
falls.
it is for central government, not, we also party in this decision to say, not whether this things were not were placed before the review committee.
Yes, central government party idara.
ಹೌದು.
Yes, party
Yes,
ಇದೆ.
Rajಶೇಖರ್. Review committee ಮುಂದೆ ಹೋಗಿತ್ತಾ ಇಲ್ವಾ?
Lords, yet to receive the instructions, my lords.
Hmm.
Statement of objections are also, my lords, being prepared, para of
Hmm.
remarks.
Because I have said all this in Mandan's case.
Please, please, that is.
I seek indulgence.
They
of
can
the-
ascertain, my lords, and come back. I'm not pressing on any interim order.
What
Let
sir,
them-
this case, President Nixon could not survive wiretapping. Yes.
Well, date is given and they ascertain and
Yes.
inform the court, my lords.
We'll take this on 7th December at 4 PM for the hearing.
Please,
Yes.
oblige.
Sorry, 7th January 2025.
7 January.
January, December ಆಗೋಗಿದೆ 7th.
Please.
7th January 2025 at 4 PM for further hearing.
Oblige.
Objections, if any, by then, the parties are directed to file a short synopsis of the list of dates and events and list of authorities, if any, that they are wanting to place reliance upon.
Please.
Yes, next.
21.
MMDR,
Yes, no, it's quarrying, he claims that he has a quarrying license.
yes.
It is in survey number 140.
ಈಗ ಮಾಡ್ತಿರೋದು ಯಾವ್ದು 141 ಅಲ್ಲ?
I have places, my lord, where not
License.
just one place, there are different places.
I have
where-
no license.
You have no license.
So your lordship may kindly see the allegation in the complaint. my lord.
Hmm.
It is at page 23, my lord.
We'll continue,
Complaint is filed against
we'll continue at 2:30. Yes.
230.
Yes. A pronouncement ತಗೊಂಡ್ಬಿಡಿ.
Please, ombudsman,
ಒಂದ್ ನಿಮಿಷ, there's some
It's number 3,
pronouncement 115
I'm
minutes.
sorry.
announcement of
2
order.
minutes, same orders ಎಲ್ಲದ್ರಲ್ಲೂ. BB Patil, Latif, same ಅದೇನೆ. Whatever I have passed earlier.
One.
Allowed cost.
Number 2.
ಎಲ್ಲ PC Act ತಾನೇ ಕೇಳಿ, ಎಲ್ಲ PC Act. ಎಲ್ಲ PC Act ಅಲ್ವಾ? ಎಲ್ಲ allowed cost.
Please.
Same order. Whoever counsels are appearing, yes.
23 list 2. The matter is remitted back from the honorable.
Appealing for the respondent, my lord. Appealing for the
Supreme
respondent.
Court.
Wapas
Yes.
ಆಗಿದೆ, PMLA matter.
My lord,
ಯಾವ್ದು ಕೊಡಿ?
23 my lords.
Next matter ಕೊಡಿ madam.
ಇವತ್ತು information, I have not got the details, what has transpired.
ಇವತ್ತೇ ಡಿಸ್ಪೋಸ್ ಮಾಡ್ಬೇಕು ಅಂತ.
ಇಲ್ಲ. ನನಗಿನ್ನ details ಬಂದಿಲ್ಲ, Supreme Court order ಇಲ್ಲ. I will look into it and I will.
the order is passed on 15th October 2024, my lord. And the Supreme Court has requested this honorable court to consider one more aspect. That is what the Supreme Court is requesting this honorable court is that, my lord, whether the acquisition of the property has taken place prior to the commission of the offense. If the prior to the commission of the offense, there is an acquisition of the property, then it is not a proceeds of crime. Serial number 1 to 6 of the
I
provision.
dismiss this. Dismiss
Yes,
ಮಾಡಿದ್ನ?
ma'am.
But Your Lordship
Yes,
was to dismiss the matter. Glance had taken it to the honorable Supreme Court. ಇವತ್ತು ಬಂದಿದೆ.
Not being
Don't-
at when time is so and so, admitted the aspect has not been considered. Admit the matter back for reconsideration.
A date may be fixed, ma'am.
Liberty is given to file a fresh petition.
For accused number 1, petition number 1.
Who is that?
His petition has been dismissed,
Details
ma'am.
ಕೊಟ್ಟಿಲ್ಲ ನಂಗೆ. I will get the details, madam.
May I make one
Two-
submission, my
there were
lord?
two petitioners.
Well, my lord.
Yes, my lord.
Two petitioners.
Total 11 properties were attached, my lord. It is the contention of the petitioner that 6 properties were acquired prior to the act coming into force. And the other properties, my lord, they have acquired subsequent to the implementation
Which
of
is the one
private act.
disposed on 27 September 22?
Same petition. My lord. The
Same
both
petition.
1 and 2 were there. my lord.
Idena. Both. Oh, following Bhavna Dibur.
Yes, part of the.
That is now reversed.
And
We'll
you
see,
also
we'll hear it
followed
afresh.
On the date fix, I will also get.
Anyway, I only have to hear it. Because it was dismissed by me.
Next week.
Anyway,
Any
there-
Serial number 22, my lord.
one ನಿಮಿಷ. List this matter on, Madam, 18th at 3:30 PM.
Very well.
My lord,
We'll rehear it as per the directions of the Supreme Court.
Very well.
List on 18th ಹೇಳಿದ್ನಲ್ಲ, at 3:30 PM.
ಅಸಲಿ ಅದು ಇನ್ನೊಂದು ಹಾಕಿರ್ತೀನಿ.
ಅದು ಯಾವ್ದಿದೆ ಅದನ್ನು ಅವತ್ತು ಅದೇ ಬಂದ್ಬಿಡ್ಲಿ. Yes.
Serial number 20.
Allah, my lord, may I make one submission? If they provide advance copy in the other connected matter, my lord, it would be convenient for
I will
me.
do that.
ನಾಳೆ
The
ನಾಡಿದ್ದು
moment I
ಕೊಟ್ಬಿಡಿ.
file, I will furnish
Yes.
a copy.
Do it, yes.
So it can be disposed of 18th.
Yes,
Very well.
it will be heard.
Sorry, it will be, sorry.
List serial number 22, my lords.
In this matter, my lord, we are seeking for an permission to travel abroad. Let
Ah.
me file an itinerary, my lord.
Affidavit ಹಾಕಿ.
Please, my lord.
Day after tomorrow, my lord.
You affidavit of itinerary.
Please.
ಅಲ್ಲ, itinerary along with an affidavit you file will permit you. Day after tomorrow.
Great.
22 list day after tomorrow.
My lords. Serial number 32, my lords. The respondent number 2 and 3 also need.
Madam, ಯಾವ್ದು adjournment ಬೇಕೋ ಅದು ಕೊಡ್ತೀವಿ. You ask the court officer. Whoever wants adjournment in any case,
The learned HCP want to take
ಇಲ್ಲ
notice of 2 and
ಕರೆದ್ಬಿಡಿ
3
madam.
also.
First list page wise ಕರೆದ್ಬಿಡಿ. Wait.
Page 4. 24 to 28.
First list, huh?
24.
Second list, yes. Yes, second list, page 4, anybody adjournment?
Page 5. 29 to 34.
33, serial number
Ah.
30. Needful has been done.
Then at council submits needful has been done, office to verify, list after vacation. Next.
32, my lord,
Yes, Anish,
my lord, the HCGP has to take notice for R2 and R3 also, my lord.
then at HCGP is directed to accept notice for respondent 2 and 3, thus completes the service of notice. Interim order,
No, my lord.
list after vacation, yes. Next.
Assistant. It is for passport permission, renewal of passport permission.
ಏನ್ ಮಾಡೋದು? ಮಧ್ಯಾಹ್ನ dispose ಮಾಡೋಣ. We'll dispose it, direct him to give an application. ಆಯ್ತು, day after tomorrow, ಮಧ್ಯಾಹ್ನ ಬೇಡ. Yes.
Serial number 28, my lord.
28. Connected matters, Nishit,
Meeting order first.
Huh?
Meeting orders and they.
that will pass an order. Post immediately after service of notice upon the respondent. Interim order ಇದ್ರೆ continue ಮಾಡಿ. Yes, next.
29, my lord.
29. Yes. ಅದು ಅದೇನೆ. Yes.
Page 6. 5 to 40. Page 7, 41 to 49.
47, my lords.
ಒಬ್ಬೊಬ್ರೆ.
41.
41 ಏನು?
I'm paying some time, my lords,
After vacation.
after vacation. Kindly. My
Serial
lord,
number-
second week, if.
No, after vacation ಅಷ್ಟೇ.
Serial number 47, my lords. Serial number 47, my lord.
42 ಇಂದ 45 ಯಾರಿಲ್ವಾ?
38 is.
30ಗೆ ಹೋಗ್ಬೇಡಿ. 40ಗೆ ಬಂದ್ಮೇಲೆ 30ಗೆ ಹೋಗ್ಬೇಕು. ಆಮೇಲೆ
47, my lord.
40?
42, my lord.
ಏನು?
For weeks time, my lord.
You have informed the other side? If the other side objects in any case, I'm going to take up. Yes, after vacation, yes. Interim order ಇದ್ರೆ continue ಆಗುತ್ತೆ.
Serial number 47, my lords.
43 ಇಲ್ವಾ ಏನು? 47, yes, ಏನು?
I'm for second respondent, my lord. I file a wakalat on
Then
yesterday.
at council, so and so submits that he
Permission
has entered appearance for the second respondent registry to print the name of so and so as appearing for the second
Permission.
respondent. After vacation, next.
Kindly to date me. And no stay, my lord.
Huh?
Date me, please, my lord.
After vacation, sir. Yes, next.
Page 8.
38, my lord.
30ಗೆ ಬರಲ್ಲ ವಾಪಸ್, wait sir.
57.
50?
Not accommodating.
All right, 50. After AVIO, yes, next.
Serial number.
Page 9, 58 to
Second list.
60.
60, my lords. Serial number 60.
Settlement.
Settlement, my lords. It may be tagged along with criminal petition 12826
When
of
do you want it?
24. Day after tomorrow, my lords. On 12th, my lords.
Yes, list on so and so.
12th.
12th is day after tomorrow, na?
Yep.
Ah,
Yes.
oh, yes, okay.
Obliged.
Yes, tag the petition along with so and so and list to report settlement.
Page 10, 3 to page 11.
Adala further hearing matters. Yes,
This one for me.
a list one.
This one. Page 8, 52 to 55, page 9. 56 to 63, page 11. 54 to 72, page 12.
ಅಷ್ಟೇ ಸಾಕು. ಮತ್ತೆ ಯಾರು ಕೇಳಿದ್ರೆ ಕೊಟ್ಟಿರ್ಬೇಕು.
Well, at least two, serial number
38 ಹೇಳಿ.
38.
38. ಮಂಡೇಗೆಲ್ಲ ಇಲ್ಲ.
Friday.
ಫ್ರೈಡೇಗೂ ಇಲ್ಲ. ಏನಿದು? ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಬರ್ಲಿ ಬಿಡಿ.
Well, stay ಇಲ್ಲ ಇದ್ರಲ್ಲಿ. Notice
ಇದೆಯಾ?
ಇಲ್ಲ ಆಗಿಲ್ಲ, stay ಇಲ್ಲ.
ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಬರ್ಲಿ.
ಬೇಡ
ಮಧ್ಯಾಹ್ನ ಬರ್ತೀರಾ?
ಇಲ್ಲ ಏನಿಲ್ಲ.
ಹಾ ಸರಿ ಇರ್ಲಿ. ಹಂಗಾರೆ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಇರ್ಲಿ.
38. 14 ಅಲ್ವಾ?
Let's call that, it's 82.
What is it, 230?
Your lordships, again, that notice, your lordship had issued notice in the,
Where are the records?
my lord, insofar as,
Lokaयुಕ್ta,
in
yes.
fact, they have filed an application for, I think Mr. Dave is online.
Application for what?
Lord,
I have moved an application for adjournment before your lordships because of the.
No, there is no stay, sir, before the division bench.
I entirely agree, my lord. If your lordships want to proceed, I will assist you.
Yes, sir.
It's my duty to Lord tell your lordships that appeal has been, notice has been issued, it's fixed for hearing. And
Yes,
we
sir.
have challenged both
No,
your lordships.
You did not seek a
substantially.
stay of the order before the division bench?
We did, the division bench said no. In fact, division bench asked Mr. Raghavan in open court that what will be your response before the learned single judge on the next date. But anyway, that's apart. If your lordships are so keen to hear this matter, I can't, Lord.
No,
I
it's
will-
not the question of keenness, but since it is listed and I had already directed.
Process
Yes,
is not, service is
that's
not
true, my lord.
complete.
That's true, my lord, but a
Will-
division bench has taken
Who has to be heard?
cognizance.
Who has to be served?
Respondent number 9, 10 and 11 are yet to be served.
Who are 9, 10 and 11?
The 9,
Well, that is, my lord, the respondent
Why-
number 9, my lord, is the chief minister.
his wife.
10, my lord, is his wife, and 11 is the brother-in-law.
Huh.
And that's all been paid, my lord, I think.
Why don't you convict them, Mr. Raghavan, right here, without hearing anybody? What is all this happening? 20 years later, you file these proceedings and you
No,
want
those
decided
those
post
proceedings are over. It is before the division bench. Let
Yes.
us not go back in time and consider, hear whatever
but
has
what-
happened in that
No,
case.
Lord, here the Lokayukt court was moved at his instance. Lokayukt
No,
court has
true.
passed an order.
No, that's why, where are the records?
My lord, can I,
One other thing, my lord, your
can I
lordship may
make,
kindly
may
take,
I have the
your lordship may
petition
kindly
to the
take.
case, and let me tell you, lordship.
All right. Yes, on
Lordship, it just-
what is your
court
ground
officer.
that you are seeking to transfer, sir?
My lord, the reason, my lord, is only this much. My lord, in fact, my lord, the reason is really what your lordships have said in an earlier judgment, my lord, where your lordships refused to transfer.
Refuse to transfer?
Yes, that is, my lord, in the Reserve Bank case.
All
Your
right.
lordships refused, but kindly see what your lordships have said at para 17.
Is that your only ground?
My lord,
Is that the only ground?
my lord, this is one of the ground. I tell you, let me point out what we have said. This is one of the ground. Kindly now see, my lord, what your lordships have said at para 17.
Hmm.
My lord, it's not a question of what the result of the investigation will be. The question, my lord, is that every investigation must inspire public confidence. And it is a matter of viewing the public confidence from the point of view of the circumstances of the case. So, my lord, kindly see what your lordships have said, para 17. And I believe, my lord, that this case falls fully within the scope of what your lordships have said in para 17.
Hmm.
It is a matter of record that a sitting member of the Legislative Assembly and certain high functionaries are allegedly involved in the alleged misappropriation of funds. When ministers or high functionaries who are involved in particular allegations and those allegations are being investigated into, such investigations must be entrusted to independent agencies which are not under the control of the state government. And it is only then it would instill public confidence in the investigation or provide credibility to such investigation. But that cannot be an interpretation of section. So that's it. Then your lordship according to the provisions of the Reserve Bank of India Act. I'm not concerned.
35A cannot.
That's it.
stretch
I'm
that.
not going to worry. I'm not going to trouble you. But the whole emphasis, my lord, is that here is the chief minister of the state who is directly involved in the matter, according to us. And then, my lord, 17A permission has been upheld, granted to
That
the
is,
governor.
that is
That's it. The appeal, my lord, we are not concerned with that. Now, today, my lord, all that we are saying is, let this matter be entrusted to an agency which is not under the control of the state government. And that is the reason why, my lord, your lordship said, let me see the investigation. What you have done. Lord, please see the investigation. Ultimately, my lord, whatever I may say, that it should be transferred to an agency outside the state and not under the control of the state government. My learned friends may oppose it. Your lordships are fully aware of the facts of the case because your lordships have heard this matter, my lord, for days and days.
Ultimately, my lord, it is a
And I
question
have
of
been
how your
condemned,
lordships
I have
feel.
been
1
condemned
minute,
without
let me
hearing.
complete. I mean, I am, please.
Respondent number
What is
12
this?
has
I'll
been
get back to you,
condemned
sir.
on suppression by Mr. Raghavan's clients.
The way, sir, I'll
On
get back to you, sir.
suppression.
Mr. Dave, I think I am entitled to
Lord, I
be
was
heard
entitled
completely
to
without
Mr.
interference from you.
Raghavan. You should have joined me
Please.
as a party in the first round. You have
Why,
obtained an
why
order
don't you have your
against
say
my
when your
back.
turn comes, not interrupt me?
Against my back.
Please.
Please tell
I
the
mean, this is
court
not
that.
this is not the way in which done, my lord.
Clearly
I
tell the
strongly
court.
object to what my learned friend does.
All right. Yes, you continue. I'll get back to you, sir.
Yeah, let him have his say. I will not interrupt him. He
Yes.
can be assured about it. My lord, your lordships are fully aware of the facts of the case. Therefore, my lord, I don't think I want to detain your lordships into telling your lordships what the facts of the case are, independent of what your lordships' findings are. Now, my lord, the only question, therefore, is as to whether your lordships think that this is the case where, having regard to the transparency in investigation and public confidence in investigation, whether this is a matter which should be entrusted to the agency like CBI. Now, it's ultimately the court's view, my lord. So, however much I may say it should be done, however much my learned friends say it should not be done, ultimately, my lord, it is not a case where we are trying to educate your lordships on what the facts of the case are, because I think your lordships knows the facts of the case fully. Now, therefore, my lord, my respectful submission is your lordships. Therefore, my lord, in order to satisfy your lordship that the investigation is going on the right lines, not the conclusion of the investigation. That, of course, my lord, your lordships are not concerned with it. None of us are concerned with it. In order to ensure that the investigation is not being procrastinated, in order to ensure that the investigation is going on the right lines, your lordships ask the state to produce before your lordships, in order that your lordships may be satisfied, the investigation record. Let them produce it.
Well, let them comply with the office of objection by service of everybody. Before he starts arguing, let the process be complete. Your lordship, we should notice.
This is the whole object.
Yeah, with your lordship's permission, Malad, have word.
sir.
Is it
Yes, sir.
possible? Malad, there are three issues that
Sir,
arise.
you're appearing for?
I'm preparing for the
State.
state, Malad.
Yes,
I'm
sir.
appearing along with the
Yes, sir.
affidavit. Malad, there are three issues that arise.
Yes, sir.
Number one, Malad, no proceedings for transfer of any investigation can take place without the presence of those who are alleged to be accused in the case.
Yes, yes.
That's number one.
Yes, sir.
No, before such a thing can be argued, Malad, they have to be present in court.
All right.
Number
Now,
Number
only R12 is represented, 9 to 11 are not.
That's what I'm saying, Malad. So everybody has
Yes.
to be present, Malad. That's all I'm
Yes.
saying.
Yes.
Number two, Malad. The matter is pending before the division bench. Of course, there is no stay, and your lordships mentioned it in the morning.
Yes.
But my request to your lordships is let's assume, Malad, your lordships is inclined to or transfers the matter to the CBI.
Yes, sir.
Our appeal will become infructuous.
No, your appeal is not to transfer to the CBI?
Yes, their
Which
appeal.
appeal?
One appeal.
There is-
Lord,
Again,
one
your
of my
lordship,
appeals.
notice was issued and call for records.
Your appeal number
But
1719.
the main appeal is not for transfer of the
No, no,
CBI.
no.
No,
that-
1719 is.
Yes.
All right.
That will
And that is
become
noted,
infructuous.
The
That will
order.
become
No,
Justice-
that should have been told to the division bench, and division bench should have pressed for an interim
No, the
order.
division bench said you mention
They
it to the next single judge. I'm sorry, but I was there. Therefore, I'm saying this.
Yes.
The division bench said, please mention it to the learned single judge. Right? That's the second issue, Maharaj, that I wish to
Yes.
raise.
Yes, sir.
The third issue, which is even more important, is, Maharaj, at this point in time, Maharaj, the problem is there are many constitutional issues involved in this, Maharaj, which have been indicated by me in the appeal, Maharaj. It is my humble request to your lordships, Maharaj, that heavens are not going to fall, Maharaj, because the investigation is going on by the Lokayukt. Heavens are not going to fall if your lordships adjourns this matter so that the appeal court can decide. Or if your lordships think that your lordships wants to continue with the matter, then, Maharaj, this application that has been moved should be rejected formally, Maharaj, so that some
Which application for adjournment?
Yes, it should be rejected formally, so
Yes.
that Maharaj, some action can be taken. These are my three requests to your lordships, and I leave it to your lordship.
Yes.
In any case, this cannot continue till such time as everybody is present. And number four, Maharaj, is a request, Maharaj, to the other side. They made some personal allegations against the Advocate General, Maharaj.
Personal allegations where?
Kindly see, Maharaj.
They are sending letters and they are published in newspapers
What
saying
personal
you are
allegations?
biased. They are biased, and it's very unfortunate. Litigation of this nature should be fought, Maharaj, on a level playing field, Maharaj, as litigation should
What
be
is
fought.
this? Your petitioner?
Your lordship, can you see next document, Maharaj?
No, Raghavan sir, I think you should ask your client to encourage
Of course, my lord.
restraint.
But I didn't know.
No,
I
but
didn't
it's
know.
not
Matter
like
is sub judice.
Of course, my lord. I agree, my lord.
Matter is
I
sub
don't
judice
think,
and
my lord,
these
I don't
things should
think,
not.
I don't think I am going to even whisper a defense. If
Malad,
this has been
number-
done by my client, it is improper and I'm going to tell him that he should not do it.
Number 4, Malad, this is
I
important.
agree, my lord. I agree with my learned friend and I bow down to what your lord was saying.
Number 4, Malad,
All of you, the parties, stakeholders should encourage restraint.
Well, I
So
didn't know,
matter
my
is
lord.
sub
In
judice,
fact,
we can decide
I
it.
got to know
Yes.
about it only now. We didn't know it all.
Yes.
Malad, number
in fact, my
4,
lord,
one second.
on behalf of the petitioner, I apologize to my lord.
No, that doesn't
Not
matter.
it, no, I mean,
Number
except
4,
this-
No,
Malad,
it should not be
I'm a
done.
learned friend, Malad.
It should not be done. I agree, my lord. It should not be done. No, no.
Malad,
Yes.
I have, there is another application, I believe, that has been filed for making an ED the party in these proceedings. Malad. If such an
Not
application
listed, my
is
lord. It's
taken
just
on
been
record,
filed.
Malad,
We have filed it.
yes.
We have filed an application to
Just-
implead the enforcement directorate also as a party to.
in which case, Malad, we
No,
will
it is
have
not
to
listed.
file a reply. I'm just
I
let
got
me.
it.
All
Of
right,
course.
all right.
In which case, we have to file a reply to that application.
Of
Malad.
course.
We strongly object to it, but we'll give our reasons for that. Malad. So therefore, these are the 4 reasons I have, Malad, which I want to place before your lordship.
So we will consider one by one the submissions and I'll pass orders. Now, the first thing is they have to be served. I asked the counsel to take notice. He said he will not take notice. So anyway, serve them by hand summons.
The petitioner will have to do.
No, 9 to 11.
No, the petitioner will have to serve.
No, that's true. I'm not asking you.
Now,
The other day, Shivana was present. I asked him to take notice. He said, he took notice and came to me. No, no, I don't want to take the risk of taking
Petitioner
notice.
is taking, advocate general is taking
My lord,
notice.
in the writ appeal, my lord, filed against the order issuing notice, my learned friend has taken notice is what I am given to understand.
Yaru?
For the state.
Nivala, sir. Yeah.
Very good.
Private parties, already they are represented.
ನಾವು ಈ ಕಡೆ ನೋಡ್ತೀವಿ ಯಾರಿದ್ದಾರೆ ಇಲ್ಲಿ
ಯಾರು ಅವರಲ್ಲ
ಅಲ್ಲ ಇಲ್ಲಿ ಯಾರು private parties
ಯಾರು
ಇಲ್ಲ.
ಇಲ್ಲ ಇಲ್ಲಿ
ನೀವಲ್ಲ ಸರ್ ನೀವಲ್ಲ.
No, where is, will direct and to be served by way of hand summons. Because on the other day I asked him, then he took notice and he said, I won't take notice.
I remember.
That's all right. Yes. The first submission. The learned counsel, learned senior counsel KG Raghavan would make his preliminary submissions. The learned senior counsel Kapil Sibal, representing the state, would submit that the matter cannot be taken up for the reason that the prayer that is sought is for reference to the hands of the Central Bureau of, reference of the investigation to the hands of the Central Bureau of Investigation, and respondents 9 to 11 against whom this said direction is sought are yet to be served. And therefore, the service of notice should be effected at the outset for any submission to be even considered, albeit preliminary. Therefore, I deem it appropriate to direct the petitioners to serve the respondents 9 to 11 by way of hand summons.
Can I make one submission, my lord? In the writ appeal that has
Or-
been filed, they are represented, there is an order that your lordship passed last time, my lord, issuing notice. In that writ appeal, these respondents have been represented
No,
by
ma'am.
counsel.
No.
One minute.
Not correct.
Sir, orders ಇದೆ.
But I have filed, Mr. Raghavan.
ತಗೊಳ್ಳಿ.
All right, if somebody is accepting
Somebody
notice,
accepted, my lord.
ಅದಲ್ಲಿದೆ.
it is the learned senior counsel KG Raghavan at this juncture would submit that against the order dated 5/12, 5/11/20, 5/11 adu, 5/11/2024, a writ appeal is preferred in writ appeal.
1719 of 24, my
Writ
lord.
appeal 1719 of 2024. 1719 of 2024. And the councils, and he would request that the councils representing the appellants therein can be served upon.
Correct.
It is open for the petitioner to serve on the councils who represents the appellants. Appellants.
Not appellant, my lord.
No,
Appellant
not
is
appellant.
one.
The appellant, my lord, is only respondent number 12.
Then
They
who-
are now talking about respondents number 9, 10 and 11. But
They-
they are also respondents in that writ appeal.
are they represented there?
Yes,
they
answer to your
accepted
lord's question
service.
is yes.
By whom?
My lord,
They accepted service.
They accepted, is it?
yes.
Hello, who are the councils?
Who are the councils? Give me the names, no?
I think
Mr.
Mr.
Satavish Shivanna,
Of course, I told him only to take notice. He took and he wriggled out of it later. It's all right. Yes.
ತಗೋತೀರಾ sir?
ಶಿವಣ್ಣ ಇದಾರ ಇಲ್ಲಿ?
He is not here.
He is not here.
Hmm.
He is represented, my lord.
Yes, you can serve on him. If he accepts it, fine. Otherwise, hand summon.
Okay, very well.
Apart from the advocate on record is permitted to serve on counsel Sri Shatabdi Shivanna, who is said to have accepted notice for the respondents 9 to 11, who are respondents in the writ appeal as well. The next submission. What was the next submission?
Adjournment.
Adjournment, application.
Now,
ED
we
has
have
filed
made an
1 minute.
application to impede.
Yeah.
ED, man.
They have made
ED.
an application.
Allah,
for-
ED application, the learned counsel, who has filed, you have filed the
Yeah.
application. The learned senior counsel KG Raganu would submit that he has filed another application seeking impleadment of the enforcement directorate into these proceedings. The learned senior counsel Dushan Dave and senior counsel Kapil Sibal would seek time to file objections to the said application seeking impleadment of the enforcement directorate as party respondent to these proceedings. The objection, a week's time, sir?
Whatever is reasonable, Malad.
A week's
Lord,
time,
they
therefore,
they have taken 20 years to come to your lordship's court. Kindly grant, Lord, sufficient time. Lord, there is no hurry. Your lordship
all right.
knows this is all in
No,
the
we'll
realm of
do
politics.
it. Well, for application, objections to the application should be enough, sir. Yes,
I must say
a
one
week's
thing.
time is granted.
Lord,
to
one thing
file-
to correct the order. I don't
Sir.
think, Lord, notice was accepted in my matter on behalf of respondents, concerned respondents, Lord. Only
That is
emergent
what-
notice was issued to 9 to 12. So council's
fact,
name is
what
not
happened
mentioned.
Then serve it by hand summons.
Yes, I just.
If they accept, well and good. If they
Order
don't, we'll
comes
send it
correctly.
back.
Then
Your
affidavit.
lordships have said it. I'm not able to fathom my learned friend's objection.
That's all right.
No,
Why
the
is-
order, Mr. Raghavan, I am only pointing out what is recorded in the order. Please
Very
keep the order
Yes,
ready.
that's
Division.
all right. So and so. The objections to the said application be filed by the next date. The list this matter on what date is 10th, alwa?
Let
List
it
the
come up
matter
after
on
25th.
18th December.
25th, Lord,
Sir,
day 18
20
December.
From 20th, we are on vacation.
Lord,
Caribbean
kindly
17th.
keep it post vacation, Lord. There is no great
That
urgency.
we'll do it on the next day if it's needed.
17th.
No,
List
why,
the
Lord?
matter on 17th at 2:30 PM. Objections, if any, only to the application seeking impleadment of the enforcement directorate as party respondent to these proceedings. The
Well, that's
learned counsel representing the Lokayukta was directed to place on record the record of investigation that has happened till the date on which it's taken up.
Earlier 26/11.
Malad, can your lordships have it on the 18th, not 17th, Malad, if your lordships
All right,
don't?
18th. 18th, all right.
I had also indicated to your lordships, Malad, that if your lordships takes up the matter and passes any final order, it would render the, according
No,
to me.
I'll consider that on 18th.
Lord,
Oh,
I have
Because let
personal
the
difficulty.
others be served now.
Lord, I have personal difficulty after 17. Could your lordships keep it in reopening?
No,
Because
sir,
I would like to be
we'll-
personally present. This is not a
on-
matter which
on
can be
that day-
argued virtually.
On
It
that
can
day,
be
we will do it, sir. Let the objections come.
I have some difficulty on 17th.
17th, 18th, all of you have
18th.
difficulties. We'll keep it on the 19th.
Lord, kindly keep it post vacation.
No, one day before the vacation, we will keep it, sir. If it is needed, we will adjourn it beyond the vacation.
Lord, needed? It is needed, my lord. I can,
We'll see on, we'll
I
see
can
on that day.
respectfully submit it is needed, my lord.
No,
We
we'll
will
see
have
on
to-
that day, sir.
Lord,
We'll
I
get-
have to dig out the whole record of last 24 years to save my client.
No,
because
this is,
your
this is,
lordship's judgment
sir,
has
this is
hurt
a
us.
case, this is a case where we are not rehearing the earlier matter. This is a case where whether it has to be transferred or not transferred, that's all.
No,
No,
Malad,
but that can be done.
The scope
It's
of this
not so
petition is
simple,
not
my
what
lord.
is being urged in the appeal.
no,
no.
there is, I'm afraid if the
No,
appeal is allowed.
Now
if the
this is
appeal-
Lokayukta is investigating into the matter.
No, I'm saying something else. If the
Yes.
appeal is allowed, Malad, because
Yes.
if the appeal is allowed, Malad, then these proceedings will be rendered infructuous.
True.
Therefore, it is something to do with the appeal, not just a matter of transferring to the
We'll
PPI.
consider that those applications that are filed for adjournment will be considered on the.
Lord, may
There's one
Now-
Lord,
Anyway,
your
I'm
lordships
adjourning
may-
it to next week.
But
That's
your
all.
lordships may kindly consider one
If your
aspect.
lordships are inclined to adjourn it, I want to make one submission, my lord. Like my learned friend says, that if the matter is referred to CBI, then the writ appeal can become infructuous. Similarly, my lord, I have another protection that I need from the court. Now, my lord, if in the meantime, taking advantage of the fact that these proceedings where we are seeking for referring the matter to CBI is adjourned, whether up to 18th or beyond 18th, whatever, my lord, we are in your lordship's hands. Then, my lord, in the meantime, if the Lokaayukta says I have completed the investigation, I am closing the investigation, then, my lord, there will be a problem. Therefore, my lord, my respectful request is in order to make
You
this-
went to Lokayuk court.
My
You
lord,
went to Lokayuk court. You wanted Lokayuk investigation. Now you say Lokayuk should not investigate. What kind of petitions are these, Mr. Raghavan? Lord, I respectfully urge your lordships, this is an abuse of process
No,
of
1
court.
minute, sir.
Don't
I
encourage
have not
it.
even
No,
completed my
one-
submission.
one
My
minute.
learned
Please
friend
don't
already-
encourage it.
No,
Let
no.
me say what
If
I want to say,
if
sir.
I've
This is
understood
an
what,
abuse.
Let me say what I want to
no,
say.
if I've understood what Raghavan sir is saying is, it should not be, this petition should not be rendered
Exactly.
fait accompli.
Therefore, I have only one
Yeah,
request.
all.
my
So
It
lord.
should
our
not be
appeals
rendered
can be,
fait accompli.
rendered infructuous. Your lordships will accept that.
No, no, I'm not
I
saying that
don't
also.
understand this approach
I
of
am
the
not,
court.
sir,
with
that
great
is before
respect.
the division bench.
Yes,
It is for
but
the
our
division
appeals
bench
are-
to say,
Our appeals are
sir,
against
it
your
was
order
1
of
minute.
5th of November, my
It
lord.
was for the division bench to say that those proceedings would become
Lord,
a problem
cannot
if this
understand
proceeding is
what
not
is the
stayed.
great,
Lord,
if
can
your
I-
lordships are
I'm
inclined
making
to
one
transfer
submission which will
to
maintain
CBI,
until-
then my lord, nothing will be left. Because I have,
let
Lord,
me
I am
say
appearing-
something.
Now, it
Just-
is, sir, in the
I am
fitness of
appearing-
things, in the fitness of things, till the next date at least, where are the investigation papers?
Can I
Give it.
make one submission, my lord, which will protect the interest of all the parties? My learned friend will kindly bear with me and hear me for 1 minute only.
He doesn't want
All-
truth to
Well,
come out.
please, sir.
He wants that truth which
I
CBI
have
will tell
not said
him.
what I want.
He wants
I have
that
not even
truth.
said what I want.
Your
Please, Mr.
lordships
Dave.
have not indicted already parties.
I don't
by
think,
your
my lord,
judgment.
I
Lord,
don't think this court
let me
knows
say
what
one
I
thing.
want to
Mr.
say.
Raghavan,
I
you
don't know how my
are
learned friend knows. I mean, if he has got an
Raghavan,
extra
just a minute. Lord, let me say one thing.
getting into my mind to learn to know
Lord,
what I want to say, my
Lord,
lord, I don't know.
let me say one
say
thing.
what I want to say.
Your Lordship,
On a
may kindly
serious
see page
note, my lord,
256.
on a
Can I
serious
say
note,
one thing, my
What
lord?
is
Lord,
sought
on
for this
24th,
Lokaayukta
24th
investigation?
September
Done
judgment.
already.
257 in their
Can I
petition.
say one
Just a
thing?
sec, Mr.
No,
Advocate
before the
General.
Before
257 for, just for a moment.
No, it was not.
257, just for a minute, 257
Of what, which papers?
of their writ petition. Man.
257.
257. Man. Starts at 239. At 257, refer the complaint under
Police wing of the Lokaayukta.
to the police wing. That has been done. His petition has been allowed. No, his petition having been allowed, he's agreed. He's not challenged
what
that
I
order.
want to say, Mr. Learned Advocate General will kindly permit me to say what I want to say.
All right.
Let me have at least the satisfaction of saying what I want to say, without my learned friends stopping me from even saying what I want to do. Whether it will be granted or not is a different issue.
Yes.
But all that I'm saying, my lord, is in order that while their fear is that if the matter is referred to CBI for whatever reason, my lord, whatever the court may do, your lordship's power under 226, my lord, now is confirmed to have the right to refer the matter to CBI. That, my lord, cannot be taken away. In spite of the fact that...
That is
the
not
state government-
correct. I have enough number of Supreme Court judgments which say that this should not be referred to CBI. This is not a case. Unless you can point out that Lokaayukta investigation was faulty. It has
let
not
me
even
say-
begun. It has not even given report. At
Mr.
this
Dave,
stage, you
will
cannot come
have-
for CBI
Will you please
investigation.
give me the
I
courtesy
don't
of
think
1
you are-
minute of hearing?
Right from common, Mr. Raghavan, it's your duty to point out law correctly to the court. Don't cite Lordship's judgment because it pleases Lordships. There are Supreme Court judgment, I will show number of them, which say that this investigation cannot be transferred. I will show that.
I will be educated
It's not
if you show
right
it.
or not.
But please permit me to say what I want to say.
The facts of,
I mean, there is a
the
limit
facts
up
of
to
the
this.
case.
I mean, I understand your objection.
Sir,
Let
1
me say
minute.
what I want to say.
Judgments are on both sides, whether it should be transferred to the CBI and when it should be transferred, when it should not be transferred. All that,
I'm
it is not that.
I'm not on that issue at all. I'm not even said what I have in my mind, which will protect the interests of both the parties. But all that I'm now saying is because of the delay, neither the writ petition should be rendered infructuous, nor if your lordships are granting an order for transfer without adjourning it, the writ appeal should not get infructuous. Both have to be balanced.
Now,
So all
that is what senior counsel Kapil Sibal sir told.
now giving a lordship via media, my lord, which will protect the interest of both the parties. My lord, all that I want to do is, no, my lord, investigation is being done by the Lokaayukta. Let them not close the investigation with your lordship's leave. That is all. What's wrong about it, my lord?
My
Though
lord,
that,
I'm sorry.
one
I'm
minute,
sorry.
sir, let me complete.
That there
So
is
that,
no-
my lord, my
there
petition
is
doesn't
no-
become
There
infructuous.
is no prima facie
My
case,
petition
they
will
should
not become infructuous. Your lordships are not
I'm
saying
sorry.
the
This is not
CBI
fair.
should investigate the matter.
So
Right.
you want a stalemate in the investigation?
No. Let the investigation, let them not close it. Let them not come to a final
So
conclusion
let
without
them
your
not file
lordship.
the final report is what is.
Yeah, that's all. Investigation must go on. Of course, I don't know. That will be committing suicide. I will not do that.
My lord, this.
I don't think
He doesn't trust his
I'm only saying, let not the investigation be concluded without your
May I-
lordship's
may
leave.
I make a-
That's
make a-
all.
make-
No,
my lord,
if
There
that
is
happens,
no
how are they
prayer.
going to have?
There is no prayer in this petition.
No
There
interest.
is no prayer in this
It is
petition
part
against
of the
the
order
current
granting
investigation.
adjournment.
No,
It
no,
is
there
part
is
of
no
the
prayer.
condition that
You are
your
only
lordships will
praying
impose by
CBI.
granting adjournment.
Transfer to
I
CBI.
understand
There
this,
is
my
no
lord. I mean,
prayer.
this is
Look at your
going,
prayer clause.
my lords, may I make a
Look at
request?
your prayer clause.
No, sir,
Yeah.
we will take it on 17th, 18th or 19th. Please decide and tell me
But I
whatever
want it on
orders.
17th if it is possible, because I have some inconvenience on 18th and 19th.
No,
So
I
if
have
it's
a
possible
problem.
on 17th, I will be obliged.
Sybil sir
19th.
and Dave
Yeah.
sir, come to a consensus and tell me
19th,
when I should take.
19th.
Well,
I
if
can't
necessary,
come-
then we will
I-
adjourn
I
it beyond
can't-
vacation.
But it may be
Excuse me,
adjourned beyond, that's
somebody else
okay,
will
my lord.
appear.
But let this protection be there so that it should not be, otherwise tomorrow lordship kindly
For
sees fit.
professional
It is
reasons.
quite
I have
surprising,
personal-
quite surprising, my lord.
compulsion.
The friend was not so fair
I
before
have
the
no
division
difficulty
bench.
about it.
See, situation.
If my
This was
learned
so
friend is
fair.
so much hurry,
So fair before.
I can't. I can't help it, my lord. I will lose the chance of persuading your lordships, but that's all right. Maybe some other someday.
No, well, on what day do you want, sir?
19th, have it on 19th.
Yes, sir. Yes, 19th will have it.
Well, we prefer after vacation.
None of
Since
us
your
are going to
lordship
be
says
here.
that on that day you take it after.
19th we will decide, we will adjourn it, sir, if it is needed.
That's right, was after
Yes.
19th. you
We'll
have
take it on the 19th.
Even my
Yes,
colleagues
very
are saying
good.
they won't be here. ಅವ್ರಿಗೆ ನಾವು encourage ಅಂತೆ.
ಯಾರು ವೆಕೇಶನ್ ಶುರು ಆಗಕ್ಕೆ ಮುಂಚೆ ಯಾರು ಎಲ್ಲ ಹೋಗಂಗಿಲ್ಲ ಅಂತ ಹೇಳಿ. They can't leave the court,
Same,
leave the court before vacation.
Mr. Sybil, I can't be.
Didn't say
How
that
can they
was-
leave the court and go?
Of course,
Yes.
I know.
Say on
I'm
that-
traveling, so I
No, in
can't
the
be.
meantime, my lord, this protection may be granted.
Mandamus, not to,
I know, my lord.
not to leave the jurisdiction.
But this protection may be granted.
No,
No,
that we'll see. Records ಕೊಡಿ.
Records are there.
Entire records of investigation till date, where is it?
Records I can.
Please
I
give,
thought
yes.
status, your lordship.
Not status, records of investigation till date, give it, yes. I directed records of investigation.
My lords, in fact, again, as against that also, my lords, there's a notice issued by the division bench.
So I should not see the records?
Not that
Then?
your lordship should not see the records. Your lordship may see, but
Division bench has passed an order not to
no,
see the
we
records.
should only notice on that aspect.
All right.
So-
The learned counsel appearing for the Lokayukta has placed the records of investigation as was directed earlier. The same is taken into the file.
Status report. no?
And
Some
and a separate sealed
Sealed
cover with a sealed cover of the status report of investigation. The same, both these covers are taken into the file. List this matter on 19th, sir?
Yes.
19th, yes.
In the meantime, that protection which I
No.
asked.
19th will pass.
No, if they close it in the meantime, there'll be nothing left, my lord. What is there in this petition for me?
My lord,
No, but
oh,
this
it's
delay
quite-
should not, my lord. delay
Quite
should not
surprising, my lord,
affect me.
before the division bench, same
Delay
argument
should not
was
be
made.
No, my lord, it is wrong. Delay should not affect me. Just as
But-
they say, my lord,
I'm
that
sorry,
if the
it's
petition
not
is
an
allowed,
order
their
in
writ
court
appeal will
cannot
become
be passed.
infructuous. I mean, my writ petition becomes infructuous if
Yes,
ultimately,
sir.
my lord, they take an action because of the delay.
No court has ever.
Therefore, my lord, my
stopped
respect to the
investigation.
petition, the matter is being delayed.
Yes, no court has
matter is
ever
being
stopped
delayed.
investigation.
Seal ಮಾಡಿ madam.
Mr. Raghavan, why don't you submit? Mr. Raghavan, why don't you submit that it should be allowed today, your writ petition?
Of
That's
course,
the
I'm
end of the
submitting it.
matter.
Of course, I'm submitting. Of course, I'm saying it. But it
Yes.
will not be granted, but the court will not grant it. That's all the problem. Of course, I'm saying it.
Lord, this is your lordship knows today's body politics. You can't.
I mean, I
get
don't know my lord, all this, but
government
my learned friend knows all that better
judicial
than I know.
process.
I am only
Yes.
arguing a case.
All right.
Oh,
yes.
you are arguing a case. Everybody knows your public spirit, Mr. Raghavan. It is very highly
Yes,
respected.
Dave, sir, yes.
Lord, I'm sorry, Mr. Dave was saying he has some difficulty on 19th.
19th,
No,
my lord, then
let
what?
him- We'll see on that day what can be done. We will not close the proceeding without hearing anybody. So rest assured.
If
about
Mr.
that.
But I am not-
20th,
But I was suggesting first day of the reopening. First day
We'll
of
do
the
it- We'll
reopening.
do it on that day, sir. We'll do it on that day. If needed, we'll do it on that day.
19th,
First, let the
19th.
objections to the, sir.
But if needed is what worries me. your lordship's my lord, words if needed. Otherwise, my lord, yeah, everything will come to an end. That's
no.
why.
Nothing will come to an end anywhere because we are before the
My lord,
division
it will
bench.
come to an end if the Lokayukta files any final report. Please therefore ensure, my lord, that nothing comes to an end.
Yes, sir.
My lord, let it be.
My lord, with
My lord, let
great
it be
respect,
made. After all, my lord, all that I'm asking is that they should not do anything without leave of the
I am
court. What am
sorry
I
to say,
saying?
this
Am I
is
saying anything
unheard of.
unreasonable about it, my lord? My lord, nothing should come to an end, my
Sir,
lord, if it is right.
This is the entire records of investigation
As on yesterday,
as on yesterday, right from the beginning till today. Yeah, till yesterday, the seal madi.
request is not to seal it,
Yes, yes.
only for my lord's consideration.
Of course, yes.
Of course, I'm not even asking for seeing it.
He satisfied. I am aware, my lord, sir.
But in the meantime, let them not close it, my lord. With your lordship's leave. But what is the harm that will be caused to the other side if this is done?
Where is the
Nothing
prayer,
will be
Mr.
done.
Where
My
is
lord,
the
all that you're saying
prayer?
is-
Where is the
harm
prayer
if
in
it
the
is allowed?
petition?
What is the harm it is allowed?
Let status quo be maintained. So far as the proceedings are
Status quo.
concerned,
Very
investigation can go on. Let not
Status
final
quo.
action be taken without your lordship's leave.
You have not
What is
challenged,
wrong about
you have
that?
not challenged, my lord, I must think.
What
Lokayukt
is this, my
order
lord? I
is
don't
not
understand, my
challenged.
learned friends.
Lokayukt order
The
is
very
not
fact that
subject
they're
to this writ.
objecting to this reasonable test.
Yes.
What kind of submissions are being made?
My lord,
You have not challenged,
no,
Mr.
my lord, it is
Raghavan,
part of,
Lokayukt
no,
order.
it is part of a,
Challenge
it will be part, no,
No,
my lord,
amend the
it will
petition,
be
challenge
part
it.
of your lordship's
Look.
direction adjourning the
Because
proceedings.
obviously, this is
My lord,
not a
that is the
legal
reason, my lord,
proceeding.
your lordships can always impose terms
This
when
is
your
not
lordships
a
are
legal
adjourning a case.
proceeding.
That happens day in and day out.
It is obvious
That's
this
all
is
that
not
I'm
a
saying.
legal
My
proceeding.
lord, delay itself should not render any proceeding
What delay? You
infructuous.
should-
If
you
that
should
is the
That was our
principle,
argument in DB.
if that is the principle, my lord, and that
You did
equally
not
applies
agree to
me.
that. DB requested you, Mr. Raghavan, personally. DB, that's why I said, Mr. Raghavan, please be careful before learned single judge. He
Please be
left it to
careful.
your
I
discretion.
don't know
to
what
your-
my management is saying, my lord. I'm not
What-
going to take
what-
what
Now
he's
you
saying.
are
Sir, what is-
opposing here
please-
any
please be careful.
requirement.
I don't know what he's saying, my lord. I don't take no notice of what he's saying.
The lordship said the entire.
Is this the
properties-
entire records?
Property seized, documents seized are not here because they are voluminous.
Hmm.
But seizure of properties, that PF, my lord, PF list is here.
What is there in the other cover? Status report, then what is there?
Status report and one statistics, number of witnesses examined.
That's all right.
communication.
The other one,
But other
statements
one is,
recorded.
other one is two files.
Statements recorded.
CD, yes, CD is there. No?
Yes,
CD is there, about 49 pages of CD is there.
all right.
And then lot witness statements which are recorded as on today. It is there.
All right.
But PFs are there, Mahazars are there, but not the properties themselves. The files
That's
which are
all right.
seized and the sale deeds or documents which are seized, those are not there.
All right.
Lordship
Yes.
said
Sir, what
entire
is curious, my
investigation-
lord, is the state opposing it in this matter. I don't understand. What is their interest?
If the matter is curious, others are
I
curious.
know, my lord, it becomes curiouser and curiouser as we
Like
go on.
curious, others are furious. What is this? Yes.
And it is becoming curiouser and curiouser, my lord. And a lot of fury is also added by my learned friend, Mr. Dave.
All in the lighter way in the way.
All in later vein, my lord. My lord, I have the highest regard and respect, and he's a very dear and noble friend of mine.
Yes.
Then
As
you
long
should
as it is
accept
done.
his
Like-
nobility.
You have
In the court, my lord, it is
Mr.
different.
Raghavan, otherwise you would have agreed to adjournment readily.
My lord, this protection may be given, my lord. I'm not asking for anything unreasonable.
But I don't know
Please
why my
consider
learned
it.
friend, why my learned friend
Please
even
consider
making
it, my lord.
there.
Investigation?
Well, anything.
Are you completing the investigation?
Well, I'm sorry to say,
Huh?
may I make a
No, that's
submission?
the,
May I
great
make a,
respect.
Like,
Advocate General, may I make a
My
submission?
lord, with that, my lord, with
What
great
to-
respect, my lord.
Lord, in the court, not before the
Well-
trial court, where I'm supposed to, my lord, my investigation officer is supposed to submit report, date is fixed for 24th
Of,
December.
we'll have it on the 19th. Yes.
My lord, it's-
19th, sir.
Right.
Now it's a jumble of proceedings. Before the concerned court, before 24th, he has to file. There is an
my lord, the
application here.
petition is
There are
filed
writ
without,
appeals pending.
the petition is filed without interim relief, moved after 1 month after.
Without
moving-
interim relief.
Without interim relief, moved
Interim
after.
relief will reference.
No, not challenging the, seeking for a relief to refer to the matter of the Lokayukta. That order is not challenged.
Please,
This-
My lord, this is my response and request to your lordships on the plea for adjournment that is being made.
Therefore, my lord,
And adjournment can
the
also
question-
be granted on conditions.
Therefore, the question is whether the Lokayukta will
Don't
finish or
grant
not
the
finish. My
adjournment.
lord, it is for the
I'm not
Lokayukta
saying
to
don't grant,
decide. my lord.
reject the adjournment.
It should for the
No,
Lokayukta
But
to
I'm
decide.
sorry
minute.
to say,
To inject-
Mr. Raghavan, accept his plea, reject the adjournment. I don't
Now-
mind.
1 minute. Even if they file the final report, are the hands of this court tied to pass orders?
My lord, may
That's
not be, but things become very complicated.
No.
Things become very
No
complicated.
complications, sir. You are before the court earlier to it.
If it
Now
is
there is a-
transferred
there
to
is a
CBI,
direction
it
by
will
the
not be
court, they will do it.
complicated. What will happen to our appeals? What will happen to
So-
our appeals? Lord, the problem is, I'll tell your lordships in a second. Lord, 24th September judgment of your lordships, the detailed judgment. Your
Yes.
lordships, Lord, have been led by Mr. Raghavan to, Lord, I think, a wrong proposition of law. That judgment was only to decide learned governor's sanction under section 17A.
No, no,
Instead,
everything was argued. I had to answer everything.
no, but complaints, merits of complaints could not be before your lordships. Your
That
lordships
was
have
what was put forth
committed on
also,
merits
sir.
of complaint. That is why we are.
That was what was put forth by the petitioner and the other councils also.
No, my lord, merits were never put forward.
It
They were-
was put forth. Merits were
No,
put
it is-
forth.
It is in the context of sanction
Because
of
it
the
is,
governor.
it is available everywhere. It is in
Lord,
public
it is
domain.
in
You
the
can see also.
Your lordships are right. It is in the context of sanction of the governor's order.
True, but everything was put in.
But your lordships have said complaint is correct. Your lordships have said allegations against me are correct. Your
Those are,
lordships have
no,
said I
that is
am
only
guilty of fraud.
granting permission for investigation.
But I was not there. Your
It is in
lordship
the
said my client is guilty of fraud. My client
No,
is
my
guilty
lord,
of
No,
not
fraud.
petitioner, no. The petitioner had to implead you if at all that was needed. Petitioner
No,
alone
no.
had come before the court.
But your lordship should have not refrained from
No,
making findings against me.
there is all prima facie findings.
Lord,
Anyway, it is before the appellate court.
Which trial court?
No, it is before
Which
the
trial
appellate
court
court
will
anyway,
see it
sir.
as prima facie? Your lordship knows which trial court will see it as prima facie.
No, but it
From-
is matters before
Coming
the
from the
appellate
High
court. I
Court
will be.
and coming from my Lord Justice Nagaprasanna's court, these are final findings.
No,
Every trial court is bound by it.
no,
Every trial court is bound.
because the matter is before the division bench. Their lordships are seized of the matter. Then
Now
I will
it
not.
is infructuous the way your lordships want to proceed. Lord, it is
No,
infructuous.
this would, if mere reference I have not yet done anything. Mere consideration of a reference to CBI will not render the appeal that you have filed infructuous. It is after all for investigation. If
sorry
the
to-
appeal is allowed,
sorry.
any investigation goes away, whether it is to the CBI or to the Lokayukta. Any investigation goes away. It goes lock, stock, barrel.
Now the matter is being considered at large by the division bench, at
Yes,
large.
sir. Yes.
So if the division bench comes to a different conclusion on law matters, then all this is infructuous. This
No,
cannot
all,
go
see,
on.
even assuming there is an order passed, that also will flow away with the division bench's
In the
order. It
meanwhile,
says the division
Lord,
bench.
in the
How will it?
meanwhile,
How will it?
in the
If there
meanwhile,
be a
no,
fair
no.
comply, Milord. Fair comply. CBI would have taken over investigation, be a fair
No,
comply.
in the place of Lokayukta, CBI would have come in.
That's not, no, it's still be a fair comply, Milord. How will this go on, Milord? They will have said, we have investigated half the matter and we have now come to a conclusion. All that, nobody will be able to.
We'll consider
You
it.
know that, I know that. We've been
Yes,
enough. You have been enough years at the bar and so have I, Milord. So you know that it will be infructuous.
Yes.
Yes, so let's be clear on that. And let's not think that it's not going to be infructuous. It will be. Therefore, it is our fervent request, Mullah, that your lordship
No,
should have. If you don't
I'll
want to
post
do
it on the 19th. We will
Yes.
definitely pass some order on the 19th.
Yes, please do. And
Yes.
then adjourn it afterwards. That's all that we are requesting.
Yes, we will definitely pass some order on the 19th.
Deeply.
They should not close the investigation and make the whole thing infructuous. My lord. That is not, that's
My
not,
lord,
we
first
should
of
not
all-
be faced with that situation.
First
But
of all,
this is what
my lord-
this is the, if I may
This is
say, so,
the,
this is the
this is
reason why the matter
the
want to be
20th
adjourned.
time my learned friend has made this request.
Of
20th.
course. I mean, you have made a request for
For-
adjournment
for-
umpteen times
for-
now.
You know very well that
Yes,
I mean,
we'll take it on the 9th.
obliged, Mullah.
Yes.
my lord, in the meantime, would you
And
not-
even if they do something like that, matter is here.
my lord, but then,
Is it,
Well,
that's not, sir, that's not,
Lord,
be-
this is not,
that's not be all and end all. Nor these proceedings are be all and end all. It is before the.
my lord, I understand.
also.
My lord, this is not a 482 proceeding where your lordships can pass any type of an order. In a 482, I understand, my lord, your lordships can mold and
Type of
relieve, do
order.
all. But this is not a 482. This is
Any kind of order.
a writ petition. the writ petition.
Yes.
Therefore, my lord, there are some
we-
apprehensions that we
you-
have.
you
And
know
in
that-
view of the fact that the matter is to be adjourned, in the meantime, my lord,
Reject
nobody's
the
rights will be
adjournment.
prejudiced. I
You
don't
reject the
understand how their
adjournment.
rights will be prejudiced at all by the prayer I'm making.
Reject the
In the
adjournment.
least,
Why allowing?
nothing is going to happen. Nothing is going to happen to
All
them.
Reject the
applications I will
adjournment.
consider on the next day. Yes.
Very well. I will.
So, sir, copies, lordship looking for originals, but I can paste that.
Why have you given copies?
But I was not prepared for giving, but I only status report I thought.
No. How can you give copies to the court?
Of the entire set.
Yes,
I can paste that.
before the end of the day.
Uh,
Yes,
10 minutes.
yes. Yes, sir, on the 19th.
Great.
Yes,
Fine.
Can take back.
and get the entire thing.
Is that 2:30? Is it be to 2:30?
Yes, sir, at your whatever time you want.
2:30, Malak,
All
2:30.
right, 2:30. Yes.
Deeply obliged.
So I'll list on 19th for the hearing at 2:30. Adipodi, I should get back. Yes.
Grateful.
Continue ಮಾಡಿ. 2:30 ಇದೆಯಲ್ಲ ಮೇಡಮ್. 2:30. For the hearing. We'll take it, sir. Definitely. ತಗೊಳ್ಳಿ ಅದು. ಯಾವ್ದು 2:30?
Number 2. Number 60.
ಹಾ. 83 ಯಾವುದು? Oh, ಇದು this. We'll see. Wait, I've not called your matter still. By the end of the day, we'll pass some orders. ಅದು ಇನ್ನೊಂದು ಯಾವ್ದು ಮೇಡಮ್? ಸರ್ ನಿಮ್ಮ ಸೀರಿಯಲ್ ನಂಬರ್ ಯಾವುದು? 67. ಅದು 2:30 ಇದೆಯಾ? ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಮೇಡಮ್. Oh, this matter is it? All like this. Madam. Petitioners ಎಲ್ಲಿ?
The senior counsel is on his legs in court.
Sir, CV Nagesh sir.
Please.
My lords, in 60.3, my lords.
60?
60.3, my lords.
I've taken 67.
Apologies, my lords.
The learned senior counsel can commence.
Yes. ತಾವು ಹೇಳಿ sir. He will join. (14:6), my order. Oh, it's a detailed order, sir. Hello, this is a detailed order. Sir, Mike.
This is the order dated 14/6/2024.
Yes.
Submission of learned counsel is accepted. Office objections in criminal petition number 5529 of 2024 are overruled. So this is anticipatory bail petition.
Bail petition either.
There is a bail petition directly filed under 438 before the High Court.
Not gone.
No, it was never taken before the sessions.
Oh, straight away here.
Straight away here.
Hmm.
The case in WP number 15522 of 2024, filed under Articles 226 and 227 of the Constitution, read with Section 482 of the Criminal Procedure Code, seeks quashment of the proceedings arising from crime number 84 of 2024, Sadashivnagar Police Station, Bangalore. It alleges offences punishable under Section 8 of the Protection of Children from Sexual Offences Act 2012 and Section 354 capital A of Indian Penal Code. The petitioner is directed to array Mr. So-and-so as second respondent.
One second.
Shashank Singh is father or brother?
Yes, sir.
The court has directed one Mr. Shashank Singh to be arrayed as a party.
Who is that?
He is the brother of the victim. Court may kindly recollect.
Who is the complainant?
The complainant was the mother.
Was the mother?
Mother. She passed away.
Oh, complainant is no more.
Passed away.
All right.
After the.
Sir has come.
Yeah.
Our preliminary ಏನೋ ಮಾಡ್ತಾರೆ ಆಮೇಲೆ.
So the case in criminal petition number 5529 is filed under section 438 of the CRPC for grant of anticipatory bail in respect to the same crime number. The records reveal that the police had issued a notice under section 41 capital A of CRPC on 28/3/2024 for the appearance, and accordingly petitioner appeared before the investigating officer and thereby participated in the investigation process. The second notice of the first kind, dated 10/6/2024, served on the petitioner on 11/6, instructed him to appear on 12/6 at 10:30 a.m. for interrogation. Petitioner, by his reply dated 11/6, told the police that he would come on 17/6, he having some scheduled meetings at New Delhi. In fact, he flew to New Delhi on the night of 12/6/2024. Therefore, it cannot be said that the petitioner is not cooperating in the investigation. Sir, these are the details. Court asked, what are the details? It's a detailed order. So I'm showing the details. The learned senior advocate Sri So-and-so, appearing for the petitioner, submits that the power to arrest availing under section 41 having not been exercised, and the notice under section 41 capital A of the CRPC having been adopted consciously, and his client having already participated in the investigation process, and further assuring to participate again on 17/6/2024, police could not have secured a warrant of arrest under section 73 on the ground that the custodial investigation is necessary. Sir, kindly pause for a minute. The warrant of arrest was not under challenge. He is not under challenge either in this petition or in the other petition. As a matter of fact, he draws attention of the court to the material particulars of the case as to the incident of the offense, delay brooked in lodging the FIR, the credentials of the complainant who breathed or lost in the recent past on account of cancer, and the nature of allegations leveled against the petitioner. He also mentions about a plethora of cases filed by the complainant against others, and that they are all frivolous, as is the case against his client too. I will show not a single case was filed by her. I'll demonstrate that. Further, he also mentioned about the political vendetta. So, arguing, he seeks stay of all further proceedings. Learned Advocate General, per contra, makes submission that the petitioner is not cooperating in the investigation process. Police notice dated 10/6/2024 has been violated. with no justification whatsoever, even otherwise, custodial interrogation has become imperative. Regard being had to seriousness of the offences involved and the political background from which the petitioner hails, no interim relief can be granted to him. Mr. So-and-so appearing for the now added second respondent in the quashment petition also made similar submission, highlighting the recent demise of the complainant and lethargy attributable to the police in the matter of investigation. He also notifies to the court his client's writ petition number 156239 of 2024, wherein he has sought for the arrest and detention of the petitioner and for a direction to accomplish the investigation on a wharf T. Having heard the learned counsel for the parties for some time, having perused the petition papers, I am of the considered opinion at this stage, no case is made out for halting the ongoing investigation in crime number 84 of 2024, and that the petitioner should participate in the same by appearing before the jurisdictional police on 17/6/2024, as was assured by him. That being said, the petitioner, who is a former chief minister of the state for multiple times and who is now an octogenarian, shall not be arrested when he appears before the police and cooperates in the investigation process. Very many issues canvassed by both sides merit deeper examination after the filing of statement for text. So I fail to understand whether this is a bail granted to the petitioner or a stay of arrest. What is the nature of the order that has been passed?
All interim protection.
With great respect, such a protection cannot be given in a matter of this nature, which is so serious. Heinous offense is alleged against the petitioner. And when such is the case, without even making out a prima facie case, without even considering the balance of convenience, no such order could have been made. I have therefore applied for vacating it.
No, I'm hearing it.
Maybe.
Yes, sir.
In a nutshell, if I may say so, the simple case made out in the FIR lodged against the petitioner is.
Now I will hear him. Petitioner. Not on the application, on the main matter.
And the main matter
Yes,
of this application?
On the main matter. Yes.
ಬೇಕಾದ್ರೆ ಇದ್ರ ಮೇಲೆ ಒಂದು 2 ನಿಮಿಷ ಬೇಕಾದ್ರೆ ಹೇಳ್ತೀನಿ ನಾನು.
ಯಾವ್ದ್ರ ಮೇಲೆ?
ಇವ್ರ ಆಂಟಿಸಿಪೇಟರಿ ಬೇಲ್ ಮೇಲೆ.
That's power of the court.
ಅಲ್ಲ 2 ನಿಮಿಷದಲ್ಲಿ ಹೇಳ್ತೀನಿ ಇನ್ನೇನು. Well, the offences that are compliant against me is one which is made penal under section 354 capital A, as well as under section 8 of the POCSO. 354
Sexual assault.
354A, the maximum sentence that could be imposed is 3 years.
Mike, sir.
Mic on ಆಗಿದೆ. ಸಂದೀಪ್. ಆಗಿದೆ.
On ಆಗಿದೆ.
Mike
Let me repeat, man.
Yes.
Offences that are compliant against me are one under section 354 capital A of the IPC, and the other being one under section 8 of the POCSO. 354 capital A, the maximum sentence that could be imposed is
3 years.
of 3 years. As far as section 8 of the POCSO is concerned, maximum sentence that could be imposed is 5 years. So section 41A of the CRPC would come into play. But the judgments of the Supreme
Arnesh
Court,
Kumar.
commencing from Arnesh Kumar and ending with Satyendra Kumar
Until.
that they would say, that the question of when once you issue a notice under section 41 capital A, it presupposes that there is no need for the investigator to lay his hands upon the accused and to arrest him. But may I just invite your lordship's kind attention to first page of the request that is made by the investigator before the magistrate.
I'm holding writ petition 15522 of 24. Is that the one you're referring to, sir?
ಇದೆಲ್ಲ ಒಂದು ಡಾಕ್ಯುಮೆಂಟ್ ತೋರಿಸ್ತೀನಿ ಅಷ್ಟೇ ಇನ್ನೇನು. ಕೊಡಿ.
ಅವ್ರ writ petition
ಕೊಡಿ.
ಇದ್ರಲ್ಲೇ ಇದೆಯಾ?
Court of- Well, let's,
Yes, sir.
the investigator, in his wisdom, having thought it fit and necessary that there is no need for him to lay his hands upon me in connection with the crime that is registered against me,
Issues 41A notice.
issues a notice under section 41.
Otherwise, direct arrest. Yes.
Otherwise directly arrested. Well, I would comply with the demand which came to be made upon me to mark my presence before the investigator for and in connection with the investigation of the crime. May I just request your lordship to kindly turn to the application which the investigator himself would file before the jurisdictional magistrate, page 123. This was on 13/6.
One 120?
123.
All right.
Would your lordship kindly turn to page 125? Well, what he could not do for having chosen to issue me a notice under section 41 capital A, but he would invoke the jurisdiction of the magistrate under section 73 of the code. That is disastrous. I shall show to your lordship.
Issuance of a warrant.
Yes, my lord, why? May I just request your lordship to kindly go to page 125? Third paragraph. ದಿನಾಂಕ 6/4/2024 ಸಾಕ್ಷಿದಾರರಾದ ಮೈ ಲಾರ್ಡ್ ಗೆಟ್ಸ್ ಇಟ್
Yes.
6/4/2024 ಸಾಕ್ಷಿದಾರರಾದ ಶ್ರೀ ಶಿವಾನಂದ ತಗಡು, ಶ್ರೀ ಮಹೇಶ್ ಕುಮಾರ್ ಅವರನ್ನು ವಿಚಾರಣೆ ಮಾಡಿ ಹೇಳಿಕೆಯನ್ನು ಪಡೆದುಕೊಂಡಿರುತ್ತದೆ. ನಂತರ ಸದರಿ ಪ್ರಕರಣದಲ್ಲಿ ಅಮಾನತುಪಡಿಸಿಕೊಂಡಿದ್ದ ಪೋಕ್ಸೋ ಮೊಬೈಲ್ ಫೋನ್ಗಳನ್ನು ಪರೀಕ್ಷೆಗಾಗಿ SFSSU ಗುಜರಾತ್ಗೆ ಕಳುಹಿಸಿ ವರದಿಯನ್ನು ಪಡೆದುಕೊಂಡಿರುತ್ತದೆ. ಕೈಂಡ್ಲಿ ನೋಟ್ ದಿಸ್. 12/4/24 ಸದರಿ ಪ್ರಕರಣದಲ್ಲಿ ಅಮಾನತುಪಡಿಸಿಕೊಂಡ ಒಂದು ಐಫೋನ್ ಮತ್ತು ಒಂದು ವಿಮೋ ಮೊಬೈಲ್ ಫೋನ್ಗಳನ್ನು ಪರೀಕ್ಷೆಗಾಗಿ
ಅದು ಕಾಪಿ ಕೊಟ್ಟಿಲ್ಲ.
ಇದೇ ಕೊಟ್ಟಿದೆ. ಕೊಡದೇ ಇದ್ರೆ ಅವ್ರು ಸುಮ್ಮನೆ ಇರ್ತಾರೆ. ಎಷ್ಟು ದಿನ? 1 ವರ್ಷ ಆಯ್ತು.
Yes.
Well, now kindly go to the next paragraph.
ದಿನಾಂಕ 6/4.
ದಿನಾಂಕ 6/4/24 A1 ಆರೋಪಿಯಿಂದ ವಾಯ್ಸ್ ಸ್ಯಾಂಪಲ್ ಅನ್ನು FSLಗೆ ಮಡಿವಾಳಕ್ಕೆ ಕಳುಹಿಸಿ ವರದಿಯನ್ನು ಪಡೆದುಕೊಂಡಿರುತ್ತದೆ. Well, this would indicate that I have participated during the course of the investigation of the crime. ದಿನಾಂಕ 6/5/24 etc. he will say. Thereafter, my lord, kindly go to the next page, page 126, para 3 again. ಈವರೆಗಿನ ತನಿಖೆಯಿಂದ 1ನೇ ಆರೋಪಿತರು ಕಲಂ 8 ಪೋಕ್ಸೋ ಕಾಯ್ದೆ ಕಲಂ 354A IPC ಅಡಿಯಲ್ಲಿ ಸಾಕಷ್ಟು ಸಾಕ್ಷ್ಯಾಧಾರಗಳು ಮೂಡಿ ಬಂದಿರುವುದರಿಂದ ಮತ್ತು ಘಟನೆಯ ತರುವಾಯ A1 ಆರೋಪಿತರು ತನ್ನ ಸಹಚರಾದ A2, A4 ಅನ್ನು ಸೇರಿ ಫಿರ್ಯಾದಾರ ಮತ್ತು ಅವರ ಮಗಳ ನಂದು ಬಾಲಕ್ಕೆ ಹಣ ನೀಡಿ ಪ್ರಕರಣ ಮುಚ್ಚಿ ಹಾಕಲು ಪ್ರಯತ್ನಿಸಿದ್ದಲ್ಲದೆ ವಿದ್ಯುನ್ಮಾನ ಸಾಕ್ಷ್ಯಾಧಾರ ನಾಶಪಡಿಸದಲ್ಲದೆ ಪ್ರಕರಣ ಸತ್ಯ ನ್ಯಾಯಾಲಯದ ಗಮನಕ್ಕೆ ಬಾರದಂತೆ ಅಪರಾಧ ಎಕ್ಸೆಟ್ರಾ ತನಿಖೆಗಾಗಿ ದಿನಾಂಕ 11/6/24 ಪ್ರಕರಣದ ಮೇಲ್ಕಂಡ 1 ಮತ್ತು 2 A3 ಮತ್ತು A4 ಆರೋಪಿಗೆ ಕಲಂ 41A CRPC ಅಡಿಯಲ್ಲಿ ವಿಚಾರಣೆಗೆ ದಿನಾಂಕ 12/6/24 ಬೆಳಗ್ಗೆ 10:30 ಗಂಟೆಗೆ ಹಾಜರಾಗುವಂತೆ ಸೂಚಿಸಿ ನೋಟಿಸ್ಗಳನ್ನು ಜಾರಿ ಮಾಡದು ಇರುತ್ತದೆ. But through a notice issued to me under 41A, I was required to mark my attendance before him on the morning of 12/6/2024 at 10:30. But what I would say, kindly have a look, kindly go to page 16/16. But on 11/6/2024, the notice came to be served upon me. I would send a communication to the investigator on 11/6, which he has acknowledged it on 12/6. Your lordship would get, your lordship left-hand side bottom, the acknowledgement given for my communication. I am aware that I have been arraigned as an accused in the above crime number. Notice under section 41A of the CRPC dated 28/3/24 has been issued to me on an earlier date. Pursuant thereto, I have taken part in the investigation and extended my full cooperation. Another police notice was issued under section 41 capital A of CRPC to appear on 12/6/2024. The same was received by me, by one of my staff on 11/6/24. However, due to prior party engagements at New Delhi, in relation to my political party, I have left Bengaluru, and as such, I am unable to appear before the investigation officer on this occasion. However, kindly underline this, I would personally appear before the investigation officer on Monday, the 17th of June, 2024. On 12th, he receives my communication. I have some exigencies and work in Delhi, party work. I am going there. kindly condone my absence. I would mark my attendance before you on 17/6. But what is it he does? He doesn't wait for 5 days. But what he does is, he goes before the jurisdictional magistrate and he would make an application. But on 12/6, he would make an application, the day on which I was required to appear. By then he had received my communication also, requiring him to permit me to mark my attendance before him on 17/6. What he does, kindly go to page 127. Andre 41A notice ಕೊಟ್ಟರು ನಾನು ಬಂದಿಲ್ಲ, therefore issue a warrant under section 73. But when can the court issue the warrant under section 73 would be the next question. Kindly have a look at page 127.
When he is evading investigation.
No, my lord, no. Where I am absconding.
ಅದೇ absconding.
Have a look at section 73, my lord, for a second, just to refresh my lord's memory. Have a look at section 73. Warrant may be directed to any person. The chief judicial magistrate.
Escaped convict, proclaimed offender.
ಅಲ್ವೇ proclaimed offender, escaped convict. ಅವರು ಕೊಡ್ಬೇಕೇ ವಿನ, this magistrate, my lord, at a point of time when he accused himself, would say that I don't need to arrest you.
This may be a different case.
Disastrous consequences.
Every day I am seeing cases of 73 being issued for the asking.
But disastrous consequences would follow.
The asking and proclamation being issued under
Issue?
80 to 83 for the asking.
So how can he exercise? Well, there is no question of me challenging the order of issuance of warrant passed under section 73. That is why I am knocking at the doors of your lordship. Grant me the benefit of anticipatory bail, because the Damocles sword of an arrest warrant is hanging on me, on my neck. What is wrong in me asking for the grant of the relief of anticipatory bail? Well, he wanted to overcome section 41A. He could not have arrested. He would issue me a notice. I would mark my attendance before him. I would cooperate with the investigation. The only date on which I would remain absent according to him, with an explanation which I would give as to why I am not in a position to appear before you on 12/6 is, I have got to go to Delhi. I am coming on 17th. Am I not entitled for the grant of the benefit of anticipatory bail, my lord? In fact, strictly speaking, I don't know how far your lordship would agree with me. It is a case of contempt. Actually, that is how the Supreme Court has said. In Satyendra Kumar Antil case, that is how the Supreme Court has said, following Arnesh Kumar. It is a case of contempt. To overcome, my lord, so that he could take a shelter. No. I was not interested. The court, I appealed to the court. Court ought to have rejected it. Court issued a warrant. Therefore, I wanted to lay my hands upon you. Immediately, the very next day, I am before this court. And an interim order came to be granted.
Yes. That is on that
That is on the
merit.
merits will go on.
Yes.
Notes ಇಲ್ಲ.
ಅದು vacating stay ಅದೊಂದೇ ground ಆ? Vacating stay application
Yes, vacating stay.
and
Sir,
that and
notes
6 months ಅಲ್ಲಿ conclude ಆಗ್ಬೇಕು proceedings ಅಂತ ಅದೊಂದು.
Proceedings.
Notes ಇದೆ.
ಮತ್ತೆ more importantly, kindly turn to section 30.
ಅದೇ that last time you referred to that.
Yes.
Yes. Evidence should
He
get
should be-
concluded.
Yes, no, he should be present when the statement is recorded. When the victim statement is recorded, and it's mandatory that it should be recorded
Yes.
in his.
Ah,
And
yes.
that has been prevented by this interview.
Yes. Hmm.
Please.
Has frustrated the mandate.
Proceedings. Frustrating the mandate of the statute.
Mandate.
All right. Yes.
The date of offense is on 2/2/24.
2 synopsis ಹಾಕಿದ್ದೀರಾ?
Between 11 and 11:30 AM.
Synopsis ಹಾಕಿದ್ದೀರಾ ಏನಾದ್ರು?
ಹಾಕ್ತೀನಿ.
ಪರವಾಗಿಲ್ಲ. Yes.
ಹಾಕ್ತೀನಿ. Violation is not synopsis. 2/2/2024, between 11 and 11:30 AM
11
and 11:30 AM at the residence of the petitioner.
at the residence of the petitioner.
Yes, my lord, the offense would take place right under public gaze.
Yes.
My lord, the
Public
complaint is
gaze-
not filed on
No, no.
2/2/24.
Public gaze is discernible by what?
Yes, my lord, from the presence of more than about 20-25 persons. 20-25 persons had assembled.
Let him show one sentence.
ಈಗಲೇ ತೋರ್ಸ್ಬೇಕಾ ಅಥವಾ ಆಮೇಲೆ ತೋರ್ಸ್ಬೇಕಾ?
ನೀವು ಮಾಡಿ.
ಈಗಲೇ ತೋರಿಸಿ. Visitors book ಇದೆ. ತೋರಿಸಿ. The manipulated visitors book ಇದೆ.
Manipulated.
Yes, sir.
Yes.
That is proof.
Yes.
ಅಲ್ಲ ಈಗಲೇ ತೋರಿಸ್ಲಾ ಆಮೇಲೆ ತೋರಿಸ್ಲಾ ಅಂತ ಕೇಳಿದೆ ಅವ್ರಿಗೆ.
ಇಲ್ಲ ಹೇಳಿದ್ದನ್ನು substantiate.
ನೀವು ಅದನ್ನ ಜ್ಞಾಪಕ ಇಟ್ಕೊಂಡ್ರೆ
You continue, sir.
ಒಂದೊಂದಾಗಿ ತೋರಿಸ್ತೀನಿ ನಾನು.
Yes.
The fabrication of evidence made by you in this case, I will show you
Yes.
to the court.
Yes.
My lord, 2/2/24 is the date of offense, a very serious offense. That is what the Lawrence Special Public Prosecutor has been canvassing. The complaint was not on 2/2/24. But the complaint was on 14th of March 2024.
After 35 days.
Yes, my lord. After 1.5 months, nearly. 1.5 months later to the date of offense, the complaint. In the meantime, in between 2/2/24, she would visit me half a dozen times.
Why?
To be more, but for my favor, to put a word to A, B, C, D, found in connection with an alleged rape case or an act of rape said to have been committed on the person of her daughter. She would visit me. She would come to me.
Yeah, the complainant.
Yes, my lord, the complainant, along with her daughter, who is said to be the victim in the case, she would take pictures with me. Between 2/2/24 to 14/3/24. But she is a notorious lady. I shall take your lordship to that. How many cases are registered against her?
Not a derogatory remark against the person who is no more.
Huh.
Let him not.
Oh,
do that.
complainant is no more. Yes.
Complainant is no more. She is dead. Why should such a remark on her?
All right, let the records be taken through.
Better,
Yes.
better, sir, better. The court will certainly formulate the opinion, or you can formulate the opinion when I take how many cases, 56 cases. ತೋರಿಸ್ತೀನಿ, ನೀವು ಸ್ವಲ್ಪ ತಾಳ್ಮೆಯಿಂದ ಇರೋದಿಲ್ವಲ್ಲ ನೀವು ಯಾಕೆ?
ಅವ್ರು ಹೇಳಿ ಒಂದು ಕೇಸ್ ತೋರಿಸಿ.
All right. Sir,
ಕೇಸ್ ತೋರಿಸ್ಬೇಕಾ?
wait.
ಇಲ್ಲ, ಒಂದ್ ನಿಮಿಷ ಅವ್ರೇನೋ ಕೇಳ್ತಾ ಇದಾರೆ, ತೋರ್ಸೋಬಿಡೋಣ ಅದಕ್ಕೆ ಏನಂತೆ. Kindly go to Annexure D at page 24 of my writ petition. 24. Annexure D of my writ petition.
Annexure D.
I'm sorry, I said 50. It is wrong, my lord. I apologize. It is more than 50.
Page?
Page 24. She would file a complaint not only against her husband, against her son, against the ADG, DG, the leader of the opposition here in the Congress political party, police commissioner, against anybody and everybody on this earth. Kindly turn to page 24 of my writ petition. This is the background.
That is this writ petition 15522?
Yes, my lord, 15522 at page 24. Which they are not disputing. The state is not disputing this chart which I have furnished.
Chart ilwala.
Idralli Annexure D, my lord.
Yes. Illa, this is the final report chart sheet, Annexure G.
ಅಲ್ಲ ಪೆಟಿಷನ್ ಜೊತೆ
Petition copy.
Petition.
ಪೆಟಿಷನ್ ಜೊತೆಗೆ
One minute. Amended writ petition.
ಹೌದು.
ಅದರಲ್ಲಿ 24?
Yes.
Yes.
Unamended, right?
Sorry, yes.
ಇದು ನಾನು ನನ್ನ ಲೈನ್ ಆಫ್ ಥಿಂಕಿಂಗು ಥಾಟ್ ಅಲ್ಲಿ ಕರೆಕ್ಟ್ ಹೋಗ್ತಾ ಇದ್ದೆ. ಇವ್ರು ಮಧ್ಯದಲ್ಲಿ ಇದು ಮಾಡಿದ್ರೆ ಇದನ್ನ ತೋರ್ಸೋಕೆ ಪ್ರಮೇಯ ಬಂತ ಅಷ್ಟೇ, ಇನ್ನೇನಿಲ್ಲ. ಇದ್ರ ಬರ್ತಾನೆ ಇರಲಿಲ್ಲ.
Yes.
Kindly see, my lord, this chart which I have submitted to your lordship along with the writ petition for kind consideration is not in dispute. In fact, they would say, yes, this is correct. First case is, but in all these cases, she is the complainant.
53 cases.
Yes, my lord. Against whom? But I shall take one after the other. But first case is in crime number 790 of 2015.
Again for child sexual abuse.
Yes, my lord. She is in the habit of filing complaints after complaints, petition after petition. Against whom? I shall take your lordship one or two sentences. Well, at first complaint is at Electronic City Police Station for offence under section 376 and 506 and 468 and 12 of the POCSO Act. She is a complainant. Next, second is crime number 264 of 2016 under 328, 381, 506, Red section 34 against her sister. But now kindly go to next case, Electronic City Police Station 269 of 2017, 323, 341 against her son. Fourth complaint at Hulumau Police Station 186 of 2018 against her husband. Kindly go to next case, item number 5, crime number 188 of 2023 against her son. Well, now kindly go to page 26, item number 7, against the Additional Director General of Police of Karnataka. Item number 7. This, they would say, no, it is only a petition. A petition for action against the Additional Director General of Police in or in relation to a honey trap case. Well, at 8, 9, then, my lord, item number 13, against her son. Item number 16, against the Police Commissioner of Bangalore City. Item number 17, also against the Police Commissioner and another Srimati Yashaswini Gowda. Probably she may be a politician. Then, my lord, item number 21.
ಒಂದು ಇಲ್ಲ ಅಂದ್ರಲ್ಲ ಮತ್ತೆ
ಇದೆಲ್ಲ ಒಪ್ಕೊಂಡಿದ್ದಾರೆ
ಅವ್ರ ಮೇಲಲ್ಲ
ಅವ್ರ ಮೇಲೆ ಎಲ್ಲ ತೋರಿಸ್ತೀನಿ. ಇಲ್ಲ ಒಂದ್ ನಿಮಿಷ ಅದನ್ನೇ ತೋರಿಸ್ಬಿಡ್ತೀನಿ.
submission was she is in the habit of filing complaints, not even one
ಯಾರ ಮೇಲೆ? ಅವ್ರ ಪಾರ್ಟಿ ಲೀಡರ್ ಮೇಲೂ ಇದೆ ಇಲ್ಲಿ. ತೋರಿಸ್ತೀನಿ ನೆಕ್ಸ್ಟ್. ಅದ್ ಬೇಕಾ ಸ್ಟ್ರೈಟ್ ಅವೇ ಐ ವಿಲ್ ಕಮ್ ಟು ದಟ್. Kindly go to straight away. I will come to that, my lord. Kindly go to page 31.
not even a single case.
Kindly go to page 31.
ಬೇರೆ ಏನಾದ್ರು ಇದೆಯಾ?
Sir, ನಿಮ್ಮ ಪಾರ್ಟಿ ಲೀಡರು, present leader,
ಎಲ್ಲಿದೆ ಇದು?
spokesperson,
page
page 31. Kindly have a look at page 31. ಉಗ್ರಪ್ಪನವರು ನಿಮ್ಮ ಪಾರ್ಟಿ ಲೀಡರ್ ಅಲ್ವಾ?
ಅವ್ರ ಮೇಲೆ ಇದೆಯಾ?
31, 33.
ಎಷ್ಟನೇ ಐಟಮ್?
33 ಸರ್. ಏನ್ ಸರ್ ನೀವು, ನಿಮ್ಗೆ ಗೊತ್ತಿಲ್ವಾ ಅದು? ಅಲ್ಲ, ಅವ್ರಿಗೆ ಉಗ್ರಪ್ಪನವ್ರು ಗೊತ್ತು, ಕಂಪ್ಲೇಂಟ್ ಗೊತ್ತು, ಕ್ಲೋಸ್ ಮಾಡಿರೋದು ಗೊತ್ತು, ಎಲ್ಲ ಗೊತ್ತು ಪ್ರೊಫೆಸರ್ಗೆ. ಸುಮ್ಮನೆ ನಮ್ಮನ್ನ ಟೀಸ್ ಮಾಡ್ತಾ ಇದಾರೆ ಅಷ್ಟೇ ಅವರು.
ಪೇಪರ್ ಬುಕ್ ತೋರಿಸ್ಲಾ? ನೀವು ಹೇಳಿರೋ ಪೇಜೇ ಇಲ್ಲ.
ಪೇಜ್ ಇಲ್ದೇ ತಪ್ಪು ಕೊಟ್ಟಿದ್ರೆ ತಿದ್ಕೋತೀನಿ ನಾನು, ಅದೇನು ತಪ್ಪಿದೆ. 31 ಸರ್, ಪೇಜ್ ನಂಬರ್ 31, ಐಟಮ್ ನಂಬರ್ 33. ಮಲಡ್ ADGP ಅಲೋಕ್ ಕುಮಾರ್ ಅವರು ಮತ್ತು ಅವರ ಕಚೇರಿಯಲ್ಲಿನ 4 ಮಹಿಳಾ ಸಿಬ್ಬಂದಿ ಮತ್ತು 4 ಪುರುಷ ಪೊಲೀಸ್ ಸಿಬ್ಬಂದಿಗಳು ಅವಾಚ್ಯ ಶಬ್ದಗಳಿಂದ ಬೈದು ಥಳಿಸಿ ಗಾಯ ಮಾಡಿರುವುದಾಗಿ ಮತ್ತು ಶ್ರೀ ಉಗ್ರಪ್ಪನವರು ಬೆದರಿಕೆ ಹಾಕಿ ಒತ್ತಾಯಪಡಿಸುತ್ತಾರೆಂದು ಕೊಟ್ಟದೂರು.
ಆಮೇಲೆ
No, my lord. My learned friend submitted your lordship by way of interruption that these are all the complaints which she has filed. Complaints or petitions for inquiry, whatever it may be, and there is no case against her. That is an incorrect and inaccurate statement.
ಅವರ ವಿರುದ್ಧ ನೋಡಿರೋ ದೂರು ಅಂತಾನೆ ಇದೆ ಇಲ್ಲಿ.
ಅಲ್ಲೇ ಕೊಟ್ಟಿದ್ದೀನಿ ನಾನು. ಅಲ್ಲ, ಉಗ್ರಪ್ಪನವ್ರ ಮೇಲೆ ಬೇಕಾದಷ್ಟಿದೆ ಇಲ್ಲಿ. ಪೇಜ್ 34 ನಲ್ಲೂ ಇದೆ.
ಅಲ್ಲ, ಪೇಜ್ 36 ಅಲ್ಲಿ
36 ಒಂದು ಚಾಟೆ ಮಾಡಿದ್ದೀನಿ ನಾನು.
ಅವರ ವಿರುದ್ಧ ದಾಖಲಾಗಿರೋದು against the complainant.
Against the complainant. ಅಂದ್ರೆ why I am inviting your lordship kind attention is
habitual ಅಂತ.
ಅಲ್ಲ, kindly accept her statement. Do not accept her statement to its face value as true. Look at it with a pinch of salt. Only for that limited purpose. This is the backdrop of this lady. But the evidence is that she is a mentally retarded person.
ಓದ್ತೀನಿ
We'll see, yes.
ಓದ್ತೀನಿ ಒಂದೊಂದಾಗಿ ಓದ್ತೀನಿ ಪ್ರತಿಯೊಂದೂ. But this is the backdrop. By way of interruption, my lord, I was forced to, or I was compelled to invite my lord's kind attention to this.
Take a detour, yes.
Detour. ಅದಕ್ಕೋಸ್ಕರ ಅಷ್ಟೇ ಇನ್ನೇನಿಲ್ಲ. My lord, I was just submitting to your lordship that the date of offence being 2/2/2024, and the complaint would come into existence for the first time
On
May-
14/3/24.
on 14/3/2024 at 10 p.m. in the night.
Complaint.
Complaint 10 p.m. in the night. 1.5 ತಿಂಗಳೇ ಸುಮ್ಮನಿದ್ದು ಅವತ್ತು ಮಧ್ಯರಾತ್ರಿ, ಇಂದಿನ 2 ಗಂಟೆ ಆಗ್ಬಿಟ್ಟಿದೆ, ಮಧ್ಯರಾತ್ರಿ ಆಗ್ಬಿಡ್ತಾರೆ, 2 hours ಆಗ್ಬಿಟ್ಟಿದ್ರೆ 10 p.m. in the night. ಎಲ್ಲಿಂದ ಆಕೆ ಬರ್ತಾಳೆ, ಯಾರ ಮನೆಯಿಂದ ಬರ್ತಾಳೆ, some other politician, we are not on that point at this point of time. But anyway, a complaint is filed. In the complaint, my lord, the allegation that is made is that on the morning of 2/2/2024 between 11 and 11:30 a.m., my lord, the accused petitioner before your lordship has and made an inappropriate touch to her daughter. Thereby, my lord, he has committed an offence which is made penal under section 354 capital A and 8 of the Prevention of Sexual Offences Act. My lord, the investigation is over.
Investigation is over.
Over. Charge sheet is filed. Court has taken cognizance.
But why this appearance and other thing?
I'm sorry, my lord.
ಅಲ್ಲ investigation ಗೆ ಯಾಕೆ appearance ಎಲ್ಲ ಈಗ? ಅದು that's earlier, is it?
Earlier, during the pendency of this petition, my lord, in which petition I would seek for the quashing of the first information report, ಅವ್ರೇನ್ ಮಾಡಿದ್ರು? An observation came to be made by this honorable court while protecting my interest to some extent that the investigation can
Oh, charge sheet is already filed.
file. But by way of an amendment to this petition,
Oh,
I have
this amended writ petition.
yes, sought for the quashing of the order of cognizance and recording of further proceedings in the case. Well, let me invite your lordship's kind attention to the order of cognizance first. But I'm not satisfied, I'm not going to be satisfied even in the event of your lordship being persuaded to accept my submissions, that it is certainly not in keeping with the mandate of law as mandated under section 190 of the CRPC, as well as issuance of process as mandated under section 204. Probably your lordship may say, ultimately, if your lordship is persuaded to accept my submission on that point, all right, let us remand. No. But I want the whole proceedings to be quashed because the charge sheet has been filed. In fact, your lordship even directed me that now that the charge sheet has been filed, you can withdraw this petition and file a fresh petition seeking for quashing of the charge sheet. No. My lord, may I just request your lordship to kindly turn to page 121 of my amended petition. Compilation.
ಈಗ ಕೊಟ್ಟಿದ್ದ
ನಂದು ಕಂಪೈಲೇಷನ್ ಯಾತಕ್ಕೆ ಅಂತಂದ್ರೆ ಇಷ್ಟಪ್ಪ ಇದೆ ಬಂಡಲ್ಲು. ಐ ಹ್ಯಾವ್ ಮಿನಿಮೈಸ್ಡ್ ಇಟ್ ಅಷ್ಟೇ, ಇನ್ನೇನಿಲ್ಲ.
ಬಂಡಲ್
ಇದು ಅವ್ರ ಚಾರ್ಜ್ ಶೀಟು.
ನೀವು ಕನ್ನಡ ಹೇಳ್ಬಿಟ್ರೆ ಎಸ್.
Kindly read the proceeding sheet of the case dated 4/7/2024. Case called out, learned special public prosecutor present, heard and perused the office note and also perused the police report and the document submitted along with the police report, including
order sheet 4/7/24.
including the compliant FIR, statements of witnesses and the documents.
Copy is not served, is it, on the other side?
ಕೊಟ್ಟಿದೆ.
Yes.
ಇದು ಹೇಗೆ ಅಂದ್ರೆ ಒಲ್ಲದ ಗಂಡನಿಗೆ ಮೊಸರಲ್ಲಿ ಕಲ್ಲು ಅಂತ ಒಂದೊಂದ್ಸರಿ ಹಳ್ಳಿನಲ್ಲಿ ಗಾದೆ ಹೇಳೋದು, ನಾನು ಹೇಳ್ತಾ ಇಲ್ಲ ಇದಷ್ಟೇ, ಇನ್ನೇನಿಲ್ಲ. ದಟ್ ದಿ ಪ್ರವರ್ಬಿಯಲ್ ಸೇ.
ಎಸ್.
ಒಲ್ಲದ ಗಂಡನಿಗೆ ಮೊಸರಲ್ಲಿ ಕಲ್ಲು ಅಂತ ಅಷ್ಟೇ, ಇನ್ನೇನಿಲ್ಲ. On perusal of police report and documents produced along with the police report, there are prima facie materials placed records so as to proceed against the accused and also to issue process against the accused. Therefore, on being satisfied with prima facie materials, placed records exercising the powers.
So no reasons in the order taking cognizance.
Not commencing from
I have recently
GHCL,
Number one.
ತಾವೇ
Number-
appear
number
ಆಗಿದ್ದು
two,
recent ಆಗಿ ಒಂದು
my
ಬರ್ತಾರೆ.
lord, Sunil Bharti Mittal. Number three, Sharif Ahmed. Number four, the latest is Delhi Race
Oh,
Club.
I've written, where is the judgment?
ಬರ್ತೀನಿ ನಾನು. ಎಲ್ಲ ಇದೆ. Delhi Race Club, Sharif Ahmed, and then Sunil Bharti Mittal.
Delhi Race Club is 406 and 420 cannot coexist.
ಅಲ್ಲಲ್ಲ ಅದರಲ್ಲಿ ಕಾಗ್ನಿಸೆನ್ಸ್
Cognizance
ವಿಚಾರದಲ್ಲಿ
ಬಗ್ಗೆನೂ ಬರುತ್ತೆ.
ಕಾಗ್ನಿಸೆನ್ಸ್ ವಿಚಾರದಲ್ಲೂ ಸಹ ಅದರಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ ಅದರಲ್ಲಿ. Office is directed to register this case petition, issue summons to the accused. Well, straight away, it should go. It would be my respectful submission. Well, now may I request your lordship to kindly turn
Cognizance
to.
order ಮೇಲಾದ್ರೆ
ಅಲ್ಲಲ್ಲ, ಒಂದು ನಿಮಿಷ. Kindly go to the next page. 122. ಅಲ್ಲ, next page, order
Office.
sheet.
attend recording.
Office to attend regarding compliance of 35(1) of POCSO Act, securing statement under section 164, medical report, FSL report. Agar, which is the document which he has perused? For the purpose of coming to the conclusion that there exists a prima facie case without even adverting to the statement recorded under section 164? Milord, 164 statement is not there. Medical report is also not there. FSL report is not there. But the learned magistrate.
Cognizance is taken.
Learned magistrate would record, I have perused the documents and the papers filed. Incomplete papers. Even if he has perused, obviously it must necessarily be incomplete one. Most important, which the magistrate was required to advert to, apart from 161 statement, if any, but in the case of this type, 164 statement. That is also not before the court. Medical report is also not there. And he would say, I have perused the documents. Just like a blind man searching for a black cat in a dark room, which is not there. A blind man searching for a black cat in a dark room, which is not there. What is it that he has produced, Miller? I think this order of cognizance and issuance of summons, I would respectfully submit, is a mechanical one without proper application of judicial mind would be my respectful submission. But as I submitted to your lordship little earlier, I am not happy. I would not be happy. But even if my lord is persuaded to accept my submission and to agree with me ultimately, after hearing my learned friend, it warrants a remand. No. Now that this summons has been issued, a final report has been filed, and I have questioned the final report. Probably now I would be compelled to make my submissions on the merits of the matter now.
Should we
Continue, madam.
tomorrow?
ಆಗ್ಬೋದು. ಅಲ್ಲ, ನಾಳೆ ರಜಾ ಡಿಕ್ಲೇರ್ ಮಾಡಿದ್ದಾರೆ, ಹೈಕೋರ್ಟ್ ಡಿಕ್ಲೇರ್ ಮಾಡಿದ್ದಾರೆ.
Court is also declared?
ನಾಡಿದ್ದು ಹಾಕೋಣ. Subject to my lord's convenience of my learned friend.
Court is declared.
My lord may have to grant me 1 hour's time, minimum.
Also condole the death of
NI
the
Act,
former
of
chief,
course, yes.
unless the court.
That you need not even say.
And a notification.
When a notification is
Again,
issued,
No, I was not aware.
Negotiable Instruments Act.
ಅಲ್ಲ, NI Act ಅಲ್ಲಿ ಮಾಡಿದ್ರೆ it applies.
ಹೌದಾ?
I was not aware of.
I was not aware of the High Court notice.
So we'll day after tomorrow.
As my lord.
Day after tomorrow at 3:30.
My lord, I have to request your lordship to kindly grant me 1 hour's time, because there is an.
If it is going to stretch beyond time also, we will do it.
Please, please.
That
Provided you have no objection.
30ಗೆ ಶುರು ಮಾಡಿದ್ರೆ ಮುಗಿಸ್.
ನೋಡಿ.
ಬೇರೆ ವರ್ಕ್ ಎಲ್ಲ
ಇನ್ನ
ತೊಂದ್ರೆ
7
ಆಗುತ್ತೆ
ದಿನ
ಸರ್.
ಇಲ್ಲ,
ಬಾಕಿ ಇದೆ.
ಇವತ್ತು
Look
2:30
at it.
ಇವತ್ತು 2:30 ಸ್ಟಾರ್ಟ್ ಆಗ್ಲಿಲ್ಲ,
ಅಲ್ಲ,
ಅದಕ್ಕೋಸ್ಕರ
ಇವತ್ತು 2:30 ಇನ್ನೊಂದು ಇಟ್ಕೊಂಡಿದ್ದ.
ಅದಕ್ಕೋಸ್ಕರನೇ.
That adjournment ಗೆ it went on for 45 minutes. Yes.
4 o'clock minute? Oh,
3:30.
ಅಲ್ಲ, anytime my lord suggests I am bound to be here, I will be here.
3:30 will come.
3:30. Oh,
We'll give you time up to 4:30.
please.
ತಮ್ಗೆ ಎಷ್ಟೊತ್ತು ಬೇಕು?
ಮಾಡಿ.
ನಾನೊಂದು 3/4 ಗಂಟೆಲಿ ಮುಗಿಸ್ತೀನಿ.
ಹಾ, ಸರಿ. Then up to 5:30. Oh. ನಿಮಗೆ ಎಷ್ಟೊತ್ತು ಬೇಕು?
1 hour.
1 hour. Yes. 6:30.
6.
All right.
Or else on Monday.
ಬೇಡ್ರಿ, ಮುಗಿಸ್ಬಿಡೋಣ.
ಏನು?
ಅಷ್ಟೊಳಗೆ ಆಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಮಂಡೇ.
6:30 ಆದ್ರೂ ಸಾಲಲ್ವಾ?
ಅವತ್ತು ರೀಚ್ ಆಗಿ
ಗುರುವಾರ ಸರ್. 3:30 I will sharp take it. 1 hour, 45 minutes, 1 hour.
1 hour.
All right. Eye on the clock on that day. But the learned, senior counsels also, list on Thursday for further hearing at 2:30 PM, at 3:30 PM. And please prepare a synopsis, a list of whatever compilation, or prepare a convenience compilation of everything and place it before the court. You should have done it by now.
ನಂದು ಸಿನಾಪ್ಸಿಸ್ ಹಾಕಿದ್ದೀನಿ.
ತೊಂದ್ರೆ ಇಲ್ಲ, ಅಲ್ಲ ಅವ್ರು ಹಾಕಿಲ್ಲ ಅದಕ್ಕೆ. ನಿಮ್ದು ಹಾಕಿದ್ರೆ ಇದೆಯಾ ಸರ್?
ಹಾಕ್ತೇನೆ.
Synopsis
ಹಾಕ್ತೇನೆ.
Yes.
In fact, ಒಂದು tabular statement ಕೊಟ್ಬಿಟ್ಟು.
Better. It makes my job easier.
Yes.
Yes.
Ready reference.
Yes.
Please.
Three entry model subsisting shall stand extended to the next date of hearing. ಇನ್ನೊಂದು 330 matter. 330 ಬಂದ ಡೇಟ್ ಟೈಮ್ ಕೊಟ್ಟರೆ ಮ್ಯಾಟರ್ಗಳೆಲ್ಲ ಮುಗಿಸ್ಕೊಂಡು ಆಮೇಲೆ 230 ಎಷ್ಟು We'll just call out all 230 matters. In a further hearing, 230. Cell number 84.
Just one.
Before the end of the day, I will take it definitely.
They took time.
A second matter, alva? Nayantara madam. I will wait. Yes. See, one pass over, you will end up like this. Wait. Yes. 84.
54.
Please, Manoj.
No, 83. Shanti Bhushan Idravali.
83.
Anyway, he's gone. Innondina madam. 84.
84.
I appeal for the petitioner. Your Lordship may kindly see the order passed on.
That's 24 crores deposit.
We have deposited.
ಮಾಡಿದ್ದೀರಾ?
ಮಾಡಿದ್ದಾರೆ in the registry, Manoj. I may be given permission to withdraw it, but again, without prejudice to the quantum, Manoj.
Of course, that's
I
there.
will just
No,
pass on
I have,
the calculation.
I have something to say.
Withdraw ಮಾಡಕ್ ಬಿಡಬಾರ್ದಾ?
ಅಲ್ಲಲ್ಲ ಮಾಡ್ಬೋದು ಅವರು,
ಹಾ.
but they have mortgaged all these things in favor of financial institutions.
Which one?
Cleared.
No, you bring the letters,
The 10
deposit
crores-
all the documents in the court, and then subject to what the court says, you withdraw the money, not before that.
No, what is the problem now?
I'll just pass a calculation. Allows it also asked me to do a calculation. last
Put it.
time. I'm not with the 10 crores which was previously deposited in December. I've already cleared 3 mortgages.
All right.
And so far as there's only one more loan. I'll clear that also with this amount. I'm
All
ready.
No,
I've
sorry.
also produced documents to the effect.
I want him to deposit all the documents
No,
before.
are
the
they not
sample court.
entitled to this?
They are entitled, but I want,
Condition that you're
Milord, I
putting on
want to
entitlement.
Milord, I want to see
Ah.
that they have cleared all the mortgages on this property.
In fact, by way of a memo, my lord, I have also produced
Énidu?
proof to say what I've done with the 10 crores. I took every single rupee to ensure that the.
Of what?
cleared. Everything was cleared. So it is not that even with this 24 crores also, not whatever loans are there, I will clear it. The properties will be clear, it will be mortgage free. That I'll also produce proof to that effect.
Milord, my client has no trust, my lord.
I placed.
All that we are saying is this. What do you leave? Memo. Milord, I am submitting a memo to your Lordship, Milord.
Sir, distrust has led to these things till now. So now at least you should generate.
Milord, this trust will,
Allah, now at least you should generate trust.
Milord, that is just impossible, Milord, in this family.
2/4/2024, there's a memo, this is which I placed. Document number 9 will show all the payments that made to the bank.
No, they will produce it here. What if
Let
what
it produce all the
what is
originals.
done here?
Milord, my submission is this. All the original documents, let him place before the sample court. Let us see next
For
week.
what original documents?
Original agreements, there are 2 original sale deeds.
Hmm.
Let him produce before the sample court.
Sale deeds of what?
Sale deeds of 2 apartments.
Hmm.
They will have to be reconveyed to me.
All right.
They'll have to be cancelled and
You
registration.
want it to be encumbrance free?
Yes.
That is all?
Absolutely, man.
That they will do, yes.
It'll have to be that, Manoj, that either way, Manoj, if it is going to be a buyback, it has
Yeah.
to be a buyback itself. If
Yes,
it's a buyback,
definitely.
then I will
Where
do
is the question of encumbrance in that?
anything else, sir. There are 2 flats which are already registered to me. I cannot even go and see those flats. Now they moved an application for disobedience before the trial court saying that I'm trying to go. to
Of
court.
course, we have come and made there a lot of galata. That is a different issue. Milord, let him produce all the documents before your Lordship, then your Lordship may pass the
No,
order.
Manoj, what has to be looked at
Now
is,
you're
Manoj,
telling
what
us.
is the quantum? Manoj?
Milord,
Because-
they want the money and they don't want to agree to the amount also.
Not that I
Let
want
it-
the
let-
money. They are saying that they will not give me the flats, so they're giving me the money. That is how it is, because this was recorded also saying that 8 flats will be recorded, registered in my favor. Now they come and say, no, I'll give you the money. It's very convenient one because it's selling at 15,000 rupees.
My lord,
per
I
square feet.
don't want to join issue with my learned friend. I don't want to take your lordship's
Now,
time.
24 crores is deposited.
24 crores deposited. My lord, I am in your lordship's hands.
24 crores is deposited according to their entitlement. You
Yes.
want the properties to be
My lord, there is one more submission.
the properties that you're buying
No,
back
one
to
more.
be encumbrance free.
My lord, one
Correct?
more submission. Kindly bear with me, my lord.
Yes.
My lord, out of these 24 crores, where is the amount? My lord, about 1 crore 73 lakhs is to be deducted out of tax. There is a statutory requirement.
Hmm.
Under 197. My lord, I am paying
No,
one
no, it
17.
is not that 24 crores is his entire amount. He has claimed even
Please.
No, my lord, subject
full
to
and
that
final
condition.
settlement and then ಹೇಳಿಲ್ಲ ಅವರು.
My lord, only subject to that condition, let him accept all the amounts payable today before he withdraws the amount. I don't want to be mulcted with further liability.
No, there's no question of mulcting here. This is what you sow, so you reap. That is the problem in this. So you are restricting your claim to 24 crores.
No, no,
Last time itself I have said,
No, not even 24, is 23 crores 90 lakhs. I have deposited 10 lakhs extra. And out of this, my lord, kindly bear with me for a minute. 17 crores 60 lakhs 92,000 is the interest payable, and there is a statutory requirement that I deduct this tax deduction at source. That amounts to 1
what is
crore
the interest that
76,
is sought by you?
1 crore 76 lakhs.
I've given a breakup of 12% simple, 12% compound, 18% simple as well, man, because
The
this.
calculation
for the
ಕೊಟ್ರದ
honorable-
What is this calculation?
ಕೊಟ್ಟಿದ್ದೀನಿ. So
My lord, that is the reason why I don't want, my lord, either let him accept, otherwise let him
Just give
refund
my lords-
10 crores. I don't want anything further from your lordship.
Lord, I will
That
just
is
give my lords
sufficient.
a calculation as to how I've come to this figure.
I'll answer it on
I've said
merits.
12, I've said 12%.
We'll
And
answer
your
it on
lordship may
merits.
hear us on the
But
merits.
there's also another alternative. He's selling every flat at 15,000. 15,000 per square feet, whatever price it is, let it give to him. He will not give it to me because, my lord, it's a very simple thing for him to do. 16 crores he takes from me in 2014. Then he keeps it, utilizes it for whatever purposes. Thereafter, my lord, he then sells it at 15,000 per square feet today, and he says, no, I'll give you 34 crores, you take it and walk out. It comes to 54 crores, my lord. If all those 9 apartments are sold at 15,000 square feet, 54 crores. So each time.
My lord, let the matter be heard on merits, my lord. I do not.
Let the deposit be there. We will hear it on merits. Day after tomorrow, ಯಾವ್ದು ಹಾಕೋದು madam?
My lord, your lordship may
Friday.
have it after vacation.
No. After this, list the matter on
My lord, there are 3 accounts to be defreezed. Your lordship may kindly direct it.
which
them to
defreezement?
defreeze.
Your accounts.
Yes.
That also was
No
a
problem.
conditional order. They were supposed to deposit 50%. That's also not done.
My lord, one submission I would like to
But
make.
since I'm hearing the matter whole hog, on 17th, all that will be done. Yes, list on 17th at 3:30 PM for further hearing.
Please.
Yes.
Grateful.
On merit, sir.
Yeah, on
Finish
merit.
it off. Yes. File a synopsis of lists and dates and events. Have you- allow, advocate on record. Yes.
Alright.
85.
ಈ ಕಡೆ
85.
Yes. Including application ಆಗ್ತೀನಿ ಅಂತ. This is that matter where first matter.
ನೀವೆಲ್ಲಿದ್ದೀರಾ?
ಅಲ್ಲ ಒಂದಲ್ಲಿ ನೋಡಿ the.
ಇವರೆಲ್ಲಿದ್ದೀರಾ?
85 my lord Prasanna has argued last time.
ಇದಾ?
ಅದು ಬರ್ಬೇಕಲ್ಲ.
ಇದೆ correct. Perfect. ಪ್ರಸನ್ನ ಕುಮಾರ್ ಸರ್ ಅಲ್ಲಿ ಬೇರೆ which matter?
Hearing for complaint.
ನೀವು ಕಂಪ್ಲೇಂಟ್
Complaint.
ಮತ್ತೆ ಈ ಕಡೆ ಬಂದ್ರೆ ನಮ್ಗೆ ಹೆಂಗ್ ಗೊತ್ತಾಗುತ್ತೆ? ಎಲ್ಲಿ ಈ ಕಡೆ ಯಾರಿಲ್ಲ?
Your lordship heard him last time. This is that land, my lord,
ಕಾರ್ಗಿಲ್.
Kargil.
Yes.
In fact, my lord, the various documents which you have written to officer, seems to be there nothing such records or exist is what the department is also saying.
Which one? What records?
The Sainik board, communication with the Sainik
ಇವರು
board.
ಕಾರ್ಗಿಲ್ ಸುಳ್ಳು ಅಂತ.
ಅಲ್ಲ ಅವ್ರು ಇದ್ರು ಬಟ್ ಲ್ಯಾಂಡ್ ಕೊಟ್ಟಿರೋದಲ್ಲ.
But I had brought your lordship kind notice one letter.
ಅದೇ that's what you
ಅದು
told.
ಕೋಲಾರ ಅಂತ ಲ್ಯಾಂಡ್ ಇದೆ, ಇಲ್ಲಿ ನೋಡಿದ್ರೆ ಬೆಂಗಳೂರಲ್ಲಿ DC ಸೇಮ್,
ಇವರಲ್ಲಿ ಪ್ರವೀಣ್.
ನಾಟ್ ಶ್ರೀನಿವಾಸ್. ನಾಳೆ
ನಾಳೆ ನಾಡಿದ್ದು ಯಾವಾಗಾರ ಎಲ್ಲಿ ಪ್ರವೀಣ್
Monday,
he was here. Yes, sir.
That to argue that.
They had to argue ಅನ್ನಕ್ಕೆ ಇಷ್ಟು ಓಡ್ ಬಂದ್ರ?
They filed a vacating stay application.
That's why it was heard on the last occasion. ಅದು ಇವತ್ತು ಹಾಕಿರೋದು.
Please, my lord.
Yes.
ಒಂದು ಸಿನಾಪ್ಸಿಸ್ ಹಾಕ್ಬಿಡಿ.
Yes,
ನೀವು ಅಷ್ಟೇ. The way you succinctly put it, please put it.
Please,
Yes. And list of authorities also.
please,
We'll take it on Monday, 16th.
place these records, my lord.
ಕೊಡಿ records ಕೊಡಿ.
Madam.
And there was one more petition of yours. What happened?
ಇವತ್ತು ಹೇಳಿತ್ತು ಅದೇ ಬಂದಿಲ್ಲ therefore
So, the file is put up anyway. That criminal petition.
I filed my.
Gangappa, Sangappa, Rangappa. Yes.
ಈ ಕಲ್ಲಪ್ಪ ಮಲ್ಲಪ್ಪ ನಾರ್ತ್ ಕರ್ನಾಟಕ.
But in the other matter, I had filed my impleading application.
Which impleading application?
ಇನ್ನೊಂದು matter which is not listed today.
Where
Then
not,
implead- What, which matter?
ಅವ್ರಿಗೇನ್ ಸಂಬಂಧನೇ ಇಲ್ಲ ಅವ್ರಿಗೆ.
Which impleading application?
Lord, there is an.
ಅದ್ರಲ್ಲ.
Oh, there is a case against me, I'll contest it.
That's all right. We'll, seriatim will hear it, not tagging.
That was your lordship's earlier order. However, no,
ಅದು ಬಂದಿಲ್ಲ ಇದು anyway.
However, my lord, may kindly direct the registry to show my name so that I.
ನಿಮ್ ನೇಮ್ ಇಲ್ವಾ ಇಲ್ಲಿ?
ಅಲ್ಲಿ ನಾನು impleading application ಹಾಕಿದೀನಿ.
Application ಹಾಕಿದ್ರೆ
ತಪ್ಪಾಗುತ್ತೆ.
put up ಆಗುತ್ತೆ, ತೊಂದ್ರೆ ಇಲ್ಲ,
ತಪ್ಪಾಗುತ್ತೆ.
ಅದ್ರ ಪಾಡ್ಗದು. Yes. But file your synopsis
please, I shall.
and
I shall.
all of you. ಸೋಮವಾರ ಕೇಳ್ತೀನಿ. List on Monday
Please.
at 4:30 because Monday 500
Please,
4:30 ಆಗುತ್ತೆ. Yes.
please.
Alright, so record, ಇಷ್ಟೇನ records there, sir?
I have the entire record, but these are the correspondence which you have done with the Sainik board.
The allegation is that ಯಾವ land allot ಆಗಿಲ್ಲ ಅಂತ.
In fact, my lord, that they
will
claim that
report
the
it.
10 acres land has been
We will
granted
argue
to
on
them.
I shall make my
ಅಲ್ಲ,
submission.
submission
For
ನೀವು
any-
ಇರ್ಲಿಲ್ಲ ಅವಾಗ ಅದಕ್ಕೆ. The submission is that no, there is no allotment at all.
What Sainik board says,
Ah.
that he has given certain document, ask them to authenticate those documents.
What documents?
Whatever the land grant certificate which he claims that issued by the Sainik board,
Ah.
they say that he gave this document to authenticate. So the letter on the front says original document sought, and the back side is only say authenticate. You only authenticated, we are not issued any such letter.
So according to you, no land is granted to him at all?
No
Then
land.
what are so many litigations about that?
Lords,
The-
may I just say this, my lords? There are four documents three documents where they wanted to dispute. There is a Sagwali sheet, there is a Sagwali sheet register, there is an index of land, there is a record of rights, and constant revenue entries from an undisputed point of time. Lords, under the various circulars issued by the Revenue Department, it says, if the original file pertaining to the revenue of the grant is not available, contemporaneous documents will have to be looked into for the purpose of authentication. Notice, this is how Revenue Department is done. Now, as a matter of fact, adjudication takes place twofold. Number one, whether my grant is genuine or not is adjudicated under section 136(3). It is held that my grant is genuine. The grant of the complainant's vendors is adjudicated and it is found that their grant is bogus. Tahsildar files a complaint against them, saying that their grant is bogus. So now,
ಅದೇ ಚಾಲೆಂಜ್ ಮಾಡ್ತಾರೆ.
That's what not in the other petition, where not in the coordinate bench, not in KLR matter. There is an interim order that is concerned.
so
ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ಯಾಕೆ?
That's what, that was my contention in the other one.
that's essentially what we are saying, my lords. Matters are at large. Now, whether the findings which is recorded by the Deputy Commissioner quay my grant or the grant which is made in favor of our grant claimed by the vendors of the present complainant, whether it is genuine, not genuine, whether it requires a further investigation, further inquiry or investigation is a matter which will have to be decided by the coordinate bench dealing with the KLR matters. Here, what they wanted to do is they say that there are three documents which we have found that there are some aberrations in the dates. So on the basis of which we wanted to initiate criminal proceedings. But what remains is that there is a grant certificate, there is a Sagwali sheet register extract, and that is a report which is submitted by the Tahsildar also. Tahsildar very succinctly states that these are all the contemporaneous documents on the basis of which I am saying that there exists a grant. Monday 4:30.
Monday
Yes.
4:30.
Yes,
Even if it goes beyond 5:30.
I'll be here.
Yes,
Lords.
please.
Please.
ನೀವು ಅಷ್ಟೇ ಪ್ರಸನ್ನ ಕುಮಾರ್. And ಅದು, I'll take, ನಾಳೆ, what is that? Jagdish sir, the composition of the committee, first matter,
Yes.
we'll take it on Friday ಬೆಳಗ್ಗೆ.
Please,
By
Please.
then,
please,
what has happened, you just
we shall
place
update you.
it on record.
Please.
Yes.
ನಿಮ್ದಲ್ಲ.
ನಿಮ್ದಲ್ಲ ಇಲ್ಲ ಇದು, that association CBI matter.
ಫಾರೆಸ್ಟ್ ಒಂದು, ಅದೇ ಅಡ್ವೊಕೇಟ್ ಮೇಲೆ ಫಾರೆಸ್ಟ್ ಆಫೀಸರ್ ಒಂದು ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿದ್ದು ಒಂದು ಮ್ಯಾಟ್ರ್ ಇತ್ತು ಅವರು.
ಅದು ಇದೆಯಾ?
ಹಾ.
Serial number?
ಎಲ್ಲೋದ್ರು ಅವ್ರು?
Real number
ಬನ್ರಿ.
81 man.
80?
81.
81.
Further area.
81 ಅಲ್ಲ, 81 is Hashmat Pasha sir. Pradeep Kumar,
Yes, sir.
that is 80.
80.
Serve ಆಗಿದೆಯಾ?
Lords,
Is the complainant served?
the complainant, my lords, I am just filing a memo, my lords.
Complaint is present before the.
Complainant is present before the court. ಗವರ್ಮೆಂಟ್ ಕ್ವಾರ್ಟರ್ಸ್ ಡೋರ್ ಲಾಕ್ಡ್ ಅಂತ ಪೋಸ್ಟ್ ಮ್ಯಾನ್ ಕೈಲಿ ಬರ್ಸಾಕಿದ್ರು. ನಾವು ವಾಟ್ಸಪ್ ಅಲ್ಲಿ ಇಮೇಲ್ ಎಲ್ಲ ಕಳಿಸಿದೀವಿ, ಅದನ್ನ ಮೆಮೋ ಆಗ್ತಾ ಇದ್ದೀನಿ.
Government quarters locked.
ಹಾ, ಇದಿರ್ಲಿ, ಅವ್ರಿಗೆ ಬಂದಿದ್ದಾರೆ, ಏನ್ ತೊಂದ್ರೆ ಇಲ್ಲ.
ಕರೆಕ್ಟ್ ಆಗಿ ಬರ್ಸ್ಬೇಕು, ಇದೇನು ಲಾಕ್ಡ್ ಅಂತೆಲ್ಲ ಗವರ್ಮೆಂಟ್ ಕ್ವಾರ್ಟರ್ಸ್. And if the complainant is present, is she engaging anybody? ಕೇಳಿ.
Lawyer ಇಟ್ಕೊಳ್ತೀರೇನು?
Lawyer ಇಟ್ಕೊಳ್ತೀನಿ, ಇಲ್ಲಾಂದ್ರೆ party in person.
Lords, and
Yes.
Namaste, sir.
You're engaging any counsel?
Sir, I'll engage a counsel or I'll do in party in person.
Whatever,
sir.
if you want to appear party in person, you have to go before the committee.
Yes, sir.
If you want to engage the counsel, we'll grant you time.
I need
Either
time,
ways,
sir.
we'll grant you time of 10 days.
So I needed 1 month time. sir.
1 month, for what? For what, 1 month?
Since I have to go for office also, sir.
No problem. You're engaging the counsel, why do you need 1 month? Yes.
It's
Let's-
like otherwise I have appeared before the committee also, sir. It's
Which
like
committee?
for party in person.
You
sir.
already appeared?
Today they told me to submit the form, sir.
All right, you have submit the form.
Yes, sir.
List the, we'll list it on 19th.
Lordships,
Lordship
List
has
on
directed me
19.
to secure certain
Could you
records.
give the records? Get the records.
Can be
Some
called
more
at
records,
2:30
my lord,
minutes,
but
sir.
this is the-
Huh?
19th at 2:30.
19th at 3:30.
3:30, very well, my lords.
The learned additional SPP has produced the records as was directed earlier. The same is taken into the file. List the matter on 19th at 3:30 PM for the hearing. Yes,
Please, madam.
next. Madam, ಇದು earlier matter ತೆಗ್ದಿಟ್ಬಿಡಿ. For the hearing matter ಕರೆದ್ಬಿಡಿ. What is this batch matter 76?
76.
Nobody is there. You want 77?
77.
Yes, Rajat. 76 ಏನಿದು?
This is the matter where that accused is, my lord, he had forged and fabricated the chief minister and the governor's letterheads. One case, my lord, charge sheet has been filed and they had withdrawn one case.
ಅಲ್ಲ, 5 cases are there, all
Please,
5
ma'am.
cases the same.
No, my lord, he's a common accused.
Ah.
He is involved in multiple cases. Complainants are different, my lords, in this case.
All right, list on first week of Friday, 10th ಬಿಡ, on 17th January 2025 for further hearing.
2:30.
2:30. Yes, next. 77,
77.
Abhishek. Same day.
My lord, I appear for the petitioners.
Yeah, this is the journalist.
Yes, my lord, this is a matter regarding the journalist.
ಅದೇ ಮುಡಾದು ಹೇಳಿದ್ದು, ಅದೇನಾ ಇದು?
Yes, my lord.
ಏನಿದೆ?
File or objection, formal.
3 occasions they have taken time, my lord.
Finally, list the matter on 18th at the request of the learned additional SPP as a last chance to to file statement of objections or make his submissions as the case would be. Interim order subsisting would continue till the next date of hearing.
My name might be shown, my lord.
Interim order will be the final one, my lord.
It's a detailed interim order. Not,
There is-
back at the time.
There is a detailed interim order, my lord, which
Yes,
is,
finally on 18th,
yes, my lord.
failing which petition will fail. Yes. Next.
78.
Balraj. This is 7A. This 7A and 13, I had heard this. Code.
I appear for the respondent, your worship.
It's
7A case.
13 or 7A?
7A.
Placed on 18th.
Yes, please.
Yes. Next. Adu ನೀವು ಅದು 7A 13.
Here case.
ಇದು 13. Huh?
I appear short accommodation.
Short accommodation. Why? It's 13, madam. All the orders I have passed already. Kodi. My entry order kodi. It's covered by what I have passed, what I pronounced today also. All 13 cases. Yes, reserved. Next.
Interim order may be extended.
That litigation. Next. Pradeep Kumar Raikal. What is dictating judgment yavudu sir? Submissions idea?
But FIR was registered for 354. Charge sheet is filed for 376. Lord, they were the friends, my lord, for 2 years continuously.
I've heard.
But, she had attended the birthday party in the house
I
of.
know,
the-
yes.
That
Head
case.
massage.
Yes, my lord.
Began with head massage.
Yes.
Yes. Ade case alva idu?
It do not
Yes.
constitute offense of 376, my lord, your lordship.
No, if it stayed at head massage, it would not have constituted. Otherwise, allegations are so many.
Sir, allegations are there, but they do
Yes.
not constitute
No,
offense
I
of
will answer.
376. your
Ade alva idu? Yes. No, I only said I remember the facts. So.
The fact is, this victim, my lord, she had attended a birthday party hosted by
sir.
this accused.
Yes.
My lord, along with other 5 girls. My lord, after party, my lord, they went away. After 5 days, my lord, she lodges a written complaint of her own handwriting. There is no allegation of sexual harassment.
354 was the allegation.
354 was the allegation. Well, even that, my lord, do not constitute because they were friends, my lord. We have produced, my lord, many materials to the effect that they were exchanging, my lord, texting messages, my lord, for 2 years. They had relationship also.
Yes.
In
So
this background, my lord,
they were
even
consensual acts is what you
yes,
said.
consensual act is there, my lord.
We'll reserve it.
My lord,
I've heard it anyway.
My lord, he is a software engineer. Because of this case, my lord, his prospect of going to other, my lord, foreign country, my lord,
Other-
for a better
Prospect of going to foreign country, ನೀವು other ಅಂತ other parties ಅನ್ಕೊಂಡ್ಬಿಟ್ಟೆ.
not, my lord, that he has a better
Attending
future,
other
my lord.
parties has become difficult.
He has a better future, my lord. That's how it is. It is this case, my lord, is coming on the way. Require, my lord, your lordship's
No, I'll reserve it. I'll pass by next week. We'll pass some order.
oblige
Yes, heard reserved.
interim order.
Interim order to continue to the disposal of the petition. Any
4
judgments
o'clock
ಏನಾದ್ರು ಕೊಡೋದಿದೆಯಾ ಕೊಡಿ.
4 o'clock matter, my lord, your lordship.
4 o'clock.
Second list, your lordship. This is, my lord, a boy alleged an offense of POCSO against a lady of 52 years.
Oh, this is strange case ಅಂತ ಒಂದು
Yes,
interim
yes,
order
your
ಕೊಟ್ಟಿದ್ದೀನಿ
lordship,
ಅದ. Yes.
So that,
But this was to be listed on Friday, not listed today. It has been listed.
Friday I was not sitting, I guess.
Yes, my lord.
That's very good.
My lord, this is a case, my lord, because of some,
That 69.
my lord,
69, right?
69, my lord.
ಮೊಹಮ್ಮದ್ ಮುಬಾರಕ್ ಅಂತ ಇದೆ ಅದ.
ಅದೇ.
ಹಾ.
69.
No,
my
but-
lord. Yes.
Who is the complainant there?
Complaint is the mother, my lord. Respondent number 2 is the mother. My
But-
lord, when this.
Mother should be served ಅಲ್ಲ?
Not ordered, but office have put a note. I requested your lordship, but for verification, my lord, it was.
No, here the
allegation.
lady of 52 years
Yes, my lord.
alleges that
16-year.
A 13-year-old.
13-year-old boy, my lord, is.
13-year-old boy has
Also Act, my lord, applies, my lord.
against gender
Ex-
neutral.
Yes.
Delhi High Court, my lord, has dealt
No,
with this issue.
POXO Act is gender neutral. It applies to both.
It applies to both.
But
my
whether
lord,
it is, whether the facts are, ingredients are met or not,
But
we'll see.
after 4 years, your lordship,
Complaint is after 4
after
years.
4 years delay, my lord, they have lodged a complaint. My lord, after the alleged act, my lord, continue to appear, continue to attend to the house of the accused. They were normal. There is no allegation of any of this.
Now, this lady of 52 is alleged to have committed sexual assault on a 13-year-old boy.
13-year-old boy. This is the allegation, my lord, after 4 years. And no other corroborative material except this complaint allegation, my lord. This complaint is
See,
got prepared
anyway,
with
but-
legal consultant.
But
my
the
lord.
complainant has to be heard.
They travel, my lord, they go to Dubai. The family of the victim,
All right.
there they take him to psychiatrist. There he discloses this issue. Therefore, she comes back and files a complaint.
So those 4 years are explained in that
Explained in
manner.
that complaint. And 164 statement, my lord, is clearly discloses the various acts committed by the petitioner.
All right.
Lord, the instance, my
No,
lord.
committed by the petitioner.
Yes, ma'am.
So you say 52-year-old lady has indulged in sexual assault of a 13-year-old boy.
Yes.
Yes.
Lord, this was said to be, my lord, on 17/5/2020, your lordship.
Yes.
After that, my lord, this boy was continuously coming to the house of
Well, it will-
petitioner. There is no allegation, my lord, that after 6 months, my lord, they left India and went to Dubai. They stayed there for 4 years. There was no allegation. This boy, my lord, he was away from this atmosphere, my lord. He was there in Dubai, lonely, no one was there. My lord, he was mentally affected. Then, my lord, he has been subjected for scanning and every examination diagnosis, my lord, doctors have said he is not suffering from any traumatize. There is no trauma to him. He is a normal person. My lord, they consulted, my lord, a legal consultant, got prepared a complaint of constituting offense of POXO. My lord, this is a false allegation, your lordship, that no such instance at all. And they were the neighbors, my lord, for 6 months only. And there is an allegation of some financial allegation also. And she is a well-known artist, my lord, that they want to.
Well-known artist.
Yes, my lord, she is recognized, my lord, that your lordship may kindly see many art material, my lord, we have produced to show.
Art that way.
Yes.
And he was called to take
Well,
photographs. While
Well-known
taking
art, well-known artist.
She has been recognized, my lord, with many awards, your lordship. Knowing this, my lord, her position in the society, they want to spoil her life.
So she's an architecture and design consultant. A well-known artist, and I thought film.
Not film artist, your lordship. This is, my lord, architecture.
Yes.
And your lordship can see, my lord, many of this, my lord, architecture
but-
work, my lord, we have produced it along.
No,
with
if you have to consider your prayer for quashment, the complainant has to be heard.
Your lordship is on the limited point whether the act attracts the other way as
Oh,
granted. stay,
let
my
us
lord.
decide about gender
Yes,
neutrality
yes,
and
yes,
then.
That has been settled by Delhi High Court.
That I am
judgment.
aware.
Yes,
No, even according to me,
that's
in my considered view also, it should be, every issue, everything should be
Correct.
gender neutral.
correct.
No, that is, my lord, it is not our contention, my lord, that it.
No, that's
doesn't-
not a contention, but I have to answer it.
But
yes.
here, delayed factor itself, my lord, not 1 day or 1 month, it is 4 years, my lord. They have not alleged any allegation before leaving to Dubai.
In
My lord,
fact,
a particular date is fixed here, 17/5 is the date. After 17/5/2020, my lord, this boy regularly was attending to the house of petitioner.
Where is the complainant in Bangalore?
My lord, they were from Cochin. They stayed, my lord, in Bangalore, my lord. This is, your lordship may kindly, my
No,
lord,
you serve the complainant.
complainant, my lord, address is in Bangalore only.
Serve the complainant.
And we'll
Em-
take steps, my lord,
At
but
page-
primarily, my lord,
Page
that
86 of the petition, there is a counseling has been done in the counseling report also has been placed in there.
even
apart
before
from 160.
counseling also, this boy never disclosed that this lady had committed it.
Page 86.
My lord, only a trauma was disclosed.
After Samalochana were there, the counseling, yes.
In the next page, my lord, at the fourth line.
Anyway, let the complainant come.
These are all, my lord, after registration of FIR, in the police department, my lord, some of the persons appointed, my lord, they have recorded, they have copied the allegations made in the FIR.
This FIR, if your lordship peruse, my lord, it has been prepared by a well-known legal person
Of course, that is.
constituting the offence, my lord. I relay, my lord, the decision of
Mohammed
Mohammed
Ali.
Wajid case.
Mohammed Ali.
Muhammad Ali's case.
Mohammed
and
Ali first, Mohammed
Wajid
Wajid next.
also. Both, my lord, the honorable court has to. While
Those are
exercising
back-to-back judgments of the
Yes.
same day, 950 and 951 of
between the lines,
2023.
my lord, your lordship has to read this complaint.
Between the
Otherwise,
lines.
my lord, it results, my lord, miscarriage of justice.
Let the complaint be served. Emergent notice to the complainant. Heard the learned senior counsel Hasmat Pasha and learned additional SPP. Emergent notice to the complainant. We'll take it on the first week of January. I've
Yes.
granted an interim order anyway.
Yes, yes.
Yes.
Interim
This-
order to continue.
Yes. So and so. Emergent notice to the complainant returnable by January 14th, 2025.
Please.
Tuesday. Holiday, sorry, January 15th. January 15th, 2025. Less the matter on January 15th, 2025 at 4 p.m. for further hearing. Yes.
Lord, serial number 57, well, I'm troubling lordship. This is a case, my lord, for 2 years, my lord, they were living, my lord, as living in a relationship. My lord, she was age of 30 years, married lady. My lord, got separated from husband.
Oh, the big group ಅಲ್ಲಿ ಇದೆ.
Yes,
Further hearing
my lord,
ಅಲ್ಲ.
big group, my
ಅದು
lord,
ಆಮೇಲೆ.
interim order may be continued. my
Interim
lord.
order will continue in every case which is not called. Yes.
But because of this case, my lord, she is lodging one or the other complaint. My lord, police are calling him because she is capable
Interim
of
order
looking
ಕೊಟ್ಟಿದ್ಯಲ್ಲ.
after them. This is, your lordship, that this has become an indirect harassment to this petition.
But interim order ಕೊಟ್ಟಿದ್ಯಲ್ಲ.
This is interim order for this, additional complaint by complaint.
Challenge. Complaint ಮೇಲೆ complaint, challenge ಮೇಲೆ challenge. ಅಷ್ಟೇ. Yes. Next, 230 matters.
Interim order to continue.
That will continue.
Mood matters, fresh matters, still number 1, Srivastava Gowda, MM.
Please. Petition.
Records, original.
Please, my lord. Petition by accused number 1, my lord.
ಏನ್ ಗ್ರೌಂಡ್ 138 ಅಲ್ಲಿ?
138
ಅಲ್ಲ
ಅಲ್ಲಿ, my lord, the
420.
my lord, ಇದರಲ್ಲೂ my lord, they file complaint, my lord, on 6/7/2023, complainant files.
So
138, my lord, he files on 18/10/2023.
now both are pending.
Both are pending.
ನಡೀಲಿ ಬಿಡಿ. Okay.
Double jeopardy, my lord.
Double jeopardy. 138 is quasi criminal, sir. It is not even criminal. Yes.
My lord, other 2 accused have approached this honorable court and my lord, interim order has been granted.
ಅದು ಕೊನೆಗೆ ಅಸ್ತ್ರ ಇರುತ್ತೆ. ಕೊಡಿ, yes, so and so. Tag with so and so, same order.
Please.
Heard the learned senior counsel Vignesh Shastri appearing for the petition.
Oblige.
Yes, Shankar.
My lord, in this case, my lord, I am a petitioner, my lord, the petitioner, the complaint, my lord, and accuser, my lord, brother and father.
Brother and father.
Please, my lord, brother and sister and father. My lord,
What
kindly
is
see,
the
my lord,
problem now?
Ink page number 14, my lord. The complaint, at least complaint has to be filed, my lord. Date to time na.
230 ಗೆ ಯಾಕೆ ಮಾಡಿದ್ರಿ?
ಅಲ್ಲ, ಅದರಲ್ಲಿ ಸಮನ್ಸ್ ಇಶ್ಯೂ ಆಗಿದೆ. Kindly see, my lord, petition number 7, my lord, aged about 85 years. You won't father of the complaint. 85 years old, man.
ಏನು allegation?
Kindly see, my lord, allegation in the ink page number 14. ಅಲಿಗೇಷನ್ ಏನಾದ್ರೆ 4ನೇ ತಾರೀಕು ಆಯ್ತು ಅಂತ ಹೇಳ್ತಾರೆ. ಲಾಸ್ಟ್ ಅಲ್ಲಿ ಕೈನಲ್ಲಿ ಬರೀತಾರೆ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ 14/10.
ಏನ್ ವಾಟ್ ಇಸ್ ದಿ ಅಲಿಗೇಷನ್?
ಅಲಿಗೇಷನ್ ನಮ್ಮ ತಂದೆ ಕಾಳೇಗೌಡ ನಮ್ಮ ತಾಯಿನ ಮದುವೆ
ಅಸಾಲ್ಟ್.
ಏನು ಅಸಾಲ್ಟ್ ಏನಿಲ್ಲ ಇದರಲ್ಲಿ.
ಏನಿಲ್ಲ.
ಅಲ್ಲ, ಉಂಡ್ ಸರ್ಟಿಫಿಕೇಟ್ ಏನಿಲ್ಲ. ತಾವು ದಯವಿಟ್ಟು
ಎಸ್ ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ ಕಾಪಿ ಕೊಟ್ಟಿದ್ದಾರೆ ಅದಕ್ಕೆ?
ಚಾರ್ಜ್ ಶೀಟ್ ಕಾಪಿ ಕೊಟ್ಟಿದ್ದೀನಿ. ಕೈಂಡ್ಲಿ ಸಿ ಮೈ ಲಾರ್ಡ್, ಇಂಕ್ ಪೇಜ್ ನಂಬರ್ 23.
ಎಲ್ಲಿದೆ ಉಂಡ್ ಸರ್ಟಿಫಿಕೇಟ್?
ಇಲ್ಲ, ಉಂಡ್ ಸರ್ಟಿಫಿಕೇಟ್ 23. ಅದಕ್ಕೆ ಇಂಕ್ ಪೇಜ್ ನಂಬರ್ 23 ಕಾಲಮ್ ನಂಬರ್ 17.
ಅಸಾಲ್ಟ್ ಗೆ ಉಂಡ್ ಸರ್ಟಿಫಿಕೇಟ್ ಇಲ್ವಾ?
ಇಲ್ಲ, ಕಾಲಮ್ ನಂಬರ್ 17 ಇಂಕ್ ಪೇಜ್ ನಂಬರ್ 23 ಲಾಸ್ಟ್ ಲೈನ್.
ವಾಟ್ ಇಸ್ ದಿ ಸಿವಿಲ್ ಸೂಟ್?
ಸಿವಿಲ್ ಸೂಟ್ ಇನ್ ಇಂಕ್ ಪೇಜ್ ನಂಬರ್ 38.
ಅಪ್ಸರ್ಕಂಡ್ ಅಪ್ಪನ್ ಕೊಡಿದ್ರು.
ಸೂಟ್ ಫಾರ್ ಪಾರ್ಟಿಷನ್.
ಫಾದರ್ ಅಂಡ್ ಚೈಲ್ಡ್ ಯಾಕೆ ಕೊಡಿದ್ರಿ?
ಅಲ್ಲ, ನಾವು ಹೊಡೆದಿಲ್ಲ ಸ್ವಾಮಿ, ಸುಮ್ನೆ ಕಂಪ್ಲೇಂಟ್ ನೋಡಿ 4/10 ಇದು ಅಲೀಸ್ ಇನ್ಸಿಡೆಂಟ್ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿರೋ 24/9 4/9 ಇನ್ಸಿಡೆಂಟ್ 24/9 ಕಂಪ್ಲೇಂಟ್.
20 days ಡಿಲೇ.
20 days ಡಿಲೇ.
ಹಾಸ್ಪಿಟಲ್ ಟ್ರೀಟ್ಮೆಂಟ್ ತಗೊಂಡು.
ಟ್ರೀಟ್ಮೆಂಟ್ ಇಲ್ಲಿ ಇಂಕ್ ಪೇಜ್ ನಂಬರ್ 23.
ಅಸಾಲ್ಟ್ ಮಾಡಿದ್ಮೇಲೆ ಟ್ರೀಟ್ಮೆಂಟ್ ತಗೊಳ್ಳೋ ಟೈಮ್ ಬೇಡವಾ?
ಪೇಜ್ ನಂಬರ್ 23 ನಲ್ಲಿ ದಯವಿಟ್ಟು ಒಂದೇ ಒಂದು ಲಾಸ್ಟ್ ಲೈನ್ ನೋಡ್ಬಿಡಿ.
23.
ಹಾ ಸ್ವಾಮಿ. ಅಲ್ಲೆಯಿಂದ ಸಾಕ್ಷಿ 1-2 ರವರೆಗೆ ಚಿಕಿತ್ಸೆ ಪಡೆಯುವಂತ ಪೆಟ್ಟಾಗದಿರುವುದು ಈ ಕೇಸಿನ ತನಿಖೆಯಿಂದ ಆರೋಪ ದೃಢಪಟ್ಟಿದೆ.
ಚಿಕಿತ್ಸೆ ಬೇಕಾಗದೆ ಇರುವಂತದ್ದು.
ಆರೋಪ ದೃಢಪಟ್ಟಿದೆ.
ಮತ್ತೆ 324 ಹೆಂಗ್ ಬಂತು? 126 is 324.
ತಪ್ಪನ್ನು ಕೊಡ್ತಿದಾರಲ್ಲ ಅಂತ.
ಅದಕ್ಕೆ aggravated assault. Yes. The petitioners are before this court calling in question proceedings in CC so and so for registered for offence punishable under so and so. Madam, adu offence punishable under so and so. The learned counsel appearing for the petitioner takes this court through the documents appended to the petition to demonstrate that in a case of assault, the finding of the investigating officer is that there was no injury that was caused that needed treatment. It is ununderstandable as to how an offence under section 324 of the IPC could spring without any injury being caused to the petitioner, to the complainant. Therefore, there shall be an interim order of stay.
BNS ಇದೆ 350.
ಅದು ಹಾಕ್ತಾರೆ.
Please,
Both BNS, 126 BNS, yes, next.
please. Oblige.
ಅದು 126 BNS, next. Yes, next. Hemant Kumar.
Number 3.
This is the second complaint. First complaint ಅಲ್ಲಿ
Stay ಆಗಿದೆಯಾ?
ಇಲ್ಲ.
ಮತ್ತೆ ಕಾಪಿ
ಅಲ್ಲ, first
ಕೊಟ್ಟಿದ್ದಾರಾ?
complaint ಅಲ್ಲಿ
ಕಾಪಿ ಯಾಕೆ ಕೊಟ್ಟಿಲ್ಲ? ಆಶ್ಚರ್ಯವಾಗಿ ನೋಡ್ತಿರಲ್ಲ.
ಸರ್ವ್ ಮಾಡಿ.
What is shocking about that? ಕಾಪಿ ಕೊಟ್ಟಿದ್ದೀರಾ ಅಂತ ಕೇಳಿದ್ರೆ yes 498
ಪ್ಯಾರಾ ನಂಬರ್ 5 ಅಲ್ಲಿ ಇದೆ ಮೇಲೆ. ಫಸ್ಟ್ ಕಂಪ್ಲೇಂಟ್, ಫಸ್ಟ್ FIR ಅಕ್ವಿಟ್ ಆಗಿದೆ ಮೇಲೆ.
2 to 5 Kailas Ben. Next. The petition, the learned counsel for the petitioner submits that the the subject complaint is second in line and the petitioners have all been acquitted in the first complaints registered by the complainant on the same cause of action. Amele permitting further proceedings, finding nothing. Yes, next.
4.
Chandrasekhar.
Page number 53, GNWC proceedings, my lord, and the MC petition also pending, my lord, for dissolution of marriage. After filing of the FIR, my lord, these two proceedings came to be filed. Allegation, my lord, the child aged about 4.5 years, my lord, said to have been taken away by these petitioners.
GNWC, in whose custody is the child in terms of the GNWC?
It is in the custody of father, my lord.
Where is the order?
There is no order on petition, my lord, page number 53.
No, petition ಕೇಳಿರೋದು ಯಾವುದಕ್ಕೆ ಸರ್? ಕಸ್ಟಡಿ ಯಾರು ಕಸ್ಟಡಿ ಕೇಳಿದ್ರು?
As the father asked the custody of the child, my lord.
Is it granted?
No, my
So,
lord.
custody, child is with the mother.
Mother.
Why did you take away the child?
My lord, on the guise of settlement of the matter, my lord.
Why did you take away the child? You are the father.
No,
You are the mother.
Mother.
Yes, in the meantime, next.
Number 5. Shant AV.
My lord, this
You have read the matter? Yes, tell me.
Lord, this is a matter where the petitioners have been arraigned as the accused number 1, 2, and 3 in crime number.
Copy ಕೊಟ್ಟಿಲ್ವಾ ಇದನ್ನ? Copy should be given here. How many times should I tell every advocate? Yes.
In crime number 0260 of 2024, my lord.
What is the offense?
My lord, the offense is under the.
Atrocities Act.
Please, my lord. My lord, there's a prior complaint that is filed by the petitioner. My lord, may you kindly look at annexure G, my lord.
Page
Page number 50, my lord.
50.
Please, my lord.
What happened to this?
My lord, in this, the petitioner has filed a complaint where one Mr. Victor and Chandru, my lord, who have along with.
Petitioner has filed a complaint against the complainant.
Please, my lord.
All right. 23/9/2024. What is the date of the impugned complaint? 27/11/2024. ಅಲ್ಲಿ ಯಾರ ಮೇಲೆ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ರಿ ಮೇಡಮ್?
My lord,
Victor and Chandru.
Victor and Chandru, my lord. And they were accompanied by 7 others, my lord. My lord, if may kindly.
Who are the present complainants against you?
Please, 1 second. My lord, kindly look at page number 54, my lord. My lord, this is a statement, that is given by one of the respondents, one of the complainant, my lord. They have told that one Mr. Manjunath, along with the 7 others, one of the 7 others is Manjunath, my lord. He is the one who has filed this Atrocities Act complaint, my lord.
Yes. Heard the learned counsel appearing for the petitioner, so and so. I'll take the name. The learned counsel for the petitioner submits that the first petitioner registered a complaint on 23/9/2024 against one Victor Chandru and 7 others. The statements of those persons were recorded by the police, including the present complainant, one Manjunath. As a retaliatory step or as a counterblast to what the petitioner has registered, springs the impugned complaint, including the offences under the Atrocities Act. In the light of the offence being, in the light of the registration of the complaint being a counterblast to what complaint the petitioners have registered against the complainant and 7 others, the permitting further proceedings, further investigation would become an abuse of the process of the law, albeit prima facie. Therefore, there shall be an interim order of stay of further investigation qua this petitioner till the next date of hearing. List the matter on 18th in the fresh matters list. Copy could eagle.
Grateful.
Yes, next.
Number 6.
But I, for petitioner in this case. My lord, the petitioner, a complaint have been registered against the petitioner for an offence punishable under section 353 of BNS Act. My lord. BNS. My lord,
353 of BNS is 505.
yes, my lord. My lord, the petitioner is a editor of a newspaper. Now, my lord, he has published one article. As against that article, my lord, he has just written a letter to the magistrate and FIR have been registered.
ಏನ್ ಬರೆದ್ರಿ ಆರ್ಟಿಕಲ್ ಅಲ್ಲಿ?
My lord, he says that ಅದರಲ್ಲಿ ಅವ್ರಿಗೆ he doesn't make allegations in the complaint. What is written in the article, he never states.
What did you write?
My lord, he has taken some bribe and he has tried to close the breweries and all those things. And finally he went to the, in Chamarajanagar, my lord. My lord, this article was published after he being transferred to that place.
One ನಿಮಿಷ. ಯಾರು this 19/10/2024 this Abakari Ayukta?
Yes, my lord. He is the complainant.
He is the complainant.
Yes, my lord. As against him, I have written an article, my lord.
Oh,
Your
no,
lordship, my
you
lord.
wrote an article
Yes, my lord.
3 years ago.
No,
He was trapped. I quashed the proceedings. That is affirmed by Supreme Court.
Yes.
After that, this complaint has come against you because you wrote that article. ಇದು ಯಾವುದು? ಚಿತ್ರದುರ್ಗ ಅಲ್ವಾ?
ಅಲ್ಲ, ಚಾಮರಾಜನಗರ.
ಚಾಮರಾಜನಗರದ್ದು.
Yes.
ಅವರು ಚಿತ್ರದುರ್ಗದಲ್ಲಿ ಇದ್ದಾಗ ಏನೇನ್ ಮಾಡಿದ್ರು
ಚಿತ್ರದುರ್ಗದಲ್ಲಿ ಇದ್ದಾಗ ಏನೇನ್ ಮಾಡಿದ್ರು ಅಂತ ನೀವು ಬರೆದ್ರಿ.
ಬರ್ದಿದ್ದೆ. ಸೊ
ಅದನ್ನ ನಾನು ಕ್ವಾಶ್ ಮಾಡಿದ್ದೆ. This is in 2022.
ಅದು
230 ಮೂವ್ ಮಾಡಿದೆ. ಏನ್ ಅರ್ಜೆನ್ಸಿ?
My lord, his wife is also a inspector, police inspector. She is influencing for a charge sheet. So therefore I moved it, my lord.
ಈಗ ನೀವು ಸ್ಟಾಪ್ ಮಾಡಿ ಸಾಕು. ಆರ್ಗ್ಯುಮೆಂಟ್ ಅಲ್ಲ, ನಿಮ್ ಕ್ಲೈಂಟ್. Yes. Yes. So and so. Heard the learned counsel appearing for the petitioner. What is alleged in the case at hand is the offence punishable under section 353 of the BNS, which is 505 of the earlier regime, the IPC. Not an iota of ingredient that is necessary for an offence under section 505 of the IPC is even present in the case at hand. Therefore, there shall be an interim order of stay of further proceedings so and so till the next date of hearing. Idu quash agidde agid complaint agirodu. Yes. Next.
Order still number 7. Jagdish.
I appear for petitioner in this case. This case and the serial number 11, my lord, is connected to same.
7 and 11 na?
Yes, my lord.
ಒಂದೇನಾ?
Yes, my lord.
7 ಯಾವುದು?
7 by the state.
11 ಯಾವುದು?
11 by the complainant.
What's the problem?
The issue, my lord, is with respect to granting police custody. The offence alleged in this case, my lord, is imprisonment up to 10 years. Now, the BNSS says, my lord, the custody can be taken if it is 10 years above, up to 60 days, because charge sheet filing of charge sheet is 90 days. So we have moved an application before the expiry of 60 days, asking for police custody because subsequent to doing the investigation, a series of mobile devices have been analyzed and where we found that various other investigation is required to be done. So we moved an application. Now the trial court says, my lord, since the imprisonment is only 10 years, you have to, you left the right at 40 days, not 60 days. The filing of charge sheet is 60 days, not 90 days.
Which provisions?
Now 187, my lord.
Of the BNSS?
Yes, my lord.
Hmm. Madam.
One distinction one distinction between BNSS and CRPC. My lord, it says that old CRPC, my lord, your lordship may see 167 says 90 days where the investigation relates to an offense punishable with death or imprisonment for life or imprisonment for a term not less than 10 years.
Yes,
That's 90 days.
all
Now,
right.
your lordship may see in the BNS,
Hmm.
90 days where the investigation relates to an offense punishable with death,
Death, imprisonment of life,
or imprisonment for a term 10 years
or
or more.
term 10 years or more. Not less than 10 years or more than 10 years. So you say threshold bar is 10 years.
10 years.
All right. Yes.
So that is the offense contemplated, my lord, is up to 10 years.
Hmm.
So therefore, our submission was that the 90 days is what required to be complied, not the 60 days as contemplated in the earlier regime of CRPC. That is the argument, my lord. Of course, trial court relying on the Supreme Court judgment of 2017 says that, my lord, no, you have, the limitation is only 60 days or not 90 days. That per se, my lord, is may not be correct.
So you hinge upon whether it is less than 10 years or 10 years or more.
Yes, my lord, because earlier it says up to not less than 10
No,
years.
no, not less than 10 years. Now, not more than, now it is 10 years or more.
10 years or more.
So that's the
Distinction.
difference.
That's the difference. Your lordship may see.
Regular in language.
In
Yes.
fact, my lord.
In fact, your lordship
Same
will be-
footing.
Your
To add
lordship-
to-
I had
Yes.
passed one order
And I
where
have it,
15 days at
copy-
the
copy-
beginning and not passes case.
That, my lords, now.
I had said fruit of the poisonous tree cannot be relied upon. Yes.
And in fact, in that matter, my lord, now the Honorable Supreme Court has said, my lords, 15 days can be at any point of time, one thing.
No,
Yes, my lord, this-
first 15 days.
Now it is now, my lord.
No,
Correct,
no, in
correct.
BNSS.
Yes, yes.
No, that is,
CRPC.
that is
there's
Justice
one
M.R. Shah has
Doubted the-
doubted that and
Correct.
that is now
My lord, in
settled now.
No, it's still
Sundaresh,
pending.
now it's in amended provisions. It's
Amended
written-
provision
yes.
early.
No, you are.
But 15 days at the beginning of the
Correct.
investigation was what was earlier permitted. Not ನಿಮಗೆ ಯಾವಾಗ ಬೇಕು ಅವಾಗ 15 days ಅಲ್ಲ.
That is doubted, please. That was doubted in
Refer
Senthil,
to a larger bench, I
Correct.
guess.
Senthil Balaji's case, my lords. Where
Senthil
is
Balaji
doubted.
case, it is
And
doubted.
now, my lords, anyhow, now on that point, my lords, law is now clear. It can be
Because the BNS says that-
section itself, BNSS now says, my lords.
BNSS,
Please,
that
please.
is, yes.
That
Hmm.
Kulkarni's case, CBI versus Kulkarni,
Yes,
now
yes.
stands.
That is 1994.
Exactly, my
Yes.
lord. Now stands legislatively overruled.
Yes.
My lord, this question what my learned friend is putting, my lords, and under the old law, on 167 CRPC, the law was, it should be not less than 10 years.
Not less than 10.
Then it will, death, life imprisonment or an offense not less than,
Not less than 10.
then it's 90.
So not less than 10 years is 10 years.
Yes. Not less
Not
than.
less than 10 years can stretch up to 10 years. Correct?
No, my lords, the Supreme Court said not less than means it should be minimum. That's what the Supreme Court is. Rakesh Paul's case, my lords, in two cases, your lords, the Supreme Court analyzed it. And the after 3 judges, my lords, honorable, 2 judges said not less than means should be minimum. The honorable 3rd judge, Justice Pant, said, my lords, this is the language used, not less than can also be
10 years.
may extend to. So these two, avoid this confusion. Now, while amending the provision, my lords, they have deleted this not less than.
More than incidentally.
10 years.
10 years or more.
Or more. Or
So
more.
it stops at 10 years.
Yes.
Yes, yes.
Hmm.
So therefore, my lords, now the offense is punishable 10 years. Now, my your lordship, this wordings will also come for a debate, my lords. What is the meaning of up to and only 10 years if it's written? What is the effect, my lords? Your lordship had considered this point in the Copyrights Act, my lords. Whether it's
That is 63 when I interpreted.
Exactly,
saying
my
3
lords.
years,
There-
up to 3 years.
yes, exactly. My lord. There the section punishment is up to 3 years, whereas in the
So I
schedule
said
two-
it can stretch up to 3 years.
Yes,
So it is a cognizable offense.
Now, my lord, after my lord's order, in fact, the Supreme Court
Supreme
considered-
Supreme
very
Court
point.
confirmed it and
Yes.
reiterated.
Yes.
So that now the point of law is very clear, my lords, when the law says and the legislature wanted a change. Earlier decision will not be holding good. Now what the learned magistrate does is, earlier decision said it should be minimum in Rakesh Kumar Paul. Therefore, I have to apply that decision. Despite the fact, my lord, the learned public prosecutor put forth this contention, the law has now been changed. Now, my lord, our respectful submission is, now for this offense, punishment is up to 10 years. Therefore, it's necessarily comes within clause 1, the minimum need not be there. So the period for filing, completing the charge sheet under 167 or now 187, my lords, is 90 days. So they are entitled to police custody is one aspect. Now, the urgency is this, my lords. Taking cue from the London magistrate dismissed on the application and that Rakesh Kumar said it should be minimum. Therefore, I hold that period is only 60 days. Therefore, police custody is dismissed one aspect. Second aspect is.
You are aggrieved by the dismissal of police custody?
I am appearing for the first informant because, my lords, it's my brother who, my London friend is
Appearing for
here.
the
He will
accused.
support, you support the, support the order.
all
My
right,
London
all
friend will support.
And I thought all this while you are appearing for the.
It's for the-
Hagadre, let Pasha sir say it, yes.
Please, my lord,
Yes, sir.
please.
87 provision which is, my lord, under the new BNSS Act. My lord, here the consideration, my lord, substantive offence, your lordship, which are alleged, my lord, punishable to the extent of 10 years.
10 years. No.
Already
it
this
it
is, my
10
lord,
It
your
is
lordship.
10 years and more.
Yes, 10 years and more. To the
Or-
sorry, this, my lord, your lordship, offence alleged, my lord, similar to 306. Now 108, my lord, is invoked.
Yes.
My lord, this is abetment to commit suicide.
Suicide, yes.
Punishable to the extent of 10 years is not clear 10 years that is been interpreted by the Supreme Court in Rakesh Kumar Singh case.
Hmm.
My lord, this provision has already been interpreted. My lord, this substantive offence, my lord, IPC, your lordship has to consider.
Hmm.
Not, my lord, there is no dispute with regard to this. My lord, this BNSS, my lord, what it is used is, it should be minimum of 10 years or more. 10 years or more. This, my lord, offences punishable, which are punishable to the extent of death, life imprisonment, or 10 years or more, it should be a clear of 10 years or more. To the extent of 10 years is not 10 years and above. Therefore, my lord, that the offences which are invoked here are punishable to the extent of 10 years, cannot be said as 10 years or more. The magistrate has rightly considered the decision of the Supreme Court and also the decision, my lord, that they should have availed
So
with
the interpretation now rests with
Yes.
10 years or more.
or to the extent of,
10
to the extent of.
Now, if it is 10 years, 1 minute. If it is 10 years, the investigation should get concluded in
60 days.
60 days. If it is beyond 10 years, it is 90 days.
Yes,
Correct?
yes, your lordship. That is, my lord, definitely
Even
it
if
is.
may read that clause, clause one, my lord.
No, 10
90
years.
days, comma, where the investigation relates to an offence punishable with death, comma, imprisonment of life, or imprisonment for a term of 10 years or
Ah.
more.
That is 90 days.
90 days.
All
So
right.
it should be 90. The clause 2, your last mail, 60 days, where the investigation relates to any other offence.
Oh, it is,
60 days, any
Not
other
a-
offence. So
that's a blanket.
Yes.
or-
Here it's punishable with the 10, with the 10 years. So their contention is, it should be not less than 10. So the section says 306 of IPC says, my lords, punishable with imprisonment up to 10 years. It's not clear, it's only 10, it's up to 10 years. Therefore, it should be. That content, in the earlier code, my lords, 167.
No, we will have to steer clear this problem.
In fact, the
My lord,
Supreme Court
here-
judgment on this issue, my lord.
The, my lord,
Taking
Bo-
advantage of this observation of the London magistrate while dismissing the police custody. Now an application is filed yesterday stating that investigation is not completed 60 days. We are entitled to bail on the 60, on this.
my
This
lord, that
They
is
are
a
entitled
statute.
to bail. If investigation is not complete, they are
Yes,
entitled
yes, if they have
to statutory bail.
statutory bail, my lord, but
Should be 90 days, my lord. It's not 60. Because offense punishable with the 60 day minimum 10 year, punishable with the 10 years here in the present case. If clause 2 is applicable, my lord, in other cases. Whereas 10 is not provided. Clause 2, you are not mechanically see 187 clause 2.
Here-
60 days.
Anyway,
my lord, you
tomorrow is a
one,
holiday.
one submission.
One
my
ನಿಮಿಷ,
lord.
tomorrow is a
One-
holiday. Day after
ಅಲ್ಲ-
tomorrow will still
ಅಲ್ಲ-
clear this.
My lord,
ನಾಳೆ ಯಾವ ಕೋರ್ಟ್ ಫಂಕ್ಷನ್ ಮಾಡ್ತಾ ಇಲ್ಲ ಸರ್.
How it's going on.
What is going on?
Today
Today
is
is
my lord, on this ground. That this all report, the magistrate has already held, my lord. That.
ಈಗ arguments are going on for what?
On this default bail.
Default bail.
On this
my lord,
observation.
ಮಳೆ ಏನಿಲ್ವಲ್ಲ.
This observation.
one submission, my lord.
ಇವತ್ತು
My lord,
Supreme
there
Court
is,
taking up the matter today is what been told.
my lord, bail, regular bail petition also pending before High Court. My lord, since
Regular bail you
my lord,
argue.
after expiry of 60 days, my lord, they have invoked the provisions of 187 for statutory bail that is also pending consideration. Here, my lord, that the
Now, what have you
My lord,
challenged?
here you lordship may kindly see, my lord, compared to old code and new code, my lord, there is no difference. There is no difference in this. My lord, it should be about 10 years and above, only 90 days applies.
Let's.
My lord, to the extent of 10 years, my lord, is not clear 10 years. This has been interpreted by the Supreme Court in Rakesh Kumar Pal's case. And also in Raju Chaudhary's case, my lord, this has been interpreted. Rakesh Kumar and Raju Chaudhary's case, my lord, is very clear. The similar provisions are invoked here. To the extent of 10 years is not clear 10 years.
In fact, the very language in 167 is very clear. It says not less than 10 years is the language. Therefore, Rakesh Kumar Supreme Court says not less than 10 years, it has to be
Not
10
less
years.
than
No,
10 years,
here
here
it is
more
not-
than
not-
10 years.
It is
10 years and more.
Yes.
10 years and more, both are same, meanings are same.
And more illa, David, or 10 years. or
10
more,
years,
10
10 years or
or
more.
In
Not,
other cases, 60 days, in other cases.
in fact,
not
now
less
the
than-
present code by words, by virtue of 10 years or more rigor. It is more rigor, the period should be 90 days for that. Clear 10 years should be punishment or more. And this has been interpreted by this court, my lord, that
We will have to see the interplay between IPC offense and.
IPC offense, my
And
lord, is
CRPC.
substantive.
Where is CRPC?
Where is CRPC agala? IPC offenses, my lord, punishment to
See,
the
now
extent of.
it says 10 years or more.
Yes.
We will have to look into the BNS corresponding
DNS
offense.
corresponding
Adhral
provision,
ಏನಿದೆ?
my lord, is very
What is
clear.
the offense here?
My lord, 108, my lord, 108,
Yes.
up to
10
illa,
years.
to the extent, your lordship.
No, no, what is the offense here?
108, your lordship.
306.
108 is
Abetment to
equivalent to
suicide.
306.
No, abetment to suicide.
Abatement to commit suicide.
Ah, yes.
Is
Adhral-
to the extent of 10 years, my lordship.
That's why we say class 1 is the extent of 10 years.
1 minute, 1 minute.
Note,
In other
it is
cases,
not clear 10 years. To
here
the
it is
extent
like
of 10 years.
section ಒಳಗಿಲ್ಲ.
This has been interpreted by the Supreme Court in Rakesh Kumar and Raju Chaudhary continuation.
That's Rajiv
Many,
and Rakesh.
Raju,
Give me that copyright judgment.
I think that gave me.
Nandu, Nandu.
And also subsequent.
Supreme Court then
Then,
same reasoning was given later.
Exactly.
Justice Nagaratna ಅವರು.
How? My lords, the same point answers this because schedule 2, the word is used same. Schedule 2 CRPC up to. And the honorable court says when the law says up to, which means that punishment is also applicable. So the law says, my
All
lord.
right, issue ಅಷ್ಟೇನಾ?
That's the
And
issue.
now, my lord, there is an observation made by the learned magistrate in that application, dismissing the police custody application. That only 60 days. Now, based on that, now if the learned magistrate, based on that observation, proceeds further. Nothing remains here.
my lord, here,
Because they will be now granting the
Lord,
167 on that.
as,
basis.
Let
as,
the- let
lord-
the
lordship,
magistrate-
here, my lord, that
No, let the magistrate hold its hands till day after tomorrow. ನಾಳೆ ಹೆಂಗೂ ಇಲ್ಲ ಕೋರ್ಟ್.
Now argument is going on, exactly.
ನಿಮ್ದೇನು? It's all right. We'll decide about the language day after tomorrow. Yes.
this one decision, your lordship.
ಕೊಡಿ, ಎಲ್ಲ
Raju
ಕೊಡಿ.
Chaudhary. My lord,
Because these things will keep cropping up. We'll decide it.
clear period of 10 years. To the extent is not clear period of 10 years. That is what it is said.
Again,
Kind-
that of the
ಕೊಡಿ,
Rakesh.
ಕೊಡಿ.
How?
Same language, same words are interpreted.
Tomorrow anyway, it is, courts are closed. So day after tomorrow morning I'll pronounce it. Or afternoon at 2:30. Yes, we'll still clear it.
This require consideration, your
Yes.
lordship, your lordship. has to
Detailed
decide.
consideration. ಇಷ್ಟ ಇರೋದು ಇನ್ನೇನಿದೆ?
Also, my lords, whether police custody is required, because as a first information.
No, if that you want, then we can't stall the bail. Statutory bail, as far as the interpretation now is concerned, we
yes.
can't
Lord,
hold
this
this.
is-
I mean, if your lordship interpret against us, question of police custody does not arise.
Does not arise at all.
Yes, yes.
If your lordship interpret otherwise, then
Have to be granted.
your lordship can.
You want the police custody to be granted.
Police,
Now, who is abetment to suicide, ಏನು?
Extortion also, my lord, what happened is, my lord, this is the fact of extortion.
Police-
Now, video recording, audio recording is found. They want to confirm it by with reference to voice.
My lord,
They protect it. And this is dismissed on this ground.
one submission, my lord. Police custody also, they are not entitled because 60 days is already expired. My lord, even in respect of offenses of,
One minute, sir.
of 90
You're
days,
going
60
to
days.
say, if the investigation period is extendable by 90 days in terms of the provision, your 15 days police custody also gets extended between that date?
No, 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 no.
Eh?
Up to 60 days.
No, 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 no.
Up to 60
Your
days.
police custody for 15 days in those 60 days.
Yes, madam.
Any period in those 60
Yes.
days and not the beginning of
Not-
15 days.
Yes, madam.
But that does not get extended to between those 60 to 30.
No,
Yes.
that is not our contention.
One point.
60 days is
We have
already
filed-
60 days is over now.
over now.
We have
it
filed
is over.
application before expiry of the date.
No, 60 days is over now. So
Yes,
there is no
today is
question of police
66
custody
days.
now.
Alala, since we have filed an application before expiry of the date.
That's all right.
our
Now
order-
60 days are over. Where is the question of police
Alala,
custody?
the trial court rejected it saying that up to 60 days, your custody, you're entitled for custody within 40 days, not 60 days.
Reason may be wrong. We'll see.
That's the only thing. Ali, your lordship.
Point out, my lord, Supreme Court said, if a wrong order has been passed by the magistrate, my lord, during this
ಹಾಗಾದ್ರೆ ಒಂದು 15 ನಿಮಿಷ wait ಮಾಡಿ. We'll take up all the cases. Wait. You don't argue. Urgent ಮನೆಗೆ ಹೋಗಕ್ಕೆ. Then wait.
I wanted to say, Senthil.
5:30 I'll call you back. Yes.
In the meanwhile, document director.
In the meanwhile ಏನು?
Magistrate is about to.
ಅಲ್ಲ ಅಲ್ಲಿ let him hold his hand.
I'll tell you.
5:30 I'll call you back. Yes. Let us finish other cases. Yes. Sir. Abhishek,
Bill number 8. Prasad Shantan.
ಏನಿದೆ?
Number 2. The allegation is wrongful confinement, extortion, and criminal importation.
ಕಾಪಿ ಕೊಟ್ಟಿದ್ದೀರಾ?
Copy, yes.
Yes, Jagdish.
The allegation against accused number 2 is, allegation against accused number 1.
ಏನೀಗ ಅರ್ಜೆಂಟ್ ಏನ್ ಮೂವ್ ಮಾಡಿದ್ದು?
Hearing before that.
360, ಹಿಯರಿಂಗ್ ಬಿಫೋರ್, ಹಿಯರಿಂಗ್ ಅಷ್ಟೇ ತಾನೆ? ಯಾವತ್ತಿದೆ ನೆಕ್ಸ್ಟ್ ಡೇಟ್? List on Monday in the fresh matters list, copy ಕೊಡಿ. Yes, next. 9. Osmani.
Sister-in-law has filed a complaint against the petitioner.
What?
Proceedings Act. Aldi says filed a complaint 2 years back, my lord, that is fixed for trial, my lord. Now with the new allegation that on the way of Vijayadashmi, my lord,
ಇದು ಕಾಪಿ ಕೊಟ್ಟಿದ್ದೀರಾ? ಯಾವತ್ತು ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಯಾವತ್ತಿದೆ?
state ಇಲ್ಲ ಸುಮ್ಮನೆ FIR ಆಗಿದೆ, they have filed a application for cancellation of bail, my lord.
Cancellation of bail. Yes, list on Friday in the fresh matters list. No coercive steps or precipitative action shall be taken against the petitioner till the next date. Yes, next. One HCG, additional SPP is directed to accept notice for the respondent. Copy ಕೊಡಿ ಈಗಲೇ.
10. Withdrawal.
In terms of.
Okay.
Yes, PP ಇದೇ ಆಗಿದ್ದೀಗ. Yes, next. Raghu. ಹಾ. Hmm.
Now, my lord, as per the except A, page number 70, the special court has taken a copy with under the province of Kerala.
You serve on Unni Krishnan,
Please, my lord, sir, with my lord,
served already
I'll serve you. I'll undertake to.
in urgency. And
Lord, the appearance is for tomorrow.
the learned counsel, M. Unni Krishnan is directed to accept state illegal. Directed to accept notice for the respondent enforcement directorate. The petitioner shall serve requisite set of papers upon the said counsel. List the matter on Monday in the fresh matters list. Till such time, the appearance of the petitioner before the enforcement directorate stands deferred. Before the special court stands deferred. List on Monday. Sivate Kodi. 13 withdrawal. Sirajuddin.
14.
Sirajuddin. Your serial number 14? 13 withdrawal, madam. Memo ಇದೆಯಾ? ಏನ್ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದಾರಾ? ಮೆಮೋಲಿ ಹೇಳಿದ್ದೀರಾ? Have you said so in the memo? In terms of the memo, yes. Withdrawn in terms of the memo, liberty granted. Next. Shanti Bhushan. Sirajuddin illa? Yes, list on Tuesday. Then ನೆನ್ನೆ ಹೇಳಿದೆ ಅಲ್ವಾ ಮೇಡಮ್? The list on Tuesday. Next. ಇನ್ನೆರಡು ಮ್ಯಾಟ್ರ್ ಯಾವ್ದು? ಕಾರ್ತಿಕ್ ರೆಡ್ಡಿ.
Subsequent and multiple FIRs not are being registered, not by the respondent, very same second respondent. Not first FIR may not is at page number 37.
Same ground?
Not on a ground, not your lordship will find in the first FIR complaint, not a list of not.
Which is the first FIR, sir?
Not page number 37. But the same Raghavendra S. may not the employee, the authorized officer of the company, not alleging that not page 45 my lord will find. Not these 18 vendors had not had submitted bills, and I have cleared these bills. Or may not, I have cleared these bills, not on the allegation is may not these vendors had may not fabricated certain bills. Now, with reference to different vendors, not one more FIR, not I was granted not anticipatory bail not on page 50, not by the learned session judge.
Yes, Jagdish.
Now,
Earlier FIR is limited to 2023 and 24.
this is in violation of not
It was available then.
242 BNSS, not in respect of 1 year, not everything that takes place.
All right, Monday in the fresh matters list, not to precipitate or take coercive action against these petitioners to the next date.
Please.
ಅದು ಓದ್ಕೊಂಡ್ಬಂದ್ಬಿಟ್ರೆ
Please.
ಕಾಂಪ್ರಹೆನ್ಸಿವ್ ಎಂಟ್ರಿ ಮಾಡ್ಕೊಡ್ಬೋದು. Yes, next. ಸ್ವರೂಪ್.
ಅಲ್ಲ, ಅದ್ರ ಮೇಲೆ ಮತ್ತೆ not, let them not, I am told that they
No precipitative action or coercive
not
action.
on,
Both.
ಮತ್ತೆ ಬೇರೆ ಏನಾದ್ರು ಮಾಡಿದ್ರೆ.
Supreme Court says it virtually stay. Yes.
ಅಲ್ಲ, ಮತ್ತೆ ಇನ್ನೊಂದು ಏನೋ ಥರ್ಡ್ ಫೋರ್ತ್ FIR ಮಾಡಬಾರ್ದು ಅಂತ.
ಅದನ್ನ. Can that be stopped, sir? Yes.
ಮಾಡ್ರಿ, ನಾಳೆ ಇನ್ನೊಂದು ಹಾಕ್ತೀನಿ.
ಅಷ್ಟೇ. ಇನ್ನೊಂದ್ ಮಾಡಿದ್ರೆ ಇನ್ನೊಂದ್ ಹಾಕ್ತಾರೆ.
ನೀವು ಹಂಗೆಲ್ಲ ಸ್ಟಾಪ್ ಮಾಡ್ಬೇಡಿ, ಅವ್ರು ಹೇಳ್ಬೇಕು ಇನ್ನೊಂದ್ 2 ಹಾಕ್ಸಿ ಅಂತ.
ಎಸ್ ಸ್ವರೂಪ್, ಗುಲಾಮ್ ಮುಸ್ತಫಾ,
Milords,
ಇವ್ರೇನ್ ಕಟ್ಟಲ್ಲ ಬಿಡಿ ದುಡ್ಡು.
Milords, out of 19 crores, 17 crores is paid.
ಮತ್ತೆ ಕ್ರೈಮ್ ಬೇರೆ ರಿಜಿಸ್ಟರ್ ಆಗಿದೆ ಈಗ.
Milords, the crime is registered because initially when I had taken
GM ಅಲ್ಲಿ ನಾನು ಟೈಮ್ ಕೊಟ್ಟು ಸಾಕಾಯ್ತು. ಕಟ್ಲಿಲ್ಲ.
17 ಕೋಟಿ ರೂಪಾಯಿ ಕಟ್ಟಿದೆ. ಅವ್ರು ಹೇಳ್ತಿರೋದು 5 ಕೋಟಿ ಇನ್ನ ಬಾಕಿ ಇದೆ ಅಂತ, ನಾವು 3 ಕೋಟಿ ಬಾಕಿ ಇದೆ ಅಂತ ನಾವು
ಕ್ರೈಮ್ ಯಾಕೆ?
ಕ್ರೈಮ್ ಏನಕ್ಕೆ ಅಂತಂದ್ರೆ 16 apartment was mortgaged for the purpose of obtaining the loan of 19 crores. 10 apartments are sold. 6 apartments are still there. For 5 apartments, there was a prior charge of IDBA, which is for 1.5-2 crores.
ಬ್ಯಾಂಕ್ ಹಾಕಿರೋದಲ್ಲ.
Bank files a complaint saying that I have
ಆರ್ಮ್ ಟ್ವಿಸ್ಟ್ ಮಾಡಿ.
armed twist.
ಬೇರೆ.
Yes,
ಇನ್ ದ ಮೀನ್ ಟೈಮ್ ಹರ್ಡ್ ಲರ್ನೆಡ್ ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್.
grateful.
ಇದು GM ಅಲ್ಲಿ ನಾನು ಒಂದು 6 ತಿಂಗಳು ಟೈಮ್ ಕೊಟ್ಟು ಏನೂ ಆಗ್ಲಿಲ್ಲ. ಅದಕ್ಕೆ ನೇಮ್ ನೋಡಿದ ತಕ್ಷಣ ಗೊತ್ತಾಯ್ತು ಇವ್ರೇನ್ ಕಟ್ಟಲ್ಲ ಬಿಡಿ.
ಇಲ್ಲ, ಈಗೆಲ್ಲ ಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರೆ ಪಾಪ.
ಹೌದಾ? ಇವ್ರು
ಹಾ,
ಸುಪ್ರೀಂ
ಈಗೆಲ್ಲ
ಕೋರ್ಟ್
ಕಟ್ಟಿದ್ದಾರೆ.
ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಡ್ಮೆಂಟ್ ಇದೆ ಒಂದು.
ಹಾ.
ಇವ್ರದೇ.
ಸರ್, ಅಲ್ಲಿ NCLT ಹೋದ್ಮೇಲೆ ಎಲ್ಲ ದುಡ್ಡು ಕಟ್ಬಿಟ್ಟಿದ್ದಾರೆ.
ಅದಕ್ಕೆ ರವಿಶಂಕರ್ ಅವ್ರ ವಾಯ್ಸ್ ಸ್ವಲ್ಪ ಕಡಿಮೆ ಇದೆ, ಇಲ್ಲ ನೀನು ಜೋರಾಗಿರುತ್ತೆ.
ಅಲ್ಲ ಅದೆಲ್ಲ ದಟ್ ಡಸ್ ನಾಟ್ ಮೇಕ್ ಎನಿ ಡಿಫರೆನ್ಸ್. ಕೇಸ್ ವೀಕ್ ಆರ್ ಸ್ಟ್ರಾಂಗ್, ಈಸ್ ಆಲ್ವೇಸ್ ಸ್ಟ್ರಾಂಗ್. ಎಸ್ ಭಗವತ್ ಸರ್, ಯಾವ್ದಕ್ಕೆ?
29.
ಒಂದ್ ನಿಮಿಷ ನಾನು ನೆಕ್ಸ್ಟ್ ಮ್ಯಾಟರ್ಗೆ ಅನ್ಕೊಂಡೆ.
79 ನಲ್ಲಿ.
ಒಂದ್ ನಿಮಿಷ ನೆಕ್ಸ್ಟ್ ಮ್ಯಾಟರ್ ಮುಗಿಸ್ತೀನಿ.
For the
ರಾಜಣ್ಣ ಮನೆಗೆ ಹೋಗ್ಬೇಕಾ?
ಇಲ್ಲ.
ಹಳೆ ರಜಾ ಹೆಂಗೋ ಇರಿ. ಎಸ್.
ಪ್ರೊಟೆಸ್ಟ್ ಮಾಡಿದಕ್ಕೆ ಇಟ್ಸ್ FIR has been registered against
ಎಲ್ಲಿ ಪ್ರೊಟೆಸ್ಟ್ ಮಾಡಿದ್ರಿ ಸರ್?
in a road actually ಅಂತ ಅಲ್ಲ
ಯಾಕ್
road ಅಲ್ಲ,
road ಅಲ್ಲಿ
ಕಡಬ
protest
ಟೆಂಪಲ್
ಮಾಡಿದ್ರಿ?
ಕಡಬ ಟೆಂಪಲ್ ಮೈದಾನದಲ್ಲಿ ಅಂತ ಹೇಳ್ತಾರೆ.
ಯಾಕೆ ಪ್ರೊಟೆಸ್ಟ್ ಮಾಡಿದ್ರಿ?
ಕಸ್ತೂರಿ ರಂಗನ್ ರಿಪೋರ್ಟ್ ಇಂಪ್ಲಿಮೆಂಟ್ ಮಾಡಬಾರ್ದು ಅಂತ, ದಟ್ ಶುಡ್ ನಾಟ್ ಬಿ ಇಂಪ್ಲಿಮೆಂಟೆಡ್ ಅಂತ ಹೇಳಿ ಒಂದು ಪ್ರೊಟೆಸ್ಟ್ ಮಾಡಿದ್ದಾರೆ. ಆಲ್ ದಿ ಅಗ್ರಿಕಲ್ಚರಿಸ್ಟ್ಗಳು 2 MLAs ಇದ್ದಾರೆ, ಅಲಾಂಗ್ ವಿತ್ ಪಿಟಿಷನರ್.
Hope you went up? Yes. List on 19th. There shall be an interim order of stay for the further investigation till the next date of hearing. 1 additional SPP, 2 emergent notices. Next. 2:30 mood mugita? Yes. Now come back.
Nothing else. 79 ತಾವು ರಿಸರ್ವ್ ಮಾಡಿದ್ದೀನಿ, ನನ್ನ ನೇಮ್ ತೋರಿಸ್ಬಿಡಿ, ಯಾಕೆ ನನಗೆ ಆ ಕೋಡ್ ಹೆಲ್ಡಪ್ ಆಗ್ಬಿಟ್ಟು.
ತೋರಿಸಿದ್ದೀನಿ ನೇಮ್.
ನಮ್ಮ ನೇಮ್ ತೋರಿಸ್ತಾ,
ಇನ್ಯಾರ ನೇಮ್ ತೋರಿಸಿ? ನಿಮ್ ನೇಮೇ ತೋರಿಸಿರೋದು. ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ನೇಮ್ ತೋರಿಸ್ಬೇಕು.
ಯಾಕಂದ್ರೆ ನಾನು ಹೆಲ್ಡಪ್ ಆಗ್ಬಿಟ್ಟೆ.
ಆಯ್ತು.
ಕೋರ್ಟ್ ಆಫ್ ದ 7 ನಲ್ಲಿ. ಆಯ್ತು. ಲೇಡಿ
ಅದು ಅವ್ರು ಕೇಳೋದು ನನಗೆ ಗೊತ್ತಿತ್ತು.
ಇಲ್ಲ.
ನೀವೇ ಕೇಳಿಸಿ. ಆಯ್ತು, ತೋರ್ಸೋಣ.
79
ಆಯ್ತು.
ಶೀಟ್ ನಂಬರ್ 1.
ಆಯ್ತು. ಫಾಸ್ಟ್ ಅವ್ರು ಕರೀರಿ.
Serial number 75.
ಒಂದ್ ನಿಮಿಷ, ನಾನು ಎದ್ದೋಗ್ತಾ ಇಲ್ಲ, ವೇಟ್. ನೀವು ಎಲ್ಲರೂ ಹೋಗ್ಬೇಕಾ? ಹೋಗಿ ಕರೆದ್ಬಿಡಿ ಸೆಟಲ್ಮೆಂಟ್.
Voting settlement. It's number 174.
ಒಫೆನ್ಸ್.
ಎಸ್. ಪಾರ್ಟಿ ಆರ್ ಪ್ರೆಸೆಂಟ್ ಅಂಡ್
ಒಫೆನ್ಸ್ ಏನು ಗಣಪತಿ?
498 and.
ಅಷ್ಟು ಫಸ್ಟ್ ಅದೇ ಹೇಳಿದ್ರೆ ಸಾಕು.
Appearing on behalf of respondent lordship.
ಲರ್ನೆಡ್ ಕೌನ್ಸಿಲ್ ಸೋನ್ಸ್.
Party is present.
ಪಾರ್ಟಿ ಆರ್ ಪ್ರೆಸೆಂಟ್.
ವಕಾಲತ್ ಹಾಕಿದ್ದೀರಾ ಮೇಡಮ್?
ಹಾಕಿರುವುದು lordship.
ಸೋನ್ಸ್ ಸೆಟಲ್ಮೆಂಟ್ ಮೆಮೊ. ಅರ್ಜೆನ್ಸಿ ಯಾವುದೂ ಇಲ್ಲ, ವೆಕೇಶನ್ ಮುಂಚೆ ಬರುತ್ತೆ ಕಾಪಿ ಎಲ್ಲ. ಆಯ್ತು, ಅಷ್ಟೇ ಸೈನ್ ಮಾಡಿ.
74.
ಒಫೆನ್ಸ್.
498.
ಪಾರ್ಟೀಸ್. ಆಲ್ ರೈಟ್, ಕೊಡಿ. ಬೇರೆ US ಅಲ್ಲಿ ಇದ್ದಾರಾ? ಕೊಡಿ.
Joint petition.
ಎಸ್ ವಕಾಲತ್ ಯಾರು ಹಾಕಿದ್ರು ರೆಸ್ಪಾಂಡೆಂಟ್ಗೆ? ಹಾಕಿದಿರ ಆಲ್ರೆಡಿ? ಹಾ ಸರಿ. ಎಸ್ ನೆಕ್ಸ್ಟ್. ಸೀಲ್ ನಂಬರ್
39 list number.
ಸೆಟಲ್ಮೆಂಟ್ ಮಾತ್ರ ರೈಟ್. ಎಸ್ ಮೇಡಮ್.
List number 2, seal number 60.
39.
39 settlement.
Oversight, it has been listed in admission.
Overriding.
ಸರಿ, ಯಾವ್ದು ಫಸ್ಟ್ ಲಿಸ್ಟಾ ಸೆಕೆಂಡ್ ಲಿಸ್ಟಾ?
Second list.
Second list, serial number 39.
Copies.
ಅಫೆನ್ಸ್ ಏನು?
419A, 323.
302.
ಶಂಕರ ಹೆಚ್ ಸಿ
Yes.
ಅದಾ?
Winter ಜೊತೆ.
Second list.
ಎಸ್.
Grateful minutes.
ವಾಟ್ ಈಸ್ ಇಲ್ಲಿ?
What is the present?
ಹಾ ಎಸ್.
They are the government employees.
ನೆಕ್ಸ್ಟ್.
Grateful.
25 in serial number, list number 2, my lord.
ಸೆಟಲ್ಮೆಂಟಾ?
Yes, my lord.
ವಿಚ್ ಒನ್ ಸರ್?
Serial number 25 in list 2.
25.
Yes, my lord.
ಒಫೆನ್ಸ್ ಏನು?
506 ಮತ್ತೆ 341. You were the respondent who was.
Parties are present?
No, he is not present. He is shifted to Chennai. I have filed the settlement which has been executed before the labor officer under section 12 clause 1 and 3.
Kodi, it's settled there, is it?
Yes, my lord. Along with the memo on 12th.
Settled before the nodal officer?
Yes, my lord.
Madam, a memo no extract ಮಾಡಿ plus terms of settlement ಅಲ್ಲಿ ಒಂದು ಪ್ಯಾರಾಗ್ರಾಫ್ ಇದೆ ಇಲ್ಲಿ, ಪ್ಯಾರಾಗ್ರಾಫ್ 4 and 5 ಎರಡು ಪ್ಯಾರಾಗ್ರಾಫ್ 4 to 6 ಹಾಕಿ ಮೆಮೊ ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಆಗ್ಬೇಕು because it is before nodal officer. Yes, close. Next. Fast over.
Passed over matters. List number 1, seal number 2.
Four.
4, please.
2 ಯಾವ್ದು ಮೇಡಮ್? being spoken to ಎಲ್ಲ ಬಿಡಿ ಅದನ್ನ ಹಂಗೆ ರಿಲೀಸ್ ಮಾಡಿ.
Your lordship's interim order, my lord, it spells out everything.
ಕಳಿಸ್ಬಿಡಿ. ಎಸ್ ನಂತರ ಮೇಡಮ್ ಒಂದು ಪಾಸ್ ಓವರ್. Yes. 1 minute's pass over has resulted in end of the day.
But I'm sorry, I was held up in the other court.
I have not been lighter ways.
But
Now
now
pass over bad.
there is only one point not which we wanted.
My interim order is in detail, sir.
Yes, Lord. Yeah, I have gone through that. Now, Lord, at page 167 is the proceedings which were initiated by the children of
Yes.
petitioner's aunt.
Yes,
Subsequent to that, sale deed is executed.
yes.
But our case is that it was possibly impossible that the petitioners were not aware of such a claim being made by the aunt's children. That's all. Though technically they say,
So
we got to know about these proceedings.
Your allegation is that knowing full well they.
Yes, yes, and this is not a family dispute. It is not that not they went, these people are outsiders to the family and they the first time went to the proceeding. The case now which is sought to be made out before your lordship sees that though the proceedings were initiated earlier, we got notice from the deputy commissioner subsequent to the sale deed. That was for the first time it came to. But in their own pleadings, they say they first went and demanded a share to them. Obviously, it's not that not they rushed to the court. It's a family dispute. They went and demanded a share to them. They denied that share. Therefore, they went. Now, the question as to whether they are entitled to a share or not is a matter which could be decided in the civil court. Insofar as look at my position, Lord, today. 16 crores 33 lakhs I have paid. They were aware that there was a claim being made by the aunt. All that not if they had disclosed to us at that point of.
You want the money back?
No, Lord, we are that this the land is very strategic for my mainland. No.
It was argued at length.
No, I'm not, I will not repeat. I only want to.
No, it is 2 months ago.
Correct,
3
correct.
months ago.
No, all that I'm pointing out before your lordship is that we have been taken for a ride, quite a, Lord, having paid the valuable consideration of 16 crores. As if we had known that there is another member, we would have possibly sat with her, negotiated with her also had paid.
So now you don't want the money back, but the land.
No, land is very, very important for us.
That's
because
all I want to
this
know. Yes.
Second aspect which I must bring to lordship, the last one is that they produced at the time a genealogical tree at page 167.
And that, my lords, according to us, very conspicuously does not depict the name of the aunt.
Who is now in litigation.
Yes, yes. Because all these things we procured in order to ensure that there is nobody left out. And this genealogical tree which they produced it, they procured it for us. Did not contain that. There is allegation is.
So according to you, it is not free from encumbrances.
Yes, it was not. It was not, and we had not. They were aware that they had not known. Then that forms. It's not that much. It is a civil dispute. After having very well known that there was a claim against this property that was not suppressed from us, thereby not inducing us to part with this property, and then that is resulting in criminal breach of trust.
406 and
Yeah,
420.
that's.
Yes, synopsis, my lords, in the list of dates I have mentioned, but 2005 is the grant order. I have short synopsis with the dates only, my lord, 2 pages is my lords.
I think I've captured that also. in
Please,
interim order.
that's 2, my lords. 2005 is the grant order and agreement in favor of these persons, my lord, 2012. And they took out publication also, my lord. In the meanwhile, the sale permission 2013 from the deputy commissioner. Then, my lord, Tata is changed our name. 2023, they issue a newspaper publication. And this relative which they say, somebody has now approached, aunt's son, they say, not related to us. Grant is directly in the name of these persons who has now sold, my lords. They're very, very far relative, my lords. This is a very far-fetched excuse to launch.
Far relative, far-fetched.
Excuse to launch a criminal prosecution, my lord. Forgery, no forgery.
Far consequences.
We have suffered. Lord. Yes. Our land is with them, and money is with the police. In the sense, it's locked in the.
Land is with them, money is with them.
With the police means in the freezed. So this
Land is with us. No, let them. Yes. It's not a question of money. We want land free of encumbrances.
It cannot be free of
not
money.
that. This is
So
practically not now.
No. Is it that strategically located that you don't want the money also?
No, without that access, we purchased this property only because it will give access to our main land. Which is there.
What are you constructing?
In college.
College?
No, they have not come. It's basically an educational institution. New Horizon is an educational institution.
Villa estate.
Villa?
They say villa estate.
No, it's an educational institution, well-known educational institution.
Educational villa.
Nothing like. No, but the point is, my learned friend says land is with us, but money is with us. But nothing, this land is useless today with the claim being made today. Without that, we can't do anything with that claim being. And we have parted with the money, they take the money and the land is being given with
No, that's all. Now you are getting a higher price, huh?
Yes.
No, my lord.
Yes.
No, are you getting a higher price for this area?
They'll get much registered sale deed is executed, my lord.
Yes.
Possession handed over.
In fact, because it was strategic, we have paid them double the market value.
According to us,
says
half the market
16
value. I don't want to say anything because registered documents. my lords.
Anything else, sir?
But only one short synopsis, if lords permit, what we'll place on record.
Madam would file.
Yes.
All judgments also.
Please.
Whatever you want to rely
Please.
on. But reserved. Yes.
Forgery, Muhammad Ibrahim, my lords, if you launch permits, only on that point. Forgery.
ನೀವೇನ್ ಕೊಡ್ಬೇಕು ಕೊಡಿ.
My God. Please with God.
ಮೊಹಮ್ಮದ್ ಇಬ್ರಾಹಿಂ ಹಳೇದಾಯ್ತು 2006-8 ದೆಲ್ಲ ಕೊಡ್ಬೇಡಿ.
Only one sentence, my lord, as to whether they were aware or not. Of course, we ascertain very strongly they were aware. It's something, my lord, which will be disclosed in the course of the investigation. It's something which I must bring.
Yes.
They have suppressed. Yes. That genealogical tree which they have obtained also
That
is
you
on
told.
account of suppression of
Aunt is
facts
suppressed.
before the authority. Please. Grateful. But that is seek a week's time for filing that.
No, why 1 week? What, madam?
Almost 2-3 days. By Monday we'll file.
ನಾಳೆ ಹಾಲಿಡೇ.
By Monday we'll file. 4-5.
ಈ ಕೋರ್ಟ್ ಇದ್ರೆ ಕೆಲಸ ಮಾಡ್ತಾ ಇದ್ರಲ್ವಾ ಸಡನ್ ಆಗಿ ಹಾಲಿಡೇ ಆಗಿದೆ ಕೆಲಸ ಮಾಡಿ.
Monday we'll file. Please.
Interim order will continue.
Interim order will continue.
Most great.
Past or
ನೀವು ಇರಿ.
Please.
ಇನ್ನು ಅಲ್ಲ ಅದು ಫೈಲ್ ಕಾಲ್ ಬ್ಯಾಕ್.
My lord, please.
10 years, more than 10 years will decide.
Please.
past or list number 2, still number 3. Okay.
ಸುಯೋಗ್ ಏನಕ್ಕೆ ಪಾಸ್ ಆಗಿದೆ ಯಾಕೆ ಮಾಡಿ
Vacating ಹಾಕೊಂಡು.
ವೆಕೇಟಿಂಗ್ ಯಾರು ಹಾಕಿರೋದು?
Complainant.
ಕಂಪ್ಲೇನೆಂಟ್ ಯಾರು? H.T. Nataraj appearing for them. 138,
Please, no, my lords.
420.
420.
Yes, list on 19th. Next.
Pre-mortem ethics.
ಬೆಳಗ್ಗೆ ಇದ್ರ ಅವ್ರು ನಟರಾಜ್?
No, my lords.
ಬೆಳಗ್ಗೆ
Not
ಇರ್ಲಿಲ್ಲ.
present.
No representation on behalf of the respondent, second respondent complainant, both in the forenoon and in the afternoon, list after vacation, interim order continues till the next date. Next.
Number 9.
ಇದ್ಯಾಕ್ ಪಾಸ್ವರ್ಡ್ ಆಗಿದ್ದಾರೆ?
I am held up on that portal.
Huh?
Morning I am held up on that.
ಪಾಸ್ವರ್ಡ್ ಯಾಕಾಗಿ?
ನಾನು ಬೇರೆ ಕೋರ್ಟಲ್ಲಿ ಎಂಡ್ ಅಪ್ ಆಗಿದೆ ಸರ್. Please, my lordship. The 311 application is rejected. Earlier, the 91 application.
ಈಗೇನ್ ಅಲೋ ಮಾಡೋದ್ ಬೇಡವಾ?
ಬೇಡ ಸ್ವಾಮಿ, 91.
ಬೇಡವಾ?
ಅವ್ರು ಸುಮ್ಮನೆ ಡ್ರ್ಯಾಗ್ ಮಾಡ್ತಿದ್ದಾರೆ. When the case was
ಒಂದ್
posted
ಡೇಟ್
for the argument,
ಒಂದ್ ಡೇಟ್
final-
ಫಿಕ್ಸ್ ಮಾಡ್ಬಿಡೋಣ.
final-
ಅವತ್ತೇ ಮುಗಿಸ್ಬಿಡ್ಲಿ.
This is 8th time it has been.
ಏನು?
ಅರ್ಜನ್ ಆಗ್ತಾನೆ ಹೋಗ್ತಿದೆ.
ಆಗ್ಲಿ ಬಿಡಿ. 10th time. Yes, list on. It's 5:30, sir.
Any
Got up and gone at 4:45. What do you have done?
date.
Yes, list on 18th.
Interim order.
Interim order will continue, please. And I'm going to allow the petition. Allow the petition, fix a date for appearance, documents ka idu appearance ka?
Bank manager, bank statement, my lord.
Bank manager, bank statement da
Bank
idu.
statement. ಆದ್ರೆ
91 application ಆಗಲೇ ರಿಜೆಕ್ಟ್ ಆಗಿದೆ.
Apex Bank da?
ಅಲ್ಲ, ಆಕ್ಸಿಸ್ ಬ್ಯಾಂಕ್.
Axis Bank. ಅದಕ್ಕೆ ಕೊಡು, yes.
80.
ಅದು ಮಂಡೇಗೆ ಹಾಕಿ, fresh matters. That I'm not going to allow. Bank manager I'm not going to, yes, ಅವತ್ ಮಾಡಿ, yes, next.
Please. Interim order.
That will, till Monday. Next. ಆಯ್ತಾ? ಸರಿ. ಹ? ಯಾವ್ದು? ಇಲ್ಲ, ಒಂದ್ ನಿಮಿಷ, ಬೇರೆದೆಲ್ಲ ಮಾಡಿ.
List 162.
One minute. ಒಂದು page wise I'll call. Matter wise I will call.
11 application.
This one.
Judicial.
Wait,
Please.
yes. 2 ಮೂವ್ ಮಾಡಿದ್ದೀರಾ?
311.
2:30 ಮೂವ್ ಮಾಡಿದ್ದೀರಾ? ಇಲ್ಲ ತಾನೆ? Wait.
Mine is 2:30, madam, my lord.
Wait, sir. Yes, there the DSJ wanted some more time.
Yeah,
Yeah, all right, yes.
please give me an interim order, my lord.
Interim order for what, sir? Entry to India.
My lord, as you know, bail is a rule.
Bail,
Bail.
I'm not here answering bail petition,
In
sir.
this case, allowing me to come inside the country is akin to bail only.
Don't deviate the statement saying that bail is a rule, jail is an exception. You're
I have
neither
to be-
in
I have to
jail
be
nor
allowed
you're
to-
seeking bail. Yes.
He has given all false allegations.
So
He
that
was
we'll
given
see.
10 days
Let
time.
him file his objections. You want entry into India, we will see, yes. ಅದು ಒಂದು ಡೇಟ್ ಕೊಡಿ, list that on 18th. Yes, 52,
Admission.
2:30, my lord.
yes.
My lord, 18/2/30.
Yes, sir, I've told you, yes. Parshram, ಇವಾಗ ಎಲ್ಲಿ vacating stay ಆಗುತ್ತೆ? After vacation. Immediately after, list on 7th January 2025. Admission, sir. In admission, yes, next.
53.
That will continue, sir. Where, don't mention, interim orders will continue. 53,
53.
list after vacation, interim order ಇದೆಯಾ? Continue, yes, next. AVIO, next. Shankar? Yeah. ಇಲ್ಲ. Sir, VCL, please wait. Yes.
Please. 54.
Oh, marriage ge wife is seeking NOC whether criminal cases are pending or not. Kudi.
Well, that my lord, I've seen this thing will not be covered because your lordship recall, they claim is
ಧಾರವಾಡದ್ದು
that.
ಕೊಡ್ತಾ ಇದ್ದೀರಾ? That's the wrong order. That we will see. Merely because your wife is asking NOC about criminal cases, I am not going to take, yes. Marriage cancel ಆಗೋಯ್ತಾ? ಅವ್ರ ಮದ್ವೆದು ಓದಾಡ್ತಾ ಇದ್ದಾರೆ, ನೀವು ಚಾರ್ಜ್ ಫ್ರೀ. Wait, sir. Marriage cancel ಆಗಿದೆ because of the pendency of the crime. Yes, we'll list it on Friday. List on Friday 54 because of marriage problem. Yes, next. 55
55.
after vacation.
6.
Name for the respondent.
After vacation, yes.
7.
Interim order ಇದ್ರೆ interim order ಇದೆಯಾ?
Name for the respondent, my lord. We are moved the matter for, my lord, in serial.
Which one? Serial number?
56, my lord.
ಏನಾಗಿದೆ?
We are moved the matter for vacating of the interim order, my lord.
You are for the respondent.
Day after tomorrow.
Vacating stay day after tomorrow, yes. 57,
This one.
13th, sorry, 13th. ಎಲ್ಲಿಯವರು 13th.
57,
Interim order will continue. Yes, 57. After vacation, yes.
58,
Interim order ಇದೆಯಾ? List number 1. AVIO, next.
59,
Lord, I appeal for the petition in this case. Lord, matter is Lord urgency because PCR has been filed. Lord,
When vacating stay ಹಾಕಿದ?
no, even it is stay is not been granted.
After vacation.
No, Lord, matter is because PCR is already, charge sheet has been already filed
So
before
what?
the trial court. Lord, it is only private complaint where it is a false allegation which has been alleged. He is a political, Lord, politically person. Lord, because of his
ಏನ್
influence.
power TV ಇದಾ?
Poverty.
ಏನು?
Lord, he is, because he's the everyone.
Copy serve ಮಾಡಿದ್ದೀರಾ?
Copy ಮಾಡ್ಕೊಟ್ಟು.
ಯಾವಾಗ ಕೊಟ್ರು ಮೇಡಮ್? ಯಾಕೆ?
ಅಲ್ಲ, Lord, for the reason, they have
List on-
closed the office, not even
List
whenever
on
they.
Monday in the fresh matters.
Please, my lord,
Yes,
both.
next. Yes, next.
60,
So I am for the petitioner in this matter.
Interim order ಇದೆಯಾ?
No interim order, ma'am. The
Why?
petitioner is aged above 74 years.
Why no interim order?
So it was not granted to notice
Offense,
issue.
offense.
The 409,
ನನ್ನ ಮುಂದೆ
120B
ಬಂದಿತ್ತ ನೋಡಿ.
477A, my lord.
1 minute.
And complaint came to filed after lapse of 2.5 years.
Wait, sir. I have not granted stay.
Not granted issue.
After vacation, yes.
Notice issued, my lord.
Correct.
Is unrepresented.
ಬರ್ಲಿ ಅವರು.
Unrepresented, notice served upon the respondent.
Petitioner in this case,
The
my lord.
petitioner aged about 74 years.
So what?
Yeah, after lapse of 2.5 years, complaint came to be filed.
What offense, sir?
The 409, 120B 477A, my lord.
That's
False and frivolous allegations
Yes,
made against
next,
the
next,
petitioner.
after vacation, next.
Alla, date may be, my lord.
7th January, yes.
Alla, before the vacation.
7th January 2025.
61,
My petitioner in this case promised to marry relationship, 8 years relationship. Petitioner ಗೆ
Stay ಇದೆಯಾ?
ಇದೆ ಸ್ವಾಮಿ, ಎಂಗೇಜ್ಮೆಂಟ್ ಆದ್ಮೇಲೆ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿದ್ದ ಸ್ವಾಮಿ, ಮ್ಯಾರೇಜ್ ಇದಾಗಿದೆ, ಅದಕ್ಕೂ ಡೇಟ್ ಮೇ ಫಿಕ್ಸ್.
ಯಾರಿದು? ಸುನಿಲ್ ನಾರಾಯಣ.
ಐ ಆಮ್ ಫಾರ್ ದಿ petitioner, my lord.
You are for the petition.
Yes,
Who's
ma'am.
for the respondent? Manjula. Anyway, list on Tuesday. Yes,
Fresh
fresh
matter.
matters, we'll close it. 62,
Petitioner, my lord.
62,
311 applicant, judicial custom, PW1, PW, mother and victim.
ಇದು
Father.
day after tomorrow.
13,
Yes, 13th, yes, sorry, 13th.
63,
My lord, appear on this petitioner, my lord. Really, there is no interim order in this case. In the counter case, there is an interim order.
Which is that counter case?
Counter case, my lord. See, criminal petition 13,629 of 2023.
ಯಾರು? ಸದಾ ಮುಜಾಫರ್ ಅಹಮದ್.
ಹೌದಾ? NOC ಬಂದಿದೆ.
14%.
ಮನೋಹರ್ 14% ಯಾರು?
ಅಲ್ಲಿ ಪಾರ್ಟಿ ಇವರು ಅವತ್ತು ಅಪೇರ್ ಆಗಿದೆ, ನಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ.
ಹಾ?
He had filed a memo.
ಅಲ್ಲ, ಇದು ಕೌಂಟರ್ ಕೇಸಲ್ಲಿ ಸ್ಟೇ ಇದೆಯಾ?
Counter case ಅಷ್ಟೇ ಇದೆ.
Number.
Number 13,629 of 2023.
Tag this petition along with so and so and list them both on 17th in the fresh matters list. In the light of the learned counsel submits that there is an interim order operating in the companion petition. Therefore, there shall be an interim order of stay in the case at hand as well. Yes, next. ಇದಕ್ಕ ನೀವು ಕಾಯ್ತಾ ಇದ್ದು ಒಂದು ವಾರದಿಂದ.
ಇಲ್ಲ, ನನಗೆ ಗೊತ್ತಿಲ್ಲ, ಮೂವ್ ಮಾಡಿದ್ರು.
Filing, sorry, for filing this petition, charges frame.
64
Yes, my lord.
Ah.
29
charge frame ಆಗಿದೆ.
Serial number 25.
Date of framing of charge.
29/7.
October of what year?
29/7.
October ಅಲ್ಲಿ 1 first to 31st ಇದೆ. ಯಾವ ಡೇಟ್?
29/7.
ಸುಮ್ನೆ ಅಕ್ಟೋಬರ್ ಅನ್ಬಿಟ್ರೆ ಇದೆ ಮೂವಿ ಟೈಟಲ್. ಮತ್ತೆ ಫಸ್ಟ್ ವೀಕ್ ಅಗೇನ್ ambiguity. What, sir? You're at council, sir, you should be precise. ಈ ಡೇಟು ಗೊತ್ತಿಲ್ಲ ಅಂದ್ರೆ ಆಫ್ಟರ್ ವೆಕೇಶನ್.
29/7.
ಇಂಟ್ರಿ ಆರ್ಡರ್ ಕೊಟ್ಟಿದೀವಾ? ಲಿಸ್ಟ್ ಆಫ್ಟರ್ ವೆಕೇಶನ್. ಎಸ್, ಡೇಟ್ ಎಲ್ಲ ನೋಡ್ಕೊಂಬಿಡಿ ಆಮೇಲೆ. ನೋ ಇಂಟ್ರಿ ಆರ್ಡರ್. ನೆಕ್ಸ್ಟ್.
65 civil dispute given criminal
ಇಂಟ್ರಿ ಆರ್ಡರ್ ಇದೆಯಾ?
ಇಲ್ಲ ನೋಟಿಸ್ ಹೋಗಿ ಬರ್ಲಿ ಅಂತ.
65
Charge already frame.
Evidence comments ಆಗಿದೆ. ಸಿವಿಲ್ ಡಿಸ್ಪ್ಯೂಟ್.
ಮೀನಾಕ್ಷಿ ಬಾಲ್ ಯಾವ್ದಾರು ಆಗ್ಲಿ ಸರ್.
ಒರಿಜಿನಲ್ ಸೂಟ್ ಇಸ್ ಪೆಂಡಿಂಗ್.
ನೀವು ಮುಗಿಸಿ ಪಾಲಿ ಲೈಸ್ ವಿತ್ ದಿ ಕ್ಲೈಂಟ್ಸ್. ದೇ ಡೋಂಟ್ ಕಮ್ ಇನ್ ಟೈಮ್. ಚಾರ್ಜ್ ಎಲ್ಲ ಫ್ರೇಮ್ ಆಗಿ ಎವಿಡೆನ್ಸ್ ನಡಿಬೇಕಾದ್ರೆ ಇನ್ 482 ಕ್ಯಾನ್ ಐ ಇಂಟರ್ಫಿಯರ್? ಎಸ್, ಮೀನಾಕ್ಷಿ ಬಾಲ ಆಲ್ ಕಂಟೆನ್ಷನ್ಸ್ ಅಲ್ಲೇ. ಅರ್ಜಿ ಯಾವ ವರ್ಷದ್ದು ಅದು? Want the trial to be concluded early or direct?
Within
2 months.
Yeah, 2 months. Within 4 months, if not earlier.
CT is of 23.
23? No, sir. Yes. Dispose, Meenakshi Bala. Yes, next.
Within 4 months at least.
23 ಆದ್ರೆ ಇಲ್ಲ. ಟ್ರಾನ್ಸ್ ಫ್ರೇಮ್ ಆಗಿ ಅವ್ರಿಗೆ ಏನ್ ಮಾಡ್ತಾ ಇದೆ?
22 crime ಆಗಿದ್ವು, 23 ನಲ್ಲಿ.
Yes, next. ಅದು ಕನ್ಕ್ಲೂಡ್ ಮಾಡ್ತಾನೆ ಬಿಡಿ. 66. ಯಾರು ಇಲ್ಲ ಅಂದ್ರೆ after vacation. Next.
67,
After vacation.
68,
For the respondent in this case,
Ah.
file the objections. They have not even served the copy as well, your lords. It was
Yes,
directions
Avinash.
given. Directions
Yes,
was given by, no, where you have,
When,
served?
when did,
Directions was given that they have to submit the copy
They have served
before the
and,
trial court
filed
in the
the
3 days.
account in the filing counter, my lord.
No, no,
That I have
the-
who has received, sir?
the court order,
I have received objections.
Who has received the objections ಹಾಕಿದಾರಾ?
objections
Without
ಹಾಕಿದ್ದೀನಿ
copy ಹೆಂಗ್
beginning,
ಹಾಕಿದ್ರೆ
ಅಲ್ಲಲ್ಲ.
ಮತ್ತೆ?
Swami, my submission is that they have not, according to the court,
ಒಂದ್ ನಿಮಿಷ. Without copy, how did you file objections?
a copy then I have obtained, your lords. ಅವ್ರು ಯಾಕಂದ್ರೆ magistrate court ಅಲ್ಲಿ they have filed a memo stating that there is a stay ಅಂತ ಹೇಳ್ಬಿಟ್ಟು.
Stay ಇಲ್ವಾ?
stay ಇದೆ ಸ್ವಾಮಿ.
ಇದೆ ತಾನೆ. ಸ್ಟೇನು ಇದೆ, objections ಹಾಕಿದೀರಾ, ಕಾಪಿ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಹೆಂಗ್ ಹೇಳಿ?
ಅಲ್ಲ, direction, according to the directions, they have not completed my submission.
He will not do that, sir. Vacate ಮಾಡ್ತೀನಿ ಅಂತ ಗೊತ್ತು, he will not do that. Acknowledgement ಇದೆಯಾ?
ಇದೆ.
see.
ಆಗ ಯಾರ್ದು acknowledge? ಇದೆ. ಸರಿ ಸ್ವಾಮಿ. Date may be given.
ಇವೆಲ್ಲ small submissions you should not.
Light is in.
You should come on merits, sir.
Yes, my lord.
ಎಲ್ಲ ಬೇಡ. Yes.
Date may be given, my lords.
ಯಾವ 138
130.
Yes.
Please.
On
There is a presumption of statutory in section 1.
18th.
Obliged, my lord.
List on 18.
Please.
Obliged.
Yes, next.
69, 70,
After vacation.
71,
Intermodals ಇದ್ರೆ ಕಂಟಿನ್ಯೂ ಮಾಡಿ.
71 copies not served, your lord.
Constitutional submission. Yes. After vacation. Next.
72,
ಇದು ಟ್ರಯಲ್ ಸ್ಟೇ ಆಗಿದೆಯಾ ಈಗ ಇಲ್ಲಿ? Why? There is another bench's order, the trial should get concluded early. How is it?
Other case, please, but not.
ಆದ್ರೂ ಏನ್ ಇದ್ರಲ್ಲಿ ಸ್ಟೇ ಆದ್ರೆ
Really, charges were not framed in accordance with your
my
lordship
order is
indicated.
confirmed by Supreme Court.
Yes, madam.
But ಅದಾದ್ಮೇಲೆ ಏನಾಗಿದೆ ಈಗ?
That trial is going on, madam. This is a different FIR.
Different FIR.
Different FIR.
That's a different case.
This
I tell
also
you,
your lordship
list this
indicated
on-
that the earlier order, your lordship will follow the earlier order and
ಅದಕ್ಕೆ ಫ್ರೈಡೆ ಕ್ಲೋಸ್ ಮಾಡ್ಬಿಡ್ತೀವಿ. Will list it on Friday?
This Friday.
ಇನ್ಯಾವ Friday?
Yes, please.
This Friday.
Please.
Next Friday, last day. Yes, list on Friday. Yes.
73,
Fire has been distributed pursuant to, commercial transaction.
Stay ಇದೆಯಾ ಇಲ್ಲ? List on Monday in the fresh matters list. Yes. Reporting settlement ಆಯ್ತಲ್ಲ, further hearing ಆಯ್ತು. Now come to second list.
number 2,
Orders ಇಂದ ಸ್ಟಾರ್ಟ್ ಆಗ್ಬೋದಾ?
hearing
Orders ಎಲ್ಲ awaiting.
35,
Since 21 was heard, your lordship, before lunch.
sorry,
Wait,
orders 24, withdrawn.
24 memo, in terms of the memo, 24.1 ಅದೇ madam, same. 25 reporting settlement is over. 26 post immediately after service of notice upon the respondent, interim order continue ಮಾಡಿ.
Manage. Cause list 221 minutes. It has been passed over minutes.
Wait,
Heard for this.
wait.
27,
Post immediately after service of notice upon the respondent.
27, my lord, there is interim order.
Interim order will, who is that saying in feeble voice? Yes. Interim order will continue.
date has been 30,
Your lordship, what by your lordship is judgment, what said, so.
But that judgment is wrong.
Oh, your lordship, I think it's correct. Two
Correct.
judgments are there.
No, list on Friday. Yes.
Interim order may be.
We will continue. Yes, Urmila madam.
This is a bailable offense. Bail bond was cancelled before without issuing notice Friday.
Yes, we'll dispose it on Thursday. List on Thursday in the fresh matters list. Cancellation of bail bond will close it. ಈ Thursday. Oh, ಆಗೋಗಿದೆ, sorry, Friday. List is over for Thursday. Yes. Next, Anish is urgent. 34.
35,
35, my lord, Therefore, the second respondent.
ಆಮೇಲೆ ಆಮೇಲೆ ಏನಿಲ್ವಾ? ಸರಿ ಬಿಡಿ, ಆಫ್ಟರ್ ವೆಕೇಶನ್.
That's been granted. Talks of settlement, my lord, are going on.
ಹಾ,
In fact, my lord.
ಆಯ್ತು, ವೆಕೇಶನ್ ಪೂರ್ತಿ ಮಾತಾಡಿ. ಆಫ್ಟರ್
ಅಲ್ಲ,
ವೆಕೇಶನ್
35/1 ನಲ್ಲಿ, my lord, Sunil Rao, my lord, has to take notice on behalf of the respondent.
Counsel Sunil Rao is directed to accept notice for the second respondent complaint list after vacation. Yes, next. ಈಗ ಅವ್ರು ಬರ್ತಾರೆ, 4:45 ಮೇಲೆ ಕುತ್ಕೊಂಡು ಆರ್ಡರ್ ಮಾಡಿದ್ದೀರಾ ಅಂತ ಬರ್ತಾರೆ. ನಂಗೆ ಸ್ಟೇ ಬೇಕಾಗಿತ್ತು. Yes.
Stay ಇದೆ.
ಇದೆಯಾ?
Order.
ತೊಂದರೆನೇ ಇಲ್ಲ. Yes. Next.
36.
Krishnappa. Correction of the advert. Yeah, for the list after vacation. Next.
37.
I'm for respondent in this case, my lord. Vacating interim order. CV Srinivas.
I'm for respondent in this case, my lord.
Vacating stay.
Interim order may be extended, my lord.
You are for respondent and interim order may be extended.
Yes, there is an interim order insofar as respondent is
Very
concerned.
fair counsel, sir. Learned counsel for the respondent submits interim order is to be extended. Therefore, it is extended beyond vacation, list after vacation.
The date may be fixed, my lord.
Date 8 January.
Please, ma'am.
Lords.
Wait.
38 is the
Wait.
case and counter case, my lords. My lords.
ಈಗೇನು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ಬಿಡಿ. ಎಸ್, ಆಫ್ಟರ್ ವೆಕೇಶನ್
My
ಸ್ಟೇ
lord,
ಇದೆ. ಸ್ಟೇ
charge
ಇಲ್ವಾ?
is the, my lord, Monday.
ಸ್ಟೇ ಇಲ್ವಾ?
Stay ಇಲ್ಲ, my lord.
ಮಂಡೇ ಇನ್ ದಿ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಲಿಸ್ಟ್.
Please.
39. 39 ಆಯ್ತಲ್ಲ ಮೇಡಮ್?
39. 40.
Vacatings after vacation.
51.
Yes, after vacation. Interim ಮಾಡಿದ್ರೆ ಕಂಟಿನ್ಯೂ ಮಾಡ್ಬಿಡಿ.
42. Urgent 43.
And for the petitioner, my lord, offense is 498. Petitioner is similar. First time.
ಇಂಟ್ರಿ ಮಾಡ್ರಿ ಇಲ್ವಾ? ಇನ್ಲಾಸ್ಗೆ ಇಂಟ್ರಿ ಮಾಡ್ರಿ ಇಲ್ವಾ?
That matter was listed on 24/6/2024. That
List on Monday in the fresh matters list. Yes.
44.
I appear for petitioner in 44. There's an interim order, your lordship, that
AVI.
Respondent 40.
After
Respondent
vacation.
ಅದು ಇದರಲ್ಲಿ ಇದಾರೆ ಮೇಡಮ್, ಪ್ರೊಟೆಸ್ಟ್ ಮೆಮೊ ಮೇಲೆ ಇದಾಗಿರೋ ಸ್ವಾಮಿ ಅದು.
Pardon, after vacation, immediately 8 January. List on 8 January in the 8 January ಎಷ್ಟು ಮಾಡಿ sir. Yes.
interim order to be.
Interim order continue till then. Yes. 45.
Some 14%.
Shankar.
Third time the matter is listed after.
ಅದೊಂದು ಬಿಟ್ಟು ಬೇರೆ ಏನಾರು ಹೇಳಿ.
Appearance of the other party.
ಸರ್ವ್ ಯಾವತ್ತಾಗಿದೆ?
October 24th.
ಅದೇ 10 lakhs ತಾನೇ ಇದು?
It is 341/323.
Oh, that is another council. Yes.
I'm covered with the judgment.
Well, I know, sir.
1 week.
List on Tuesday in the fresh matters list, we'll close it. Yes. 46
46.
after vacation.
47. Urgent 48.
Entry order ಇದೆಯಾ? ಏನಿದೆ ಅದು? ಬಿಲ್ಸಾ? ಬಿಲ್ಸ್ ದ ಡಾಗ್ ಬೈಟ್. ಎಸ್ ಎಸ್, ಡಾಬರ್ಮ್ಯಾನ್ ಕಬನ್ ಪಾರ್ಕ್ ಅದೇ ಅಲ್ವಾ? ಹಾ, ಎಸ್. ಈಗ ನಾಯಿ ಕರ್ಕೊಂಡು ಹೋಗೋದು ಬಿಟ್ಟಿದ್ದೀರಾ ಅಲ್ಲಿ? ಅಲ್ಲೇ ಕರ್ಕೊಂಡು ಹೋಗ್ತಾ ಇದ್ದೀರಾ? ಮತ್ತೆ ಇಟ್ ಬೈಟ್ ಸಮ್ಮನ್ ಎಲ್ಸ್. ಎಸ್, ಅದೇ ಕಂಪ್ಲೇಂಟ್, ಅದು ನಾಯಿ ಚೂ ಬಿಟ್ಟಿದ್ದೀರಾ ಅಂತ, ಅದೇ ಅಲ್ವಾ? ಎಸ್. ಲಿಸ್ಟ್ ಆನ್ ವೆಡ್ನೆಸ್ಡೇ. ಪರವಾಗಿಲ್ಲ, ವಿಡ್ರಾ ಮಾಡ್ತೀನಿ. ಆಯ್ತು, ಕೌನ್ಸಿಲ್ ಚಾರ್ಜ್ ಶೀಟ್ ಫಾರ್ಮ್ಯಾಟ್ ಕೊಡಿ ಮೇಡಮ್. ಎಸ್ ಎಸ್, ಚಾರ್ಜ್ ಶೀಟ್ ಫಾರ್ಮ್ಯಾಟ್. ನೆಕ್ಸ್ಟ್.
49.
On behalf of the petitioner, my lords.
Yes, Amit.
On behalf of the petitioner.
After vacation?
After vacation.
Less after vacation. Interim
Interim
order
order.
subsisting, that will get. Yeah, I got to, sir. I had dealt with in GMFC
Yes, my lords.
after vacation. Oh, yes, that does not bind this courts. Yes. That's a statute. This is constitution, fountainhead of statutes. Yes, next.
Highly obliged, my lords.
Urgent 51.
Petitioner, my lord, entry ಮಾಡಿದೆ.
After vacation, yes.
52.
National, one day fresh matters. Yes, next. 53.
53.
Appear for petitioner in this case, your Honor.
Respondent.
There is no interim order in this case, Your
After
Lordship.
vacation, yes.
Your Lordship, date may can.
For petitioner, my lords, one short date may be accommodation.
ಯಾವ್ದ್ರಲ್ಲಿ sir?
Short date.
Huh? ಯಾವ್ದ್ರಲ್ಲಿ?
54, Swami, 54.
54, 8 January, yes. Big group ಕರಿಬೇಡಿ madam, ಎಲ್ಲ after vacation, all big group matters.
A date may be fixed in seal number 55, my lord.
All,
First big
yeah,
group matter, a date may be fixed.
8th January,
Jan, my lord.
yes. All big group matters on 8 January.
My Lordship, serial number 56, my lord. The respondent number 2 is suffering from cancer, my lord.
ಯಾವ್ದಪ್ಪ ಅದು ಕ್ಯಾನ್ಸರ್ ಕೊಡಿ.
Serial number 56, my lord. I'm appearing for respondent number 2 and 3.
Give it, which is that 56. Mediation fail ಆಗಿದೆಯಾ?
Mediation has failed, my lord.
ಇದು list on Friday.
Please, please.
Yes.
Please.
56 ಮಾತ್ರ list on Friday.
My lord, I have filed an application for vacating of interim order.
Registry to put up the application filed for vacating the interim order on the next date. List on Friday.
Copy I already served on via WhatsApp.
ಇನ್ನೊಂದು ಕೊಟ್ಬಿಡಿ.
I'll serve. Please.
Humble submission, my lord. Humble submission, my lord. Tomorrow date given memos are,
Tomorrow holiday.
no, memos are missing, so I'm.
Memos are missing.
Yes,
Tomorrow everything is missing.
my lord, I'll, fresh memos I'm filing, my lord.
One
You
submission.
do one thing. You move it on Friday, on Thursday. I will take it at 2:30. All right?
Thursday morning, my lord.
Thursday morning, you move the matter. I'll take it at 2:30.
My lord, my submission, party in person.
Yes, sir.
Today I have filed the memo,
Ah.
but it is missing 3-4 times running around. It is a Herculean task. But ಇಲ್ಲಿ ಬಂದು submission ಮಾಡ್ಬೋದು.
Ah.
ಆದ್ರೆ ಅಲ್ಲಂತೂ ಓಡಾಡಕ್ಕೆ
ಅದಕ್ಕೆ ಅವ್ರು
ನಾಲ್ಕೈದು
ಹೇಳಿದ್ದೆ ನಿಮಗೂ ಅಪ್ಲೈ ಆಗುತ್ತೆ.
ಅದಕ್ಕೆ ದಯವಿಟ್ಟು ಕೇಳ್ತಾ ಇದ್ದೀನಿ.
ನಾಡಿದ್ದು 10:30 ಮೂವ್ ಮಾಡಿ 2:30 ತಗೊಂತೀನಿ.
ಮಚ್ obliged.
ಆಯ್ತು.
One submission, my lord.
Serial number 66. Then it is, there we have filed an application for vacating interim order as such. Further
After vacation ತಗೊಂಡು. ಎಷ್ಟು ಅಂತ ನಾನು ತಗೊಳಕ್ಕಾಗತ್ತೆ.
specific date.
8 January 8.
Interim order 6.1.
ಇದೇನ್ ಮೇಡಮ್? ಹಾ ಸರಿ ಆಯ್ತು.
66.1,
submission, my lord.
Where my name
My
is
lord.
not showing for the respondent number.
66 ಅಲ್ಲ,
66.1.
ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಅಲ್ಲ.
Second,
ನಿಮ್ಮ ಹೆಸರೇನು?
Girish DS.
So and so. Registered to print the name of so and so and 66.1 is appearing for the respondent.
Direct the petitioner to furnish the copies.
Petitioner ಯಾರು? ಕಾಪಿ ಕೊಡಿ. ಕಾಫಿ ಅಲ್ಲ, ಕಾಪಿ. Yes.
Interim order may be.
Interim order transaction. Yes, next.
One submission, my lord. 4398, 392 concurrent, my lord.
ಸುಮ್ನೆ ಇರಿ ಸರ್. ಅದು ದೊಡ್ಡ ಕಾಂಟ್ರವರ್ಸಿ ಆಗಿದೆ. ಎಲ್ಲ ಡಿಫರೆಂಟ್ ಅಲಿಗೇಷನ್ಸ್ ಅಲ್ಲಿ ಜಡ್ಮೆಂಟ್ ಆಗಿ
ನ್ಯೂಸ್ ಕಡೆಯವರು ವಕಾಲತ್ ಕೇಳ್ತಾರೆ, my lord.
ಏನ್ ಅದ್ ಮಾಡೇ ಮಾಡ್ತಾರೆ, ಗೊತ್ತಿಲ್ಲ. ಅದು ಫರ್ದರ್ ಹಿಯರಿಂಗ್ ಹಾಕ್ತೀನಿ, ಅವಾಗ ಗೊತ್ತಾಗುತ್ತೆ. ದಟ್ ಈಸ್ ದಿ ಹೋಲ್ ಪ್ರಾಬ್ಲಮ್. ಯು ಸೆಡ್ ಆಲ್ ಒಂದೇ ಚಾರ್ಜ್ ಅಂತ, ಒಂದ್ ಅರೈಸಿಂಗ್ ಔಟ್ ಆಫ್ ದಿ ಸೇಮ್ ಟ್ರಾನ್ಸಾಕ್ಷನ್. ಇಟ್ ಈಸ್ ನಾಟ್. ಐ ಆಮ್ ರೀಕಾಲಿಂಗ್ ದಟ್ ಆರ್ಡರ್. ಐ ಪೋಸ್ಟ್ ಇಟ್ ಆನ್ ಟ್ಯೂಸ್ಡೇ.
Yes, my lord.
ವಕಾಲತ್ ಕೇಳಿದ್ರೆ ನಾವೇನ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ? ಐ ಹ್ಯಾವ್ ಟು ರೈಟ್ ಎ ಜಡ್ಜ್ಮೆಂಟ್. Yes.
Investigation records in original, my lord.
Good.
And I genuinely felt it is only status report that my lord is asking, so I brought status.
All records I had. ಅದೇ ಇಮ್ಮೇಲೆ ಯಾಕೆ, ಡೋಂಟ್ ವರಿ ಅಬೌಟ್ ದಟ್. ಮೇಡಮ್ ಅಂತ ಸೇಮ್ ಬೆಳಗ್ಗೆ ಆರ್ಡರ್ ಮಾಡಿದೆ, ಅದನ್ನ ಸೀಲ್ ಮಾಡ್ಬಿಡಿ.
60.3, my lords. The interim order may kindly be extended, my lord.
Seriously, this is submission at 6 o'clock. It will be extended, madam. Yes.
Cause list to serial number 21, my lords. It was passed over, my lords, and date may be given, my lords.
ಚಿದಾನಂದ ಅವ್ರದಾ? Next week, yes.
But serial
17th or 18th. ಬರ್ಕೊಂಬಿಡಿ, 16th or 17th ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ. Yes.
Much obliged.
ಇದೆಯಾ? ಇಂಟರ್ಮ್ ಆರ್ಡರ್ ಇದೆ, ಆಫ್ಟರ್ ವೆಕೇಶನ್. ಎಸ್.
But serial number 65 list 2, my lord. There are 2 more petitions to be tagged. Your respondent number 5, my lord.
ಆಫ್ಟರ್ ವೆಕೇಶನ್.
Memo may be taken. So
ತೊಂದ್ರೆ. ಎಸ್.
230,
Any date, my lord.
Serial number 10. I have been filed a memo for withdrawal.
Withdrawn. Ordered, madam, in your absence. Yes.
Yes, ma'am.
My lord, one submission, my lord. My lord, one submission, my lord.
ನಿಮ್ದೇ 10 ಲಕ್ಷದಲ್ವಾ? ಅದು ಇದೆಯಾ? ಇದು ಯಾರಿಗೆ ಹೇಳಿದ್ವಿ ಇದಕ್ಕೆ? ಬಿಬಿ ಪಾಟೀಲ್ ಇಸ್ ನಾಟ್ ಹಿಯರ್. ಬಿಬಿ ಆ 10 lakhs ತಹಶೀಲ್ದಾರ್ದು ರೆಕಾರ್ಡಿಂಗ್ ಇದೆ.
I was present, your lordship. Today they were present.
Yes. When do you get the records? What investigation have you done in terms of that complaint? Nothing.
Senior will make submission regarding that, your lordship.
ಅದನ್ನ ಫ್ರೈಡೆಗೆ ಹಾಕಿ ಮೇಡಮ್. ಸೀರಿಯಲ್ ನಂಬರ್ ಏನು?
64.
ಹಾ, ಫ್ರೈಡೆ. ಡೋಂಟ್ ವರಿ ಅಬೌಟ್ ದಟ್. R2 ಯಾರು? ಕಂಪ್ಲೇನೆಂಟ್ ಅಲ್ಲ, ಅಕ್ಯೂಸ್.
Tahsildar, I have to is a Tahsildar.
Don't worry, if it doesn't come, doesn't come.
My lord, serial number 26 in first list, my lord. My lord, I urgent the matter for tomorrow, my lord. Kindly have it out day after tomorrow, my lord, because
Day
tomorrow
after
is all
tomorrow
day.
ಬರೋದು sir, tomorrow ಎಲ್ಲ day after tomorrow.
Oblige, my lord, oblige.
ನೀವೇನ್ ಮ್ಯೂಸಿಕ್ ಕೇಳ್ತಾ ಇದ್ದೀರಾ? Yes. Don't worry, we'll post it on Friday. Yes, PP Agde sir. NVJ madam. ನೀವು ಹೊರಡಿ. 64 64 fresh matters ಅಲ್ಲೇ ಹಾಕಿ on Friday. Further hearing ಇದೆ, ಅದು ಹೆಂಗ್ ಬರುತ್ತೆ? ಆಯ್ತು, fresh matters ಹಾಕಿ. Further, release the matter from the status of being part heard. List the matter on so and so date, fresh matters. Yes, next. Obviously, yes. Next. ನಾವೆಲ್ಲರೂ ಹೋಗಿ ಅವ್ರನ್ನ ಕೇಳ್ತೀನಿ ನಾನು. ಅಲ್ಲ ಇರಿ ಬೇಕಾದ್ರೆ ಬೇರೆ ಕೇಸ್
ಈ ಕಡೆ ಬನ್ನಿ
6 o'clock who would want to stay? Yes.
Meanwhile, my lord, one more actual aspect is our duty to bring the kind notice on court. This application was dismissed, my lords, for police.
No, don't jumble it. Now come correctly.
Please, now, one, my
Now,
lord.
whose petition first? Jagdish.
Yes, please.
ಹೇಳಿ.
Now, we stand on the same footing, my lord, both, only on the question of law, my lord. Other things, institutions point is, my point is there should be a fair investigation is my point.
Your lordship may
Not
see.
crippled.
Who are those standing there? Why? Settlement matter ಇದೆಯಾ? Settlement case is it?
Not in particular. In particular.
ಕೂತ್ಕೊಳ್ಳೋಕೆ. Yes, sir.
Please, my lord. My lord, the only question is this, my lord. Is there a change in law in 187 BNSS? That's the only point. In 167 CRPC, my lords, the categories, 2 categories were made, one as 167. And your lords may also take judicial notice, my lords. Prior to 1973, in 1898, the maximum period was only 15 days. The time to time legislature has, my lords.
Correct, no problem.
It has changed it, my lord. So the Rakesh Kumar Paul's case, my lords, the Justice Pant's discussion is elaborate on how the law is being changed. Law can be changed any time on this point, my lords. How much time should be granted for the investigation? My lord, as far as 167 CRPC as it could, my lords, it provided like this wordings I beg to read, my lords. The magistrate may authorize the detention of the accused person otherwise than in the custody of the police beyond the period of 15 days if he satisfied adequate grounds exist, and so for a period, etc. 90 days, comma, where the investigation leads to an offense punishable with the death, comma, imprisonment for life or imprisonment for a term of not less than 10 years. 3 categories, my lords, for 90 days in that. Then 60 days where the investigation relates to any other offense. And this question, my lord, the meaning of the term for a term not less than. And finally, the Honorable Supreme Court did 2 decisions, my lord, Raju, and also the subsequent decision, my lord, 3 judge which Rakesh Kumar Paul said not less than means legislative intention must be, it is minimum should be 10.
That's what I have held in
Your lordship,
corporate.
please.
No, it should be minimum is not the word. If it is extendable to 10 years, it can go up to 10 years. It should be 10 years is not the law at all.
Not the law, but my lords, in Rakesh Kumar Paul and Raju's case.
See, earlier, if a punishment can be extendable up to 10 years,
Please.
maximum is 10 years. It is not that maximum should be imposed. It can be less than 10 years.
That's-
Maximum is 10 years.
See, please, my lord.
Beyond 10 years, you can't go. Now it is 10 years and above.
My lord, may I beg to submit in this my line of submissions in this, my lord, this question,
If-
my lord, in clause.
Prima facie,
Please,
what is running in my
please.
mind is there is no change.
That's right, I beg to submit.
There is no change between 167 and 187.
Yes, yes,
It
please.
is the
Your lordship
same,
may-
it is up to say 60 years, now 60, whatever it is.
Please.
Now it is said up to 10 years is not changed. You could have imposed up to 10 years earlier.
Yeah.
Now also 10 years and above, doesn't make any difference.
Please, may I submit, my lord? Please, my lord, first blush it appears so, my lords. May I beg to submit, my lord. Clause 1, the word used earlier, my lords. I beg to read the words, my lord, with kind permission, lords. For
So
a
prima
term
facie, unless you.
not less than 10 years. And it is Rakesh Kumar
No,
Paul.
reason 40 ದಿನ ಅಂತ ಕೊಟ್ಟಿದ್ರೆ ಅದು ತಪ್ಪು. That's a
Uh,
different thing. That order of the magistrate may be incorrect.
Please, please,
That's a different thing.
Once if magistrates, once if it come to conclusion that the charge sheet has to be filed within 60 days, then the police custody is entitled only up to 40 days. That is.
That is under the BNSS.
Yes, sir.
So if it is charge sheet is to be filed within 60 days, is a provision which is up to 10 years or whatever it is. Now, otherly, entitlement of police custody stops at 40th day
40th
because in 40 days you have to file charge sheet.
In 60 days, you have to file.
In
charge.
60 days you have to file
Correct.
charge. If it goes beyond 10 years, you have 90 days and charge sheet you can file up to 60 days. Police, custody you can seek up to 60 days.
Correct.
That is police custody
correct.
at any time during 60 days.
That's
ಈಗ
correct.
ಎಷ್ಟು ದಿನ ತಗೊಂಡಿದ್ದೀರಾ police custody ಅವ್ರಿಗೆ?
No, we have taken, we have not taken
Initially,
full
my lord,
15 days.
Initially, from 10 to 17th, it was taken.
7 days.
10 to 17, 7 days custody was already availed. And my lord, they
Interest
can
of what
avail,
day?
my lord, up to 15 days,
Yes.
varying from up to 40 days.
No, up to 40 days if it is 60 days.
Yes,
If it is 90 days, up to 60 days.
Yes.
So that interpretation we will have to give.
Please, please.
According to me, I don't think there is any change between
No change.
167 and 187.
That is,
Your
your
lordship
lordship may
is
take.
They filed application in the, on the 55th day, they filed an application seeking custody.
Please, my lords.
No, your
My
lordship
lord-
may take 167 for a moment. Your lordship may see 160.
CRPC.
Yes,
Please,
Yes.
please, please.
it says, my lord, 90 days where the investigation relates to an offense punishable with death, imprisonment for life or imprisonment for a term not less than 10 years. Language used there, my lord, not less than 10 years.
Not less than 10
Not
years.
less than 10 years.
Here 10 years or more.
More, this
Language-
language.
No, it's jugglery of words. It does not take away the purport or the meaning of the earlier provision and this provision. 10 years remains 10 years. 10 ವರ್ಷದವರೆಗೂ impose ಮಾಡಬಹುದಿತ್ತಲ್ಲಿ.
Correct.
10 ವರ್ಷ and more impose ಮಾಡಂಗಿದ್ರೆ ಮಾತ್ರ ಇದೆ.
Correct. That's a different, my lord. Now, they say not less than 10 years.
It could be 9 years.
It could be 9 years.
Now it can't be 9 years, it shall be only 10 years is your
Still,
submission.
Not less than.
The reason why they've, the reason why they've incorporated.
10 only, my lords, earlier. That's the problem, my lords.
Huh?
Earlier, Supreme Court said, not less than 10 means it should be minimum 10.
Copyright Act ಅಲ್ಲಿ ಅದೇ ಮಾಡಿರೋದು.
ಹೌದು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಹಂಗೆ ಹೇಳ್ಬಿಟ್ಟು therefore my lords which is punishable up to 10 ಅಂದ್ರೆ.
Very tricky question.
Now they change the law, my lords. According to me, they change the law. Therefore, what they've done, my lords, earlier was not less than. So Supreme Court said minimum. So they wanted to delete that term minimum. That confusion. They that not less than delete ಮಾಡ್ಬಿಟ್ರು ಈಗ. ಈಗದ್ರೊಳಗೆ not less than deleted, my lords.
Not less than is not there in BNSS.
BNSS ಇಲ್ಲಿಲ್ಲ.
BNSS up to 10 years or more.
My lord, one submission.
ಹೌದು ಹೌದು
My
up to
lord,
10.
there is
ಹೌದು.
a decision of this court also, my lord, under the
Under
NDPS.
BNSS.
Yes, sir. Under the NDPS, my lord, similar words are used.
TPS.
Both 167
Sorry,
applies.
which is that judgment ಕೊಡಿ?
My lord, there the word, my lord, 5 years or more. It should be above 5 years or more. That has been interpreted by this court. My lord, here, my lord, 10 years or more means it should be more than 10 years. My lord, not less than 10 years, my lord, was misinterpreted by, my lord, by different high courts. Ultimately, Supreme Court has clarified in Rajiv Chaudhary, it should be 10 years or more. The 10 years or more word used in Rajiv Chaudhary has been inserted in the statute now. Under the BNS, my lord, under the BNSS, my lord, it has been inserted. That word, not less than, has been removed. 10 years or more has been now, my lord, inserted under 187.
Which are those judgments you gave, sir?
No,
My lord,
I
Rajiv
gave-
Chaudhary, lordship may kindly.
Rajiv Chaudhary.
Rajiv Chaudhary and Rakesh Kumar Pal, your lordship, both, my lord, are very clear it is. Rajiv Chaudhary, para 6, your lordship. Para 6, my lord, it is very clear. From the relevant part of the aforesaid section, it is apparent that pending investigation relating to the offence punishable imprisonment for not less than 10 years. Rajiv Chaudhary.
Pass on that judgment.
This, your lordship.
One minute.
Paragraph 6, your lordship, please.
Rajiv Chaudhary.
Rajiv Chaudhary, paragraph 6, your lordship. And Rakesh Kumar Pal, Miller, paragraph 71 and 72. And this Dharam Singh case, my lord, under the NDPS, the same words, my lord, are used. More. 5 years or more has been interpreted, my lord, minimum 5 years and should be above 5 years.
Paragraph?
Paragraph, my lord, it is paragraph 11. your lordship.
ಇಲ್ಲಿ ಪ್ಯಾರಾ ಇಲ್ಲ ಬಿಡಿ ಇದ್ರಲ್ಲಿ.
Paragraph
ಇದೆ,
11. your
6.
lordship. Paragraph 11, it is marked, my lord. Now, this BNSS, my lord, is more clear. Rather than, my lord, what it was indefinite, my lord, under the old code, it has been put it in a more clear manner. 10 years or more. They could have stopped, my lord, 10 years. But the word or more, my lord, they have put it. It should be 10 years and above. The offenses should be.
Yes, Jagdish.
Now, the my lord, 109, 108 is invoked. 306, my lord, offense. The extortion 381. Punishable to the extent of. It may extend to 10 years.
To the extent interpretation.
Yes. My lord,
To the extent.
to the extent, my lord, in Rajkumar Pal and Raju Chaudhary's case, my lord, it has been interpreted that it is below 10 years or up to 10 years. In both these words, my lord, has been interpreted in both the cases.
No, the interpretation, my lord, that not less, even these two judgments speaks about not less than 10 years.
Yes.
Therefore, there, the proposition is.
Now, Justice Mirde ಅವ್ರದ್ದಿದೆ.
Yes.
Yes.
ಅದರಲ್ಲಿ 5 years or more was in the NDPS.
Yes.
That is interpreted to be 5 years
5 years and above.
and above.
And above.
So if it is less than, it carries a different trigger. If it is more than,
Yes,
it
do not
carries a
attract.
different trigger.
No, but
Same statutory provision.
Don't think there is any change.
No
meaning
changes,
is
my
the
lord. No
same.
change, it is more.
The purport was not to change it at all.
no, but I think the
No,
purpose.
the purport was to change also is there because that very police custody that is necessary
Yes.
was wanted a period purti beku anta any
Correct.
time in
Now
15.
the period of 40 days, 60 days, my lord, is the only change. My lord, earlier initial 15 days, my lord, I had argued in another case, my lord. That has been
No,
made
that
now.
is, that I have myself said.
Yes. Now,
First 15 days and not any time they want.
yes.
Yes.
Now, my lord, that 40 days or 60 days, out of these 60 days and 90 days.
Let's see.
The purpose, my lord, if that is the case, my lord, they should have used the same language. Not less than 10 years.
No, because I'll have to analyze. ನೀವು ಹೇಳೋದು there is some meaning because that was what was necessary, doubted by the Supreme Court time and again, whether 15 days would commence from the beginning or it stretches throughout the period on which investigation is permitted under 167.
Correct.
Now, because 187 only, whether we'll have to answer this.
So
I'll have to
therefore, my lord, they purposefully use this language here, 10 years or more. Otherwise, they would have used it more than 10 years. The language, if they wanted to copy the exact term
No,
used in
like it is done in any other, every other provision, it is just copied. ಇದೆಲ್ಲ ಎರಡು ಮೂರು ಮಾತ್ರ change ಇದೆ.
Correct, my lord. Correct.
223 CRPC, where accused has to be heard before cognizance. 175 CRPC, where reference ಮಾಡ್ಬೇಕು ಮುಂಚೆ police,
Yes.
whether he
police
has
should be
complied with it or should be, these are the changes.
Yes.
My
And
lord,
in fact,
here,
the judgment of your lordship with respect to Copyright Act,
Yes,
which is subsequently confirmed by Supreme Court,
yes,
is similarly on the same line.
yes,
There the-
that is what he says, PP Agde sir
Yes,
ಹೇಳ್ತಿರೋದು ಅದು.
Therefore, para
So
16,
3
my
years
lord.
should be
No,
construed
that I have
as.
considered the entire spectrum of the law.
Yes, yes. That is exactly applicable is my submission, my lord. Now.
So this
applicable.
is one such proposition, my lord, where I would say, my lord, legislature,
No, the whole problem is ನೀವು police custody ಕೊಡೋದು. ಯಾವಾಗ ಬೇಕಾದ್ರೆ ತಗೊಂಡ್ಬಿಡ್ತೀರಾ?
up to 60 days we are entitled.
Not up to 60 days.
But that's the legislature intended. What happens, my lord?
ಹಸ್ಮತ್ ಪಾಷಾ ಸರ್ ಕೇಸಲ್ಲಿ 2 ವರ್ಷ ಆದ್ಮೇಲೆ ಇನ್ಯಾರೋ ಸಿಕ್ಕಿದ್ರು ಅಂದ್ಬಿಟ್ಟು
Yeah,
ಮತ್ತೆ
yeah.
ತಗೊಂಡಿದ್ರು.
ಆಮೇಲೆ ಕೇಳಿ ಅಲ್ಲ
Accused number 3 in that case was caught 2 years after
2
filing
years
of the
after.
charge sheet.
ಅಲ್ಲ what happens, my lord? There is one
Correct.
reason, the one
correct.
Yes.
ಅಲ್ಲ one reason, my lord, why they have given this. What happens, my lord? When we arrest certain accused people, initially we take them into custody when recover certain material object. They may have disclosed the true facts, may not have disclosed the true facts, but subsequently during the course of investigation, we may stumble upon anything else. So that also needs to be confronted with accused people. So that's where, my lord, this entire provision.
ಅದು ಬಿಟ್ಬಿಟ್ರೆ you will be getting new material every week. Police custody ಕೇಳ್ತಾನೆ ಇರ್ತೀರಾ.
No, that's only the maximum period is 15 days, my lord.
ಕರೆಕ್ಟ್, 15 days ಥ್ರೂಔಟ್ ಅಲ್ವಾ, ಫಸ್ಟ್ 3 ದಿನ,
ಹೌದು.
ಆಮೇಲೆ ಒಂದೊಂದು 10 days ಒಂದು 3 ದಿನ ಕೇಳ್ತಾರೆ.
ಅಲ್ಲ, that is where, my lord, Supreme Court also doubted the judgments of the CBI.
ಕುಲಕರ್ಣಿ judgment
Kulkarni's judgment.
1994.
Yes, my lord. They have referred it to larger bench to that extent.
ರೆಫರ್
Therefore,
ಮಾಡ್ದಂಗಿಲ್ಲ, ಮಾಡಿದಾರ.
ಅದು
It
refer
is referred,
ಮಾಡಿ. In the meanwhile, the law itself changed, my lord. That's why it was referred.
Yes.
Last para.
But I place on record, my lord, this M. Ravindran's case,
Good.
where, my lord, while interpreting 167, the interpretation should be in favor of saving the liberty. That's what that, this your lordship, my lord,
Yes, Ravin,
this
yes,
Justice Mohan Santanu Kuda.
no,
My lord,
Innu
very
ಏನ್
intent,
sir?
one sentence, very intendment of the legislature, according to us, is now in the BNSS is to overcome these different
There is
verdicts,
no
my lords.
ambiguity
There
in
were
any of
different,
the provisions. This
now they have removed the ambiguity. Earlier, there were ambiguity. There were the series of decisions, my lords, different high courts and different levels, my lords. Some of the high courts said, my lords, not less than
ಈಗ
10
ಏನ್
means
ಮಾಡಿದ್ರು? What did the court do?
court is waiting for my lord's orders. Court is waiting
And
for,
now that no order is passed. it will-
ಅಲ್ಲ, waiting for
court
the
has-
orders ante. Court ಅಲ್ಲಿ, honorable court is waiting, it's informed that the honorable court is directed to hold on the hands till 5:30, your lordship said, my lords.
Correct, 6:30 ಆಯ್ತು.
This how that initially your lordship said day after.
ಅವ್ರಿದ್ದೋಗಿರ್ತಾರೆ.
Everybody would be waiting, my lords. Now, 2 points I wish to add, if your lordship.
Let the court defer it till I pronounce.
yes.
This is a matter which has to be decided because it has wide ramification.
Wait, driver.
At the drop of the hat, we cannot.
Please.
Yes.
My lords, yes, please. If your lords permits, my lord, on factual aspect, my lord,
No, on facts ಏನಿಲ್ಲ sir.
ಇಲ್ಲ,
It's
ಅಲ್ಲ,
only
ಒಂದು ವಿಚಾರ ಇದೆ. Your lords pointed out, my lords, the 60 days period now is over. Now, as on day. So even if it is 90 days, according to this, is certainly 90 days, one aspect. Now 60 days period is over. One aspect your lords may kindly consider what the Supreme Court has said in such cases, my lords. Now, by virtue of, if the honorable court is pleased to hold that the order is wrong, magistrate's order is wrong. Now, by virtue of a wrong order, the right to send something to expert evidence, etc., is lost. To obtain the voice sample, etc., is the application where is lost. Whether investigation can suffer. So in Senthil Balaji's case, exactly same proposition happened, my lords. The honorable court finally.
I'll tell you one thing. Merely filing of the charge sheet. If their claim, they have staked their claim for statutory bail before the filing of the charge sheet.
Yes, yes.
Filing of the charge sheet will not obviate, ನೀವೇನೋ ಒಂದು ಕೊಟ್ರಿ,
Yes,
ಅದೇ.
yes.
That is not the law. Mere filing of the charge sheet will not take away the right of the accused for statutory bail. If they are not heard at the time when the extension was granted, the Coca case,
Coca matter.
That is-
extension was granted.
The special statute.
Special statute, Coca extension ಕೊಡ್ಬೇಕಾದ್ರೆ, you just bought them on VC. They said, we don't know what the application is, our advocate is not there, even then it is extended, then time is extended, the
effective
statutory
hearing,
bail
that's
goes
what-
away. Even in such cases, even if charge sheet is filed,
So that is what
they are
Supreme
entitled
Court,
to bail.
that is Supreme Court has said, there where I was trying to interpret saying that communication is the word used in Coca, no, unlike the
No, no,
UAP.
communication ಪ್ರಶ್ನೆ ಅಲ್ಲ. That's a statutory bail, they are right. And that right should be taken away from them in accordance with law. ಅವ್ರನ್ನ ನಿಲ್ಲಿಸ್ಬಿಟ್ಟು ನಿಮಗೆ ಗೊತ್ತಾ, ಏನು ಗೊತ್ತಿರಲ್ಲ ಅವ್ರಿಗೆ, ಏನ್ ಗೊತ್ತಿರುತ್ತೆ ಅವ್ರಿಗೆ? Do they know the entitlement saying that you can take extension and the court also passes the order.
Yes. When in Hitendra Vishnu Thakur
Lord.
case, 94 Supreme Court,
Yes.
hearing should be effective hearing. That's
No,
what-
hearing ಅಂದ್ರೆ not that you have objections or not ಅಂತ ಕೇಳಿದ್ರು.
Yes.
At least some semblance of hearing.
That he should be informed.
You know the result now. Yes.
My lords, may I also point out a factual aspect, my lords? Before the period of 60 days, the police have found that is an organized crime, my lords, under the act. They have incorporated certain other provisions.
ಇದ್ರಲ್ಲ.
ಇದ್ರೊಳಗೇನೆ, that has to be, that's why.
ಈ fact ಅಲ್ಲಿ.
ಈ fact, ಈ case ಒಳಗೇನೆ.
ಇದ್ರಲ್ಲೂ ಕೋಕಾ ಇನ್ವೋಕ್ ಮಾಡಿದ್ದಾರೆ.
Coca ಇಲ್ಲ. Coca means now in the IPC, my lords, Organized Crime Act and the IPC, they are not.
Allah,
Coca
this is
exactly.
only to deprive the.
No, whatever that.
benefit
Statutory
policy.
bail.
Your lords may kindly see. No. This should be
Supreme
brought
Court
to the
has
kind notice
again
of the
act of
honorable court.
politics.
No, let me see. We will bring the facts to the honorable, kind notice of the honorable court.
To
My lord,
curtail the
there is,
liberty of-
my lord, the extortion.
Cases of abetment to suicide.
No, my lord, initially FIR is for abetment of
What
suicide.
happened, my
When
lord,
this
that certain
application is-
certain videographs of a person who committed suicide has been taken by accused number 1.
Why suicide is short?
No, my lord, not suicide, not
Huh?
sexual act is captured, my lord, it was.
Sexual act.
Sexual act has been
Case of
captured.
my lord.
That has been threatened, demanded for 1 crore rupees.
By
Certain amount
recording
was
this,
paid.
So the person who was committing the act commits suicide.
Please, my
No, no,
lord.
no,
Lady
that is not the true
captures
facts,
it.
Lord.
No, we are not on the true
Accused
facts.
number 1
Prosecution
and
cases, prosecution cases, sexual act is captured by the lady, my lord, and some of the group, then they start demanding, they procure the money, extort certain money, it goes to the bank account, several lakhs of rupees, my lords. Then they again demand money, there is a group, my lords, against whom there are other criminal cases also.
Allah,
So therefore, my lords,
impugned order is
Is
not
that-
connected to
Is
this. Impugned order is not connected to death, your lordship. Impugned order is only for the old provisions. They invoke this provision only day for yesterday. This
No,
is a.
before
organized
yesterday that has
crime
been
and all that.
invoked, is brought to the
The
kind
order
notice of
was
this
not-
honorable court. Day before yesterday it is invoked, my lord, before 60th day, before 58th or 59th day.
ಸುಮ್ನೆ
But we
ಕೇಸ್
are
ಟು
not-
ಕೇಸ್ ಬೇಸಿಸ್ ಮೇಲೆ 16 14 ಮಾಡ್ಬಿಡ್ಬೇಕಿದೆ.
That's right. My lord, one aspect, this aspect,
One
my lord.
clarification, my lord, bail petition is coming on day after, my lord, before the other court, coordinate bench. With the liberty, my lord, we have observation, my lord, that this will not come in the way of urging bail petition on merits.
No, but the police
Can I,
custody.
how can I tell the coordinate bench?
Hello,
saying-
only observation, my lord.
No, no,
This-
no,
this-
that
this-
is not
Police
correct.
custody, unless my lord decides on this, my
So
lord.
this I will decide.
No, my lord.
ನೀವು bail
may-
ಬೇಕಾದ್ರೆ
Bail on
Lord,
merits,
may
my
kindly-
lord.
ಜಸ್ಟಿಸ್ ಶೆಟ್ಟಿ ಅವ್ರ ಮುಂದಲ್ವಾ?
ಹೌದು.
ಅಲ್ಲಿ ಇಲ್ಲಿ ಪೆಂಡಿಂಗ್ ಇದೆ ಅಂತ ಹೇಳಿ ಯಾವತ್ತು ಡೇ ಆಫ್ಟರ್
After it is coming, your lordship.
By then I will give you at 2:30.
yes.
At 2:30 day after I will.
My lords, one aspect, my lords. Now, my lords, at the time when this application was filed, it was, my lords, 306 of IPC and 384 of IPC, 387, punishable up to 10 years.
Extortion abatement.
Before
To the extent
60
of
days,
10 years.
police have added, my lords, earlier 364A, my lord, he was abducted, etc., my lords, for ransom, that's up to death. And
That
now,
is life imprisonment up to death.
yes, that is now added, unorganized, now organized crime is added, section 111 of the present act. That punishment is up to death. That is added. So the armor.
364A is, yes. up to
Yes,
death.
no, please, let me.
a permission from the.
No, my lords,
magistrate
investigation
and
stage only. Investigation is added and reported to the court. There is no
59th
question
day
of
they file
seeking
an
permission.
application.
There is no question of
That
seeking.
will come
Therefore, my
another,
lords.
my lord, another
No, no,
petition
this will
will
change the
come further.
complexion, my lords. My lord, this will change the complexion. Therefore, my respectful submission is, my lords, that application for police custody, anyhow, now it is because of this, my lord, before the statutory period itself, one more application is filed and the report is made, requisition is made that we added this. Therefore, it's certainly 90 days. One aspect, but your lordship may
1
kindly
minute. When was the requisition filed before the expiry of
60 days.
60 days?
How though?
But this
7th
order, my lord, is
7th
passed at
December.
the time of passing
7th.
this order, my lord,
It
no
was not.
such invocation.
Anantara,
No
7th.
such
That
invocation.
is on 59th day, they filed an
Yes,
application.
55th day,
And
some order is
the
passed.
Police custody was rejected on 55th day.
Yes, that's true. My
Because
lord,
their
that is-
application was
submission is-
rejected, they invoked.
Requisition was filed only to take the voice sample, and that was rejected. And subsequently on 59th day, they filed a requisition.
Now, my lords, now by virtue of this requisition, this offense is now death or imprisonment for life. Now, my lord, by virtue of this requisition,
In the
these
entire
act sections
remand application,
are
there is
added.
no
This
ingredients of
is
unlawful
required to be brought to the kind notice of
activities.
this.
There is no ingredients in
This
the
is a
remand
factual
application
question.
at all. And in the complaint also, no such allegations.
And they have
And the
mentioned it.
factual matrix is deceased and accused number one had a
We will not,
living
will not with the
and
facts, all this.
living
Now, I-
relationship for long term of 3 years. And there is an statement by the accused number one say that he delivered a baby and they were having continuous relationship and amount was transferred voluntarily by the deceased to the accused number one when the accused number one was supposed to marry.
The
That was the
telephone,
transaction from last
the
3
telephone
years.
conversations and
Defense.
CTR analysis discloses something else. Initially, it was, my learned friend was right, it was a living in relationship as he claimed, we don't know that. We even though agree to that extent, my lord, that thereafter all accused have joined, blackmailed this person, forced him to deliver the money, threatened him, and that led him to commit suicide. He left a voice message before committing the suicide to many family members and other people.
No.
And thereafter he committed suicide, my lord. It
No,
is
no.
not just
Accused number two is the who contested the election for the masjid. He was the president. The deceased was the president of a masjid. Victim approached the masjid to filing a complaint, saying that he had misused me and he used my husband for some other work. And then the complaint was placed before this deceased, and he had torn the complaint. And then the victim had no other option. He had approached this accused number two, and he conveyed the what was transferred between the deceased and accused number one, and told him to settle. That, Lord, in the matrimonial dispute, no one go to the police station directly. They approach the local masjid to settle the dispute. Then, Lord, when the accused number 2 to 3 is the secretary of the masjid, 4 is the secretary of the masjid, and he being the president of the masjid, of the deceased was the president, and conveyed the incident what was narrated by the accused number 1. And he got it humiliation and he committed suicide. And one more thing, Lord, what are all the transaction? Transaction was happened, Lord, in a sale
Those are
agreement.
matters of investigation.
Yes.
We are not on the merit of the matter.
They
Now
made
we
a
are on
provision.
whether police custody should be given or not. Interpretation of 187. Do
My
it.
lords,
Day
in,
after
in
tomorrow.
Senthil Balaji, last
if
para one only, Senthil Balaji,
Put it
what
judgment
happens, I have produced it, my lords, but can, mark,
ಕೊಟ್ಟಿದ್ದೀರಾ ಈಗ?
ಕೊಟ್ಟಿದ್ದೀನಿ,
ಹಾ, ಸರಿ.
ಅದ್ರೊಳಗೆ, if the wrong order is passed for wrongly, police custody is not given. Can it be given later by a superior court, my lords?
That is
And,
what
the
Kulkarni
principle
was
of,
doubted in that.
actus curiae nemium is applied was, my
Act
lord.
of court will not.
That's applied, and police custody was given, despite that years had lapsed, my lords. So
Yes.
therefore, my respectable investigation will
Madam,
hamper,
divide
my
by
lords,
that.
by virtue of this, my
Divide
lords.
Good, good.
So,
We'll post it for further hearing at 2:30 day after
Please,
tomorrow, but
please.
I'll pronounce.
please, your lordship,
Your
can you
lordship
directly, specifically direct them not to proceed, my lord?
Your lordship may observe, my lord, that trial. court
The matter is heard at length, heard so and so, the ಬರ್ಕೊಂತಾರೆ ಬಿಡಿ. I'll pass the order and get it uploaded.
Yes.
Notice may be ordered for respondent to lordship will accept it.
Which
Advocate
respondent?
on
But the
record.
accused persons, in
Advocate
both the
on
petitions, my
record.
lord, accused are also made as respondents. Because
Who you accept notice?
for respondent.
ಒಂದ್ ನಿಮಿಷ.
ವಕಾಲತ್ತಲ್ಲ ಇದೆ.
ಈ cause list ಅಲ್ಲಿ ಒಂದ್ ನಿಮಿಷ ನಾನೇ ಬರ್ಕೊಂತೀನಿ.
Appearance ಮೇಲೆ.
One moment. Serial number?
7.
7 ಅಲ್ಲಿ respondent.
7 and 11, respondent Mustafa.
1 minute. You accept notice for which respond? Both the respondents?
Second respondent.
Second respondent.
In the
Mustafa.
serial number 7, my lord, this for the
Second
respondent number 2.
R2.
I am for accused number.
R2 Mubarak.
Accused number 3.
Karyappan.
Karyappan.
Ah.
3 and 5.
3 and
3 and
3 and 5 Latif.
Mustafa ಅದಲ್ಲಿ
ಈ ಕೇಸಲ್ಲಿ
Accused number 3 and 5.
Mustafa
3 and 5.
3 and 5 Latif.
1 and 3.
ಅಲ್ಲ accused number, respond number.
ಅಲ್ಲ ಯಾವ್ದ್ರಲ್ಲಿ ಇದು ಸ್ಟೇಟ್ ಹಾಕಿರೋದ್ರಲ್ಲಿ.
Respond 1 and 3 Latif, man.
1 minute. 1 and 3 Latif. ಆಮೇಲೆ
Respondent number 3 in that matter, ma'am.
ಒಂದೊಂದಾಗಿ ಹೇಳಿ ಸರ್. ಫಸ್ಟ್ ಇದ್ರಲ್ಲಿ ಹೇಳಿ.
Respondent number
ಸ್ಟೇಟ್
2.
ಹಾಕಿರೋದ್ರಲ್ಲಿ
respondent number 2 ಇಲ್ಲ.
ಮೊಹಮ್ಮದ್ ಮುಸ್ತಫಾ
Respondent number 2, man.
2 R2 ಗೆ ಕಾರ್ಯಪ್ಪ.
ಅದರಲ್ಲಿ R3 ಇಲ್ಲ.
R3 is this Kalandar Shafi.
Yes.
Latif appears.
I am.
1 and 3 Latifa.
Please.
And Soheb. Soheb less than
3
3.
is 3, I am appearing in that matter. Mohammed Mustafa.
Mustafa is 2 sir.
Mustafa is appearing.
2 in this petition. ಈ petition ಕೊಡಿ ಮೇಡಮ್. ಇದರಲ್ಲಿ ಕಲಂದರ್ ಸಫಿ ಲತೀಫ್.
Please.
ಆಮೇಲೆ ಮೊಹಮ್ಮದ್ ಮುಸ್ತಫಾ ಕರಿಯಪ್ಪ. Then Soheb Latif. So service is complete. Copies ಎಲ್ಲ ಇದೆ already. They have exchange copies anyway. Yes. Let's day after tomorrow. It's only legal interpretation.
But this
I'm-
will have
I'm
a
not-
long,
I'm not going on facts, we'll see, because
which will have long.
it has wide
Wide
ramifications.
ramifications, my lords. One on facts is, my lords, that the London
On
magistrate.
facts, nothing.
Allala, on merits, my lords, the London magistrate dismissed the application holding on this ground.
That will.
Please. Therefore, my respectful submission is, my lords, is the reasoning is improper, my lords. Application with the London magistrate liable to be allowed, my lords.
Will have to be?
The application before the London magistrate for the police custody, because it's filed within the time. Only on this legal ground it has been dismissed. Only on that.
Allowed if I am
If you.
accepting your
Yes, yes, only if the honorable court is pleased to accept.
Defer the proceedings, my lord, the order.
Huh?
Defer the proceedings, the order, my lord.
ಅದು upload ಮಾಡಿಸ್ತೀನಿ.
Please.
Because I have asked this stenographer.
Grateful.
Yes.